Defrauding America. Encyclopedia of Secret Operations by the CIA, DIA, and other covert agencies. Rodney Stich, former government investigator, assisted FA, CIA and other spook whistleblowers. Defrauding America is written by Rodney Stich, author of 3 editions of Unfriendly Skies. He describes and documents massive government misconduct that he and several dozen former deep cover sources discovered during the past 30 years. These agents and operatives, from the CIA, DIA, ONI, and FBI, either participated in the criminal activities under orders, or were in a position to know of the corrupt activities. The author was a Navy pilot in World War II, an airline captain after the war in domestic and international flying, an inspector investigator for the FAA, and assigned safety responsibilities at several major airlines. He has appeared as guest and expert on over 2,500 radio and television shows in the United States, Canada, Mexico, Germany, and Holland. He has been a crusader against high-level government corruption since 1962. He is a member of the Association of Former Intelligence Agents, International Society of Air Safety Investigators, Lawyer Pilots Bar Association, among other prestigious groups. The reader will learn from these pages many of the inner secrets of covert activities by such powerful government bodies as the Central Intelligence Agency, Defense Intelligence Agency, Justice Department and its many divisions, and others. The reader will discover operations by those in control of key government agencies, especially the CIA and Justice Department, that have inflicted through arrogance great physical, personal, and financial harm upon many Americans, and even death. Among the many government operations revealed within these pages that are secret are the following: drugging of America, initially by the CIA, as first discovered by the author in the early 1950s while flying captain for various airlines out of Japan and Middle East countries. This CIA drug operation has been repeatedly confirmed by the author's many deep cover sources, including agents and operatives of the FBI, CIA, DIA, and ONI. Even drug traffickers and mafia families have revealed these secrets to the author. Long working relationship between the CIA and organized crime, including joint drugging of America. The role of the CIA in looting the savings and loans in the 1980s, as revealed to him by FBI and CIA sources, including those who were actively involved in the corrupt activities. The secrets behind the interrelated October surprise, Iran-Contra, and drug trafficking activities, reaching into the White House itself. Secrets behind the downing of Pan Am Flight 103 over Lockerbie, as revealed to the author by DIA, Mossad, and CIA personnel close to the scene. Secrets associated with the downing of TWA Flight 800, and the author's earlier warning to Congress of missile attacks, the cover-up of which required unprecedented disinformation and cover-up of the most probable cause of the disaster. The duping of a compliant American public, and how they themselves share blame by their deliberate refusal to become informed and to exercise the responsibilities associated with our type of government. Contents. Chapters. Air disasters and government corruption. A brief reference to government corruption related to a series of airline disasters and the author's attempts to expose and halt the misconduct. Attacking the whistleblower. The bizarre misuse of the judicial system to silence the author's exposure activities. Complicity by federal judges. Federal judges who became key players in the cover-ups, the obstruction of justice, and the persecution of a whistleblower. Chapter 11 Retaliation. An accounting of how government personnel forced the author into Chapter 1 and then stripped him of his life's assets, all in violation of law. Report crimes of federal officials go to prison, how federal judges and Justice Department prosecutors colluded to sentence the author to federal prison in retaliation for reporting the federal crimes and for defending himself through the exercise of constitutional and statutory remedies. Exercising federal remedies. Various unusual federal actions filed by the author reporting the federal crimes and defending himself, and the felonious reaction of federal judges. HUD fraud. Looting of the HUD program, bribes, favoritism, and cover-up by Justice Department and Congress. Pages 13, p. 33, 59, AO 7, 14, 16. Savings and Loan Fraud 104. Another perspective on savings and loan looting, including CIA involvement. October Surprise 134. CIA scheme against a President of the United States. CJA Whistleblowers 143. The author's chance meeting of CIA informants who participated in the October Surprise operation, providing further proof that the operation existed. October Surprise Cover-Up 173. A detailed accounting of the tactics used to obstruct the truth relating to the October Surprise operation. Iran-Contra 202. The progeny of October Surprise, reveals the sordid side of Iran-Contra, including the illegal arms sales, the assassination squads trained and funded by the CIA, and the drug trafficking into the United States. CIA Review 229. A brief portrayal of the CIA. CIA's Nugan Bank 241. CIA money laundering operation in the Pacific, until its cover was blown. BBRDW 247. CIA money laundering operation in the Pacific, taking over after the cover was blown on Nugan Bank. INS Law and Crimes at Justice 281. Corruption by Justice Department officials relating to the theft of software developed by a small company. BCCI Bank of Crooks and Criminals 309. The BCCI operation, its contacts with Bank of America and the CIA, and its crooked method of operations, as well as the cover-up. Bank of Lavoro and Iraq Gate. U.S. suspicious funding of Iraq's war machine. CIA and DIA drug trafficking. CIA drug trafficking into the United States. Silencing whistleblowers. Tactics used to silence informants and whistleblowers, including killings, mysterious deaths, felonious persecution by Justice Department prosecutors and federal judges. Federal government as a criminal enterprise. The criminal activities by federal personnel in control of powerful government entities and their felony persecution of informants. Legal fraternity as a criminal enterprise. The element found in each of the criminal enterprises, or their cover-up. Israel, the Mossad, and America. The part played by Israeli officials, the Mossad, in several of the criminal enterprises. Other corruption. Other forms of government and non-government corruption in the United States. Supreme Court complicity. Aiding and abetting by Supreme Court justices. Crimes of cover-up. The felony and endemic cover-up by the establishment, media and government checks and balances. Anatomy of a CIA proprietary. CIA airline and its cargo of drugs. Continuing discoveries. Additional CIA whistleblowers and CIA operations discovered by author. 29 CIA DIA drug roll in PA 103. 641 CIA DIA drug pipeline making possible placement of bomb on Flight 103, and Justice Department cover-up. 30 The Clinton Gang 648 Sex, drugs, killings, attorneys, CIA, and more of the same. 31 Evidence on top of evidence. 665 Additional sources, including agents of the FBI, CIA, DIA, providing information and documentation on criminal activities, including drug trafficking, assassination of American POWs, and more. 32 Implications and action required. 97 Devastating future for the indifferent American public. Dedication. This book is dedicated to the memory of those who have suffered so grievously at the hands of corrupt government in the United States. They include, those who perished in fraud-related airline crashes, which the author details and documents in his classic book, Unfriendly Skies. Those who were fraudulently imprisoned to silence or discredit their disclosure of high-level government corruption. Those who were stripped of their life's assets as they were targeted through the misuse of government offices and power, especially through the federal bankruptcy courts. Asterisk those who died in wars generated by the CIA and other government entities on sham pretenses, such as Korea and Vietnam. Asterisk those who died in government raids such as at Waco, Ruby Ridge, and the many other incidents that the national media chose to ignore. Asterisk those who have yet to suffer from financial, personal, and physical harm, even death, as a result of the corruption described within these pages. Asterisk those people in other countries who were the victims of U.S. invasions and undermining of their governments, economic sanctions, the training, arming and funding of guerrilla forces that inflicted torture and death upon them. Asterisk to those brave people who sought to expose different aspects of this corruption and who paid and are paying the consequences for their foolish acts. It is unfortunate that the government and most of the non-government checks and balances have become involved through complicity of cover-up and disinformation, and that most of the public lacks the courage and integrity to meet their responsibilities in defending against these national outrages. It is hoped that this book will motivate others to learn about what is being done to America and its people by those in control of the invisible or secret government. Applicable European quotation. In Germany they came first for the communists, and I didn't speak up, because I wasn't a communist. They then came for the Jews, and I didn't speak up, because I wasn't a Jew. Then they came for the trade unionists, and I didn't speak up, because I wasn't a trade unionist. Then they came for the Catholics, and I didn't speak up, because I was a Protestant. Then they came for me, and by that time no one was left to speak out. Attributed to Martin Niemöller. An appropriate U.S. quotation. I didn't speak out when the leaders acting in my behalf destabilized governments throughout the world, invaded foreign countries, and trained terrorists, making possible the deaths of millions of innocent people. I didn't listen, or care, as Americans went off to wars engineered by people in control of the CIA and other government entities, and remained mute as tens of thousands of America became cannon fodder. I didn't listen as people told me about the years of CIA drugging of Americans. I didn't listen when I was told about the corruption associated with specific airline crashes. I didn't listen as brave people spoke out and who were subsequently falsely charged and imprisoned. I didn't listen, or care, as fellow citizens were being physically and financially abused by arrogant government agents breaking into their homes and subjecting them to indignities unknown in civilized countries. I didn't listen as voices spoke out about the looting of savings and loans. I chose to remain ignorant about the depth of corruption by government officials and judges. I ignored the pattern of cover-up and criminal activities by members of Congress and much of our media. I ignored the patterns of corruption as if they didn't affect me. I ignored my responsibilities as a citizen, and was indifferent to the tragic plight of those who were directly affected by the massive corruption in government. I shirked my responsibilities by eagerly believing the disinformation and denials given by the mainstream print and broadcast media and federal officials. The noose is tightening, and more of us are being incarcerated, deprived of civil and constitutional protections, and even our freedom. Eventually it will be too late. Many share the blame for these human rights outrages. Very few of the victims would have suffered if enough Americans had exercised courage and responsibilities to fight this cancerous growth. Sample of reader comments sent to Rodney Stich. In my opinion, you deserve the highest commendation this country can bestow on a man. Instead, our subversive and corrupt government has tried to crucify you. God bless you, sir, for the wonderful work that you are doing. I think that you are a modern-day American hero. First of all, I would like to congratulate you and thank you for your heroic efforts and patriotic morals to the people of this nation in your heartfelt work. Just a short note to send my highest regards to you. Your truthfulness is so very refreshing. I am writing to thank you for your perseverance and dedication. I don't happen across too many true African patriots anymore. It was hard not to cry through certain parts of the book. Ever since the publishing of your book, The Unfriendly Skies, in 1978, I have been a follower and admirer of you, your activities, courage, and intelligence. I am inspired by men such as yourself who have the courage and conviction to stand against overwhelming odds and aggression, all in the name of truth. May God bless you, Rodney, bless you and protect you. I have a strong stirring in my heart that men such as yourself will not be much longer tolerated by the powers to be. You, sir, are a patriot by the very definition of the truth you shine. May you live long and prosper in the kingdom of righteous men. When I manage to meet a man such as yourself, Rodney, I am reminded of the greatness the nation once had. If only there were more people with the courage of Rodney Stich. Dear Mr. Stich, brave, honest, noble, bright. That's Rodney Stich. Chapter 1. Air Disasters N. Government Corruption. Investigator and then private investigator, and a large number of former CIA and other deep cover operatives, have experienced or discovered during the past 30 years. This corruption, adversely affecting the national security and the lives of many Americans, has been kept from the American people by virtually every government and non-government check and balance. The intent of this and other books that I have written has been to inform the public of the misconduct and harm inflicted upon Americans by people in control of their government and to motivate them into meaningful action and exercise of their responsibilities. I first discovered criminal misconduct associated with a series of brutal airline disasters that were occurring on programs for which I held federal air safety responsibilities as a federal air safety inspector investigator for the Federal Aviation Administration. A major air disaster was occurring on programs for which I had safety responsibilities on an average of every 6 months, and continued for many years. To this date, not a single one of the guilty parties ever suffered for their crimes, and actually profited. Because of these tragedies and the arrogance of those who held a key role in making them possible, I started exercising government and non-government remedies. The more that I tried, the greater was the amount of corruption that I encountered. It turned into a David versus Goliath battle against powerful elements in government. Without that government experience as an insider, I would probably be as uninformed and indifferent to the corruption and the harm as most Americans are today. Extensive aviation background, my ability to recognize the relationship between airline crashes and the behind-the-scene problems that caused or made them possible arose from a combination of unusual aviation experiences. The basic aviation knowledge arose from my many years in military and commercial aviation. I joined the Navy at the young age of 17 and after training, and before the Japanese attack upon Pearl Harbor. AK has pages detail and document corruption that ace of former government. I became a radio man on a PBY Catalina seaplane. In 1943 I received my wings as a naval aviator and then became a PBY flight instructor, followed by command pilot on 4-engine Navy Liberators and privateers throughout the Pacific. After World War II I became an airline pilot and captain, flying in virtually every type of plane flown by U.S. airlines, including the double-deck Boeing Stratocruiser and Lockheed Super Constellation. My flying included passenger operations throughout most of the world. While flying captain for Japan Airlines I had Japanese co-pilots, a few of whom ironically were in the same small group of pilots flying out of Wake Island during the war who used to shoot at me when I was flying patrol flights out of Midway Island. In these types of flight operations there were many interesting experiences, including for instance the time that I found myself in the middle of an Iranian revolution in 1953. I had my share of engine failures, engine fires, sudden closing of virtually all airports at my destination, serious icing problems on the North Atlantic, sudden shortage of fuel when the headwinds over long overwater flights more adverse than forecast. Discovering the politics of air safety, where I really learned about highly technical air safety matters and the politics of air safety, was after I became an air carrier operations inspector for the Federal Aviation Administration. My first assignment was to the FAA Los Angeles District Office. I joined the FAA shortly after the FAA was legislated into being following a spectacular mid-air collision over the Grand Canyon when a United Airlines DC-7 crashed into a TWA Constellation, causing the deaths of everyone on board. At this time I have many FAA-issued licenses, and had extensive aviation experience. Among my many safety-related responsibilities were conducting flight checks of airline pilots and issuing ratings enabling them to fly that particular aircraft in airline operations. There were problems in the Los Angeles office due to the internal culture within the FAA that continues to this day, but there were more serious problems at another location, with one politically connected airline experiencing more airline crashes than all the other airlines combined. After an initial assignment to the Los Angeles district office, I was asked to volunteer for a crash-plagued program that experienced more air disasters than all the other airlines combined. The corruption that I discovered from that assignment, and concern about the many people who were killed as a result of the deliberate misconduct, started me on years of attempting to expose and bring to justice extremely serious corruption involving federal officials. I constantly discovered other areas of corruption that, if someone had told me earlier about it, would have thought them to be paranoid. The problems that I discovered had already been discovered by other FAA inspectors. Some had transferred to other assignments when their lawful duties were blocked and they were subject to threats by airline and FAA management. My predecessor, who was persistent in seeking to correct the serious safety problems, was ordered transferred to a meaningless assignment in Puerto Rico. People who also suffered from the politics of air safety were the flight crew members, some of whom were denied the legally required and industry-accepted training, and subjected to aircraft that had inadequate safeguards. By denying 3. Training to pilots and lowering competency requirements, that particular department saved considerable money. The people responsible for this situation received the benefits that went along with that conduct. There were other aspects to this misconduct. Government-required records were falsified to fraudulently indicate that training was given when the training and competency checks were not accomplished. These were criminal acts, and in light of the repeated crashes associated with the air safety fraud, the implications were extremely serious. Almost every crash experienced by that airline was due to pilot competency problems that originated from the violation of training regulations. Compounding these problems, FAA management in the local district office, in the Los Angeles regional office, and in Washington, knew of the violations and their relationship to the continuing crashes that covered a period from 1960 to 1978. L'expérience, as did other inspectors, harassment, intimidation, threats, and adverse personnel actions. It was a nasty situation. FAA management repeatedly removed and destroyed inspector reports of these safety and criminal violations. Whenever I discovered this occurrence, I filed copies of the originals, which simply enraged management. When weak captains were scheduled for flight checks to be performed by FAA-approved company check airmen, and I made it known that I would be observing the check, as FAA inspectors were required to do, I would be ordered by FAA management not to show up. I arrived on this tragedy-plagued program shortly after it experienced the world's worst air disaster, in which a DC-8 crashed into the heart of New York City. That senseless tragedy was followed within a few months by another senseless crash at Denver. At that time, FAA inspectors like myself were outraged at the massive safety problems at the airline and FAA actions blocking federal inspectors from performing their duties. One outspoken and concerned inspector, Frank Harrell, took the extraordinary step of circumventing the Denver district office and Los Angeles regional office and went to Washington, complaining to both high-level FAA and National Transportation Safety Board personnel. Typical of the culture in the FAA, nothing was done in response to these reports. Years later, after many other crashes occurred in that same program due to the same combination of corrupt acts, I also went to the same high-level officials, unknown that my complaints were preceded by other inspectors. Since we inspectors had the technical ability and authority under federal law to establish the existence of these safety problems and safety violations on the part of the government, the actions taken against us, including the threats and adverse job actions, were extremely serious. Especially so in light of the many people who died in related air disasters. In response to these serious problems, some inspectors transferred to other assignments where the airlines were more cooperative and in compliance with the law. A very few, like myself, sought to do something about the problems and fought the system, paying a heavy price for trying to comply with our federal responsibilities. 4. The really smart inspectors, and there were plenty of those, simply looked the other way, did not report the problems, and even covered up for them. They gained promotions and higher pay, including outstanding performance awards with their financial bonuses. Of course, people paid the consequences, as many were cremated alive, dismembered alive, and experiencing the horror that accompanies air disasters. Among the problems that I encountered and reported included, violation of federal air safety training requirements, denying to flight deck crew members the legally required training and competency checks, and then falsifying records to indicate that these requirements were accomplished. FAA approved company check airmen with an anything goes safety standard, allowing the airline to eliminate the need for corrective training of pilots and flight engineers who needed additional training. When FAA inspectors, who monitored such checks, reported the problems as they were required to do, FAA and airline management threatened and harassed them. Removing FAA inspectors from company-conducted flight checks of known weak pilots. Refusing to take corrective action when inspectors reported that the airline was falsifying records, was not conducting important safety training and competency checks of flight crew members. Refusing to take action on the flight engineer training program and chaotic competency standards of many of the flight engineers. Refusing to take action on my reports that the important emergency evacuation training, which was required by law to be accomplished every 12 months, was being accomplished only every 3 years, and the records falsified to indicate compliance. Refusing to correct serious flight instrument deficiencies, which resulted in a foreseeable crash and over 100 deaths during a Los Angeles airport departure. Refusing to provide required corrective training to specific pilots who reported as having dangerous piloting habits. In one instance, due to the same piloting deficiency that I had reported of a specific pilot, 32 people were cremated alive at Salt Lake City several months after I made the report. That same pilot had been denied the corrective training that was required by federal law. FAA management and the airline had a relationship that played a causative and permissive role in many air disasters over a 20-year period. Silencing federal inspectors when arrived in the Denver office to take over the new assignment, one of the inspectors who knew of the problems and who was disturbed by them, but who lacked the courage to fight FAA management, clued me in on the many problems. I was surprised when he would motion for me to talk in some remote location of the FAA building, or we would go outside the building, to discuss the serious problems at the airline and within the FAA. Listing a few of the many crashes caused or made possible by this combination of fraud and criminal misconduct at United Airlines, the following shows how everyone on these flights was subjected to the dangers, and that periodically some of them paid with their lives. For example, 5. UAL Douglas DC-7 ramming a TWA Constellation over the Grand Canyon, June 30, 1956. This crash caused the formation of the FAA in 1958. UAL DC-8 crash into New York City, for many years the world's worst. The crash was precipitated by extremely poor and dangerous piloting technique. And this problem was caused by the airline denying to the crew the legally required training, which was covered up by FAA management. UAL Douglas DC-8 crash at Denver. This and other UAL crashes were an extension of earlier company and FAA misconduct. UAL Boeing 727 crash Salt Lake City. This was caused by poor knowledge and dangerous piloting technique by the entire crew. This consisted of a dangerous approach technique that I had observed on an earlier flight check of that same captain. I also reported that certain check pilots at United Airlines had a similar problem. I had repeatedly reported that the flight engineer training program was the worst that I had ever seen and that the competency checks of the engineers was a sham. In that tragedy, the flight engineer failed to shut off the fuel valves and fuel booster pumps, allowing fuel to be pumped out of the aircraft through broken fuel lines. The final nail in the coffin for the cremated passengers was the deliberate refusal of airline management to provide the mandatory emergency evacuation training, resulting in the crew poorly performing evacuation of the passengers. United Airlines falsified important records to cover up for these safety violations. This was a criminal act that resulted in many deaths. UAL Boeing 737 crash into Chicago due to poor piloting performance, continuing to show the consequences of UAL and FAA management misconduct existing behind 20 years of fatal crashes. UAL Douglas DC-8 crash near Salt Lake City due to poor piloting performance, compounded by the alcohol-impaired flight engineer. UAL Boeing 727 crash into the Pacific near Santa Monica, caused by several factors, known poor engineer training and competency, illegal dispatch of the aircraft with one generator inoperative and a second generator malfunctioning, absence of backup-powered flight instruments, a known dangerous condition which I had earlier reported. UAL Douglas DC-8 crash into Portland as all four engines ran out of fuel due to poor knowledge by the flight crew of the aircraft systems. UAL Douglas DC-8 crash out of Detroit due to poor piloting technique. UAL Boeing 737 crash into Chicago due to poor piloting technique. UAL Boeing 727 crash into Lake Michigan due to known altitude awareness problem that I had repeatedly identified, tried to correct. I was ordered by FAA management to disregard this problem that had already resulted in several major air disasters and near crashes. Many other crashes and incidents. Typical of the toll in human misery arising from FAA misconduct was the refusal to correct the cargo door problem on the DC-10 that caused the loss of nearly 400 persons, and other crashes with similar misconduct. What was revealed in 20 years of fatal crashes? 6. Sending a hatchet man to silence me. FAA management used various tactics to stop my reporting and attempted corrective actions that were required by federal law. But instead of halting my reports, the retaliation caused me to increase my inspection and reporting of the tragedy-riddled misconduct. I had tried to work within the system, making office reports, and filing reports with the regional office, making high-level regional management aware of the serious problems, to no avail. Showing that this was not a local FAA culture problem, Washington sent a replacement manager to take over the Denver district office, and he spent a major part of his work function seeking to halt my reporting and corrective activities by a pattern of harassment, threats, and job actions. An FAA independent prosecutor, as the crashes continued to occur from the same basic problems, and pressure increased to silence me, I exercised an internal procedure to force a hearing upon the FAA during which I acted as a form of special prosecutor producing testimony and evidence supporting my charges of FAA corruption related to a series of specific air disasters, including of course the air safety and criminal violations of the airline in question. FAA management engaged in perjury, subornation of perjury, fraud, using legal arguments to deny the existence of the safety and criminal violations that were already established in the FAA records. Many more people would experience the horror preceding their deaths in subsequent crashes caused by or allowed to occur by these corrupt practices. This hearing lasted over 4 months, and produced over 4,000 pages of hearing transcript and documents. During the hearing I was opposed by the FAA legal staff, high-level management, and an attorney who was on the FAA administrator's staff. During this hearing I discovered still other documents, including an inspection report that I did not even know existed that provided more evidence of misconduct relating to the New York City and other crashes. More crashes and more deaths during the hearing. During the hearing several other air disasters occurred in my area of responsibility, making it even more obvious how the public pays for the corruption at the airline and within the FAA that I was exposing. Long before the hearing had started, I had talked by telephone and sent letters to high-level officials in the National Transportation Safety Board, detailing the air safety and criminal violations, associating them with prior air disasters, and warned of still more crashes that could be expected. Under law, the NTSB is required to investigate any air safety problems brought to their attention. But here we had much more than air safety oversight. We had criminal misconduct that could be directly linked to specific air disasters, and to expose this would expose what would probably be the world's worst aviation scandal. NTSB complicity. I reminded the NTSB of the obvious, that if they did not immediately conduct an investigation, that the problems would undoubtedly bring about more of the same air disasters. They did nothing. Then, as the FAA engaged in a concentrated 7. effort to cover up for the serious problems during the hearing, engaging in obvious perjury, subornation of perjury, fraud, legal chicanery, I again contacted high-level NTSB officials in Washington, advising them of what was being done, and of the probable consequences in continuing crashes. Déjà vu again and again during the 4-month hearing and hearing cover-up, several more crashes occurred, due to the same basic problems that I had reported, and which were associated with prior air disasters. The NTSB had to then rush to the accident scenes to investigate the crashes caused by the serious safety problems and criminal violations that I had brought to their attention earlier, and as other inspectors had done. To protect their own contributing role in these crashes, the final NTSB accident report prepared by the politically appointed board members had to omit the serious misconduct that I had brought to their attention. Under federal law, this constitutes a false report, and fraudulently misrepresents the report's conclusion. The NTSB had to report the direct causes of the crashes, but omitted the misconduct that made the direct causes possible, or caused the direct causes to occur. Cover-ups by every check and balance. As the misconduct, cover-ups, and crashes continued, I sought imaginative ways to circumvent the high-level government blocks. I had gone to various divisions of the U.S. Department of Justice with my complaints, including the FBI, various U.S. attorneys, and the Department of Justice in Washington. I encountered a block, a cover-up, obstruction of justice, wherever I went. I sought to circumvent the Justice Department cover-up by appearing before a federal grand jury in Denver, where I quickly discovered the power of the U.S. Attorney. As the Wall Street Journal frequently writes, the grand jury would indict a ham sandwich if requested by the U.S. Attorney. Likewise, most grand juries would not act on their own to render an indictment if the U.S. Attorney did not want an indictment to be handed down. Whenever it was appropriate, I would notify the print and broadcast media of my charges when a major air disaster was front-page news. Even though the crash occurred in my area of federal responsibilities, and I had federal authority to make these determinations, not a single media source would receive my statements and evidence. Over the years, I found this cover-up by the media to be standard operating procedure. Exhausting judicial remedies under a federal criminal statute. A federal judge is required by federal law to receive evidence of a federal crime from any person. It is also a felony if any person who knows of a federal crime does not promptly report it to a federal judge or other federal tribunal. Since people in control of the U.S. Department of Justice refused to receive my evidence and were themselves implicated through cover-ups and obstruction of justice, I exercised this right, and this responsibility. Under Title 18 U.S.C. Section 4. I filed the first action in the U.S. District Court at San Francisco, seeking to report the corruption within the Federal Aviation Administration. The federal district judge sympathized with my position, but in accordance with the opposing brief filed by the Department of Justice, dismissed my action. I then appealed it, and in argument before the Ninth Circuit Court of Appeals in San Francisco, the 3-judge panel argued that this is a matter for Congress and not the courts. I argued otherwise, saying that it was a responsibility of the courts to receive my evidence, under the federal criminal statute, and also that a federal judge had the responsibility to order a federal agency to halt unlawful actions. Again the action was dismissed, and again, the dismissals caused the deeply entrenched problems to continue, as well as the crashes and the deaths. I filed similar actions following the PSA San Diego crash, which was at that time the world's worst air disaster, taking the title away from the New York City crash that occurred on the program for which I had air safety responsibilities. In that crash, the NTSB had covered up for the all-night partying and drinking of the airline crew, whose actions early the next morning resulted in a horrible tragedy into a residential area of San Diego. Following a pattern, the NTSB covered up for the underlying cause of the crash, and I petitioned the NTSB to receive my evidence relating to that tragedy. They refused to receive the evidence. I then filed an action with the District Court at San Francisco * seeking to have the court order the NTSB to receive my evidence and that of a witness who could testify to the partying. Shortly after I filed the action, an assistant U.S. attorney called and stated to me over the phone that he was supporting my position and was recommending to his superiors in Washington that this be done. That relatively new AUSA with the Justice Department was unaware of the prior Justice Department involvement and cover-ups, not realizing that supporting my position could expose the Air Safety and Justice Department scandal that already existed. That AUSA then filed a motion to have my action dismissed, which the judge did. I also filed a friend of the court brief associated with litigation against Douglas for a scandalous DC-10 crash, which required that I obtain the approval of the various lead attorneys involved in the litigation. I received this approval, but again the district judge dismissed my attempt to provide evidence. Going direct to the people still harboring the fantasy that the public wanted to hear about the corruption that was threatening them when they flew, I decided to circumvent the government and media blocks that encountered by publishing the first edition of Unfriendly Skies, which went to print in 1978, immediately after the PSA San Diego crash. Publishing the book, and appearing as guest and air safety expert on radio and television shows, the truth would come out. There is much more to this period of corruption, and I strongly recommend that anyone really interested in how government operates, how government corruption continues year after year, and how this corruption results in tragedies, read the latest edition of Unfriendly Skies. 5 Between Unfriendly Skies and Defrauding America, the reader will learn more about government corruption, as seen by an insider, than found virtually anywhere else. Were it not for the people responsible for the pattern of air safety and criminal acts and related air disasters, I would never have been motivated to become a crusader or activist against corrupt government, and I would never have discovered the endemic corruption detailed and documented within these pages. In a perverse way, these producers of tragedies can be thanked for making possible the discovery of even worse corruption and the tragic consequences suffered by many Americans. The examples given in this book are highlights of events, and only a small part of what I and other federal investigators, and other insiders, discovered. The criminal activities and the harm suffered by Americans and America, have and are occurring in part because of the breakdown in checks and balances, the refusal of Americans to become informed, and massive indifference that became so very clear to me during the past 30 years. These first few pages will detail and document the corruption within the government of the United States that led to the deaths of many people, and still affects to a lesser extent safety in air travel. Chapter 2. Attacking the Whistleblower. Published the 1978 and 1980 printings of Unfriendly Skies. One appeared as guest on hundreds of radio and television shows and had also filed federal lawsuits against FAA and NTSB, all of which were focusing attention on serious corruption in government. The people and groups threatened by my exposure activities included officials within the Federal Aviation Administration, the National Transportation Safety Board, U.S. Department of Transportation, members of Congress, federal judges, including the justices of the U.S. Supreme Court, and management at United Airlines. Those who could do the greatest harm to me, however, were Justice Department officials and federal judges, and their influence with state law firms and judges. I had yet to recognize other areas of government corruption far worse than I had already discovered. The importance of describing what was done to me is that it shows the control over state agencies by federal officials and the type of actions taken, misusing government offices, to obstruct justice, all of which makes possible the infliction of great harm upon the American people. Inadvertently giving the clue, I inadvertently gave my adversaries the clue as to how to stop my exposure activities. During several radio and television appearances, the hosts asked me, "Aren't you afraid of what they might do to you?" The question implied physical harm, but I sidestepped it, saying, "As long as they can't get to my money, I'm okay." I felt there was no way that my adversaries could get the assets which funded my exposure activities. At the beginning of the 1980s, the market value of my real estate properties was close to $10 million, and my net worth was over $6 million. Foolishly, instead of just enjoying life and these assets, I continued my air safety activist activities trying to expose the government corruption that continued to play a role in air tragedies. I was the only person with the evidence and the willingness to fight the powerful thugs involved in this scandal, and perhaps escalating exposure actions threatened many powerful people. I had foolishly felt I had an obligation as a citizen. Start of a bizarre judicial proceeding. It took money to continue the activist activities, and I had already inadvertently given the clue to my adversaries that my exposure activities were funded by my assets. A bizarre scheme commenced in late 1982 via a sham lawsuit that had been structured to immediately separate me from my assets, and eventually to take them away from me. Those who carried out the scheme had to have assurances, either specifically or from knowledge of widespread corruption in the judicial branch, that every check and balance in the California and federal courts would protect the scheme and the perpetrators. However, though it was costly for me, it provided me the opportunity to discover a pattern of corruption against America far beyond what I could have imagined at that time. Even though I already knew of very serious corruption in the three branches of government, I felt there was a limit. To commence and continue the sham lawsuit required repeated violations of blocks of California and federal statutory and case law, as well as constitutional protections. The sham action and the voiding of all state and federal remedies and protections caused loss of the assets that funded my exposure activities. There are two basic ways to judicially strip a person of his or her assets almost immediately. One is through probate proceedings, but this requires that the person be dead. The other way is through divorce proceedings, seizing the assets on the basis that they are community property. I had been divorced since 1966, and 5 divorce judgments established that fact. In California where I resided, the 1966 judgment had been entered as a local judgment in the Superior Court, Contra Costa County. Under California and federal law, the judgments were final and conclusive of our divorce status and property rights. The California and 1966 judgments were entered as local judgments in the courts of Nevada, Oklahoma, and Texas. In addition, my former wife, residing in Texas, had been declaring herself divorced for the past 2 decades, buying and selling real estate as a divorced woman. She applied for higher Social Security payments on the basis of the 1966 divorce judgment, which the federal government recognized when they raised her Social Security benefits. It was safe to say that I was legally divorced. The bizarre judicial scheme in December 1982, several months after the Supreme Court justices dismissed my action against the NTSB, I was served with a dissolution of marriage action, even though I had been legally divorced for the past 2 decades. The San Francisco law firm of Friedman, Sloan, and Ross filed the action in Superior Court, Solano County, Fairfield, California. The lawsuit alleged that I was married to Friedman's Texas client and that she wanted a termination of that marriage. Using the pretense of the marital relationship, the Friedman law firm claimed that my assets were community property. On that sham basis, the law firm filed dozens of lis pendens upon them, which halted important segments of my real estate activities, inflicting serious financial harm upon me. The Friedman law firm claimed that all of my properties were community property, even though they had been acquired years after the 1964 Colorado separation and after the 1966 divorce, which adjudicated all property rights. Under law, these properties were not community. Even if there had been a marriage, California judges lacked jurisdiction over separate property in a marriage dissolution action under clearly stated statutes. Building upon the sham divorce proceeding, the Friedman law firm filed lis pendens on all of my properties, preventing such necessary activities as refinancing loans coming due on various properties. Massive and unprecedented violations of law. The lawsuit was filed under the California Family Law Act, which grants state judges limited jurisdiction. It clearly prohibits attacks upon prior divorce judgments. Orders rendered by a judge who lacks personal or subject matter jurisdiction are void, and also subject the judge to lawsuits under the Civil Rights Act. 0 For the next 8 years, commencing in 1982, California judges rendered orders lacking jurisdiction for the cause of action filed against me, on the basis of California law. Absence of jurisdiction also arose from other sources. California law prohibited the lawsuit technically. Jurisdiction could have been obtained to file a lawsuit under declaratory judgment statutes to determine whether the parties were married or not. But to have done that would have prevented immediate seizure of my assets, which can be done in a real divorce action on the basis of community property. In addition, California statutory law prohibits collateral attacks upon any prior divorce judgment in any cause of action. The statutes and related case law, to require mandatory recognition of each of the prior divorce judgments. California Supreme Court decisions prohibited attacks upon prior divorce judgments. 3 attorneys for the Friedman law firm argued that all 5 divorce judgments were void on the basis that I did not intend to reside forever in the jurisdiction that rendered the 1966 divorce judgment. But that argument had been declared unconstitutional by the U.S. Supreme Court in the 1940s. The Friedman attorneys spent months arguing what my mental thoughts must have been about permanently residing in the 1966 court's jurisdiction. A person getting a divorce does not have to pledge that he or she will reside forever in that jurisdiction. This is the lie that I had to fight during 6 years of litigation in California courts. Further, the statute of limitations prohibited an attack upon prior judgments 3 years after they are rendered. Any one of these dozens of state protections barred the action, in addition to the absence of jurisdiction under California law. Violating federal and California law in addition to California law barring the sham action, overriding federal law barred the action. Federal statutory and case law, and constitutional safeguards, protect people who change their state of residence from having their prior divorce judgments and personal and property rights voided by a judge in some other state court. The Constitution provides that a person cannot suffer loss of previously adjudicated or acquired personal and property rights when the person changes residence to another state. Federally protected rights barred the refusal to recognize residence as a basis for exercising personal jurisdiction in a divorce action. This was settled almost 50 years ago by the U.S. Supreme Court when California judges refused to recognize Nevada divorce judgments obtained after 6 weeks residence. 5. Federal law, especially the constitutional and statutory full faith and credit doctrine, requires state judges to recognize the judicial acts of another state. This requirement applied to the prior divorce judgments and the property settlement. California statutes also have a full faith and credit mandatory recognition requirement. 7. These protections required that the California judges recognize the California, Nevada, Oklahoma, and Texas divorce judgments. The sham lawsuit also violated fundamental constitutional rights and protections. 8. Remarrying long divorced persons. The California judges held that they had the right to remarry people who had been divorced for decades, to invalidate subsequent marriages, to void prior property settlements adjudicated in other states and jurisdictions, and to order property acquired years after a prior divorce to be community property with the prior spouse. 3 judges in the California Court of Appeal upheld these decisions, as did the judges in the California Supreme Court. Their published decision established the right of California judges to void divorce judgments and property rights adjudicated decades earlier, contrary to federal and state statutory and constitutional protections. The person initiating these attacks need not even reside in California, as long as a former spouse resides in the state. Using the published decision as precedents, California judges can order the former spouse to pay your attorney fees for a new divorce, and pay support at the same time. At the present time, until that published decision is overturned, the same scenario that happened to me can happen to anyone who has been previously divorced. Suspending appellate remedies. The appellate court remedy for a judge's refusal to dismiss an action following a motion to quash is to file a petition for writ of mandamus with the California Court of Appeal. Then, if denied, file a petition for hearing with the California Supreme Court. If the lower court lacks jurisdiction, the upper court must grant the petition. Point 2. Even though the lower court judges clearly lacked jurisdiction, the California Court of Appeal judges denied the petition for relief. The California Supreme Court justices also upheld the violations of state and federal laws and constitutional protections. The remedy under California law to vacate an order to pay money is by appeal, and I appealed. The appeal was heard by Court of Appeal judges, Donald King, Harry Lowe, and Zern Hanning, all appointed by former California Governor Jerry Brown. Media articles reported the judges paid bribe money for the judicial appointment. These judges rendered a published decision, upholding the violations of state and federal law. That decision was published and is case law in the state of California today. I appealed that decision to the California Supreme Court and, when the violations were approved by California's highest court, I appealed to the U.S. Supreme Court. The issues were of utmost importance to thousands of people who were subjected to the same constitutional outrages inflicted upon me. None provided any relief. This was a major constitutional setback, something like returning to the 50s when blacks were required to sit in the back of buses in the South. But it was upheld by the California Court of Appeal and the California Supreme Court. The decision was unconstitutional. As long as that decision stands, others risk the same fate I suffered. This little-noticed decision affects everyone who exercises a constitutionally protected right to change residence to California, making them fair game for losing their personal and property rights, making their wives adulteresses, making their children bastards. Retaliation. For exercising legal defenses, the Court of Appeal judges held in their published decision that it was frivolous for me to exercise my remedies under California law. The decision held that I should have willingly submitted to the jurisdiction of the California judges, that I should have agreed to be remarried, that I should have agreed to undergo another divorce proceeding, and have the properties and assets I acquired during 2 decades of divorce status divided with Friedman's Texas client and the Friedman law firm. Based upon this published decision and the holding that it was frivolous for me to object, the 3 appellate judges ordered me to pay $50,000 attorney fees and financial sanctions. This order was shortly followed by another order that I pay $170,000 attorney fees to the Friedman law firm. They can't do that. Many attorneys stated to me that the California judges couldn't do what they were doing. I agreed, but they were doing it anyhow. I had not yet recognized that the California lawsuit was a scheme involving federal and state personnel to strip me of the assets I relied upon to fund my exposure activities. Dozens of illegal lis pendens. The illegally filed lis pendens halted my real estate activities. Valuable property was lost, including my mountaintop home that had over $250,000 equity in it. Everything I worked for was being lost. Even on the eve of losing valuable properties due to mortgage foreclosures caused by the lis pendens, the Friedman firm and their attorneys refused to allow the existing loans to be refinanced. Initially, I had legal counsel, but they were as incompetent as the attorney I hired for the Denver FAA safety grievance hearing. I had to terminate them and proceed in pro se status, representing myself. None of my legal counsel argued current California law. They argued 50-year-old case law from the days of segregated busing, toilets, and eating establishments, that had been superseded for decades. None of them knew federal law, which under the Federal Supremacy Clause of the United States Constitution takes precedence over state law. To get the law argued, I had to file my own briefs. But in pro per status, due process almost always goes out the window as state and federal judges side with their attorney cohorts. While under constant judicial attack and suffering severe personal and financial losses due to the sham action, my doctor advised that I must immediately undergo open heart surgery, which I did, receiving 6 coronary bypasses. Before I left for surgery, I notified the California Court of Appeal judges, King, Lowe, and Hanning, of the hospitalization, and requested they delay their decision on the appeal of the May 10, 1983, order until after I got out of intensive care. Otherwise, I would not have time to request a rehearing from the California Supreme Court judges for the expected unfavorable decision. I was barely out of intensive care and had just arrived home, when the Court of Appeal judges rendered their decision. Several attorney friends described the decision as the closest thing to a poison pen letter that they had ever seen. I rushed to prepare a petition for hearing to the California Supreme Court. But the Supreme Court judges had protected the judicial civil right violations since 1983. There wasn't much hope, as the judicial Ponzi scheme protected the renegade judges. The published decision fabricated facts out of whole cloth. It refused to address any of the California or federal laws that I raised in defense. Contrary to California and federal statutes and constitutional protections, the decision held that California judges could void prior divorce judgments of any party moving to California, could remarry the parties who had been long ago divorced, could order a person to financially pay attorneys on both sides during the divorce action, could seize properties and businesses that had been acquired years after the prior divorce, and to convey half of it to a former spouse. They held they had the power to destroy, in this bizarre fashion, the personal lives and possessions of innocent people. The published decision eulogized the Friedman law firm who filed the action that was prohibited by law. The decision eulogized my ex-wife who openly committed fraud and perjury by simultaneously declaring herself married to me in the California action while declaring herself divorced from me in her resident state of Texas. The published decision approved the rendering of orders inflicting great harm upon people without having jurisdiction under California law to even conduct hearings once the prior divorce judgments were presented to them. Despite the absence of jurisdiction, the absence of any marriage, the absence of any contact between the former spouses for many years, despite the blocks of state and federal law barring the action, California judges continued to render orders inflicting great financial and personal harm upon me. California appellate judges used all types of schemes to block my appeal remedies. They refused to receive my appeal briefs, they misstated the facts and the law, they ordered me to pay huge fines for filing appeals and oppositions, they threatened to impose additional fines if exercised any of the judicial remedies available under law. In one instance they ordered me to pay over $250,000 in fines to the Friedman law firm for having filed appeals and oppositions, which were rights guaranteed by the statutes and Constitution of the state of California. Bench warrant for my arrest. The judicial outrages didn't stop. When I lacked access to my funds to pay the $170,000 to the Friedman law firm that was ordered by Judge William Jensen, Peterson sentenced me to jail. Despite the unconstitutionality of the cause of action, its prohibition under California statutory law, despite the absence of jurisdiction under the Family Law Act, California judges repeatedly protected and rewarded the Friedman law firm. The California judges blocked every attempt to defend against the bizarre action. Something was radically wrong. To support the violations of blocks of law, the California judges blocked every procedural defense. Retaliation for exercising federal remedies. Another scheme was concocted to put me in jail. Jensen ordered me to appear in court on May 9, 1986, a date that he knew I was calendared to be in federal court at Sacramento. That action was a civil rights action I filed against Jensen on the basis of violating my rights under state and federal laws and causing me harm. Jensen retaliated against me for having exercised these rights by ordering me to appear in court to show why I should not be held in contempt for failure to pay the judgments, which he knew I couldn't pay. I filed papers in the Solano County Court notifying Jensen that I physically could not appear on that date. I also stated my inability to pay the money orders since the Friedman law firm, with his help, had tied up all my funds with the lis pendens upon my properties and assets. I again reminded him of the absence of jurisdiction and the wholesale numbers of California and federal laws that barred the attack upon the 5 prior judgments. T also advised Jensen that an attorney would appear for me at that hearing. Despite all this, Jensen held me in contempt of court for not being present, and issued a bench warrant for my arrest. Since I resided in Nevada, this bench warrant kept me from appearing in California for the next year and a half. Seeking relief from the bench warrant, I submitted petitions for relief to the California Court of Appeal and the California Supreme Court. The Ponzi-like scheme of judge protecting judge continued, and relief was denied. Sham divorce judgment without my knowledge. the Friedman Law Firm and California Judge Dennis Bunting conducted a hearing on July 28, 1988, to terminate the non-existing marriage and order the taking of my properties. During the hearing, Judge Bunting rendered a judgment that described the cause of action as a dissolution of marriage action. Having established that Friedman's Texas client was married to me, Bunting then rendered an order holding that all my assets were community properties. All of my properties met the legal definition of separate properties since they were acquired years after the 1964 separation and 1966 divorce. The same order required me to pay $2,500 monthly spousal support for the remainder of my life. There were now 6 divorce judgments. 5 showed me divorced since 1966, showed all properties were separate, and held that neither party had any spousal support rights or obligations. Then we had the 6th judgment rendered 22 years later by California judges lacking jurisdiction under California law, lacking jurisdiction under federal law, lacking jurisdiction over properties legally classified as separate, violating dozens of California and federal statutes, constitutional protections, and other laws, in a cause of action barred by 45 years of U.S. Supreme Court decisions. Federal statutes provide that a person can obtain a declaratory judgment from a federal judge, declaring his personal and property rights and the validity of the 5 prior divorce judgments, when these rights are under attack. There is no other place to go but into federal court when judgments from another state are attacked by a state judge. But to render a decision would unravel the scheme concocted against me, expose the civil and constitutional violations, and the criminal conspiracy under which they were perpetrated. To this day, my constitutional and statutory rights to have a ruling holding these judgments and the related personal and property rights declared valid have been unlawfully and unconstitutionally refused to me by at least a dozen federal judges. I filed a notice of appeal with the California Court of Appeal in San Francisco, which was heard by the same justices that had aided and abetted these violations of law for the past 7 years, Justices Donald King, Harry Lowe, and Zern Hanning. This 3-judge panel rendered a decision approving the judgment. They approved the judgment that under law was a void judgment and which violated numerous federal protections, such as the Civil Rights Act. Worse, they placed a frivolous label on my appeal, ordered me to pay $65,000 sanctions to the Friedman Law Firm for filing the appeal, and ordered me to pay $20,000 sanctions to the state of California. I then filed an appeal with the California Supreme Court, which also had protected the massive judicial violations since 1983. The entire court approved these judicial violations. It was several years before I recognized what was behind the sham California action. Once the judicial scheme started rendering the unlawful orders, it became necessary for each succeeding judge to enlarge on the violations so as to protect the prior acts and protect those involved in the scheme. This daisy chain scenario then occurred, time and time again. Another routine air disaster in an area riddled with corruption. United Airlines crash at Denver in the area of the author's air safety responsibilities. Upon me in the sham California action invoked mandatory federal court jurisdiction. For 6 years California judges and the Friedman Law Firm had been violating important civil and constitutional rights, which were escalating. Federal statutory and case law and the Constitution guaranteed declaratory judgment and injunctive relief, and financial damages, for any citizen undergoing these violations. In their positions of trust, federal judges are paid and have the mandatory duty to provide federal court access and relief. *6 In addition to the statutory right to federal court access and relief, the First Amendment to the Constitution provides additional safeguards so that no one suffers as I suffered. When a divorced person exercises his or her constitutional right to change residence, his or her previously adjudicated personal and property rights in a divorce must be recognized by judges in another state. That person cannot be subjected to another divorce proceeding 20 or 30 years later, invalidating subsequent marriages, as was done to me in the sham California action. In the bizarre action taken against me, one of the remedies arose under the Declaratory Judgment Act and statutes. These remedies required, A federal judge to declare the validity of each of the 5 prior divorce judgments and the validity of my divorced status and property rights. The refusal by California judges to recognize any of the prior judgments entered in 5 different states and refusal to recognize a New York one of the many violations of California and federal law inflicted property rights established in those divorce judgments and acquired as a separated and divorced person, invokes federal remedies. In my case, to declare these rights, the U.S. District Judge must first apply federal law that requires recognition of the judgments and then secondarily apply state law if it conforms to federal law. In my case, any one of over a dozen state and federal doctrines of law, constitutional rights, and statutes required the California judges to recognize the rights established in the 5 judgments. They refused to do so, and even imposed financial sanctions upon me for exercising procedural defense remedies against the grotesque violations of long-established protections. Because California judges inflicted great financial and personal harm upon me through their violations of my civil and constitutional rights, there were additional federal statutes ensuring that I have access to federal court. These remedies also provided jurisdiction to obtain financial damages against the state judges and the Friedman law firm. This relief arises under the Civil Rights Act, among other statutes, which is embodied in Title 42 Section 1983.9. When 2 or more people act to do a certain thing, it is called a conspiracy. It was obvious that the various attorneys in the Friedman, Sloan, and Ross law firm and the California judges were acting together to inflict great harm upon me through repeated violations of state and federal law. This conspiracy violated another section of the Civil Rights Act, Title 42 U.S.C. 1985.30. If any person knows that your civil rights are being violated and they have the power to prevent or aid in the prevention of these violations, and they don't do so, other federal statutes provide federal court jurisdiction and relief. This cause of action arises under Title 42 U.S.C. Section 19863 and Title 28 U.S.C. Section 1343.32. Under certain conditions, this conspiracy creates still another federal cause of action under the RICO Statutes 33. When federal officials violate a person's civil rights, they are said to be acting under color of federal law. They can be sued. These federal personnel include federal judges, federal trustees, or other federal employees. The authority is the Bivens Doctrine *4, which is federal case law applying the Civil Rights Act to violations by federal personnel. Mandatory duty to provide relief. I filed the first federal action in the United States District Court in the Eastern District of California at Sacramento. 35 Although I had years of legal experience working with attorneys and in filing federal actions against the FAA and NTSB, and could have filed this lawsuit in pro se, I hired Sacramento attorney James Reed to file the action. He had experience with civil rights as a law school teacher at McGeorge School of Law in Sacramento. The lawsuit sought a declaratory judgment to declare my divorce status and property rights, as established in the 5 divorce judgments and under federal and state law, injunctive relief to halt the orders rendered by the California judges who were acting without jurisdiction under California law and violating blocks of state and federal law, and financial damages. The federal lawsuit raised issues that had been settled in the 1940s by the U.S. Supreme Court. It sought to declare my constitutional right 3* to change residence without being remarried to a person from whom I was divorced decades earlier. It sought to protect the considerable real estate that I had acquired since the 1966 divorce and which was the primary target of the sham action. The lawsuit sought financial damages against the California judges and the Friedman law firm. In the same year, the U.S. Supreme Court clarified the right to sue state judges who violate state or federal law or who act without jurisdiction. The court clerk assigned the lawsuit to Judge Raul Ramirez. The start of the federal due process gridlock. The Friedman law firm and California Judge Dwight Ely filed a motion to dismiss the federal declaratory judgment and civil rights action on the grounds that the California action was a divorce action and, therefore, the federal courts must abstain. The mere fact that I was subject to a divorce action when federal law established that I had been divorced for almost 2 decades constituted violations of federally protected rights. These violations invoked mandatory federal court jurisdiction. Many federal laws, and over 24 California statutes and rules of court had been violated, constituting major federal causes of action. Further, even if I had been legally married, federal court jurisdiction over civil rights violations does not cease when federally protected rights are violated. Repetition of the frivolous tactic. The standard tactic used by the California judges when I exercised my legal procedural remedies was to place a frivolous label on it and call me a vexatious litigant. The frivolous labels were then used to order me to pay huge financial sanctions to the Friedman law firm, who initiated the civil right violations. U.S. District Judge Raul Ramirez unlawfully dismissed my action, refusing to render a declaratory judgment addressing the validity of the 5 divorce judgments, or my personal and property rights. Ramirez sought to support his order of dismissal on the argument that the California action was a domestic relations action for which federal courts should abstain. That was a misstatement of the law and facts. First, the Civil Rights Act protections apply to all actions regardless of the label placed upon the suit. Second, I was exercising my rights under the Declaratory Judgment Act to have a federal court declare as valid the prior divorce judgments and the personal and property rights stated in them. Federal law, in addition to state law, required that these judgments and these rights be recognized. Third, the divorce label was a farce as I had been legally divorced for the past 2 decades. It would not have been much more bizarre to have placed a probate label on the action, ignoring the fact that I was still alive. Ramirez compounded his refusal to act by ordering me to pay the Friedman law firm $10,000 for having sought declaratory and injunctive relief remedies. If an attorney files a frivolous action, it is the attorney who is ordered to pay, and not the client. But it was I who was the target of the judicial attacks, and this became obvious over the years. Ramirez violated still another federal statute. It is a federal crime to inflict harm upon anyone for having exercised rights and protections under the laws and Constitution of the United States. 38 Definition of a frivolous action. The United States Supreme Court and other federal decisions define the term frivolous as any complaint, appeal, or any other motion from which there is not an arguable point. The U.S. Supreme Court held that they are not frivolous if any of the legal points arguable on their merits. Haynes v. Kerner 404 U.S. 519, 521-522. Obviously, my federal complaint exercising the right to have my personal and property status declared under federal and state law was not frivolous, and the validity of 5 divorce judgments was not frivolous. Nor was it frivolous to seek injunctive relief against the repeated violations of state and federal law by California judges acting without jurisdiction under California law. This judicial charade was repeated time and time again, as the pack of renegade federal judges engaged in a Ponzi-like scheme protecting the scheme and the perpetrators. Protection against wrongful dismissal. Federal law prohibits dismissing an action if the complaint states a single federal cause of action. The law requires that the allegations stated in the complaint be recognized as true for the purpose of determining whether a federal cause of action is stated. 39 If any single federal cause of action is alleged, the case cannot be dismissed and the district judge must exercise his duty to provide a federal court forum. These and many other protections to which all Americans are entitled were repeatedly violated during a 10-year period by a daisy chain of federal judges, including justices of the U.S. Supreme Court. Suspension of appeal remedies. In response to Ramirez's dismissal, I filed a timely notice of appeal with the U.S. Court of Appeals at San Francisco, the same appellate court that had wrongfully dismissed my lawsuits against the FAA and NTSB in 1974 and 1980. These unlawful dismissals continued the practices that played key roles in subsequent air disasters. In those earlier actions I exercised the mandatory responsibilities under federal criminal statutes to report safety and criminal violations to a federal court. By their refusal to receive my testimony and evidence, these same federal judges blocked the reporting of serious crimes and became co-conspirators in the criminal acts I sought to expose. Federal appellate law requires the Court of Appeals to vacate the order of dismissal and the frivolous holding, if the complaint alleges at least one federal cause of action for which federal courts can grant relief. And the allegations stated in the complaint far exceeded that test. For the purpose of this test, all allegations must be accepted as true. The Court of Appeals judges denied my appeal, upholding the violations by the U.S. District Court judge and upholding the pattern of civil and constitutional violations in the state court. They also upheld the $10,000 financial sanctions ordered by Judge Ramirez. In retaliation for exercising defenses guaranteed under the Constitution and laws of the United States, I then sought relief by filing petitions for writ of certiorari with the justices of the United States Supreme Court. Even they had been implicated in the judicial cover-up associated with the air safety corruption. They also protected the scheme. The Ninth Circuit Court of Appeals and the U.S. Supreme Court dismissed my federal action seeking relief. Their acts approved the unlawful denial of a federal court forum, the violations of federal law, the unlawful dismissal of the action, and the obvious conspiracy to commit these acts. These higher federal courts gave the California judges and the Friedman law firm carte blanche approval to escalate their attacks upon me, which then occurred. The lis pendens that were placed upon all of my properties prevented the normal replacement of mortgages as they came due, and I lost valuable properties. My personal life and my business were in shambles. California Judge J. Clinton Peterson sentenced me to jail for 5 days in 1987, charging me with contempt of court when I failed to pay a money judgment to the Friedman law firm. That same judge had tied up all my assets, leaving me without funds to pay any judgment, valid or not. Repeatedly seeking relief as the California judges rendered additional orders, inflicting greater harm upon me, which were new federal causes of action, I filed additional federal lawsuits seeking to halt the escalating harm arising from the unlawful and unconstitutional acts. In every instance, federal judges protected the hardcore civil and constitutional violations occurring in the sham California action, while simultaneously protecting those committing the offenses. I filed numerous petitions with the justices of the U.S. Supreme Court, making the justices aware of the pattern of judicially inflicted civil and constitutional violations. Sham oaths. All federal judges, including the justices of the U.S. Supreme Court, take an oath to uphold the laws and Constitution of the United States. The oath is as follows: I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservations or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Many judges would be impeached if the law was applied as written. Recognizing the judicial conspiracy __ exercise this court's power of supervision. The petition for writ of certiorari exposed a pattern of corruption by federal judges and officers of the court who were under the supervisory responsibilities of the justices in the U.S. Supreme Court. In every case they either stonewalled me, refused to file the petition, or refused to provide relief. I even accompanied my petition with a demand under the Federal Crime Reporting Statute, Title 18 U.S.C. Section 4, demanding to report to a federal judge the criminal acts that I uncovered. As a former federal investigator holding federal authority to make these determinations, my charges had extra validity. I explained that the criminal acts were perpetrated by federal judges over whom they had supervisory responsibilities. The responsibility to receive this testimony and evidence was even violated by the justices of the U.S. Supreme Court. The allegations of judicial corruption were so serious that the justices of the Supreme Court had responsibility to act regardless of how the message was conveyed. Federal Criminal Statute Title 18 U.S.C. Section 4 requires that a party learning of federal offenses report them to a federal judge or other official. Many times I followed this procedure in my petitions to the Supreme Court justices. Each time they blocked me from reporting the crimes, inflicting great harm upon the United States by refusing to receive my supporting evidence. They compounded this obstruction of justice by refusing to provide relief from the harm I was experiencing as a result of the criminal acts of federal judges over whom they had responsibilities. The Supreme Court justices also had vicarious liability responsibilities over the corrupt actions of the judges under them, and the justices share criminal responsibility for the criminal acts that could only occur with their complicity. Justice Department attorneys protected every segment of the criminal activities. I filed several federal lawsuits against Duck and the law firm of Goldberg, Stinnett, and McDonald *4 and against the subsequent trustee, Jerome Robertson. The civil action addressed criminal acts that Duck already admitted, seeking damages from him and the government on the basis of these acts, as well as injunctive relief for the return of my assets. Federal judges dismissed every action I filed. In one action, Degree 5 U.S. District Judge Eugene Lynch ordered on October 3, 1989, that the action I filed be unfiled, without the lawful requirement of a hearing and in defiance of constitutional and statutory rights and protections. This judicial dismissal protected Duck and Chapter 11 judicial corruption, of which Duck was a part. Preventing exposure of a major criminal enterprise in another action filed in the U.S. District Court in the District of Columbia, Judge Stanley Sporkin dismissed the action against Duck without a hearing, again protecting Duck and the system of judicial corruption. Sporkin's dismissal had an interesting aspect to it. Sporkin was formerly counsel for the Central Intelligence Agency, and as later pages will show, the CIA was heavily involved in Chapter 11 corruption, benefiting from the looting of assets. Department of Justice attorneys and officials also intervened to protect Duck and the system by filing motions with the court to dismiss my actions. An action that I filed against Duck in the Superior Court of the State of California in Alameda County at Oakland, California was wrongfully dismissed by Judge Edward Gellin of Oakland without a hearing. He had a sordid history of protecting the criminality exposed in these pages. The entire federal judicial system and Justice Department attorneys were protecting Duck whenever the need arose. After Duck admitted his embezzlement, Judge Gellin ordered that over $100,000 of my assets be paid to Duck and his San Francisco law firm of Goldberg, Stinnett, and McDonald for services that consisted of looting the assets. By March 1990, Judge Gellin ordered over $250,000 taken from my assets to pay legal fees solely to protect the trustees and their law firm involved in the seizure and looting of my assets. Simultaneously, Judge Gellin deprived me of funds from my own assets to pay for legal assistance, dental and medical bills. While $6 million of my equity assets were corruptly seized and looted, Judge Gellin forced me to live on $12,000 a year, for housing, food, and the other necessities. Further, Gellin refused to provide money for me to hire legal counsel, while he simultaneously authorized hundreds of thousands of dollars to be taken from my assets to pay attorney fees for the Friedman law firm, and for the woman in Texas who falsely claimed she was my wife. Additionally, Gellin rendered an order barring me from filing appeals and oppositions, stating that this could only be done by an attorney. His withholding of money to pay an attorney ensured that I would not have one. Decades of Chapter 11 corruption. Public pressure forced Congress to change the Chapter 1 statutes for greater protection of the public against judicial corruption, causing Congress to pass the Bankruptcy Reform Act of 1978, creating the office of the U.S. Trustee. The trustee was charged with the responsibility of preventing fraud and corruption. But the changes providing protection in law were openly violated in spirit and specifics by Chapter 11 judges, with the cooperation of higher federal courts. These U.S. trustees, arms of the Justice Department, usually attorneys, protected the system instead of the people. Justice Department officials routinely forced people into Chapter 7, 11, or 13, as part of schemes to silence whistleblowers, as will be seen in later pages. The public outrage and pleas for help continued. Except for minor investigations and cover-ups, Congress again refused to investigate the corruption. When the public pressure again reached a crescendo, Congress went through the motions and changed the law, passing the Bankruptcy Act of 1986.56. The legislative history of that act addressed the past judicial misconduct in guarded terms, and gave the impression that the new legislation addressed the corruption. The legislative history re-emphasized that the U.S. trustee was to prevent corruption. The U.S. trustees were given important oversight and watchdog responsibilities to ensure honesty and fairness in the administration of bankruptcy cases and to prevent and ferret out fraud. In carrying out critical watchdog responsibilities, such as preventing fraud and other abuses, and in monitoring debtors in possession in Chapter 11 reorganization cases. Congress knew that the rampant Chapter 11 judicial corruption was known to the Department of Justice, that the Justice Department attorneys protected those committing the multi-billion-dollar-a-year racketeering enterprise. Congress knew that Justice Department officials misused Chapter 11 proceedings through their control over the U.S. trustees. The Chapter 11 judicial racketeering activities continued as before. The media kept the lid on the scandal, ensuring its continuation, and ensuring that their readers pay the price. By law, the U.S. trustee had the responsibility to prevent corruption, as well as the Civil Rights Division of the Justice Department. For 2 years I made U.S. trustee Anthony Sosa aware of the corruption that continued without let-up. If anything changed, it was for the worse. After Duck was imprisoned in November 1989, Sosa refused to provide relief from what Duck had done to my assets, and appointed another attorney as trustee, who then continued looting my assets as Duck had done. The new trustee, Jerome Robertson, immediately accelerated the harm done to my estates that Duck had started. Within a few months, Robertson and his retained law firm of Murray & Murray had requested and obtained court approval to take over $250,000 from my assets for legal fees to do things that I routinely did when I controlled my business. When the U.S. trustee refused to prevent these corrupt acts, I filed a lawsuit against him and his boss, the Department of Justice, in the U.S. District Court, District of Columbia. Again, federal judges protected the system of which they were a part. District of Columbia Judge Stanley Sporkin dismissed the action on January 17, 1990, without a hearing, and despite the law barring dismissal when the complaint stated federal cause of actions. Examples of other victims: in one case, the Department of Justice forced a publishing company into bankruptcy. The company was set up for the purpose of spreading political ideas, and the Justice Department attorneys did not like the exposures. Presidential candidate Lyndon LaRouche informed the public of corruption by federal officials via the publications Campaigner Publications, Caucus Distributors, and Fusion Energy Foundation. Without a hearing, the Justice Department obtained an ex parte order forcing the company into bankruptcy. The company argued that the law required 3 parties to force a person or company into bankruptcy, and sought to have the seizure overturned, without success. The Justice Department used its United States Trustee Division and its control over private trustees and federal judges to force the company into a Chapter 7 liquidation. Then Justice Department officials secured indictments against LaRouche and 6 associates for mail fraud on the basis that the companies did not repay earlier loans. LaRouche argued that the loans could not be paid back because Justice Department officials forced the company into bankruptcy. The Justice Department attorneys obtained a 15-year prison term for the 67-year-old LaRouche. Fortunately, LaRouche had friends outside of prison willing to fight for him. While LaRouche and his associates were in prison, District Judge Martin Bosteder ruled in a 106-page decision on October 25, 1989, that the Justice Department's seizure of the assets and the involuntary bankruptcy action were illegal and a fraud upon the court. In another case, the husband and wife publishing house of Stein and Day was induced by attorneys to seek relief in Chapter 11 when a major customer refused to pay a large bill owed to them. Their 26-year-old business had run a small but respectable operation that published about 100 books a year. Their business was good and they were otherwise financially strong. Seeking a time delay in paying pending bills, the primary reason for Chapter 11, owner Sol Stein filed Chapter 11 on the advice of his attorney. Following the standard script, instead of providing time to pay bills, the Chapter 11 judge seized and then looted the assets of this once profitable company. The husband and wife team experienced corruption by the bankruptcy courts that if committed by an ordinary citizen would result in criminal prosecution and imprisonment. Stein lost everything he accumulated for the past 3 decades. Incensed, he wrote about the judicial Chapter 11 corruption in the book A Feast for Lawyers, subtitled inside Chapter 11, an exposé. Even though Stein recognized only a small part of the criminality in Chapter 11 and 13 courts, he described these courts as inhabited by hacks, vultures, and scoundrels, who feed on productive companies and people. In another of thousands of examples, Chapter 11 judges and officers of the court stripped San Diego resident Samuel Shen of millions of dollars of assets he acquired from hard work after immigrating from Hong Kong in 1959. Shen was so badly affected by the trauma inflicted upon him that he was committed to a mental institution for 30 days. As other victims had done, with many succeeding, Shen tried to commit suicide several times. He lost his family, who didn't have the character to support him during these troubling times. Shen's 1982 Chapter 11 filing showed assets of $10 million with liabilities of $2.5 million. Everything was almost free and clear. The Chapters 11 and 13 racketeering activities, protected by every level of the federal judiciary, including the U.S. Supreme Court justices, financially destroyed him. Over $7 million in assets were looted by the judge-appointed trustee, the trustee's law firm, and whatever hidden interests that Judge Herbert Katz may have had in dummy corporations. There were some who claimed Katz was part of a Jewish mafia that had stolen hundreds of millions of dollars of assets from people who naively sought relief in Chapter 11. Real estate investor Jay Sobernia of San Diego was another typical case. He encountered a sudden cancellation of a verbal permanent loan commitment from his bank. When the bank construction loan came due, the same bank that had promised permanent financing commenced foreclosure on the expensive house. If the bank had been successful, it would have made a windfall profit. This was a common tactic with Bank of America during the Depression years and in recent 59 San Diego Tribune, July 10, 1989. 45 times. Sobernia's attorney, who had close ties to the Chapter 11 courts, advised him to file Chapter 11 and get a stay of the foreclosure to permit him time to obtain permanent financing. On the lawyer's assurance, Sobernia then put his entire $1 million equity estate into Chapter 11. Despite federal statutory law barring seizure of the assets, the Chapter 11 judge ordered Sobernia's assets seized and turned over to a trustee. The routine destruction of the assets then began, enriching the attorneys, law firms, and corporations that are part of this racketeering enterprise. Sobernia's $1 million equity estate was stolen. These sad tales are repeated thousands of times, reflecting the theft of billions of dollars a year by pious-appearing federal judges that have stolen more money than many organized criminal enterprises. The legal and judicial fraternities at every level are a part of the Chapters 11 and 13 racketeering activities. They include federal judges, justices of the U.S. Supreme Court, attorneys and officials in the Justice Department, trustees, and law firms. In addition, those who aid and abet these crimes by their duplicity of silence include members of Congress and the establishment media. Their victims include many older people who are left destitute, and who are no match for this gang of thugs. One of many Texas victims, another victim who told me of the experiences he had with crooked federal judges, trustees, and law firms was John Hamilton of Cuero, Texas. He owned a 1,800-acre ranch until he was targeted by the bankruptcy club, and then financially destroyed. Earlier, he had been invited to White House functions as a result of his charitable work. Hamilton and his wife had obtained a loan of $475,000 on their ranch, which was worth almost $4 million, the proceeds of which had been used to build a commercial building. For the next 10 years the Hamiltons made payments on the loan, which had a 10-year due date. They expected the bank to renew the loan when its term was up, as is standard practice. Over $300,000 had been paid on the $475,000 loan during the 10 years, leaving a balance due of $184,000. Instead of renewing the note, the bank registered called the loan. Under advice of legal counsel, the Hamiltons filed Chapter 12 degrees to gain time to refinance the loan that was only about 1/20th of the property value. These are the types of filings that are targeted by the bankruptcy club members, consisting of judges, trustees, and law firms. By law, the Hamiltons should have kept control of their assets. But if the law was followed, the assets could not be seized and looted. As is widespread throughout the country, the practice then was for an unlawful seizure of the assets and subsequent liquidation, enriching the criminal enterprise. U.S. Bankruptcy Judge Richard Schmidt ordered the seizure of the Hamiltons' ranch and placed trustee Gary Knostman in control of the assets, a kiss of death for their life's assets. The trustee hired a closely aligned law firm, and between them and their coterie managed to financially destroy the Hamiltons, showing the consequences of trusting the statutory protections to the crooked federal judges and their bank of thieves. With the seizure of the Hamiltons' assets, there was no money to pay for legal counsel, and they had to appear without an attorney, ensuring the rapid loss of their life's assets. Eventually the Hamiltons did obtain attorneys, all of whom assisted in the loss of the assets. Today the Hamiltons are destitute, their life's assets stolen from them. These are only a few of the thousands of cases every year in which honest Americans are stripped of their assets after exercising in good faith the protections of Chapter 11 or 12. They trusted their government, unaware that epidemic corruption of the highest level has taken over many of the federal offices, including the federal courts. Their plight, and the thriving criminality in bankruptcy courts, are well known to members of Congress who have oversight responsibilities, to the media, with its obligation to report criminality in government, that financially destroys many of their own readers, to the checks and balances, every one of which aids and abets the ongoing racketeering enterprise. Congressman Jack Brooks, chairman of the House Economic and Commercial Law Subcommittee, knew about the rampant criminality as a result of having received reports from hundreds of victims in congressional hearings, and from my reports. Brooks stated, registered, I would tell members, if you've gone broke, go into bankruptcy. But if you've got any money at all, don't take bankruptcy, fight it out. They'll take it all. But the statutes provide that Americans can file under Chapter 11, 12, or 13, to get a time delay in paying their debts, and that they will remain in control of their assets. Brooks admitted that the assets were taken, and Heckertanely knew the rampant criminality by federal judges, trustees, and law firms. He protected the system of crooks that prey upon the American public. A bankruptcy attorney, Lawrence A. Beck of San Antonio, reported, registered, what many attorneys have admitted or known. Unfortunately, most individual debtors who enter bankruptcy with significant assets eventually conclude that they have become trapped in acro-ocade, dishonest system which is run for the benefit of the panel trustee and his hand-picked attorney, and which is supervised by bureaucrats. This is the type of criminality that creates the epidemic criminal mindset in the United States. The trustee program was established by Congress in 1986, and is run by the U.S. Department of Justice, to ensure honesty in the trustee program and the courts. Before the last page is reached in this book, the criminality by Justice Department attorneys in almost any Justice Department activity should be obvious. Standard silencing tactic protecting corrupt federal judges and system. Hamilton described the killing of two attorneys who had knowledge of the criminal activities in Texas Chapter 11 courts. He described the death of a bankruptcy trustee, Jane Ford, in June 1993, by a shotgun blast to her head. Her death left behind a 12-year-old son. Ford reportedly played a key role in the bankruptcy corruption, but eventually the massive theft from bankruptcy estates, carried out with judicial approval and complicity, and the outrage of victimized citizens, caused indictments to be handed down against her. Seeking to reduce her prison sentence, she announced her intention to expose the criminal enterprise in the Texas bankruptcy courts. This was similar to others who announced their intentions to expose federal officials and judges. She ended in the same condition that many other whistleblowers did, including those who blow the whistle on judicial corruption in the bankruptcy courts, dead. And in a scenario similar to others, the local police and coroner ruled her death a suicide. Hamilton described another bankruptcy-related killing, in which attorney John Scott was murdered as his charges of bankruptcy corruption started to expose the looting of assets involving federal judges, trustees, and law firms. Scott was killed near Austin, Texas, giving themselves immunity from their crimes. Federal judges of the Ninth Circuit registered held that the private trustees, including embezzler Charles Duck, who committed the worst reported trustee fraud, were officers of the court, and were therefore immune from liability. Federal judges, therefore, held that a citizen has no claim against an officer of the court arising from the criminal acts of that federal official, even though the acts are criminal and inflict enormous harm upon an innocent person. They held in effect that officers of the court could inflict any type of outrage upon the public, and the public has no remedy. One of the many people victimized by the judicial corruption was Thomas Reed of Connecticut. Reed obtained a Connecticut judgment against Duck, but bankruptcy judge Alan Yaroslavsky of Santa Rosa, who had protected Duck's criminal activities, issued an injunction forever barring Reed from enforcing the judgment. Reed argued that the injunctive order exceeded the judge's authority and filed an appeal with the Ninth Circuit Bankruptcy Appellate Panel. The appellate panel rendered a published decision holding that, 6 as an official acting under the authority of the bankruptcy judge, is entitled to derive judicial immunity because he is performing an integral part of the judicial process. Sound policy also mandates immunizing the trustee. The possibility that we would hold trustees personally liable for judgments rendered against them in their representative capacity would invariably lessen the vigor with which trustees pursue their obligations. Immunity is essential because, as Judge Learned Hand noted, to submit all officials, the innocent as well as the guilty, to the burden of a trial and to the inevitable danger of its outcome, would dampen the ardor of all but the most resolute, or the most irresponsible, in the unflinching discharge of their duties. Accordingly, we hold that the trustee, acting under the authority of the court, is entitled to derive judicial immunity. Fraud, violation of statutory and constitutional protections, are not within the authorized duties of a judge. But this has been conveniently ignored by federal judges protecting themselves against the many forms of judicial misconduct in which they are involved. As the judicial involvement in the Chapter 11 corruption surfaced, the Ninth Circuit Court of Appeals rendered a judgment registered protecting judges against responsibility for their criminal acts. The Ninth Circuit rendered the decision holding that regardless of any criminal conduct committed against the public or an individual by a judge or person acting on his behalf, such as a trustee, the public had no remedy against the judges or anyone acting with the judges. The need for these self-protective and unconstitutional decisions is rapidly increasing as federal judges are heavily implicated in some of the worst criminal activities ever exposed in the history of the United States. Justices of the U.S. Supreme Court enlarged upon the protection against their own criminal acts. The Supreme Court justices held in Stump v. Sparkmans that a judge could deliberately commit unlawful, unconstitutional, and corrupt acts upon a citizen, destroy personal and property rights, and be immune from financial liability. This decision was repeatedly stated by U.S. District Judge Marilyn Patel, San Francisco. The Constitution and statutes disagree with judge-made law. Federal civil rights statutes and constitutional rights to seek relief clearly do not provide immunity to federal judges when they violate clear and settled civil and constitutional rights, or against corrupt or criminal acts and who inflict harm upon any member of the American public. In Stump v. Sparkman, the judge entered into a conspiracy, ordering a young girl permanently sterilized. The Supreme Court held that the girl had no remedy against the judge, as the public's welfare requires that a judge be free to exercise his duties without fear of the consequences. The corrupt system protects its own. I filed an administrative claim with the Administrative Office of the United States Courts, addressing the judicial misconduct. The claim was based upon the looting of my assets by trustee Charles Duck. The Justice Department denied my claim on October 17, 1989, stating the claim may not be settled under authority of the Federal Tort Claims Act because that act specifically excludes claims arising from the performance of a discretionary function. In the mindset of Justice Department attorneys and federal judges, Duck's criminal activities were a discretionary function. Secret Justice Department Memorandum. An assistant U.S. attorney in the San Francisco office, Michael Howard, wrote a July 11, 1990 report describing the rampant criminal corruption by federal officials in Chapter 11 courts in the Northern District of California, stating in part, subject, Alan Yaroslavsky, bankruptcy judge, Charles Duck, former trustee in bankruptcy, convicted, Philip Arnett, Harvey Hoffman, Timothy J. Walsh, Malcolm Bicirca, Ruth Harrell, attorneys for numerous trustees in bankruptcy, Susan Euchre, Jeff Walk, trustees in bankruptcy, Goldberg, Stinnett, and McDonald, law firm that specializes in bankruptcies. Primarily Carol Stinnett, David McKim, attorney at law, San Francisco attorney Monsieur, first name unknown, Robert N. Harrison, law firm in many bankruptcy cases, and primarily Mr. Cook, Esquire, William Kelly, Esquire, attorney for Graham and James law firm in San Francisco, Peter Robinson, private attorney, former assistant U.S. attorney. Why referral to Public Integrity Section, U.S. Attorney's Manual, Chapter 3, states in part, most government corruption cases are both sensitive and of intense public interest. It is particularly important that the appearance of fairness and impartiality always be present. Considering the possible involvement of bankruptcy court judges, a former U.S. attorney, and the magnitude of the investigation necessary, it is possible that the U.S. Attorney's Office does not have the resources available to investigate the widespread corruption and cronyism which presently exist in the bankruptcy courts. To thoroughly investigate the present quagmire, there is the need for a virtual full-time prosecutor to clean up the system. Main Justice would probably have the resources to provide the prosecutors and the investigators necessary to fulfill the present need to clean up the system. I don't believe we have any criminal assistants who have the time to take on such a case as this, for such investigation. Offenses indicated so far, information provided to me to date indicates that one or more of the above-named subjects have engaged in one or more of the following felonies: perjury, submitted false, forged, or altered documents to the courts, obstruction of justice, churning of Chapter 11 estates for the exclusive financial advantage of the trustees and the trustees' attorneys, failure to provide accurate financial accounts and reports to the courts. Most of the problems appear to arise in Chapter 1. Justice Department officials sequestered the report, took no action on judicial corruption, and reprimanded the assistant U.S. attorney who wrote it. The few concerned Justice Department investigators who sought to expose government corruption faced the same problem that I and other FAA inspectors faced. Media cover-up. The media was fully aware of the gravity of the Chapter 11 corruption, its nationwide extent, and the pattern of criminality that made many of their own readers victims. The media either didn't report any of the findings by its investigative reporters or, as in most cases, reported the peripheral and minor aspects of the corruption, portraying the acts in a more innocent manner. The San Francisco Daily Journal wrote in an October 4, 1990, article that Haley's pattern of alleged wrongdoing is strikingly similar to that uncovered against her friend and mentor, Charles Duck, who has admitted embezzling $2.5 million from bankruptcy estates under his control. Occasionally, the media hinted at the problem, but never identified it in a way that the public would react in outrage. The journal had months of articles describing the Chapter 11 corruption, using such headlines as Bankruptcy Courts, a System in Crisis, The Bankruptcy Club, a System in Crisis, The Road to Ruin. It avoided the heart of the matter, the epidemic pattern of crooked federal judges, trustees, and powerful law firms, and the cover-up by Justice Department officials. The few newspapers that addressed Chapter 11 corruption reported Duck's embezzlement as the worst by a trustee in the nation's history. And this assessment was given without considering the total amount of what he actually embezzled. Obviously, Duck did not operate in a vacuum, especially with the vocal complaints of his victims, and he needed the protection of federal judges to continue his criminal activities. I notified over a dozen magazines and newspapers registered of the misconduct from 1988 through 1990, a year and a half before signs of Chapter 11 corruption was exposed. Damage control for Duck. The Justice Department's prison authorities, where Duck was confined, provided him with unusually lenient conditions. His prison duties were made pleasant, and he was allowed to use prison automobiles for unescorted travel into town where his family was staying. After being released from prison, a large San Francisco law firm hired him as a full-time consultant, despite the crimes that he had committed. A law firm is not going to risk unnecessarily alienating federal judges and the Justice Department by hiring a major criminal unless it is with the tacit approval of these government entities. Reporter Linda Martin of the San Francisco Examiner spent over 2 months investigating the corruption, interviewing many of those victimized by the bankruptcy club. During the end of January 1990, Martin revealed to Mrs. McCullough, a California resident and activist against corrupt government, that the Examiner refused to print the main part of the judicial corruption, causing her to quit the Examiner. While several San Francisco Bay Area newspapers publicized the Chapter 11 corruption, the mass media papers kept the lid on the scandal. Reporter Bill Wallace for the San Francisco Chronicle explained to one inquirer, Virginia McCullough, that the reason they had not contacted me on the Chapter 11 corruption was that I incorporated other areas of government corruption into the discussion. A corollary to that would be a reporter ignoring an informant's description of a murder that took place because the informant also reported another murder. Another reporter for the Chronicle gave a different excuse to another inquirer months earlier in answer to a question why the Chronicle did not print anything about the air safety corruption that I had earlier reported. His reply, "Stich wouldn't give us any facts." Reporters Bill Wallace and Jeff Palin came to my home, looked at the volumes of material I had, and went to the federal district courts at Sacramento and San Francisco, examining the papers that I filed describing the corruption in detail. I gave them copies of my earlier book, which explained the serious corruption in detail. All questions presented to me were answered. Nothing was withheld. It was my belief they were under instructions to sequester any mention of the matter in their news stories. It took a determined effort to keep the scandal hidden, not only in the San Francisco area, but throughout the United States. The number of people financially destroyed by blatant corruption, outright violations of federal statutory and case law, the number of complaints to the Justice Department, to higher federal courts, to members of Congress, reached epidemic proportions. Most of the mass media knew of the corruption and refused to report it. A scandal affecting thousands of people a year could not have escaped the media's attention. By their cover-up, the media deceived their readers, some of whom lost their life's assets by being unaware of the judicial racketeering activities. Members of the U.S. Senate and House knew of the corruption, as their constituents pleaded with them to investigate and provide help. The legal fraternity in Congress protected the legal fraternity in the Chapter 11 corruption and made possible the financial destruction of their own constituents. There were a few exceptions. The Indianapolis Star published numerous reports on the Chapter 11 racketeering enterprises, commencing in 1987. The articles described the judicial corruption that most newspapers kept quiet. In an April 19, 1987, article, the system was described as follows: the court system is burdened with cronyism, political favors, and conflicts of interest, while a club of bankruptcy attorneys reaps the largest fees. Critics, including other lawyers, use the harshest terms. One described the system as incestuous, subverts the judicial system. Direct and indirect financial relationships between 3 judges and lawyers or others to whom they award fees, forged, fraudulent. 59. Or misleading documents, fraud. At stake is the fate of thousands of economically distressed companies and people, as well as the financial interests of hundreds of thousands of companies and individuals. Congress belatedly feigns an interest as a result of the exposures. One Chapter 11 judge in Indianapolis was sentenced to prison, very possibly to diffuse further investigation. However, the system continued and flourished, and the maverick U.S. trustee whose effort put the judge into prison was terminated by the Justice Department. Two small-town papers near San Francisco, the Napa Sentinel and the Santa Rosa Press-Democrat, ran articles on Chapter 11 corruption. But the major newspapers, including the San Francisco Chronicle, the Wall Street Journal, and others, kept the scheme going by not reporting it to their readers. The articles by the Napa Sentinel and the Santa Rosa Press-Democrat /inked the Chapter 11 corruption with numerous drug enterprises, to federal judges, judge-appointed trustees, the Department of Justice, and to the CIA. This book doesn't go into those areas, but makes reference to these tantalizing issues, especially in light of the revelations of government-protected drug activities by the CIA. For years, constituents of California Congressman Don Edwards had pleaded with him for help, as they were victimized and financially destroyed by the Chapter 11 racketeering activities. Edwards was known as the father of the bankruptcy code. Attorneys in the Chapter 11 club praised Edwards for the law that so enriched their lives. Edwards had congressional oversight jurisdiction over the scandal-plagued system, and he also chaired the House Judiciary Committee's Subcommittee on Civil and Constitutional Rights. The Chapter 11 corruption obviously violated these civil and constitutional rights. I had repeatedly reported to Congressman Edwards since 1965 the federal air safety and criminal violations related to a series of airline crashes and the corruption by federal officials, including the Justice Department. From 1988 through 1990, I repeatedly made Edwards aware of the rampant corruption and the specific criminal acts, by Chapter 11 judges and their closely knit trustees, law firms, and corporations. I reported the shocking pattern of civil and constitutional violations committed for over 5 years by federal judges and Justice Department attorneys and asked him to help. Instead, he aided and abetted the acts by covering up. Not even once did he respond. In recent years, congressional jurisdiction over Chapter 11 was transferred from Edwards' subcommittee to Representative Jack Brooks of Texas. The same cover-up tactics followed. I had repeatedly notified both of them of the hardcore criminal activities that I had discovered, starting in the mid-1960s. Brooks did criticize President Bush and the Justice Department registered for not appointing an executive director to head the U.S. trustee system, which had been vacant for a year at that time. My subsequent 18-page petition to every United States Senator by certified mail on April 1, 1991, detailed and documented the ongoing criminal acts, which were crimes against the United States and the American people. Not a single senator made a meaningful response. Several years later, Congressman Brooks was still investigating Chapter 11 corruption, while thousands of American citizens were defrauded of their life's assets. One of many murders throughout these pages appear the names of some who threatened to expose the criminal activities implicating federal officials, and who conveniently ended up dead. One of those victims was San Francisco attorney Dexter Jacobson. Jacobson was preparing to file several lawsuits against key law firms implicated in the Chapter 11 corruption in the San Francisco area. The San Francisco legal paper, Daily Journal, had publicized Jacobson's impending filings, along with the evidence he intended to present to the San Francisco office of the Federal Bureau of Investigation on Monday and Tuesday, August 20 and 21, 1990. His evidence implicated Chapter 11 judges, trustees, powerful law firms and powerful corporations, including Bank of America. Jacobson and I had exchanged information on the corruption in the Chapter 11 court several months earlier. He didn't know about the Justice Department involvement in the Chapter 11 corruption, and I did not have time to bring this to his attention. 2 days prior to Jacobson's meeting scheduled with the FBI, his body was found in nearby Sausalito with a bullet hole in his head. Jacobson's death acted to protect Justice Department officials, federal judges, powerful law firms made rich by the Chapter 11 looting, and other members of the bankruptcy club. Several Northern California newspapers linked Jacobson's death to the corruption in Chapter 11 courts. Jacobson was the only attorney willing to speak out, as the others either took advantage of the system or kept the lid on it, protecting the legal fraternity from public scrutiny. Many of the attorneys feared retaliation from the judges and trustees who can withhold hefty legal fees. Trustees appoint attorneys to represent the estates, and favored attorneys who play the game can be handsomely rewarded. Jacobson did not practice in the Chapter 11 courts and therefore did not risk the judicial and financial retaliation faced by attorneys who specialize in those courts. He specialized in real estate and business law, mostly in California and federal district courts. Jacobson's murder ended the threat of exposure faced by Justice Department attorneys, judges, law firms, and private attorneys. Some papers reported the problems typical of the media stories after Jacobson's killing included that of the McClatchy News Service. Everybody around here is 100% convinced that it was a hit. Jacobson was about to drop a bombshell lawsuit into the burgeoning Northern California bankruptcy court scandal, naming trustees and high-powered lawyers, and was about to take his evidence to the FBI and the Justice Department. We both talked about the safety of the documents and we both talked about the safety of each other, recalls Sosnowski. We are dealing with some very tough people. They're making big money. The killing sent a shudder of apprehension through the legal profession, when an examiner concluded in 1988 that Duck had engaged in serious misconduct in the Sosnowski case, and suggested further investigation. Santa Rosa bankruptcy judge Alan Yaroslavsky ordered the 49-page report sealed. The January 1991 issue of California Lawyer magazine ran a 9-page article entitled, "Who Killed Dexter Jacobson?" Reference was made to key parts of the Chapter 11 corruption that had appeared in other publications, including, Jacobson planned to file a civil complaint that would charge some of San Francisco's top attorneys with involvement in the nation's most costly bankruptcy trustee fraud and embezzlement scandal. Jacobson's secretary, Ginny Morrison, recalls her boss saying shortly before his death that filing the suit was a dangerous move. He said he was going up against some powerful people, and that this would be on the front page of every newspaper in the country. Attorneys in tightly knit bankruptcy community were aware of Duck's schemes, and probably had participated in them. Dexter Jacobson was one of the first people willing to investigate that possibility. The final drafts of lawsuits have disappeared from Jacobson's house, his office, his car, and from the hard drive of his computer. On the day of his death, Jacobson had planned to meet with FBI agent Eddie Freyer. Jacobson was overwhelming his opponents with his meticulous research and questioning. "There is not much doubt in me mind it's tied in with this bankruptcy stuff," one federal source says. Cover-up by local police. The Sausalito Police Department and the FBI refused to contact me when I advised them in 1990 that Jacobson and I had exchanged information on the Chapter 11 corruption shortly before he was killed. My information may or may not have been helpful, but an investigation into Jacobson's murder demanded that I be contacted to determine what was discussed between Jacobson and myself. But to bring me into the investigation risked exposing a still bigger scandal. Another attorney was murdered as he was trying to expose the Chapter 11 corruption. Attorney Gary Ray Pinnell, who had been vocal in fighting the corruption within the Chapter 11 system in Texas, was slain in San Antonio, Texas on February 11, 1991. The San Antonio Texas Express reported that Pinnell was preparing to turn evidence over to the FBI but was killed before he was able to do so. In both cases, Justice Department officials, including the FBI, would have been exposed if these attorneys had succeeded in attracting public attention. A man was killed in Las Vegas as he was about to testify about an alleged scheme taking the properties of Karen Huffer and her husband, implicating Valley Bank of Nevada and the same Chapter 11 judge who corruptly seized my assets, Judge Robert Jones. None of these who died, who were about to present evidence of Chapter 11 judicial corruption to the FBI, realized their evidence threatened Justice Department officials and federal judges, up to and including the justices of the U.S. Supreme Court. 55. While these deaths were occurring, the same Justice Department officials and federal judges, who would be implicated by an exposure, were seeking to silence me by repeatedly charging me with criminal contempt of court for seeking to report the criminal activities through federal filings. More about this later. Criminal contempt for reporting crimes. I had been vocal in exposing the criminality in Chapter 11 courts, and especially that of Trustee Charles Duck. In an attempt to silence me, Federal Judge Edward Gellin of Oakland charged me with criminal contempt for filing appeals and oppositions to the seizure and looting of my assets. Gellin denied me the right to testify in my defense, denied me a jury trial, denied me legal counsel, and then sentenced me to prison for objecting to the seizure of my assets. U.S. District Judge Samuel Conti approved the prison sentence, and it was sent to U.S. Attorney Russ Aniello for prosecution. Several months after federal judges seized my assets and started liquidating them, other federal judges sentenced me to prison for having filed notices of appeal and oppositions to the seizure and looting of my life's assets. Those acts were criminal in nature, violating specific criminal statutes. 72 While I was in prison, Federal Judge Edward Gellin ordered fire sale liquidation of my assets. While I was in prison, Trustee Charles Duck unlawfully ordered my mail diverted to his office and opened. Postmaster Dennis Hughes in Alamo, California, where I resided, stated to me that many federal officials came to the post office checking on my mail, and that he expected to be subpoenaed because of the serious irregularities. The reason for rendering these unlawful orders barring me access to the federal courts was that I had numerous claims against federal officials and judges. If federal relief remedies were not denied to me, the escalating corruption and the judicial and legal participants in the scheme would be exposed. When the initial scheme involving the sham California action backfired, and federal judges involved themselves in the complicity when I exercised federal protections, the number of judicial and legal personnel implicated in the attacks upon me greatly escalated. With each escalation there were new federal causes of action permitting me to sue for damages. The only way to stop that was to render orders, unlawful of course, voiding my protections in the statutes and Constitution of the United States, denying to me the right to court access and relief. More about this in later pages. In later pages, a more complex web of intrigue is presented, showing other reasons why Justice Department attorneys and federal judges blocked all defenses exercised by the victims, and showing how the CIA has infiltrated all segments of U.S. society, misusing government offices, defrauding American citizens and the United States as a whole. Numerous trustees and judges have been. 71 charges were filed on December 10, 1990 in the U.S. District Court, San Francisco, number CR 90-0636 VRW. 72 including Title 18 U.S.C. 241 and 1512, 1513. 73 Title 18 U.S.C. 1702, 1703. 56. Identified to me by deep cover CIA operatives as being deeply involved in corrupt CIA activities, especially Charles Duck and Judge Robert Jones, both of whom brought about the destruction of my life's assets. Discovery of additional criminal activities throughout Chapter 11 courts from 1987 to the present. I discovered, both in my own case and from reports I received from CIA sources and other victims, that the criminal seizure and looting of assets in bankruptcy courts was epidemic. The criminal acts involved the federal judiciary, including federal judges, trustees, attorneys, law firms, Justice Department attorneys, and CIA personnel. Demanding bribes to get out of Chapter 7. As my knowledge of this corruption broadened, I discovered other versions of enriching the participants. In Chapter 11 proceedings, for instance, as was earlier described, the incentive was to steal the assets that exceeded the liabilities. But I later discovered from victims that, even when there is no equity in a person's Chapter 7 filing, money is extracted to discharge the case and allow the person to resume a normal life. Pat Class of Denver and attorney Andrew Quayat described to me another form of extortion. The law provides that a person with liabilities exceeding their assets may file Chapter 7 to completely wipe out their indebtedness, allowing them to basically start all over again. The pattern of court duplicity touches upon every possible source of money, and in Chapter 7 proceedings, where the debtor has the potential of making sizable income in post-Chapter 7 proceedings, the trustees and judges often demand hidden money to be discharged, even though all issues have been adjudicated. Pat Class, for instance, described how she was forced into Chapter 7 in the Denver area HUD and savings and loan-related corruption, and then a discharge refused unless she paid the trustee money under the table. Pat and attorney Quayette told me of a case in the Denver courts where the trustee demanded, and received, $1.5 million under the table before a Chapter 7 discharge was granted by the judge. A CIA contact who had extensive dealings with federal judges in several circuits throughout the United States gave me specific data on the corruption in the San Francisco and Chicago area bankruptcy courts. More is said about this in later pages. It became clear that the bankruptcy courts serve as one of America's biggest financial frauds inflicted upon the American public, made possible by media cover-up. Example of fraud-related grief. Over the years, many people have contacted me who had suffered enormous, often lifelong harm as a result of crooked judges and attorneys operating with impunity in Chapter 11, 12, 13 proceedings. Many of the victims have committed suicide. In September 1994, the story of one of these victims reached me. Before committing suicide on July 12, 1994, in Sonoma, California, near San Francisco, 57-year-old Claire Ann Day wrote a 20-page suicide note, detailing in it the corrupt acts by bankruptcy judge Alan Yaroslavsky and attorneys working with the judge, as it affected her daughter, Mary. I had heard many stories about this judge's involvement in the crooked bankruptcy courts. One of my CIA contacts stated that Yaroslavsky was a former officer in the U.S. Navy and a part of naval intelligence, and that he was a CIA asset. The CIA was one of the groups involved in the looting of bankruptcy court assets, and this information about the judge fit in with other information. The suicide note stated in part, "To whomever reads this plea for justice, I pray that someone of conscience reads these pages, comprehends the far-reaching implications of what has happened to my family, and take action to prevent this from ever happening again in Sonoma County or anywhere else in this country dedicated to liberty and justice for all. I do not have the time or propensity to adequately chronicle this good v evil, David v. Goliath battle, before I die. For every word contained herein are 100,000 missing words." A puff of black smoke mushroomed from her body as she ignited the flammable fluid. A neighbor, Bill Anderson, rushed to her, putting his jacket around her to put out the flames. A helicopter rushed Day to the hospital, but she died the next day. Media cover-up. This woman's painful and horrible sacrifice sought to focus attention on the corrupt judges and legal fraternity. It was in vain. The San Francisco area newspapers omitted any reference to her immolation. Years ago, the immolation of a Vietnamese was pictured throughout the United States. But a similar immolation in the United States would have exposed the corruption in U.S. courts and very possibly the role played by many in the legal fraternity and the CIA in this massive judicially centered racketeering enterprise. And San Francisco is one of the hubs of corruption described within these pages. Sonoma County Fire Department Assistant Chief Alan Lee said, "None of us had ever seen a more severely burned person who had survived." Anderson said, "It's so sad when things like this happen. I keep thinking how ironic it is. I just fought for my life in the hospital for 4 months, and then someone just gives up their life." Anderson had fought a life-threatening illness. The horror of the woman's death caused the county to provide crisis counseling for the people who saw the tragedy. The system protects its own. As stated earlier, Charlie Duck still had powerful connections to the system, and was part of it, causing a San Francisco law firm to put him on their payroll in 1995. This would be highly unlikely of a convicted felon accused of the nation's worst bankruptcy fraud, unless the plea bargain was for damage control to prevent further investigations, and that Duck still had his former judicial and CIA connections. If so, it is understandable why the San Francisco law firm coveted his membership. 58. Author's home and his plane. some of many assets taken from him by the combination of Justice Department trustees, federal and California judges, as part of the bizarre scheme to block his reporting of the criminal activities detailed and documented within these pages, and in retaliation for exposing these crimes. Chapter 5. Report crimes of federal officials go to prison. Corruption involving federal officials, that circumvents the cover-ups and obstruction of justice by Justice Department or other government officials, is Federal Criminal Statute Title 18 U.S.C. Section 4. The clear wording says, whoever, having knowledge of the actual commission of a felony cognizable by a court of the United States, conceals and does not as soon as possible make known the same to some judge, shall be fined, or imprisoned not more than 3 years, or both. Implicit in that statute is that federal judges must receive evidence of a federal crime that is offered to them by anyone having knowledge of the federal offense. As the reader learns about the various criminal activities detailed and documented in these pages, the question may arise as to why I haven't used that statute to produce evidence of the crimes. I had first used that statute in 1976 seeking to produce evidence to a U.S. District Court judge in San Francisco of the criminal activities within the Federal Aviation Administration, associated with several major air disasters. Later pages show that I exercised the responsibility of that major crime reporting statute seeking to produce evidence that I had obtained relating to criminal acts by government officials and judges in the bankruptcy courts, in T = most important tool in the hands of the American public to combat the CIA drug trafficking, and other major offenses against the United States and the American people. In every single instance, federal judges blocked me from producing my evidence, something that they had no authority to block. Even worse, they eventually retaliated against me for seeking to comply with that law. If they had not blocked my reporting of these criminal activities, life in the United States would be quite different. Hundreds, if not thousands, of people who know about these criminal activities, including the many CIA operatives who would expose the crimes of the agency if they could, would be exercising that protection. Early in 1987, in an attempt to thwart my exposure activities, federal judges and Justice Department attorneys commenced charging me with criminal contempt of court in retaliation for seeking to report the criminal acts I had discovered, and for exercising federal remedies seeking to halt the harm inflicted through the sham California lawsuit. They actually sought to put me in prison for exercising federal crime reporting responsibilities under Title 18 U.S.C. Section 4, and for exercising federal defenses against the acts taken to silence me. The sham California lawsuit had not gone as planned. My exercise of federal remedies was unanticipated, and federal judges had to openly protect the scheme and the participants by unlawfully dismissing the actions. These judicial acts raised additional federal causes of actions, for which additional federal remedies existed. It was a literal perpetual motion scenario as federal judges violated federal law, blocking my exercise of federal remedies, thereby raising additional federal causes of action. The more that was done to me, the greater the number of court remedies that arose. The method used by this daisy chain of judicial obstruction of justice was to render a pattern of unlawful and unconstitutional orders barring me from federal court access and voiding all relevant constitutional and statutory protections. Several months earlier, in late 1987, this same group seized my life's assets, including my real estate investments. The first of a series of orders was rendered, making me a man without a country insofar as the protections of law and constitution were concerned. Judge Milton Schwartz rendered the first of many orders blocking my access to federal court. This order barred me from reporting federal crimes to a federal court, as required to be reported by federal crime reporting statutes such as Title 18 U.S.C. Section 4. If I did not report the criminal activities to a federal court or other federal tribunal, I would be guilty of a federal crime. Since I obviously couldn't report the crimes to the same Justice Department officials who had been deeply involved in the criminality, the only avenue open was to report the crimes to a federal court. As a citizen concerned about criminality in government, I also had the right, in addition to the responsibility, to submit the reports to a federal court. From 1974 to this day, I haven't had my day in court on any of the issues raised in any of the federal filings. Every federal judge who received my federal filings blocked my right to have a federal court declare the validity of the 5 judgments and the important personal and property rights established by those judgments. I was suffering serious personal and financial harm by their refusal. 6. To perform a mandatory duty. In 1986, U.S. District Judge Milton Schwartz at Sacramento rendered an order dismissing my attempts to obtain federal relief from the violations of federally protected rights inflicted against me in the California courts. In that order, he barred me from ever filing any federal action seeking relief or reporting the federal crimes, which was then followed by an escalation of previous acts by California judges and the Friedman law firm. Exercising rights and responsibilities under federal law, I filed 2 lawsuits in the United States District Court in the District of Columbia, naming as defendants the FAA, NTSB, the Justice Department, and Judge Milton Schwartz. In these lawsuits I sought to give testimony and evidence about the criminal acts I had uncovered, to obtain an order halting the violations of federally protected rights, to declare my rights in the 5 judgments, and to declare as void the order barring me from federal court access. Each of these issues constituted a major federal cause of action requiring the U.S. District Judge to perform his duty. U.S. Attorney David Levy and U.S. District Judge Milton Schwartz retaliated against me for having exercised these rights and responsibilities belonging to every citizen in the United States. Schwartz issued a March 1987 order to show cause for me to appear in federal court at Sacramento on April 23, 1987, to explain why I should not be held in civil contempt for filing the federal lawsuits. Schwartz argued that I was in contempt of court for filing the federal action when his May 30, 1986, injunctive order permanently barred me from federal court access. 2 days before I was to appear, Judge Schwartz's senior law clerk, Joanne Spears, telephoned me at my Nevada residence, devoting at least 15 minutes convincing me not to personally appear, but to appear by legal counsel. But the order requires that I personally appear, I stated. Ms. Spears answered, talk to Judge Schwartz, and it was decided that you do not have to personally appear. I didn't realize it then, but she was lying, and setting me up. I told Spears that I didn't have an attorney, and she replied I should get any attorney to appear for me, and that he didn't have to know anything about the case. That last statement didn't make any sense at all. The reason for avoiding a personal appearance was that California Judge William Jensen had issued a bench warrant for my arrest, which was still in effect. Every time there was an appearance calendared for me, the Friedman Group alerted the Solano County Sheriff's Office and sheriff deputies waited to arrest me. They're setting you up. I stated to a friend in Reno, Laura Link, what Judge Schwartz's law clerk had stated. They're setting you up, Laura stated. Oh, come on, I responded, I know they're a bunch of bastards, but they wouldn't do anything that obvious. Like most of the public, I was naive about the dirty tricks of federal judges and Justice Department attorneys. I made some quick phone calls and Sacramento attorney Joel Pegg agreed to appear for me. But when Pegg appeared on April 23, as Judge Schwartz's law clerk suggested, Judge Schwartz already had a multi-page order prepared, charging me with criminal contempt for not personally appearing. Schwartz and his law clerk had set me up. Schwartz then ordered me to appear in federal court on May 7, 1987, on a charge of criminal contempt, and warned that if I did not appear, a federal bench warrant would be issued for my arrest. Arraigned on criminal contempt of court charges, I appeared on May 7 with attorney Joel Pegg and was promptly arraigned, based on a criminal information filed by U.S. Attorney David Levy. The Justice Department charged me with a 3-count criminal indictment, one for each of the lawsuits in which I sought to report, via federal filings as provided by Title 18 U.S.C. 4, the criminal activities I discovered, and for seeking relief from the judicial acts taken to silence me. Federal marshals marched me to Magistrate Esther Hicks, where I was officially charged with the purported offense of criminal contempt of court. I hadn't realized that reporting federal crimes was an imprisonable offense. Justice Department attorneys sought to have me imprisoned in the federal penitentiary for 18 months. These acts were federal crimes. They inflicted harm upon me for having exercised rights and protections under the Constitution and laws of the United States and for having sought to report federal crimes committed by federal personnel. High flight risk? Assistant United States Attorney Peter Nowinski sought to deny me my freedom pending trial, arguing that my offenses made me a high flight risk, and that I had a record of not appearing in court. Magistrate Esther Hicks asked why I was considered a flight risk. He failed to appear before Judge Schwartz on April 23, 1987, replied Assistant U.S. Attorney Nowinski. This was the hearing at which Judge Schwartz's law clerk stressed I should not personally appear and at which I appeared by legal counsel. The Assistant U.S. Attorney then argued that I failed to appear before California Judge William Jensen in Fairfield on May 9, 1986. That was the date when I appeared before Judge Schwartz, and could not physically be in two places at the same time. I had an attorney appear for me, as permitted by law. The United States Attorney continued his leading to the court. The government also has information that Mr. Stich kidnapped a grandchild from Texas and threatened his wife, with whom he was litigating, that she would never see the child again, if she did not terminate the litigation. That was a fabrication. One of my 3 daughters, Linda, moved to California from Texas, taking her 2 children with her. It was those children that I was supposed to have kidnapped. I had not communicated in any manner with my former wife for years, and certainly made no threats. Nor did I know my daughter was moving from Texas until she arrived. I would discover as years went by that it is normal practice for Justice Department attorneys to fabricate whatever lie is necessary to obtain a conviction and to support whatever order they want rendered. Magistrate Esther Hicks read my rights to me, as if I were a criminal, and warned me of the consequences if I tried to flee. For the prior 15 years I had tried to appear before federal courts to present evidence, and to now imply I might flee was a preposterous statement. I was treated like a hardcore criminal in retaliation for reporting the crimes in which federal judges and Justice Department officials were implicated. After arraignment, and after signing a stipulation agreeing to a trial before a U.S. magistrate, I was released on bail. I had to post a $25,000 bond to ensure that I would appear in court. I was then booked and my fingerprints and picture taken, like a common criminal. Unknown to me, there was still more trouble waiting. Friedman alerted the California authorities waiting to arrest me and take me to Solano County Jail were 2 sheriff's deputies from Solano County with a bench warrant for my arrest, rendered by California Judge William Jensen. Fortunately I had bail money handy, which I paid to the deputies. The deputies were apparently alerted either by the Friedman law firm, California Judge William Jensen, U.S. District Judge Milton Schwartz, or all of them together. At another time during a 1987 hearing in the California action, the Friedman law firm notified the Solano County Sheriff's Office that I would appear carrying a gun. This was part of the pattern of dirty tricks pulled throughout the 8 years of litigation by the Friedman law firm. I was frisked for concealed weapons when I appeared in court. Trying to retain some semblance of sanity, I had to joke about all of this occasionally. Because the Friedman law firm was heavily Jewish, as were most of the federal judges and Justice Department prosecutors that I encountered, I asked Laura Link, "Do you suppose if told these bastards I was not of German descent, but of Austrian descent, they would pull back?" She responded, "That won't do any good. Austria was once part of Germany." This conversation was in a light vein, but as I discovered other patterns of corruption far beyond what I had discovered up to this date, I found an inordinate involvement of Jewish attorneys and the Mossad. As shown in later pages, the Mossad is involved in many of the criminal activities inflicting great harm upon the American people. Kangaroo trial. To avoid a kangaroo court trial, it was important that I receive a jury trial on the criminal contempt charge. Otherwise, I would be prosecuted by the Justice Department and tried by federal judges, who were the two groups most threatened by my exposure activities. The constitutional right to an unbiased tribunal would obviously be lacking. During my initial arraignment, Attorney Pegg instructed me to sign a waiver to permit a trial before a U.S. magistrate instead of a district court judge. That was a dumb thing to do, as the part-time federal magistrate was employed and retained only so long as he or she pleased my adversaries in the Justice Department and the federal judges. The saving grace was that the waiver contained a stipulation that I would receive a jury trial. 64. The Sixth and Seventh Amendments to the U.S. Constitution guarantee the right to a jury trial and also a trial before a fair and impartial jury. However, federal judges have ignored this constitutional protection for years, and the U.S. Supreme Court justices have held that in federal court the right to a jury does not exist if incarceration does not exceed 6 months. Federal judges euphemistically call this long incarceration a petty offense. There is nothing petty about 6 months in prison, especially while a person's business, properties, home, assets, and maybe family, are lost. U.S. Attorney David Levi sought to have me imprisoned for 18 months, 6 months for each of the 3 federal actions that were filed. Before the commencement of the trial, my attorney reminded Magistrate John Moulds that a jury trial had been stipulated earlier. Assistant U.S. Attorney David Flynn responded that I wasn't entitled to a jury trial on the basis that he was lowering his requested prison term to 6 months from the originally requested 18 months. But that reduction in prison sentence had nothing to do with the written stipulation for a jury trial, which arose when I signed a waiver to proceed before a U.S. magistrate. Like every other right to which I was entitled during the past several years, that right was violated. Magistrate Moulds denied me a jury trial, and the trial commenced without a jury. I had notified several of the news services and numerous radio and television stations in the San Francisco and Sacramento area of the government attempt to railroad me to prison for reporting the criminal activities that I had uncovered. Not a single one showed up. Attorney Pegg raised arguments that held I couldn't be found guilty, but omitted the hardcore constitutional violations associated with Judge Schwartz's injunctive order, the setup by Judge Schwartz and his law clerk that converted the civil contempt into criminal contempt, the felonious nature of inflicting harm upon a person for exercising rights and protections under law, and the felonious nature 7 of inflicting harm upon a person for attempting to report federal crimes. I find you guilty. Guilty of what? Trying to report federal crimes of his associates. Magistrate Moulds concluded the trial by declaring I was guilty as charged, setting a November 4, 1987, sentencing date. Attorney Pegg then abandoned me, making no effort to submit briefs for reconsideration as provided by law or for filing notice of appeals and appeal briefs. I felt that he did not wish to offend federal judges or the Justice Department, people with whom he would deal throughout his legal career. Several months earlier, I was forced to seek refuge in Chapter 11 to protect my assets against the events taking place in the California courts. This matter has been addressed in a previous chapter. When Magistrate Moulds held me guilty of criminal contempt of court, Judge Robert Jones used this decision as the basis for seizing my assets of $10 million. While in prison, these assets were looted and destroyed. My world was tumbling down upon me, a terrible price to pay for having exerted efforts to expose the escalating corruption within the federal government. I often thought that, if had never taken the United Airlines assignment, and had not reported the pattern of hardcore air safety and criminal violations, my entire life would have been very different. Rampant constitutional violations. After Pegg abandoned me, I filed post-trial motions in pro se status, raising numerous defenses, none of which Attorney Pegg had raised, including, 1. The underlying injunctive order, voiding for me access to federal court and the statutory and constitutional protections, was unlawful and unconstitutional. 2. It constitutes a federal crime to retaliate against a citizen for having exercised the right to federal court access, seeking declaratory and injunctive relief from the pattern of civil right violations judicially inflicted. The prosecution and judgment holding me guilty constituted a criminal act under Title 18 U.S.C. 241. 3. It constitutes federal crimes under Title 18 U.S.C. 1512 and 1513 to prosecute and hold a person guilty of an imprisonable offense in retaliation for having reported federal crimes or having sought to do so. 4. I would have been guilty of a federal crime under Title 18 U.S.C. 4 if I had not reported the federal crimes, which I sought to report through the federal filings which were used as the basis for the criminal contempt of court charges. 5. The injunctive order barring me from federal court reversed the federal criteria for rendering such an order, which is intended to protect a person suffering great and irreparable harm and not to deprive the person suffering this harm the relief available under law. 6. The underlying injunctive order fraudulently sought support by placing a frivolous label on the underlying lawsuit. The major federal causes of action stated in that action couldn't possibly meet the legal definition of a frivolous action. 7. Federal case law provides that a person cannot be charged with criminal contempt for exercising a right that would otherwise be lost and that, if I did not file the action, I would lose my right to relief. 8. A federal judge lacks authority to force a person, who knows of federal crimes, to violate federal crime reporting statutes by remaining silent. 9. A party cannot be punished for contempt when the injunctive order is on appeal. Judge Schwartz admitted this fact in an order he rendered on November 3, 1987. This court lacks jurisdiction to entertain the motion for contempt since the underlying judgment in this case rendered by this court is currently on appeal. The Ninth Circuit follows the general rule with some exceptions not relevant here, that the filing of a proper and timely notice of appeal divests the district court of jurisdiction over those matters that are not on appeal or subject to the appeal. Making reference to the verbal order, Judge Schwartz made a written order on December 9, 1987, making reference to the applicable federal law stating in part, the court denies the motion of defendants, Jensen and Superior Court of Solano County for an order adjudging plaintiff in contempt, because it is this court's conclusion that it lacks jurisdiction to entertain the motion since the underlying judgment in this case rendered by this court is currently on appeal. This holding and the law cited made the contempt proceedings before Magistrate Moulds illegal and without jurisdiction. But Moulds continued the contempt proceedings and ordered me incarcerated on November 4, 1987. Under federal law he had a statutory right to a stay of imprisonment pending appeal if the appeal raised any arguable issues of fact or law *. I obviously had many arguable issues. But Moulds refused to grant me bail, arguing that he did not think the Court of Appeals would vacate his judgment. Federal case law registered made it plain that bail cannot be denied on the belief by the judge who rendered the judgment that his decision would be upheld. Otherwise, granting bail would depend upon the judge rendering the judgment believing his judgment would be overturned on appeal. I filed a motion for stay of prison sentence with District Judge Raul Ramirez, pending appeal of the judgment and sentence. Ironically, it was Judge Ramirez's unlawful dismissal of the first federal action seeking relief in 1984 that made possible the escalation of the judicial civil right violations against me. Ramirez also denied bail, holding that he didn't think the judgment would be overturned. Supreme Court Justice Anthony Kennedy as co-conspirator shortly before Christmas 1987, the Ninth Circuit Court of Appeals at San Francisco turned down my appeal of the prison sentence. The three judges, James R. Browning, Alex Kaczynski, and Pamela Reimer, turned down my appeal without addressing a single one of the many defenses that I raised. Incredibly, they approved each and every judicial violation inflicted upon me by the California and federal judges. They approved the judicial voiding of all federal remedies. They approved the imprisonment that constituted prima facie evidence of felony retaliation for trying to report the federal crimes that I had discovered. They approved the obstruction of justice tactics, and the many other wrongful judicial acts. The implications of this judicial mindset were extremely serious. Without addressing a single issue that I raised in the appeal briefs, which they should have done, the Court of Appeals judges simply stated, "The judgment is affirmed." I quickly filed a petition for writ of certiorari with the United States Supreme Court. In my written arguments, I raised the pattern of judicial suspension of civil rights and the criminal implications by Ninth Circuit judges, their obstruction of justice, their felony persecution of whistleblowers, and reminded the Supreme Court justices of their supervisory responsibilities over these judges. Aiding and abetting these acts by judges over whom they had supervisory responsibilities, the Supreme Court justices upheld this conduct, becoming co-conspirators with the criminal acts that I sought to expose. I was ordered to turn myself in on January 14, 1988, I had to act fast. Over the Christmas holidays I prepared a petition to Ninth Circuit Court of Appeals Justice Anthony Kennedy. I worked feverishly on Christmas Day to finish the petition for submission to Kennedy the following Monday. Kennedy had testified at great lengths during his televised Senate confirmation hearing for appointment to the Supreme Court, expressing repeated concerns for due process, constitutional safeguards, respect for privacy. Kennedy denied me relief. His conduct represented numerous criminal acts, including obstruction of justice, aiding and abetting, accessory before and after the fact, misprision of felonies, fraud, conspiracy, and other crimes. The same applies to the other judges described within these pages. Judge Kennedy was already involved in the corruption I sought to expose. He was on the appellate panel that heard my appeal of the District Court's dismissal of the 1974 federal action against the Federal Aviation Administration. Kennedy knew the consequences of cover-up, as several major air tragedies associated with the air safety corruption followed his decision upholding the District Court's dismissal of my action. That action sought to report to a federal court the federal crimes I discovered, as a federal investigator, at United Airlines and within the FAA that were associated with a series of air disasters. After Justice Anthony Kennedy denied the emergency request, I filed a second motion for stay pending appeal with Judge Ramirez. When I appeared before Ramirez on February 16, 1988 on the motion, he delayed rendering a decision, continuing the matter until March 4, 1988, the date I was to be imprisoned. I asked Ramirez to grant a continuance of the incarceration date to permit me to request a stay of the prison sentence pending appeal from the United States Court of Appeals, if he denied my motion. Ramirez assured me that I could request a stay from him on March 4, implying that he would stay the sentence. I was at a serious disadvantage by appearing without legal counsel. The Justice Department and federal judges seized all my assets, and I was without funds to hire legal counsel. I was entitled to appointment of legal counsel, which I requested. Judge Ramirez appointed federal public defender Carl Larson to represent me. But instead of representing me, Larson acted as damage control for the corrupt judges and Justice Department. Every action 68 he took was to protect the system of corrupt judges and corrupt Justice Department attorneys and defeat my remedies in law. I discovered over the next 5 years that this type of legal representation occurs in almost every instance. Larson made no effort to prepare a defense to the multitude of issues that made the guilty verdict a gross miscarriage of justice. He took the position that I was guilty, advising me to prepare for prison. He refused to request a stay of prison sentence pending appeal, a statutory right in federal law. He refused to file any post-conviction motions or to file an appeal. He protected the corrupt system and became criminally implicated. When Larson learned that I was to appear as a guest on a talk show on government corruption, he became furious and ordered me not to appear. I, of course, ignored him. I finally dismissed Larson and appeared in pro se status so as to file my own briefs raising the important defense issues. Larson refused to raise any of them, protecting the federal judges and Justice Department attorneys with whom he would be working throughout his legal career. Bailiff, do your job. I appeared before Judge Ramirez at the March 4, 1988, hearing without benefit of legal counsel, expecting to receive a stay of the prison sentence pending appeal. Instead, Ramirez denied my request and ordered, "Bailiff, do your job." 2 husky marshals seized me and led me to a dirty prison cell in the basement of the federal building, where I was stripped of all my belongings. Handcuffs and leg irons were put on me. The U.S. Marshals led me to a van in leg irons and handcuffs and transported me to a county jail at Yuba City, California, in what would be one of several prisons for the next 2 months. Driving up to Yuba City, I passed the motel that I owned, Tahitian Gardens. Staying at the motel was my friend Edith Armstrong, whom I hadn't been able to visit for the past 2 years because of California Judge William Jensen's bench warrant for my arrest. No matter how bad life became, it always seemed to get worse, at least for the first month of my imprisonment. 24 hours a day you sit, eat, sleep on a thin, filthy mattress, if you are lucky to have one, and eat under filthy conditions. Life becomes meaningless. I was shocked that this could be happening in America, but things always got worse. There was also another possible reason for my incarceration. I was recovering from open heart surgery in which I received 6 coronary bypasses, and any stress could constrict them and result in a heart attack and possibly death. My death would seemingly end the threat of exposure to those implicated in the various segments of the criminal activities described within these pages. There was no one else with the evidence and the willingness to continue the fight. While I was in prison and unable to defend myself, the Friedman law firm and California judges rendered orders laying claim to my multi-million-dollar estate. They rendered a sham divorce judgment on July 28, 1988, and transferred title to my property, even though there was no marriage to support the divorce judgment. Debate with ACLU while in prison. My contact with the outside world while in the Sutter County Jail was by 69. Mail and a telephone in the crowded cell block. Each prisoner was limited to a scheduled 15-minute call. During a late evening phone call from the prison cell, a friend advised that she arranged an appearance for me on radio station KOH in Reno, hosted by Fred Taft. I was to phone the station collect the following morning, and would be on the air for an hour. In the meantime, Taft arranged that the executive director of the Nevada ACLU, Shelley Chase, would be on the show. On an earlier show, my friend revealed how the ACLU had refused to help me defend against the onslaught of civil rights violations, while soliciting money from the public to uphold these protections. Ironically, the Friedman law firm was a key member of the San Francisco ACLU. I told my friend that it was highly questionable whether I could be on the talk show since I was confined in prison, in a crowded cell, with 16 other prisoners, and limited to a single 15-minute telephone conversation. I explained the situation to the other prisoners, some of whom were bank robbers and drug dealers, explaining that I had the opportunity to debate with the ACLU. The prisoners encouraged me to get on the show. Everyone waived their scheduled telephone schedule so I could make the 1-hour talk show possible. Of course, the prison officials knew nothing about it. If they had, they would have put an immediate stop to it. There were some unusual sounds during the show. Clanking of cell block doors, screaming of prisoners, and a fight ensuing a few feet from the telephone. During this talk show, ACLU Executive Director Shelley Chase defended and upheld the outrageous civil rights violations perpetrated by Justice Department attorneys and the California and federal judges. This is the same ACLU to whom I brought information for the prior 20 years of the ongoing criminal activities that were implicated in a series of air disasters. Host Fred Taft expressed outrage over the government conduct on 2 prior shows, relating the government abuse of his cousin by the IRS and his subsequent imprisonment on a tax charge. But during this show Taft changed his colors. He upheld the ACLU's position, causing me to wonder if the station had been pressured by government officials to support the acts taken against me. Start of diesel therapy. After spending several weeks in the bleak conditions of the Sutter County Jail, I went on the diesel therapy route, being transferred from prison to prison. I was transferred to the infamous old Sacramento County Jail, where filth, overcrowding, and inhuman conditions took on a new meaning. I wondered how it compared to the infamous Devil's Island prison. During the frequent changes in prison, I once found myself in a cell with 12 bunks, occupied by over 30 people, with hardly room to sit down. It resembled a cage with animals packed tightly together. You spend every minute of the day or night sitting or sleeping on the concrete floor, unless you are lucky enough to have a thin mattress for sleeping. The stench of the dirty mattresses was sometimes unbearable. In the Sacramento jail, the open toilet was positioned along a glass wall with constant passing of male and female guards, without any screening or privacy. Many of the prisoners looked as if they hadn't washed or changed their clothes in weeks. They resembled 70. Something out of a horror story. Food came in unsanitary containers that resembled feeding time in a dog kennel. Silencing techniques in prison. Diesel therapy is one of many tricks used by the Justice Department to break a prisoner, keep him from his legal counsel, if he had counsel, and keep him from communicating with his family or friends. It is common practice in the federal prison system to move prisoners from prison to prison for weeks at a time, the prisoner being lost for all practical purposes. After Judge Ramirez ordered my incarceration, he sought to keep me in the county jails where there was no access to legal facilities, thus keeping me from filing legal papers to obtain my release. Brutality of prison. Prison has its own peculiar sounds. The constant slamming of heavy metal doors, night screams, fights in the cells, living, eating, and existing like caged animals. Many prisoners respond accordingly. There is no privacy. Prisoners sleep in crowded, inhumane conditions, often within a few feet of a dirty, seatless toilet used by dozens of occupants. Modesty doesn't exist. Anyone who hasn't been in prison doesn't know the degradation and the humiliation that goes with it. The first thing that happens is that you are handcuffed, a chain put around your waist and connected to leg irons. Prisoners are stripped of all belongings, including their watch, rings, and identification, and then put into holding cells. The filthy toilet conditions indoctrinate you to what is yet to come. Fingerprints and mug shots are repeatedly taken at every new jail or prison, and you are stripped naked and subjected to embarrassing body cavity examinations. Smelly and overcrowded prison cells become routine. The smell of urine and God knows what else is overpowering. One's appetite is easily lost. Broken, lonely, dying men. Under these conditions, broken, lonely, and dying men are found in the medium and high security prisons. Torn from their families, some for 20 and 30 years, or forever, their lives literally come to an end. There are no hopes, no plans, nothing. In the cases of those framed by the Justice Department attorneys, it is especially pathetic that this could happen in the so-called land of liberty and justice. I looked at the scribbling on prison walls made by deranged, dejected, and morbid prisoners. Despite the overcrowding, it is terribly lonely, and all meaning to life appears lost. For many, all hope was gone. Under these conditions, a day or a week seems forever. It gave me an entirely different perspective of people in prison and of those who have corrupted our government. Many of these people in prison were railroaded by corrupt Justice Department prosecutors and prosecuted for offenses far less onerous than committed by those making the charges and sentencing them to prison. Personal cost to me of United and FAA corruption. My entire life passed before me. I thought of those I loved, and those few people who helped me. I thought of those who didn't seem to care. I thought of the attorneys I hired to defend me, who then conspired with my judicial and Justice Department adversaries. I sometimes wondered what part United Airlines 7 officials played in these events, thinking of how General Motors secretly went after Ralph Nader when he wrote the book, Unsafe at Any Speed. My God, this can't be. Many times I thought to myself, my God, how can this be happening to me? This can't be. I couldn't believe that what started out with discovering deadly air safety and criminal violations at United Airlines could have such devastating consequences for me. I thought of people who perished in some of the airline crashes closely connected to the corruption I had first found in the aviation arena, and I wondered who suffered the most. I was still better off and had the chance to fight on while, for air disaster victims, it was all over. How could I be in prison for refusing to commit the crime of cover-up? Where was the media, the so-called protectors against government tyranny. Where was Congress? I sent out hundreds of flyers before leaving for prison, notifying these parties that had a check and balance responsibility. I appealed to the ACLU, the Ralph Nader Group, civil rights groups, and other checks and balances. Every single one refused to help, choosing instead to aid and abet the criminal subversion of our government. It was all so incomprehensible. I had been financially well off. I had a good life. I had a reputation throughout the United States as an air safety activist, and suddenly I found myself in prison and stripped of the assets I worked for the past 20 years to acquire, all because I felt a sense of responsibility. How stupid I was. I kept thinking that this must be a dream and I'll wake up, and it will all be over. But that never happened. Prison life is especially hard on older persons. Medical care that exists in theory is incredibly bad in practice. Heart attacks receive virtually no priority, and a dying person suffering a heart attack can linger for hours before being taken to medical facilities. Often it is too late. Older persons have various medical problems which prison life aggravates, and they become prey to young bullying inmates. Element that find prison satisfying. There is a certain element in society that finds prison life, especially in federal prison, satisfactory. They need not worry about housing or food and have the company of others either like them, or others that they can prey upon. This is the type of individual that will never cease his criminal ways because of the possibility of imprisonment. Suicide. Sometimes I just wanted to die. The strain of all this was getting to me. Flung into prison, things looked bleak. Everything was accumulating. The 6 years of judicial persecution, the loss of my home, my business, my assets, the humiliation, the character assassination, the loss of privacy, and the hopelessness. There is only so much a person can stand. It caused me to think more than once of ending it all. I had been through World War II as a Navy pilot in the Pacific. He acts and omissions complained of by the plaintiff clearly fall within the legitimate legislative sphere protected by the speech or debate clause. Memorandum opinion at 3. The court also held that the action failed to state a claim under the First Amendment upon which relief can be granted under Federal R.Civ. P. 12, because while the plaintiff's right to petition Congress is guaranteed by the First Amendment, a member of Congress is not required to listen or respond to individuals' communications on public issues. Minnesota State Board for Community Colleges v. Knight, 465 U.S. 271, 285. Memorandum opinion at 3. Judge Stanley Sporkin, one of the judges on the Court of Appeals who rendered that decision, was formerly general counsel to the Central Intelligence Agency and directly involved in several of the criminal activities described in later pages. Addressing the media cover-up. I used the same federal statutes and case law to address the cover-up of the corruption by the media. I reported the pattern of corruption to key segments of the media since 1965, including the Wall Street Journal, the Washington Post, the New York Times, and others. They had the ability, and the responsibility, to make these serious charges known to the public. That action was filed in the United States District Court at San Jose, California. Naming these newspapers as defendants, along with the San Francisco Chronicle, which became implicated at a later date. The filing of this lawsuit made a judicial record of the charges. This lawsuit was subsequently assigned to Judge Robert Aguilar. Shortly thereafter, Justice Department prosecutors charged Aguilar with using his office as a racketeering enterprise to obstruct justice on the basis of minor and far-fetched allegations. The specific acts that Aguilar allegedly committed were mild compared to the criminal acts committed by Justice Department personnel. Aguilar had made the mistake of opposing and rendering decisions unfavorable to Justice Department prosecutors in a number of cases. Many people felt that the Justice Department prosecutors were retaliating against Aguilar because of his opposition, and that Justice Department prosecutors wanted to send a warning to other judges who might become uncooperative. My lawsuit that included charges of Justice Department misconduct was then removed from Aguilar and assigned to another judge. The Wall Street Journal and its managing editor, Norman Pearlstein, filed a reply, requesting that the federal complaint be dismissed. They responded, as did members of Congress, that they knew of the charges. They did not dispute the relationship between the misconduct and the consequences. Therefore, they argued, they were immune from liability, based upon the First Amendment to the United States Constitution. They argued that they did not have to print what any person requested them to print. But I wasn't requesting the news media to print what I wanted printed. I expected them to exercise their responsibilities under federal law to report, in whatever fashion they wanted, the charges and evidence of government corruption that I brought to their attention. They had a responsibility under federal law to aid in the prevention of the corruption that was brought to their attention. Even though the lawsuit against them was newsworthy and raised issues of national concern, none of the media printed a single word about it. The responsibility of the media under the First Amendment was articulated in a Supreme Court decision relating to the Pentagon Papers and the publication of their contents in the New York Times. Supreme Court Justice Hugo Black stated, "Only a free and unrestrained press can effectively expose deception in government. And paramount among the responsibilities of a free press is the duty to prevent any part of the government from deceiving the people." The New York Times, the Washington Post and other newspapers should be commended for serving the purpose that the Founding Fathers saw so clearly. In revealing the workings of government, the newspapers did precisely that which the Founders hoped and trusted they would do. The district judge dismissed my complaint without a hearing, despite the fact it stated numerous federal causes of action. I didn't appeal the complaint as I accomplished the primary goal of making a judicial record of the media's complicity and their responses. Culpability of Supreme Court justices. The same laws that made members of Congress and the media liable and culpable under federal statutes applied even more so to the justices of the United States Supreme Court. The justices had covered up the pattern of criminal behavior by federal judges, the Chapter 11 judges, and private trustees such as embezzler Charles Duck, all of whom were officers of the court over whom the justices had supervisory responsibilities. Degree 5. Like a police chief protecting rampant criminal behavior of their police officers committed against citizens, the Supreme Court justices protected the criminal behavior of those over whom they had supervisory responsibilities. Because of their positions of trust, the justices were more guilty of criminal acts for such crimes as misprision of felonies, cover-up, accessory after the fact, conspiracy, obstruction of justice, and others. Since the Supreme Court justices had the responsibility to prevent the commission of these corrupt acts by judges over whom they had supervisory responsibilities, they were liable. I filed a lawsuit against them in the U.S. District Court in the District of Columbia. They were, of course, employees of the U.S. government, acting under color of federal law, so I also named the government of the United States as a defendant. This was probably the first time in history that Supreme Court justices were sued for civil, constitutional, and RICO violations. The arguments raised in the complaint were based on solid facts and law. But it was bizarre that a person was forced to resort to suing the justices of the nation's highest court to report federal crimes and seek relief from judicial violations of federally protected rights. The truthfulness of the serious allegations made in the complaint could be easily verified by the media. Every major news service monitors the filing of complaints in federal courts. But again, the media kept the lid on this unusual filing and the gravity of the charges made in the complaint. Refusing to respond. Federal law provides for service by certified mail. If the defendants don't respond by returning the acknowledgement of service form, personal service is then required, and the defendants must pay for such personal service. Despite their position as Supreme Court justices, they refused to return the acknowledgement of service. I then had the Supreme Court justices personally served. I filed a 28-page amended complaint on March 14, 1989, stating in part, this suit addresses the wrongful acts and omissions by the defendants, relating to an ongoing, air safety/air disaster scandal, and related air tragedies, upon which has been superimposed a government and judicial scandal of cover-up, government and judicial scheme misusing government powers to destroy plaintiffs' freedoms, liberties, property rights, privacy, in an effort to halt his exposure activities. Defendants knew of these wrongdoings, and participated in them. The defendants also had the power to prevent them and refused to do so, aiding and abetting those committing the violations. Defendants knew that plaintiff would suffer great and irreparable harm from massive violations of rights and privileges under the laws and Constitution of the United States and of the state of California, and knew that by such refusal to act, the misconduct causing and permitting the prior loss of life in fraud-related air tragedies would continue, with continuing loss of life. The defendants willingly sacrificed the lives that were lost, protecting their own vested interests, their own cover-up, and the guilty parties involved in what has become the world's worst air disaster scandal, upon which has been superimposed the nation's worst government and judicial scandal. Defendants are liable to plaintiff as a result of their wrongful acts. Self-proclaimed qualified judicial immunity does not deprive a citizen of the United States of the rights and privileges under the laws and Constitution of these United States, including the right to redress of the harm suffered from judicial misconduct. The federal government has incurred a liability from defendants' wrongful acts. It is argued that the many persons who perished, and who suffered in airline tragedies caused and made possible by the misconduct of federal officials, have a cause of action against defendants, and against the federal government. The specifics in subsequent pages of the complaint related to knowledge by the justices of the government corruption, the repeated violations of civil and constitutional rights in the sham California action, the cover-up of the civil and constitutional violations by Ninth Circuit judges, the false imprisonment for exercising constitutionally protected rights, the Chapter 11 racketeering activities, the seizure of my multi-million-dollar assets without any hearing, without cause. 86. And under corrupt conditions, that reflected the corrupt mentality in Ninth Circuit courts. Justice Department attorneys filed a motion to dismiss my complaint, admitting that the justices knew of my allegations and that they failed to act. Their response did not deny the truthfulness of the charges or the resulting harm, and under federal law my charges must then be accepted as true. The primary defense raised in the motion was that the justices of the U.S. Supreme Court enjoy absolute immunity from plaintiffs' claims. The motion to dismiss was riddled with false statements of facts and law, and with trivial matters. The justices argued that the complaint should be dismissed because Rule 8 requires that a complaint be a short and plain statement. After arguing that the complaint was too long, the justices then argued that the allegations were not specific enough. The justices argued that the complaint did not state facts with particularity in his complaint that demonstrate who did what to whom and why. The complaint stated very clearly what the Supreme Court justices had done. A complaint does not have to prove the allegations, but make reference to them so the defendants know the nature of the alleged wrongful acts. The justices argued that the complaint stated unbelievable allegations. The charges were certainly unusual, but not unusual to anyone who knows of the covert activities of the Justice Department, the CIA, and everyday shenanigans occurring within the legal process. Under federal law, the allegations made in a complaint must be recognized as true for the purpose of preventing dismissal of the action. Many of the facts stated in the complaint were supported by taking judicial notice of legal proceedings in the California courts, in federal courts, and were further supported by my voluminous evidence. The justices sought to have the action dismissed by making reference to the California action, referring to it as a matrimonial action. The very fact that I was in the 7th year of a so-called matrimonial action, when 5 divorce judgments showed me as divorced for the past 24 years, raised serious federal causes of action. The California action was riddled with a pattern of civil and constitutional violations that were major federal causes of action, raising federal court jurisdiction. On the pretext of that sham divorce action, my life's assets, used to expose government corruption, were seized. The justices argued that the statute of limitations prevented lawsuits against them, but never stated how the ongoing wrongful acts could have imposed a statute of limitations defense. The justices then argued that the allegations were already adjudicated and dismissed by other federal courts. Not one of the federal actions had ever been heard on the merits, and never once did I have my day in court. Nothing had ever been adjudicated. Further, the justices were never named in any lawsuit, so obviously the matters could not have been adjudicated. The Supreme Court justices argued, the 9 justices of the Supreme Court are entitled to absolute judicial immunity from plaintiffs' claims. A judge will not be deprived of immunity because the action he took was done maliciously, or was in excess of his authority. The criminal statutes, such as misprision of a felony, and civil rights statutes, do not state a judge is immune when he violates either civil and constitutional rights, or violates criminal statutes. The Supreme Court justices knew of the pattern of federal offenses committed against me and against the United States, and refused to take any action to halt the criminal acts committed by federal judges and Justice Department attorneys over whom they had supervisory responsibilities. Under a Bivens claim, the rights and protections of the Civil Rights Act relating to wrongful acts taken under color of state law extend to federal officials. The Constitution of the United States provides for redress of wrongdoings by government actors and says nothing about judges being immune. The justices were contradicting their own decision in Pulliam v. Allen 466 U.S. 522. The Supreme Court held, here is little support in the common law for a rule of judicial immunity that prevents injunctive relief against a judge. There is even less support for a conclusion that Congress intended to limit the injunctive relief available under 1983 in a way that would prevent federal injunctive relief against a state judge. In Pearson v. Ray, 386 U.S. 547, 18 L. ed. 2d 288, 87 SCT 1213, the court found no indication of affirmative congressional intent to insulate judges from the reach of the remedy Congress provided in 1983. Area, because we think we heard the unmistakable clear voice of the people saying on November 8, go there and do something to restore respect for the House. There. 89. Proposal is so starry-eyed in its idealism that it looks as if it could have come out of a political science class on good government. Mr. Powell's fate was decided by an Ivy League Texan and a freshman philosophy class. Bush seems to have forgotten his professed idealism, or else it was a farce. Later pages will show Bush being involved with the CIA in major scandals of enormous consequences to the United States. If these offenses are true, it is obvious why Bush did not respond to my reports of government corruption. These bizarre and convoluted scandals took me into uncharted waters. My imaginative use of the law was proper, but it was bizarre that the conditions existed that made the unorthodox lawsuits necessary. The fact that the media kept the lid on each of them is another indication of how the media censor the news to protect some of the worst scandals in the United States. 90. The following grisly picture is a DC-10 crash near Paris that killed 346 people. The tragedy was made possible by corruption within the FAA and NTSB, and assisted by Judicial and Justice Department cover-ups and retaliation. Looting HUD. Confidence of present and former employees and assets of the Central Intelligence Agency, the Drug Enforcement Administration, the FBI, and other government entities. During literally thousands of hours of deposition-like questioning, they provided me details and documentation on government corruption that expanded on what I had already discovered while a government and private investigator and as a victim. For various reasons, these people either volunteered the information to me, or they were willing to answer my questions relating to activities in which they actually participated or that they knew about. A scheme that defrauded the American public of many billions of dollars had its roots in the Department of Housing and Urban Development. This scheme involved influence peddling and self-dealing by government officials, bribes by corporations, overbilling, political payoffs, fraud, favoritism, kickbacks, and work that was never performed. This area of criminality cost the American taxpayer many billions of dollars in the 1970s and 1980s. The Wall Street Journal called the corruption a system of spoils and favoritism. To carry out the looting of government funds, Former government regulators were hired for their insider connections to obtain contracts that could otherwise not be obtained. That was the HUD scandal. The HUD program was legislated to fund the rehabilitation of housing, especially for the elderly. Hundreds of millions of dollars, if not billions, were looted through the HUD program. In the 1980s, during the Reagan-Bush administrations, the fraud in the HUD program was epidemic and is continuing to some extent today. The American taxpayers must pay billions of dollars to support the criminal activities in the HUD program. A major segment of the HUD fraud was centered in the Denver area and committed by a group of closely related people and companies, who had close ties to the Reagan and Bush administrations. Numerous HUD officials left government to work for the Denver group that defrauded the American people. As my activities became known, started winning the friendship and 92 of billions of dollars, much of which is hidden away in either offshore financial institutions or in secret locations throughout the United States. Philip Wynn was one of the kingpins in the Denver group. He was a former HUD assistant secretary who joined the MDC group in Denver and became a key player in the HUD and savings and loan scandals. Numerous HUD officials left government service and received high-paying jobs with an interrelated group in Denver. This group included, among others, MDC Holdings, Richmond Homes, Silverado Bank Savings and Loan, Aurora Bank, M&L Business Machines, Leonard Millman, Larry Mizell, David Mandarich, Ken Good, Bill Walters, Neil Bush, Silverado's President Michael Wise, James Metz, major stockholder in Silverado, and dozens of subsidiaries and related companies, limited partnerships, trusts. It was learned that Leonard Millman, Larry Mizell, and Philip Wynn, all members of the ADL, were partners in these schemes, as was Philip Abrams, former HUD undersecretaries. Federal regulators involved in the HUD scam included HUD Secretary Samuel Pierce, former Assistant Secretary Thomas Demery, Deborah Gordine and Lance Wilson, former Executive Assistant Stowe Pierce. All except Pierce have been indicted. A number of former HUD officials pleaded guilty to various federal crimes. Dean, an executive assistant to the Reagan administration's housing secretary, was indicted on 13 criminal charges of fraud, perjury, submitting false statements to Congress, and conspiring to steer valuable housing grants to favored developers and consultants. The group made huge financial contributions to various politicians, including the Reagan-Bush team and the Bill Clinton group. One of the key participants in the fraud, Philip Wynn, used part of the money looted from the HUD and savings and loan programs to bribe politicians, especially in the Reagan-Bush presidencies. In return, Wynn was appointed U.S. ambassador to Switzerland and got the protection of the Justice Department through U.S. Attorney Michael Norton, who had secret participation in several of the Denver area real estate projects. Justice Department officials, with their thousands of investigators throughout the United States, knew of the corruption and did very little. What little they did was usually to prosecute either innocent people or those who played a minor role in the massive criminality. Attorneys, developers, banks, members of the Senate and House were the recipients of the money defrauded from HUD. Consultants, for instance, with political connections, reaped huge fees of as much as $400,000 for a few phone calls or visits to HUD officials or phone calls to powerful members of Congress. Rampant political favoritism and influence peddling were part of the HUD scandal, combined with payment of millions of dollars for improvements that were never made. Former HUD personnel acted in collusion with present HUD officials in the fraudulent activities. One of the schemes was buying HUD properties for no money down, placing second loans in them for improvements that were never made, and then defaulting on the loans while receiving the rental income. In 1982, the HUD Inspector General made a report to Congress, reporting that insiders, including former HUD officials, were defrauding HUD of hundreds of millions of dollars, especially in the Section 8, and particularly Sections 224D, 223F, and 202 elderly housing. Congress did not act until 6 years later when media publicity forced Congress to conduct an investigation. In 1988, Arlen Adams was appointed special prosecutor for HUD, and during subsequent investigations confirmed that developers with the aid of present and former HUD officials were receiving Section 8 rehabilitation units, grossly overcharging the government, often billing for work that was never accomplished. Simultaneously, the group bilking the government was contributing heavily to the Reagan-Bush team. In March 1989, HUD hearings were triggered by exposure of huge financial donations by the Wynn Group and Richmond Homes in Denver. Turning prosecution over to the bad guys in November 1989, Congress asked U.S. Attorney General Richard Thornburg to recommend to the Court of Appeals in Washington the appointment of a special prosecutor. He stalled until March 1990, when congressional pressure forced him to act. Thornburg had already blocked the appointment of a special prosecutor into Inslaw, October surprise, and eventually BCCI and BNL. U.S. Attorney Generals Edwin Meese, Richard Thornburg, and William Barr knew about each of the criminal activities described within these pages, and either aided and abetted them directly, or indirectly, by blocking investigation and prosecution. A corollary to that would be the mafia controlling the highest law enforcement agency in this country. Statute of limitations. One of the reasons for stalling prosecution was to allow the statute of limitations to expire, protecting the widespread criminality in the Denver area HUD and savings and loan corruption, and in turn protecting the part played by the Justice Department, the CIA, and many federal and White House officials. In another investigation, a report was issued by the Committee on Government Operations, stating that the Wynn Group did not obtain units from HUD on merit alone, but rather from inside favoritism at HUD. Political payoffs. Key figures in the Denver-based HUD and Savings and Loan Group, Wynn and Mizell, contributed heavily to California Congressman Tom Lantis' congressional race in 1982. Part of the taxpayer liabilities. Congressional staff investigators discovered thousands of apartments were obtained by the group for rehabilitation, costing the American taxpayer over $100,000 each, when the cost for comparable privately financed units would be approximately $20,000. Congressional investigators discovered that U.S. Attorney Michael Norton owned 5 large apartment complexes with the Wynn Group being investigated. It was discovered that former FBI Special Agent in charge, Bob Pence, who retired in 1992, had been receiving bribes, along with U.S. Attorney Michael Norton and the head of the Internal Revenue Service's SID unit. Some of these bribes were laundered through the M&L Business Machine Company in Denver. 94. Usual cover-ups. When the scandal exposed California Congressman Tony Coelho and Texas Congressman Jim Wright, they took early retirement to defuse the pending investigations. The media and the public did not address the huge losses inflicted upon the American taxpayer. Instead, after key congressmen such as Wright of Texas and Coelho of California were forced to retire so as to discontinue further investigation, their constituents showed little concern about the criminality and huge financial losses to be paid by the American taxpayer. Their concern was the loss of a powerful congressman who produced pork barrel benefits for their constituents. Little was said of the huge multi-billion-dollar debt inflicted upon the public. If it had been left to the constituents of Congressman Jim Wright or Coelho, the enormous financial losses would be ignored as long as the voters received benefits from their corrupt congressman. California Representative Tom Lantis led a congressional investigation into the HUD matter, calling it influence peddling of the tawdriest kind. The scandal at HUD is one of the most complex national scandals that we have seen in decades. There is a degree of mismanagement, fraud, abuse, waste, influence peddling that we have just barely begun to touch. Representative Charles Schumer, a subcommittee member, said, like picking up a large stone only to discover that bugs and slime have grown in the darkness. This investigation has exposed the corruption which flourished unchecked under Secretary Pierce's HUD. In addition to causing Wright and Coelho to resign, Congress tried to stonewall an investigation into HUD by blocking confirmation of HUD appointees expressing an intent to expose the HUD scandal. After Jack Kemp took over HUD and stated his intent to prosecute those involved, Congress blocked confirmation of Kemp's management team. When the Department of Justice started an investigation into HUD, members of Congress then investigated the Justice Department, threatening to cut back its funding. The Justice Department investigation stopped. Referring to Congressman Wright's blocking of an investigation into HUD corruption, a Wall Street Journal editorial stated, "What is most disturbing, is the obvious pattern of so many violations extending over so many years. The brazenness is amazing." Obviously, Mr. Wright felt assured there was no prospect that he ever would be called to account for his actions. When Congress is so powerful it can intimidate the Justice Department from another abscom case, who should be surprised at corruption? Shades of the savings and loan debacle investigations showed that House Speaker Jim Wright obstructed investigation of the HUD corruption while accepting $145,000 in unreported gifts. The House committee investigating Wright's dealings with the HUD scandal quickly dropped the investigation after some House members reminded them that an investigation would implicate many other members of Congress. After pressuring Jim Wright to resign on the relatively minor charge of ethics violations, the media attention to the HUD scandal ended. The guilty parties went free, the missing billions. 95 of dollars of looted money was never found, and the stage was set for more looting of the American taxpayer. Justice Department stonewalling in typical fashion. After congressional members asked the politically appointed U.S. Attorney General to investigate their allegations, Thornburg accused them of introducing partisan politics into the HUD investigations. Representative Charles Schumer of New York replied at a news conference, "There's ample evidence of wrongdoing at HUD, but there's stonewalling at the top. And the only way to get to the bottom of the mess at HUD is through the appointment of an independent counsel. Instead of attacking us, the Attorney General should be focusing on making sure that high-ranking officials at HUD don't get away with breaking the law." Representative Schumer characterized the Attorney General's objections as a political response. A more correct characterization would probably be felony cover-up, obstruction of justice, misprision of felonies. Another time-honored way that Congress stonewalls sensitive investigations is to withhold funding needed to conduct the investigation. Congress threatens to withhold funding from the Justice Department to dissuade members of Congress from investigating sensitive matters. It was done by Justice Department officials to stonewall investigation of Chapter 11 judicial corruption. It was also done to halt further FBI investigations of congressional wrongdoings in abscom. As the FBI's continuing investigations into the conduct of congressmen became too threatening, members of Congress responded by dragging Justice Department officials in for grueling oversight hearings. It became clear to Justice Department officials that the budget for the Justice Department was in danger if the probes into congressional wrongdoings did not cease. Congress finally conducted an investigation. Eventually, Congress was forced to conduct an investigation. A House committee stated in a report that the Department of Housing and Urban Development was enveloped by influence peddling, favoritism, abuse, greed, fraud, embezzlement and theft. Samuel Pearce, Secretary of HUD from 1981 to 1988, refused to cooperate in the HUD investigation, repeatedly invoking his Fifth Amendment privilege against self-incrimination. The House committee report stated that Pearce gave misleading testimony and that he probably lied and committed perjury during his testimony on May 25, 1989. Appointing an independent prosecutor. After Congress covered up the HUD scandal, an independent prosecutor was appointed, who then had to set up an office and hire attorneys to investigate, many of whom had no investigative experience. The independent prosecutor found that HUD officials unlawfully allocated federal funds to developers and consultants with whom they had private financial relations, receiving bribes, and other favors. Silvio J. DeBartolomeis, a former 96 Deputy Assistant Secretary of HUD, pled guilty to 3 criminal charges including conspiring to mislead Congress and HUD's own regional offices concerning a HUD rent subsidy program, and to receiving an illegal salary supplement consisting of a $20,000 loan arranged by developer Philip Wynn. DeBartolomeis was charged with defrauding HUD's Section 8 rehabilitation program, which enriched the developers based in the Denver area. Indicting the small fry media attention forced Justice Department prosecutors to file charges in the HUD corruption, years after the criminal acts were known. But the indictments were selective. The power brokers with whom U.S. Attorney Michael Norton was in partnership escaped prosecution or were charged with minor offenses, and evidence was conveniently lost. Federal judges dismissed some charges before the jury could begin deliberation. The indictments omitted charging the Denver area developers who donated large sums of money to political figures, who had close ties with the CIA, and who contributed large financial contributions or bribes to White House officials and other politicians. Among the HUD officials who were directly involved in the looting of HUD was HUD Deputy Assistant Secretary, Dubois Gilliam, who pleaded guilty to receiving over $100,000 in payoffs and gifts to approve HUD grants for various developers. During the investigation, it was disclosed that HUD Secretary Samuel Pierce received over 700 formal requests from congressmen and senators requesting support for specific projects. These same members of Congress were receiving political contributions from individuals for whom they sought HUD favoritism. Eventually, Wynn pled guilty to preparing a false receipt for another HUD official that was submitted to HUD investigators. But these charges were chicken feed compared to what Wynn and his buddies actually perpetrated. My inside sources stated that over $167 million paid by HUD to the Wynn Group for rehabilitating HUD housing was never spent for that purpose, and sequestered in secret locations. A 9-count felony indictment was made against a former assistant to ex-Senator Edward Brooke trademark for allegedly lying to the FBI and a federal grand jury, who were looking into Brooke's role in the HUD influence peddling scandal. Charges against Deborah Gordine included improperly steering funds to clients of former Attorney General John Mitchell after Mitchell was released from his Watergate prison term. A federal jury in Washington, D.C. on October 26, 1993, convicted former HUD aide Deborah Dean, a central figure in the HUD scandal, of being instrumental in funneling millions of dollars to housing projects that enriched politically connected Republicans. Group of HUD whistleblowers. I became a confidant to several former CIA operatives, private investigators, and insiders, who were heavily involved in the Denver area operations, and 98 Oakland Tribune, October 15, 1992. 99 Brooke was a lawyer and consultant for Bizia Aceman seeking help with HUD on federally subsidized housing projects in the 1980s. Looting HUD. 97. Through them discovered some of the inner workings of the corrupt operations. One of the investigators and insiders, Stuart Webb, was a former son-in-law of Leonard Millman. During 4 years of marriage from 1981 to 1985, Webb became privy to many of the procedures used to loot billions of dollars from the HUD and savings and loan programs in the Denver area. Following the divorce, Webb expanded on what he had learned as an insider. Through aggressive investigations, Webb discovered the paper trail of the looted money, including thousands of documents he obtained in recorders' offices throughout the United States. Webb was able to document major schemes implicating the Denver Group in various financial scandals. Webb discovered the trail to offshore bank accounts and trusts, and their secret locations. Describing some of the key players in the Denver area looting of HUD and the savings and loans, Webb stated that among the top players were nationally known and politically connected powerhouses such as Carl Lindner, Larry Mizell, Philip Wynn, Albert Rose, George Ryder, and many others. He described how many HUD officials left Washington and joined the Denver-based group, and how their prior Washington connections made the looting possible. Additional data was given to me by other insiders, including high-ranking covert CIA personnel. Gunther Russbacher, for instance, operated numerous CIA proprietaries having secret dealings with the Denver Group, including money laundering, looting of the HUD and savings and loan programs, and other activities. Webb initially contacted me on September 17, 1991, advising me of corrupt dealings in the HUD and savings and loan program by his former father-in-law and many of the people and groups that worked with him, including MDC Holdings and dozens of limited partnerships, trusts, and subsidiaries. Webb also told me about the large numbers of federal officials who were in the schemes. Webb appeared as guest on numerous radio shows, some with investigative reporter Margie Sloan, naming the corporations, the complex paper trail, and the individuals involved. He discovered that the U.S. Attorney in Denver, Michael Norton, was deeply implicated with the group, sharing secret ownership of valuable properties. Webb discovered that the corrupt Denver group gave large financial contributions to Norton when Norton ran for Congress in the early 1980s. This discovery helped explain one of the reasons why Justice Department officials never prosecuted the key figures in the HUD and savings and loan debacle. Webb reported that he found that the Wynn and MDC Group owned over 10,000 units in Colorado, Utah, Nevada, Oklahoma, South Dakota, North Dakota, and another 10,000 units in the area controlled by the Texas Regional Office of HUD. Webb and IRS agent Walker in the Denver office frequently exchanged information that they found in the HUD criminality. In June 1991, Walker told Webb that he could no longer talk to him about the matter, and when Webb asked, "Is Bush covering this thing up?" Walker replied, "Yes," and then hung up. Webb stated that his investigation showed that U.S. Attorney Michael Norton was connected to Mizell, a major player in the Denver area HUD and savings 98 and loan corruption, and that Mizell was finance chairman for Norton's unsuccessful congressional campaign. Without success, Webb tried to have a Colorado district attorney in Denver and the U.S. attorney in Colorado receive his evidence, but they refused. Protect their flanks. Despite the large sums donated to Michael Norton's campaign for a Senate seat, he lost. But the Reagan-Bush team appointed Norton U.S. attorney in Denver, thereby protecting White House and other federal officials from investigation and prosecution in the HUD corruption. Justice Department retaliation. Webb's appearance on many radio talk shows were apparently causing concern in the Justice Department and in the Denver area. Working with Webb's former father-in-law, U.S. Attorney Michael Norton charged Webb with making harassing and threatening phone calls to his former father-in-law, Leonard Millman. Although the language could have been cleaner, the threats were nothing more than a determination to expose the HUD and savings and loan corruption in which his former father-in-law was involved, which threatened to expose the U.S. Attorney's involvement in the criminal activities. After Webb heard of the warrant for his arrest, he went underground for the next year, surfacing only to appear as a guest on radio shows in Denver and throughout the United States. For some of the shows he called me collect, and I would then relay his call to the radio station. I had no knowledge of Webb's whereabouts, and didn't want to know. Arresting an irritating whistleblower in September 1992, shortly after Webb had talked to Ross Perot by phone and revealed his location in Houston, the FBI arrested Webb. Justice Department prosecutors demanded that Webb be denied release pending trial, an almost unheard of demand in a case involving harassing phone calls. Justice Department officials were trying to silence Webb and keep him off talk shows, especially before the 1992 presidential elections. I advised Webb that he had the opportunity to get additional information on the HUD and savings and loan scandal by talking to other inmates at the federal prison who were former CIA operatives and insiders in the HUD and savings and loan scandal. It was and is standard practice of Justice Department officials to cause the imprisonment of these people in order to silence or discredit them. By entering prison, a writer or investigator has an inside track to information that he would not otherwise have. Sure enough, Webb did discover numerous inmates who gave him additional information, helping to fill in the gaps. While detained in the Federal Correctional Institution at Littleton, near Denver, Webb made contact with a group of former CIA contract agents who were deeply involved with the Denver area group. Another source of information: one of these contacts was a former CIA operative named Trenton Parker, who played key roles in numerous covert CIA operations from 1964 until he fell from grace in the late 1980s. Webb and Trenton shared a prison cell in December 1992, until Parker was released pending trial, which was to start in April 1993. Parker had seen some of the material I had sent to Webb and Looting HUD 99 contacted me after being released. This relationship produced extraordinarily secret and sensitive material and added to the mosaic establishing the complex intrigue and corruption described in these pages. The confidential status report establishing Trenton's highly secret status in the intelligence community prevented Justice Department and CIA personnel from denying his high rank-on status. Additionally, Parker gave me information, including briefs that he filed in the U.S. District Court in Denver, that depicted criminal activities by the CIA. Another insider who contacted me in February 1993 was one of the fall guys in the HUD scandal, Don Austin. He gave me insider information on the role played by federal officials and the Denver group in looting the HUD program. Austin headed groups of investors buying HUD properties and operated under the name of NITASA. Austin described to me how Justice Department officials protected present and former HUD officials who were self-dealing in violation of federal law and were involved in massive fraud, especially in the Denver area. He described how people associated with the savings and loan industry, who had done no wrong, were being prosecuted to make it appear to the public that the Justice Department was punishing those responsible for the huge HUD fraud. Austin further states how his assets were seized by Justice Department prosecutors under the forfeiture laws, depriving him of money to hire legal counsel to defend against the charges brought by the Justice Department. He described how his court-appointed attorney was incompetent in the complex area involved in the charges. In desperation, Austin discharged the attorney and appeared in pro se, representing himself, and was then overwhelmed by the top guns of the Justice Department. Austin was a successful real estate investor who worked with the HUD administration to rehabilitate and sell hundreds of HUD properties. Justice Department officials, under U.S. Attorney Michael Norton, charged Austin with federal offenses and obtained a 21-year prison sentence against him. While Norton was covering up for the multi-billion-dollar looting of the HUD and savings and loan people with whom he had been financially involved in Denver, he charged Austin with falsifying HUD applications. The alleged falsification of HUD purchase and loan agreements consisted of minor technicalities, such as showing in the cash-down block the value of notes and deeds of trust. It was standard practice to do this, and then, on an accompanying HUD form and title company closing documents, the actual form of the down payment was shown. On the form there was no other way to show the down payment other than as cash. Actually, cash is almost never given, as the standard practice is to give checks, money orders, other properties, or notes and deeds of trust as down payment. HUD officials and companies acting on their behalf approved the purchase application submitted by Austin, knew the form of down payment being made, and approved the form of payment on behalf of HUD. But when it came time to prosecute HUD-related corruption, U.S. Attorney Michael Norton protected the kingpins of the racketeering enterprise. He selected scapegoats, and Austin 100 was one of them. Justice Department attorneys wanted to indict Austin because former and present HUD officials, who had purchased many of the properties through Austin, had defaulted on almost all of the units after bleeding them dry. These HUD officials were involved with others implicated in huge HUD and savings and loan fraud. To indict those guilty of this fraud risked blowing the lid on the multi-billion-dollar racket that implicated people like Neil Bush, George Bush, powerful Denver area and Washington politicians and powerful money figures who routinely bribed the politicians. Austin learned there was a grant from HUD awarding Justice Department attorneys bonuses for the number of criminal counts filed against defendants, encouraging false charges to be filed. Attorney sabotage. Austin related to me the practice of attorneys demanding huge sums of money up front to defend him. After receiving the money, they sabotaged his case. This scenario had been told to me countless times, and I experienced it myself many times. It appears to be standard practice by the attorneys, preying upon people who are unaware of these corrupt practices. Every CIA whistleblower whom I had contacted, including Gunther Russbacher, Ron Rewald, Michael Riccanaci-Utto, the HUD whistleblower Stuart Webb, and others, encountered the same scenario. Every one of them had strong words describing the sordid conduct of the attorneys that they encountered. Austin's sophisticated lady friend, Pat Klass, described the ugly nature of the attorneys she encountered while trying to help Austin. She told of the many instances she paid $10,000, $20,000, and $30,000 to attorneys up front, who then never performed. In telephone conversations and writings, Austin described the mechanics of what he had uncovered in the HUD fraud. Austin operated a company called Nitsua, dealing in purchasing and reselling HUD properties. He also told how he and others purchased and paid for HUD insurance, which was kept by the HUD representatives and not applied to their accounts. He described the self-dealing by HUD personnel, including Grady Maples, regional director for HUD, and by Gail Calhoun, head of the Denver HUD office. Maples had a major ownership interest in Falcon Development, which in turn acquired the properties that were subsequently looted. Austin described how drug forfeiture and other forfeiture money was being distributed to federal judges and Justice Department prosecutors, something like the Chapter 11 operations. Even the U.S. Marshals were implicated as they were involved in the seizure of assets. Austin related one of many transactions in which the Maples Group purchased an apartment complex and then placed secondary financing on it through Greenwood Industrial Bank, owned by a close associate, Bob Hard, one of Maples' partners. Rents were collected but no payments were made on the HUD and Greenwood loans. Also indicted with Austin was James Grant George, who reportedly had been wrongfully convicted but who had offered to pay U.S. Attorney Michael Norton money under the table to get his conviction or his sentence vacated. This plan, looting HUD 101, went haywire after U.S. Attorney General Janet Reno fired Norton in April 1993, protecting the operation and the hierarchy following the pattern in other scandals involving federal officials. Justice Department prosecutors fabricated charges against innocent people such as Austin. In this way, Justice Department attorneys shifted the blame from those involved in the corruption, including federal officials, former federal officials, and powerful financial figures who orchestrated devastating financial harms upon the American people. Several examples follow, as the information was given to me by people who came to me for help. During Austin's trial, the Justice Department prosecutor withheld information about the HUD self-dealing, the failure of HUD officers to apply the mortgage insurance money paid by Austin and others, and many other wrongful acts. If the jury had heard this information, it would have helped prove Austin's innocence. Another person set up by Justice Department prosecutors was Paul Jenkins from Utah. Jenkins was one of the owners of 6 savings and loans in Texas who experienced problems with loans that went bad when the Texas economy slumped in the late 1980s. He arranged with U.S. Homes to purchase all the notes held by the savings and loans that had been taken over by the government at full face value, which would have kept anyone from losing money. But government personnel refused to allow this for several reasons. 1. It would diminish the justification for seizing some of the savings and loans and eliminate the criminal charges filed against some of the lower echelon people being prosecuted in the savings and loan debacle. During the first trial, Jenkins was cleared of the charges against him. Justice Department prosecutors then filed new charges. Jenkins said that he paid over $500,000 up front to a Texas attorney, Barefoot Sanders, only to have this attorney abandon him the next day, keeping the money for himself. Jenkins then paid money, up front, to another attorney from Texas, Racehorse Haynes, and again Jenkins was abandoned. During the second trial, Haynes abandoned his client, causing Jenkins, without funds, to rely upon a federal defender. Federal defenders have a history of protecting their cohorts in the Justice Department and on the federal bench. An irony was that most of the victims of Justice Department and government corruption were nice, honest, sincere people. The biggest crooks were those in control of key government offices, including Justice Department attorneys, federal judges, CIA officials, and members of Congress, especially those who are attorneys. There were other sources, including CIA operatives, who described to me their role in the HUD, savings and loan, HUD, and other scandals, who acted under orders of their CIA handlers. Their roles are described elsewhere in these pages. Political contributions. The illegal political contributions provided to Norton by the Denver Group, when he ran for Congress in 1982, were reportedly funded by extorting money from suppliers and their employees. These funds were reimbursed through 102. Fraudulent billings later paid by HUD in the rehabilitation program. When these political contributions were publicized and prosecution commenced, Norton had to recuse himself as federal prosecutor. He covered his rear by appointing a special prosecutor, U.S. Attorney Marvin Collins from Texas, for damage control. Federal judges cooperated in keeping the lid on the scandals and protecting key players from prosecution. Those who paid the heaviest for political contributions were the contractors and suppliers to the Denver Group, including MDC Holdings, Richmond Homes, and other subsidiaries, who were forced to make illegal political contributions to Michael Norton. The higher UPS, who demanded the contributions, were either not charged or, after being charged, the charges were either dropped or favorable plea bargains were made. The kingpins responsible for the illegal contributions, Leonard Millman, Larry Mizell, and others, went unpunished. Although Norton lost the election, the Denver Group, heavy financial contributors to the Reagan-Bush team, got Norton appointed U.S. Attorney in Denver. This ensured protection against criminal prosecution for the massive fraud in which they were all involved. The group involved in the HUD scandal was also involved in the fraud associated with the new Denver airport and much more. These were only a very few of the many scandals, protected by federal office holders, for which the American public will be saddled with debt for decades. CIA involvement. As is described later, the CIA, using code names for various operations, had numerous financial companies that played key roles in looting of the HUD program and savings and loan institutions. Different CIA divisions or directorates ran parallel operations, using code names for the HUD and savings and loan operations. These code names included Operation Cyclops and Operation Gold Bug. Denver Airport. My CIA contacts operating covert CIA corporations in the United States described the massive fraud involving the new Denver International Airport. They elaborated upon the tactics involved in the promotion and development of the airport, including influence peddling, payoffs, phony billings, phony land swaps, sham loans, and other forms of fraud. Denver Mayor Federico Pena reportedly received a large bribe for promoting the airport. He was reported by my CIA contacts as conspiring with the key players in the Denver area HUD and savings and loan corruption, including James Metz, Michael Wise, Charles Keating, Bill Walters and Ken Good, Phil Wynn, Larry Mizell, Norman Brownstein. Brownstein allegedly helped hide hundreds of millions of dollars of money looted from various fraudulent schemes of this group, some of the money hidden in trusts filed in remote locations, as described in later pages. Brownstein was portrayed by Senator Ted Kennedy as the Senate's 101st member. Looting HUD 103. Brownstein sat on the board of MDC Holdings and represented companies run by some of the biggest crooks in the HUD and savings and loan areas. Payment of bribe money. Former CIA operative Trenton Parker told me what other CIA sources had also reported, that former Denver Mayor Federico Pena was paid $1.5 million by Leonard Millman to get voter approval for the new Denver airport. Parker stated that Mayor Pena's office was bugged by the CIA Pegasus Group, and that the audio tape shows Millman walking into Pena's office, stating, "Okay, here's the $1.5 million goddamn dollars, now we want the airport to go through. Now, get off your butts and get this thing going." As in every other known pattern of criminality involving federal officials, hardcore criminality related to the HUD scandals was ignored. For instance, Stuart Webb learned that thousands of remodeled units and homes owned by the government were secretly removed from government records by the group consisting of former HUD officials and then sold, making it very profitable for those involved. While HUD's internal checks and balances, and Justice Department prosecutors, refused to prosecute HUD corruption perpetrated by HUD officials, they did prosecute members of the public. For instance, in 1994, these same checks and balances sought to imprison people who objected to the placement of undesirable housing in their midst. In Berkeley, California, for instance, HUD used federal resources to investigate, intimidate, and threaten with federal prison those people who objected to the placement of housing for drug abusers and the mentally disturbed in their neighborhood. HUD attorneys investigated for 7 months and threatened to charge people with violating federal housing discrimination laws. Nearby neighbors, Richard Graham, Alexandra White, and Joseph Derringer, were threatened with $50,000 in fines and a prison sentence for objecting to the HUD housing plans. HUD charged that the neighbors engaged in coercion, intimidation, and interference against the potential tenants of the planned housing. Chapter 8. Industry through the Garn-St. Act of 1982, which was signed into law by President Ronald Reagan on October 15, 1982. As he signed the far-reaching bill, Reagan announced that it was the most important legislation for financial institutions in 50 years. He added, "I think we've hit the jackpot." If he meant the jackpot reference for the mafia, the CIA, and a host of crooks, he was absolutely right. Even the famous bank robber, Willie Sutton, never envisioned such riches. I had considerable real estate at that time, including motels, hotels, truck stops, golf courses, apartments, and land, and knew the financial frauds that would follow deregulation. It didn't take any great expertise to predict the consequences, and surely members of Congress and the industry recognized that fact even sooner than developers, mafia figures, and crooks started buying small savings and loans in out-of-the-way places. In that manner they gained access to the Treasury of the United States, permitting them to engage in self-dealings, sham transactions, and massive fraud against the American taxpayer. Deregulation and the concurrent fraud were financially fabulous for many people, fueling massive growth in the real estate industry during the 1980s. The price tab was picked up by the public in the 1990s, and they would pay for decades, well into the next century. The losses, much of which were outright theft, exceeded the cost of World War II. Never in the history of the United States had such a massive financial debacle occurred, making the American taxpayer the victim of the biggest scam in the nation's history. The crooks who held the controlling interests in savings and loan associations paid themselves extravagant salaries, with virtually unlimited expense accounts that bled their companies dry. They made loans to themselves or corporations they owned or controlled and had a fabulous lifestyle that couldn't possibly be supported by the income of the savings and loans they acquired. Congress and the Reagan administration deregulated the savings and loan. 105. Many sordid details of the savings and loan debacle have never been revealed by the mass media. Crooks, with the help of politicians, Justice Department officials and CIA renegades, stripped the American people of hundreds of billions of dollars. The American economy has been badly crippled by this theft, adversely affecting the same American people whose failure to speak out helped bring about their own financial problems. Warning flags presaging deregulation. It was no secret to members of Congress what would happen if the savings and loans were deregulated. The consequences of relaxing safeguards were seen elsewhere. For instance, the danger of brokered deposits was evident when serious problems arose in California during the 1960s when these deposits were allowed to reach a high percentage of a financial institution's deposits, threatening its solvency. Sudden withdrawal of such large sums of money deposited as a block could easily make the institution insolvent. To correct this problem, regulators ordered a cap of 5% of an institution's total brokered deposits. This restriction remained from 1963 until the limit on brokered deposits was removed in 1982 by the Depository Institutions Deregulation Committee, chaired by Treasury Secretary Donald Reagan. This change was enormously profitable to financial institutions dealing in such deposits, including Reagan's prior employer before he joined the Reagan administration. Brokered deposits consisted of blocks of $100,000 deposits from individual depositors, which was the limit for federal insurance guarantees. By dealing in brokered deposits, the bank was able to build its capital and engage in huge fraudulent schemes. The danger arose from the high interest rates and fees needed to acquire them, and these costs were greater than what could be earned by lending the money to safe real estate investments. Just prior to voting for deregulating the savings and loans, the nation's worst bank failure occurred, which was caused by eliminating safeguards and permitting brokered deposits. The Oklahoma City financial institution, Penn Square Bank, failed in 1982 and brought giant Continental Illinois National Bank and Trust Company in Chicago to the brink of failure, as well as other lending institutions that had placed large sums of money into Penn Square Bank. The American taxpayers had to bail out Continental Illinois to the tune of $4.5 billion. This amount was in addition to the payments made to the insured depositors at Penn Square. It was the largest federal bailout in the nation's history, and showed the dangers of deregulation and brokered deposits and what could be expected with the subsequent signing of the Deregulation Act. Penn Square offered the deposit brokers higher interest rates and substantial brokerage commissions for funds placed with the financial institution, causing brokers to place millions of dollars into the bank on any given day. But the rates and the fees that Penn Square had to pay for these deposits required making loans on high-risk investments and in a Ponzi scheme. Further, the continual losses due to high costs of the funds and the inadequacy of returns on these funds. 100 over strong protests from people who knew what would happen, the federal deposit guarantee was raised from the previous $5,000. 106. Required a continuing infusion of money to continue the scheme. Common sense and the history of failures made obvious what would happen when Congress voted for deregulation. But many of those who voted for deregulating the savings and loans were recipients of large financial contributions. With brokered deposits there was no money available to make normal home loans, the spread was too much between the rate that homeowners could pay and the rate the savings and loans had to pay for brokered deposits. The primary problem of deregulation came when the lending institution engaged in self-dealing, land flips, sham loans, and many other devices used to carry out the massive fraud. All this was obvious to anyone close to the industry, as were members of Congress. But the immediate financial benefits to those voting for deregulation, the law firms and public relations firms, easily took precedence over the harm inflicted upon the United States and the American people, and this attitude prevails throughout these pages. Every common-sense warning sign ignored some of the practices that could be expected to occur, and which did occur after deregulation, included, 1. Inflating the value of properties through land flips, whereby a parcel of land was resold numerous times, sometimes on the same day. Each time the new buyer paid a higher price. In that way, a borrower could indicate the land was worth far more than it actually was and obtain a larger loan than the property was worth. Oftentimes no payments would be made on the loan after receiving the loan proceeds, and the property allowed to go into foreclosure. The borrower then walked away with the difference between the purchase price of the property and the loan proceeds. In many cases this constituted millions of dollars. 2. Making a loan to a controlled or a dummy corporation far beyond the value of the property, then let the loan go into default and the property taken back. 3. Making a loan that was not intended to be repaid to a controlled corporation. Then when the loan and interest payments are due, making a larger loan on the property to pay off the prior loan and accumulated interest, thus showing a sham profit. The loan would be shown as a performing loan on the books rather than a loan in default. 4. Swapping bad loans between cooperating financial institutions and showing the loans as performing loans on the books. 5. Spending lavishly on aircraft, vacation homes, trips, and other expensive lifestyles and charging it to business expenses. An honestly operated business would not incur such charges when the business was operating in the red. 6. Paying inordinately high salaries to themselves and providing themselves with bonuses when bad non-performing loans are renewed or traded for other bad loans with cooperating institutions. 7. Making sham loans on greatly overvalued real estate owned or controlled by the lending institution, with borrowers never intending to repay the loans. 8. Hiring former federal regulators at exorbitant salaries for their influence peddling abilities and knowledge, to assist in circumventing regulatory protections. 107. 9. Paying many millions of dollars in bribes to members of Congress to block actions by federal regulators, and blocking corrective legislation. Typical land flip. A typical example of the fraud associated with land flips was a tract of property northeast of Denver where the new Denver airport was supposed to be located. The original parcel of land, called the Little Buckaroo Ranch, was purchased for $1 million and then flipped over several times in dummy land sales, fraudulently showing its value as $5 million. The Denver group involved in this scam obtained a $5 million non-recourse loan on the property and then defaulted when it was discovered the airport would be built elsewhere. They made a $4 million profit on the deal. People involved in that one example were heavily involved in the HUD and savings and loan fraud in the Denver area and had close ties to the Central Intelligence Agency. Financing the looting to generate the hundreds of millions of dollars to fund these scams, the parties operating savings and loans needed a steady supply of money, far more than could be expected from local depositors. The answer was in brokered deposits. Money brokers pooled $100,000 deposits from different sources and deposited the funds into whatever savings and loan offered the highest interest and paid the highest brokerage fee. The deposited funds would either be used for high-risk loans or, as was often the case, to fund sham transactions in which there was no intention to repay the loans. The loss of several $100 billion that will be paid by the American taxpayer required more than simply poor judgment. There was no risk to the con artists, as the American taxpayers were insuring the money. Brokers would often offer deposits to a savings and loan on condition that the institution make one or more loans on a given piece of real estate. The loan amount would often be made in excess of the value of the property used for security, or made without any security. The institution making the loan may or may not realize that the loan would never be repaid. There were many variations of these scams. All could be foreseen, and all had occurred in isolated cases the decade before deregulation. The expected commenced immediately. The expected started happening immediately. Among the first was Vernon Savings and Loan in Texas, which failed in 1984, involving brokered deposits, land flips, inflated mortgages, and huge personal expenses billed to the financial institutions. Loans that would never have been made with the former safeguards were made to insiders and friends who scratched each other's backs as they made themselves rich. Ed Gray was sworn in on May 1, 1983, to head the Federal Home Loan Bank Board, and promptly discovered the seriousness of the massive fraud. He tried correcting the problem by returning the restriction on brokered deposits to the previous 5%, thereby halting the primary problem. But those who used the brokered deposits descended upon Congress, handing out money insured by the American taxpayer and succeeding in blocking this change. Treasury Secretary Reagan, whose former employer profited by the brokered deposits, and many others sought to discredit Gray as some sort of wacko. 108. Finally, the discrediting campaign succeeded, and Gray was replaced by Danny Wall, an aide to Senator Jake Garn, chairman of the Senate Banking Committee. Wall then obstructed corrective action to keep the massive fraud scheme in operation, while simultaneously keeping the money flowing to members of Congress that kept federal investigators at bay. Wall protected Lincoln Savings and Loan from the San Francisco Regulatory Board, which had planned to shut down the corruption-plagued institution, removing Lincoln from the jurisdiction of the regulators who had uncovered the corruption. In an unprecedented action, Wall transferred regulatory jurisdiction of Lincoln to Washington, and Lincoln continued its corrupt practices of looting assets of U.S. taxpayers and individual investors. One act was to offer bonds of bankrupted American Continental Corporation, Lincoln's parent corporation, to its depositors, falsely claiming they were government-protected. Thousands of elderly people with no other source of income lost their life savings through the scheme, made possible by Washington and California politicians. These tactics also increased the immediate cost to the American taxpayer to approximately $2 billion plus the triple or so amount that will be paid in interest before the debt is paid off, if it ever is. Virtually everyone who played the game, who looked the other way, or who blocked corrective action, profited. Members of Congress, including the Keating Five, received bribes for blocking corrective action by federal inspectors. The media received advertising dollars from large numbers of real estate developments built under a cloud of fraud. The crooks in the savings and loans and others acting with them profited. Everyone knew the American taxpayer would foot the bills. Another group of losers, given very little attention, were the stockholders. Many of them invested their life savings in the savings and loans, and these savings were usually lost. Simultaneously, Degree. Lincoln's president, Charles Keating, paid $839,000 of taxpayers' money to various election committees to re-elect Cranston, Degree, and hundreds of thousands more to the senators known as the Keating Five. Senators Alan Cranston, senior member on the House Banking Committee, Dennis DeConcini, John McCain, John Glenn, and Donald Regal. I had notified each of them of the criminal activities I had uncovered, and demanded they receive testimony and evidence that my CIA and DIA whistleblowers and I were ready to present. They all refused. Members of Congress sought to continue the cover-up to the end. In June 1989, Congress quietly rejected a request for $36.8 million to hire investigators to accelerate the investigation and prosecution of corrupt savings and loan officials. In 1986, the Keating Five senators applied pressure upon Washington regulators to prevent government investigators from taking actions against Keating's Lincoln Savings and Loan. This congressional obstruction of the regulatory function of the U.S. government increased the costs to taxpayers far in excess of $200 billion for the entire industry. The taxpayers also must pay for the bribes paid to politicians on the California and federal levels and to the former government officials who became high-salaried employees of Lincoln. California Senator Alan Cranston obstructed the actions of the regulators who sought to prevent others from losing money, including elderly and retired people who invested in the uninsured bonds issued by Keating's enterprises. This obstructive action interrupted the regulatory process, delaying the government takeover of Lincoln Savings and Loan, as it continued selling worthless, uninsured securities to the public. Even Alan Greenspan, then a private consultant and later chairman of the Federal Reserve Board, sent a letter seeking to block corrective actions, falsely claiming Lincoln was in good financial shape and had good lending practices. This was preposterous. Lincoln's primary assets were grossly inflated desert land. Lincoln had a practice of lending money to closely related investors or their own real estate enterprises, often without any credit check and without collateral. Eventually the losses were too great to ignore. A new agency was formed to clean up the mess, and the same parties who blocked prior corrective action wanted Wall installed as its head, fighting to retain the head of the regulatory agency who helped continue the escalating corruption. Senator Cranston and Representative Donald Regal fought hard to have Danny Wall confirmed as head of the new agency without a confirmation hearing, avoiding Senate questioning of the debacle that unfolded while he held responsibility to prevent such fraud. Congress's response to the nation's greatest financial debacle consisted of carefully avoiding charging any of their members, including the Keating Five, with any crimes. They wrung their hands trying to decide whether any of the senators who received huge amounts of money from the crooks, and who blocked corrective attempts by federal regulators, violated ethics. Using this standard on many people sent to federal prison for far less federal offenses would greatly reduce the prison population. "You rat on me and IPLL rat on you." Cranston had earlier warned the entire United States Senate that, if the Ethics Committee moved to censure him for his role in the savings and loan scandal, he would blow the whistle on the role played by other senators in the savings and loan matter. As the investigating committee considered whether to censor Cranston for ethics violations, Senator Jeff Bingaman disqualified himself, requiring appointment of another senator, which in turn required weeks for the replacement to review the evidence. Bingaman had disqualified himself after suddenly discovering, after 3 years, that a conflict of interest existed. His wife worked for a law firm that once represented 2 of Cranston's staff members whose legal bill had not been paid. That move took the heat off the Ethics Committee until media attention focused elsewhere. Congress repeatedly refused to provide money to shut down the hemorrhaging savings and loans, which then permitted the looting to go on, as well as continuing. 110. The political contributions from the insolvent institutions. Congressman Gonzalez stated, Degree 3, that the White House and federal officials could simply have placed the looted and failed institutions under government conservatorship. But Congressman Gonzalez complained to federal regulators in late 1992 that regulators can put failing institutions under government conservatorship now, with or without any new funding. This should save the taxpayers the costs of further depletion of the institution's assets. The refusal to shut down the fraud rack savings and loans escalated the losses. Usual cover-ups investigators, trying to blow the whistle on rampant corruption, testified to the House Banking Committee in October 1989 that Washington officials repeatedly overruled or restricted their investigation of corruption-riddled Lincoln savings and loan. Admitting to paying for influence, Keating admitted giving over $5 million in political contributions to influence members of the U.S. House and the Senate and state politicians in California and Arizona. Cranston and the 4 other senators pressured regulators to back off from shutting down Lincoln savings and loan, inflicting even greater losses upon the American taxpayer. Keating wasn't hesitant about stating the effects he expected when he paid bribes to members of Congress, stating several times to the press, "One question, among many Rice said in recent weeks, had to do with whether my financial support in any way influenced several political figures to take up my cause. I want to say in the most forceful way I can, I certainly hope so." Trademark. Despite the huge losses incurred by these practices, Keating paid himself and his family over $34 million in the 3 years before its demise, even though losses during this time were destroying the corporation. Representative Henry Gonzalez of Texas initially protected the system by using his post as chairman of the House Banking Committee to obstruct an investigation into questionable banking practices in his home district. Gonzalez pushed an amendment to protect First National Bank of San Antonio and other financial subsidiaries from the regulatory actions of the Federal Deposit Insurance Corporation. But as the savings and loan scandal shot out from under the media blackout, Gonzalez, head of the House Committee 5 with oversight responsibilities for the savings and loan industry under the Office of Thrift Supervision, focused attention on the savings and loan problems. Honesty doesn't pay. The Dallas Morning News reported a conversation by an anonymous Texas state legislator, who said he had to take bribes from the HUD and savings and loan crowd because he needed the money to maintain his lifestyle on a legislator's salary. He reportedly stated, "It's hard to be pious because in all honesty I could use the money. Honesty doesn't pay." My CIA contacts described a well-publicized area of the savings and loan corruption in Dallas apartment units along Interstate 30, running east to Lake Ray Hubbard. Hundreds of apartments were built for which there was no demand, no rentals, and no sales. Money was made through land flips and shoddy construction. Some apartment buildings were shown as completed even though the plumbing and other necessities had not been installed. Covert CIA proprietary operations were involved in this scheme that defrauded the American public. California involvement in the greatest financial debacle ever perpetrated. Corrupt California politics made the Lincoln debacle possible. The California General Services Department obstructed the investigation of Lincoln's corrupt practices, rendering administrative decisions resulting in the loss of almost $250 million in savings of the elderly. In California, Chapter 11, Degree 7 judicial corruption was especially acute. California was the state producing numerous attorneys and prosecutors that played a key role in some of the scandals described within these pages. The Justice Department's scheme to silence me used California attorneys, law firms, and state judges, augmented by California-based U.S. District Court judges and justices. In this way they joined the conspiracy of criminality I sought to expose. Many on the Reagan-Bush team were from California, including Earl Bryan, Edwin Meese, J. Lowell Jensen, and Senator Alan Cranston. Numerous California officials and friends of California Governor George Deukmejian, mostly attorneys, were heavily involved in these scandals. A Keating Enterprise, TCS, made political contributions totaling $48,000 to Deukmejian's campaigns. Keating paid over $189,000 to Deukmejian, in addition to the nearly $1 million given to California Senator Cranston's interests. Over 23,000 California investors were seriously harmed, as they purchased $250 million in uninsured bonds after California regulators approved their sales, knowing the corporation was insolvent. Many of these elderly people lost their life savings and their sole means of financial support. In November 1984, Lawrence Taggart, while a California Savings and Loan Commissioner, rendered official decisions allowing Lincoln to continue their fraudulent schemes, causing thousands of investors to lose their life savings. On December 7, 1984, 3 days before a crucial deadline that nobody was supposed to know about except highest-level federal regulators, Taggart gave Lincoln approval to move almost $1 billion to its subsidiaries. Taggart then left to become a director of TCS. But records showed Taggart was already hired by TCS at that time. On January 1, 1985, Taggart left his California position, responsible for regulating savings and loans, to work full-time as TCS's highest salaried executive. Additionally, he was to receive half of the after-tax profits earned by the consulting department he headed, and other perks. 3 weeks later, Lincoln bought $2.89 million worth of TCS common stock. Barbara Thomas, a former SEC commissioner, reportedly called the SEC to act as a character witness for Keating during its investigation. Gonzalez said his staff's investigation revealed that Ms. Thomas had received a $250,000 loan from Mr. Keating with unusual payback provisions, suggesting a quid pro quo arrangement. Jack Atchison of the auditing firm of Arthur Young & Company was primarily responsible for auditing Lincoln's savings and loan, and submitting the reports to the government. Atchison sent several letters to 3 senators saying that Lincoln was a sound institution and that federal regulators were harassing Lincoln executives. Atchison then left his employment with the accounting firm and went to work for Lincoln at a salary exceeding $900,000 a year. The salary far exceeded what the position justified. It was surely another of hundreds of quid pro quo agreements in exchange for the sham report showing Lincoln as being solvent and in good financial condition, when actually it was not. A California Department of Corporations lawyer regulator issued a strong warning about uninsured bonds sold in Lincoln's offices. But California officials kept the warning quiet, making possible the sale of worthless bonds to thousands of California investors. California Assemblyman Patrick Nolan received large financial contributions from Keating after Nolan sponsored legislation removing investment restrictions on state-chartered institutions. More dirty California politics followed. In 1983, I notified Governor Deukmejian, California Attorney General Van de Kamp, and numerous state legislators, of the involvement of state judges in seeking to silence my exposure of criminal activities. Instead of investigating the charges and taking corrective action, they protected the judges after I filed civil rights actions in federal court. California officials denied state examiners and legislative investigators access to records, stating there was high danger of asbestos contamination where the records were stored. Possibly 20 years residence in the building might constitute a danger, but certainly not 10 minutes to pick up the files. The building owner denied there was any danger. They could have been picked up any time in the last 200 days. They knew there was no problem. Assemblywoman Delane Easton of the California House Banking Committee stated that subpoenas would be necessary in the Lincoln case to obtain the records from the California Department of Corporations and the California Department of Savings and Loans. Officials under Governor Deukmejian refused to turn over the records, knowing that they contained evidence of California politicians' involvement in the savings and loan scandal. California and Arizona committees conducted interim hearings dealing mostly in trivia, in that way protecting California officials implicated in the savings and loan scandal. Both U.S. Senators from California, Alan Cranston and Pete Wilson, received money from Keating to block the actions by federal regulators. Wilson received over $75,000 from Keating and received large financial contributions within 2 months of his election to the U.S. Senate, holding the record for the amount of political contributions in 1990, according to the San Francisco Chronicle and San Francisco Examiner. Part of the money, often the life savings and means of economic survival, lost by investors, went to bribe U.S. senators and representatives who were protecting the crooks in the savings and loans. Widows, retired persons, many of them elderly, testified before a House Banking Committee on November 14, 1989, that they lost their entire life savings, blaming California Senator Alan Cranston and other members of Congress for their losses. Many, unaware they were uninsured, invested their life savings in the over $300 million in junk bonds after Cranston and other members of Congress blocked the actions of government inspectors and regulators. What should have been golden years for thousands of retirees, especially in California, turned into abject poverty, compliments of California regulators and members of Congress, who took bribes to prevent exposure and closure of the corrupt practices of Lincoln Savings and Loan, Keating, and others. A few exceptions: there were a few members of Congress who spoke out on the rampant criminality in the deregulated savings and loan scandal. Representative Jim Leach told a panel of journalists, "You have the opportunity to hold your legislative branch accountable, and perhaps bring it down." Referring to the cover-up by the government regulatory agency that permitted the corruption to continue, Leach stated, "This bank board did the opposite of making timely warnings. It tried to put people to sleep while a fire was raging." Attorney Joseph Cochette of Burlingame, California, representing many of the elderly who were swindled in the Lincoln bonds, described the obstructionist tactics by California officials, and now we have reached the 1000th coincidence in this case. Can the money be recovered? Federal Deposit Insurance Corporation's chairman, L. William Seidman, told of the hopelessness of recovering the huge losses. He warned that the amount of money recovered from anyone found guilty of self-dealing and other insider abuses would be small. "The money is long gone, spent," Mr. Seidman said. "We cannot expect any substantial recovery from criminal abuse. But it could be traced if they wanted to, as I found through CIA and other sources where many of the trusts were located. Whatever the actual immediate figure is, $250 to $500 billion, these figures exceed many times the total amount looted from publicized savings and loans. My CIA and other contacts, who had key roles in the HUD and savings and loan scandals and some yet to be exposed, helped move the money to secret offshore and domestic banks, trusts, limited partnerships and other financial vehicles. They told me where some of the funds could be located." In later pages. 114. Some of these locations are identified. Heavy CIA involvement. Several well-documented books. Degree have been written of the savings and loan debacle. One thing that most of them missed, which I would not have known except for becoming a confidant to several CIA operatives, was the major role played by the CIA in the looting of America's financial institutions. Among the CIA-related savings and loans listed in these books as being part of the looting but not identified as CIA proprietaries were Silverado Bank Savings and Loan, Aurora Bank, Indian Springs State Bank, Red Hill Savings and Loan, and Hill Financial in Red Hill, Pennsylvania. These authors also failed to discover that many of the other savings and loans were often cutouts for the CIA. More about this in later pages. Silverado Bank Savings and Loan. Much has been written about Denver's Silverado Bank Savings and Loan and its most prominent director, Neil Bush, the son of George Bush. But much has remained secret about Silverado. One of the best-kept secrets was that Silverado was a covert CIA operation, that it funded many covert CIA assets, and that many of the huge financial losses were the direct result of CIA activities. It is ironical that Silverado, a CIA proprietary, had as one of its directors the son of former director of the CIA, George Bush. Because of heavy CIA involvement in Silverado, and for other reasons to be covered, Justice Department prosecutors protected the Silverado gang against meaningful prosecution. Neil Bush played a key role in looting Silverado, receiving only a token reaction from government agencies that kept a lid on Silverado's criminal activities. Interest payments on money borrowed by the United States to pay off the original $2 billion looted from Silverado may cause the cost to the taxpayer to exceed $6 billion, assuming these debts are ever paid off. It required over 200 sham loans of $1 million each, not repaid, for these losses to occur. Neil Bush, like Oliver North in the Contra affair, displayed a look of innocence when questioned about his role in this horrendous fraud. Neil Bush, while in a position of trust on the board of directors, borrowed over $2 million from Silverado, part of which went into a dry hole drilling for oil in an unlikely location. Most of the money went for his salary and personal expenses. He was not so stupid as not to realize the money would never be repaid if that hole did not produce oil. He drilled this hole where it was known there was no oil. But the drilling served as justification for paying himself a large salary and lots of perks, which the ever-benevolent American taxpayers now must pay well into the next century. Bush made no payments on the money he borrowed and no charges were filed by the Justice Department beholden to his father, President George Bush. It paid to have Justice Department personnel in your back pocket. Two borrowers from Silverado who were partners with Neil Bush, Ken Good and Bill Walters, got away with $130 million in loans from Silverado that were never repaid. Some of this money went to Michael Norton, who later protected them from prosecution when Norton became U.S. Attorney. The Mafia never had it so good. When the lending institution failed, the taxpayers were stuck with the tab plus associated costs, including interest on the money borrowed to finance this portion of the national debt. The borrowers in the sham transaction, who had good political connections, often purchased the property at pennies on the dollar from the government after the savings and loans were taken over. Before the taxpayer finishes paying, the cost will probably triple. The infamous Silverado Bank savings and loan in Denver was one of the key lending institutions involved in these types of scams. Media cover-up investigative reporters for the establishment media in the United States knew for years about the financial debacle, but kept the lid on the scandal. To have removed the lid would have affected them financially, as major advertisers would have been affected financially. In Denver, for example, 3 newspapers received considerable income from the advertisements of the group heavily involved in the HUD and savings and loan fraud: Rocky Mountain News, Denver Post, and Westward. Taxpayers' bill, over $200 billion. The greatest financial debacle ever inflicted in the history of civilization is causing American taxpayers to be saddled with a debt that has been estimated as high as $200 billion, including interest, an amount far exceeding America's cost of fighting World War II. Probably this large indebtedness will never be paid off. And this is only the savings and loan fraud. Many other corrupt financial scams are pulled on the American public, including HUD, Chapter 11, and others yet to be described. This fraud, and the missing money which no one has sought, requires the American people to pay huge tax increases, and threatens the continuation of basic social programs. Very little attention has been given to the losses suffered by those people who own stock in the savings and loans, including the retired people who had their entire savings in worthless stocks, that no longer provided dividend income. Where were the FBI, Justice Department, and other federal checks and balances? A good question would be, where were the hundreds of FBI and Justice Department investigators during this massive fraud inflicted upon the American people? The criminal activities were too extensive for them not to know of their existence. With its many connections within the United States, one could also ask where the CIA was during all this. The fact is, they did know. Later pages will help to explain how these criminal enterprises are linked together, and how people in control of our checks and balances were implicated in them. A California banking investigator, Richard Newsom, testified that he went to the FBI in July 1988, after he found evidence of serious criminal activities in the savings and loan industry. He testified that he had found that the parent company of Lincoln Savings and Loan funneled over $800,000 to Senator Alan Cranston, and that the stuff was too hot. The FBI and Department of Justice refused to take any action on the reported corruption. As is shown throughout these pages, the Justice Department's gang of attorneys, including their FBI 116 Division, are most noted among insiders as being heavily involved in hardcore obstruction of justice when federal officials are implicated. Justice Department protection of kingpins and wrist slapping of their underlings. James Metz, listed as a majority owner of Silverado Savings and Loan, pled guilty to taking $100,000 of savings and loan funds for personal use, and received a 6-month sentence in a halfway house. This sentence permitted him to work as president of Richmond Homes and be home during the day, requiring only that he sleep at the location at Colfax and Fillmore Streets in Denver. This token judgment ignored the $2 billion looted with his help from Silverado. My CIA contacts stated Metz was one of many CIA assets in the Denver area. David Mandarich was indicted for illegal contributions, of which Michael Norton, U.S. Attorney in Denver, was the major recipient. Since Norton was the primary recipient of the money, he had to stand aside and have Marvin Collins, U.S. Attorney from Texas, act as special prosecutor to prosecute the case. Mandarich took the fall for the many other big names but was protected by U.S. Attorney Collins, who deliberately presented a weak case to the jury. U.S. District Judge Richard Match then assisted in the cover-up by dismissing the charges. Justice Department prosecutors waited until the statute of limitations had run out for charging Neil Bush and others of the Denver gang before filing nominal charges against Silverado's James Metz and Michael Wise. Corruption and cover-up in the Denver area was orchestrated by U.S. Attorney Michael Norton and Assistant U.S. Attorney Gregory Groff in Denver. Investigation of key players would have implicated the CIA and risked exposing White House and other politicians involved in the savings and loan crimes. Coming down hard on scapegoats, many of those charged and prosecuted by Justice Department attorneys in the savings and loan fraud were outside directors of savings and loans, in honorary positions with no knowledge of or control in the institution's activities. By seeking to put these people in prison, Justice Department prosecutors were protecting the kingpins that continued to inflict great financial harm upon the American public. By indicting these people, the prosecutors misled the public into thinking that justice was being done. The fraud didn't stop. The fraud by the Denver group inflicted billions of dollars in direct losses upon the American people. But it didn't end there. The same Denver group and others, who brought about the collapse of the savings and loan industry by their corrupt activities, used their Washington influence to buy back properties and other assets from Resolution Trust Corporation at 10 and 20 cents on the dollar. They made money bringing down the savings and loans and made money buying the assets back, with the help of the same Washington gang. MDC bought from the RDC $750 million in loans that they had obtained from Silverado for $150 million, making a $600 million profit, and defrauding Silverado out of $600 million. This was not mentioned in the investigation of that savings. 117. And loan. Central Intelligence Agency involvement. An article in Penthouse detailed the CIA involvement in fleecing financial institutions. Entitled, The Banks and the CIA, Cash and Carry, it carried the subtitle, How Agency Rogues Fleeced Financial Institutions to Help Create One of the Greatest Scandals in U.S. History. The article, describing the looting of banks and savings and loans by companies fronting for the Central Intelligence Agency, stated in part, Agency rogues fleeced financial institutions to help create one of the greatest scandals in U.S. history. Freelance CIA operatives in the course of carrying out covert operations, fleeced America's financial institutions. The CIA, it was claimed, sanctioned, pulling money out of federally insured financial institutions to fund covert activities, particularly arms deals. The article went on to say how Congress had shut off funding needed by the CIA for its covert operations, and how the CIA underground smuggled drugs into the country and looted banks and savings and loans. It further described how the CIA covert operations went underground when President Jimmy Carter ordered disbanding of its covert operations in the late 1970s. The article described how President Reagan's 1981 inauguration reinvigorated the covert CIA operations. Denied funds by Congress, the covert CIA network carried out unlawful and clandestine activities throughout the United States and overseas. These activities violated the CIA charter and were criminal acts. The Houston Post started a series of articles in 1991 revealing connections between the CIA, organized crime, and the savings and loan scandal. Investigative reporter Pete Bruton left the Houston Post after pressure was put upon him to withhold key facts. In October 1992 his book was published, The Mafia, the CIA, and George Bush: The Untold Story of America's Greatest Financial Debacle. My investigative activities brought me into contact with deep cover intelligence agency personnel who revealed to me the part played by the CIA in looting the savings and loans and other financial institutions. In the following pages this relationship is explored. Secret crimes by the CIA against America as described in detail in subsequent pages. Commencing in 1990 I became a confidant to many former deep cover CIA and DIA personnel. One of these was Gunther Russbacher, whose father was a former German intelligence officer during World War II. Russbacher held many sensitive positions within the covert segment of the Central Intelligence Agency and was involved in deep cover operations. More is said about Russbacher in later pages, but reference is made to him and some of the CIA activities that he related to me in detail over a 4-year period. Russbacher's key covert position within the CIA took him far beyond the limited knowledge many CIA personnel have of CIA operations. The agency tries to limit knowledge of overall operations by compartmentalizing operations and limiting the knowledge that any one participant has of the overall game plan. But Russbacher's high position within the agency made him privy to a vast number of secret CIA operations. Russbacher revealed to me the role played by the CIA in the savings and loan and HUD scandals. He had been with the CIA for over 2 decades and had been trained by the CIA to operate covert financial operations under various CIA programs, including Operation Cyclops. As he developed knowledge and expertise, the CIA had him organize and operate many CIA proprietary financial institutions. Russbacher and other deep cover sources gave me innermost secrets of how the CIA looted America's financial institutions, how the money was laundered, the criminal elements with whom the CIA acted, and where some of the money ended up. These CIA operatives stated how the operations worked and the names of some of the covered CIA financial institutions, fronts, and cutouts. They gave me blank checks, letterheads, copies of corporate filings, and other writings supporting these statements. For the next few years I conducted hundreds of hours of questioning with Russbacher and other CIA and insider contacts, receiving details of the most secret CIA operations in which he participated during the last 3 decades. He gave sworn statements during the 3 years before the first publication of this book. I checked his credibility as a CIA operative with other CIA sources. Most, if not all of what he stated, and what is included in these pages, I believe to be true. Some banks and savings and loans became fronts for CIA covert operations and often made phony loans, phony appraisals, and phony sales, generating enormous sums of money for clandestine CIA activities. Russbacher told me that the CIA had given him over 40 aliases. During the first 2 years of his affiliation he was a contract employee of the CIA. Then, in 1965 he entered the United States Navy and was assigned to the Office of Naval Intelligence. During all but 3 years of his CIA affiliation, he was in covert operations, consular operations, and other branches of covert government service. He did 2 tours of duty in Vietnam and Laos and was an unofficial prisoner during the second tour of duty in Southeast Asia. The U.S. government didn't list its covert personnel. 2 INA December 6, 1992, sworn declaration, Russbacher described to me part of the CIA operations in which he was involved. It is my intent to clarify, once and for all, how the intelligence services of the United States of America have used the savings and loan to fund their respective covert operations, both within the United States and abroad. The scheme creating an unlimited money supply was devised after the inside knowledge of how the Federal Reserve operated became known to operatives and case officers. A monetary growth medium had to be found which would enable the agency to have access to an unlimited supply of funds with which covert operations might be funded. The key was how to utilize/capitalize on the federal credit programs. Careful analysis and study of the Federal Credit Act provided the proper forum. It was decided that small to medium businesses of the Proprietary Operations Unit would be well online to provide these expert services. Soon, various businesses, owned and operated by either the agency or utilizing a front directorship, began to deposit funds into the selected thrifts. The loading of these institutions was always accomplished with the help of inside information, gained and acquired by and through information garnered by the FSLIC and their respective service members. It was decided that various front organizations would deposit millions of dollars into these selected thrifts, and that such deposits would permit the depositors to make collateral loans for 85% of the deposit value. The disparity of deposit and secured loan was the carrot for the ailing financial institution. The agency, through its Proprietary Operations Division, was quick to recognize the Fed lending to deposit rate for thrifts, which in turn stated that every dollar taken in on deposit would permit the thrift to borrow up to $7 from the Federal Reserve. It was a lucrative enticement to agency operations. The loan funds were soon gathered from all regional affiliates, and channeled to fund the charters for our own thrift institutions. The stage was set. It was merely a question of time until we began reinvesting our portfolio. Over a period of approximately 3 years, more than 35 federally insured agency thrifts were brought online. Each of the financial institutions was funded in part by certificates of deposit, and various other instruments of financial obligation. Sometimes, bogus bearer bonds were used to ensure sufficient start-up capital. Slowly, these institutions began making large loans to other agency front businesses. Many of them flourished regardless of the initial intent to strip them systematically of their assets. Those which jailed to provide an unending money funnel were soon brought to court, pursuant to Chapter 11, of the United States bankruptcy laws. Prior to permitting entry into such proceedings, all visual assets were stripped and/or removed from the insolvent companies. The United States bankruptcy courts, as well as the assigned United States trustees, would permit us to rechannel the obvious assets prior to satisfying the demands of the legal creditors. It must be stated that in the initial stages of such operations there were no legal creditors, as the entire operation was an in-house operation, and subsequently not issues or obligations traded on the open market. Such practices were soon discarded as the volume of the operation was not able to keep out private and corporate investors. Many of the removed assets were sold to other agency operations, which in turn sold said assets to other linked dealers. Brokerage companies of dubious repute were soon spin-offs of the mega industry. In order to provide continuity as well as expert disclosure, I shall reference the history of the funding of Hill Financial, as well as 120. Red Hill Savings and Loan, the establishment of the national brokerage companies, the creation of National Financial Services Corporation, National Leasing Corporation, National Realty Corporation, Crystal Shores Development Corporation, Crystal Shores Financial Corporation, and Clayton Financial Planning Corporation. It is imperative that the continuity and creation are uninterrupted. During my time of service within the Proprietary Operations Division of the Central Intelligence Agency, I was approached while using the assigned name of Robert Andrew Walker to initiate contact with a nationally prominent brokerage house. I followed the order and began a transfer study, which in turn was to initiate and facilitate the founding of a new savings and loan facility in Red Hill, Pennsylvania. All transfer studies were accurate and the new SNL was soon brought online. It was funded with corporate paper, other private and corporate bonds/certificates, and other financial obligations. The founding fathers of Hill Financial were Donald Lutz and Robert A. Walker, A/K/A/Gunther Karl Russbacher. The financial package of the SNL was born from funds derived from SBF Corporation. The new SNL flourished, making numerous loans to the economically depressed local and regional area. These notes were in part non-secured, and no payoff was anticipated from these local trades. We began to diversify, using the Federal Credit Act to gain and secure additional federal funds, by securing other deposits from agency operations. Our deposit portfolio was extended on a ratio of 4.3 to 1 and thereby provided considerable additional loan coverage to other more open and more lucrative markets. We began to explore bringing online additional feeder organizations which would add to our real deposit base. The decision for such action was taken after I received orders to charter a brokerage company in the state of Missouri. We, the directors of Red Hill SNL, held a closed meeting, wherein it was decided that I would become chairman of the board, and elevating Donald Lutz to the presidency. Pledging my continued assistance, I was permitted, nay ordered, to set up shop in St. Louis, Missouri, where I dropped the name Robert A. Walker, and became Emery J. Pedden. Within 3 months I was a registered broker of the Prudential Insurance Company of America. Soon after learning the business, I resigned my position and began a long-term relationship with Connecticut Mutual Life Insurance Company. I had an office in Clayton, Missouri, and soon made a significant impact on the financial and insurance industry. End of segment 1 of the deposition of Gunther K. Russbacher. I certify the information contained in this segment of my deposition to be true and correct. Such certification is given under the penalty of perjury. Further, affiant/deponent saith not. Gunther Karl Russbacher, deponent in cause. Dated, December 6, 1992. 121. Russbacher incorporated and operated a number of covered CIA proprietaries in the United States from the late 1970s to 1986. His main headquarters was in Missouri, but his CIA proprietaries had offices throughout the United States, with heavy involvement in Dallas and Denver, where much of the HUD and savings and loan looting took place. Russbacher identified as CIA proprietaries or assets numerous savings and loans, including Aurora Bank in the Denver area, Silverado Bank Savings and Loan, Red Hill Savings and Loan, Hill Financial, Indian Springs State Bank, and many others. He described the flow of money from, for instance, Silverado Bank Savings and Loan to Startup Hill Financial and Red Hill Savings and Loan. Much of the data that he and other deep-cover CIA operatives gave me still has to be analyzed. Russbacher made reference to CIA contract agents he encountered, including Heinrich Rupp and Richard Branicki, who worked with the CIA at Aurora Bank in Denver and elsewhere, and Anthony Russo at Indian Springs State Bank in Kansas City. Russbacher described the links between CIA proprietaries and organized crime and how the CIA worked with the group in Denver, looting the HUD program and savings and loans of billions of dollars. He described the corrupt practices of groups in the Denver area, such as MDC Holdings, Richmond Homes, Mizell Development, and their nearly 100 subsidiaries, partnerships and other legal entities. Describing his role in 2 of the savings and loans, Russbacher stated, "I held the position of chairman of the board. Let's back up here, and erase that last thing. Robert Andrew Walker. 3 held the position of chairman of the board." Russbacher used the CIA-provided alias of Walker for those positions. Russbacher described the massive corruption associated with the new Denver International Airport that included bribes, land flips, and sham loans. Typical CIA proprietary operation. An example of how the CIA operated secret companies in the United States is seen from the companies that Russbacher operated for the CIA. Russbacher incorporated and operated many CIA proprietaries, hiding the CIA ownership by showing the stock owned by CIA-related personnel. At the top of the group of companies that Russbacher operated for the CIA was National Brokerage Companies, a general partnership located in Missouri. Under National Brokerage Companies were a number of other general partnerships and corporations. The stock in these corporations was held in several names, including Gunther Russbacher and his CIA-provided aliases, Emery Pedden and Robert A. Walker. The various companies and corporations were controlled by covert CIA personnel installed as directors. In 1986 the NBC name was changed to National Brokerage Companies International. Russ Bacher gave me the names of many financial institutions that he said were CIA proprietaries. He described in great detail his role in Red Hill Savings and Loan and Hill Financial in Red Hill, Pennsylvania. He named other CIA proprietary financial institutions, including National Brokerage Companies, National Fiduciary Trust Company, National Financial Services, Crystal Shores Development, and Clayton Financial Planning, which had several divisions, including Aegean Lines and Europa Link. Europa Link allegedly owned WPR Petroleum International, which used leased oil tankers for oil delivery to major refineries. Also, Badner Bank, which funded Germania Savings and Loan, Commerce Bank of Missouri, Carondelet Savings and Loan in St. Louis, Mega Bank Group which owned First State System and operated in about 18 states, Shalimar Perfumes, Shalimar Armaments, Shalimar Chemical Laboratories, R&B Weapons Systems International Incorporated, Pratis Lajabraniki Munitions Amalgam, KRB Weapons Delivery System, National Realty, and others. Russ Bacher said that National Brokerage Companies was incorporated in Missouri in 1980, and that it was the parent company for many others. He said part of its initial funding came from Silverado Bank Savings and Loan via Red Hill Savings and Loan and Hill Financial. Among its subsidiaries were National Leasing, National Realty, and Crystal Shores Financial Services. A division under Clayton Financial Planning was Commercial Federal Savings and Loan, which had connections to National Fiduciary Trust Companies. A division under Clayton Financial Planning was Carondelet Savings and Loan, which also had financial connections to National Fiduciary Trust Companies. Russ Bacher stated that under National Fiduciary Trust Companies were Badner Bank and International Commerce Bank Holding Company. Under Badner Bank were various airlines, including Zantop Airlines, Tower Airlines, Southern Air Transport, Apollo Air, Virgin Air, and Raw World Service. Under International Commerce Bank Holding Company were Baja Enterprises, Property at Cabo San Lucas, Hotel Cabo San Lucas, and Cabo Airport. Russ Bacher described the practice of the CIA having their own banks as proprietaries, and named, among others, Commerce Bank of Missouri, and particularly the one in Clayton, naming as a CIA asset the manager, John Biddlecombe. He described the CIA operation known as Valley Bank in Phoenix, which he said played a key role in moving money for the October surprise operation. There were several European holdings, including Shalimar Perfumes, Shalimar Arms, and Shalimar Chemical Laboratories. Under Shalimar Armaments was R&B Weapons Systems International, Incorporated. Under R&B were two companies, Pratis Lajabraniki Munitions Amalgam and RB Weapons Delivery Systems. It all sounds rather complex, and a further explanation is follows. Removing huge sums of money overseas. Russ Bacher described how the CIA moved large quantities of money from U.S. financial proprietaries during the last few years to offshore corporations and banks, including those in the Antilles and the Cayman Islands. The agency is deadly afraid of exposure within the United States, Russ Bacher said, and they have begun to siphon off large and tremendous sums of money to foreign accounts. It must be borne in mind that in the last 3 years there has been 123. A systematic removal of funds and capital assets from these corporations. Russ Bacher described how the CIA used the savings and loan institutions to fund their covert operations in the United States and abroad and add to the massive amount of funds secreted in foreign financial institutions. Parallel operations were run by different CIA divisions and directorates, using code names to identify the various operations. Included in the operations affecting financial institutions were Operation Goldbug, Operation Cyclops, Operation Interlink, Operation Woodsman, Operation Fountain Pen, Operation Thunder, Operation Blue Thunder, and Operation Moth. Operation Woodsman was a CIA operation that targeted specific companies, forcing the owners out and taking over the assets. Russ Bacher described several of these operations in which he himself was directly involved. Information used to carry out Operation Woodsman, such as the financial condition of targeted companies, could be obtained by the CIA through a database called the Black Flag File, which is located on a Cray computer in Washington and which is accessed through a government Sentry terminal. The Cray computer also contains a list of federal judges, trustees, law firms, and attorneys who covertly work to carry out Justice Department and CIA activities. Referring to judicial involvement, Russ Bacher repeated what he had described to me during the past few years about the role of federal judges in the corruption. More than 50% of the judges are compromised through secret bribes or retainers. The bribes take many forms. Sometimes through gambling chips at Atlantic City and Las Vegas casinos, in the form of gratuities, sometimes through second and third parties, inheritances, anything that will whitewash the funds in the property that is given to the judges or trustees. Russ Bacher stated that these funds are often hidden in offshore financial accounts, adding, "Let's say it is property or stock certificates. We'll have phony documentation set up and put in place and show where the stock certificates or the property or the legacy came from. Even if we have to create our own trust with which to do it. It's not like we don't have legally capable counsel available. Now understand this too, these judges receive this heavy money regardless of the fact that they have cases pending or not. They get paid whether they do something for us or not." Russ Bacher elaborated on the procedure for gaining access to the Cray computer in Washington, telling how the identification number is first entered and then the security code. Russ Bacher stated that he learned about Operation Woodsman when he was assigned to CIA headquarters at Langley, Virginia. "Every damn thing, every crooked thing that the DOJ has done," he said, "involving any and all law firms, is registered under the code name that I have given you." Russ Bacher continued, "Our intent was to take over the tangible assets of the operating license and licenses. We go through the predetermination hearing with the judge. 124. Trustee and the simple debtors, and then we buy time to reorganize the lines, and transport capabilities. In other words, we use them for ourselves, these little feeder airlines, we try to keep them alive anywhere from 6 months to a year and a half. Slowly we set our operations and leverage to where the existing financial records are changed to reflect prior debt encumbrance. We falsify the records. We take an existing carrier, their routes, their equipment, push our schedule and freight manifest through their licenses, and then we have no interest in developing a good business or making a go of it, out of the indentured one that we have taken over." Russ Bacher described how the system uses attorney spotters throughout the United States to identify companies that have large equities but have cash problems. CIA proprietary spy up the company's receivables and indebtedness, and force the company to sign papers making them susceptible to immediate takeover if their financial situation deteriorates. The CIA proprietary then acts to make this happen, after which the owners lose control. Chapter 11 will be included in Operation Woodsman. The CIA may loot the company and then put it into Chapter 7 or 11 bankruptcy courts, where several options are available to make off with the assets or to have the indebtedness discharged. Russ Bacher told how the CIA has about 70% of the trustees and many of the federal judges in bankruptcy courts on retainer. He also elaborated upon the practice known as drop-offs that force companies into Chapter 11, involving companies with valuable assets that have a cash crunch. Russ Bacher described some of the company takeovers in which he was directly involved, naming Midway Airlines, Southern Air Transport, and Frontier Airlines. In some cases, the targeted company would be liquidated and, as in the case of Frontier Airlines, the aircraft would go to a CIA proprietary. In Frontier's example, most of the aircraft went to the CIA proprietary, Southwest Airlines. In the case of Southern Air Transport, the targeted corporation was kept as a CIA proprietary. According to Russ Bacher, referring to the CIA takeover of Chicago-based Midway Airlines during the last year of its existence, Midway Airlines was first targeted in 1986 because it had a high debt-to-asset ratio, making the airline vulnerable to the takeover scheme of Operation Woodsman. CIA assets began purchasing Midway's debt with the intention of taking over the company and then liquidating the assets in Chapter 7. Russ Bacher told how Midway tried to get absorbed by another carrier, Northwest, and that the CIA blocked it, as it wanted Midway's aircraft. The CIA got Justice Department attorneys and the IRS to take actions against the airline through criminal and tax proceedings through mostly bogus criminal and contempt charges, explaining, "We put together a bunch of phony allegations, mismanagement of funds, possible fraud. 95% of it is totally untrue and unfounded, but the 5% that does remain true and factual are at the forefront, and you push those." Some of the directorships on the board of directors were subverted and suborned to CIA tactics. 125. The plan by Northwest Airlines to absorb Midway fell through after both Midway and Northwest were pressured by government agencies acting on behalf of the CIA. This scheme caused Midway to go out of business, so the airline's Boeing 737 aircraft went to another covert CIA operation, Southwest Airlines. Russ Bacher described similar CIA takeovers which developed into larger companies instead of being liquidated for their assets. These included Southern Air Transport, Central Airlines of Fort Worth, Allegheny Airlines, and others. Russ Bacher explained that some of the directors had their own businesses and that it was easy for the CIA with its control of other government agencies to put pressure on them, adding, "They were not influenced, they were dictated to." I asked, "How could they be dictated to?" Russ Bacher replied, "The director, who has other business interests and probably a business of his own, suddenly finds himself in a financial quandary due to various tactics used by the CIA. We put him under our thumb. If he decides not to play ball, we threaten him with criminal charges." This tactic was used against Charles W. White of Houston, Texas, who was in partnership with CIA-related Jim Bath. When Bath wanted to withdraw $450,000 from an company composed of private investors and use it in a CIA-related operation, and White refused, the power of the courts and covert agencies were misused against White. After many lawsuits, White was financially destroyed. Russ Bacher stated that Justice Department attorneys worked hand in hand with the CIA in Operation Woodsman and other schemes, and that the agency not only has its own private attorneys but government attorneys on staff as well as the judges. It's a fixed deck all the way across. Russ Bacher described another CIA takeover, "We did the same thing with hotels," describing how the CIA took over the Intercontinental Hotels chain from Pan American Corporation through its CIA front, Global Hotel Management out of Basel, Switzerland. Among the airlines that were liquidated after acquisition were Central Airlines out of Fort Worth and Frontier Airlines of Denver. Russ Bacher described how the CIA created so much friction between Frontier and United Airlines, who had proposed taking over Frontier, that the deal fell through. These problems included union and other problems. The Boeing 737s then went to another CIA proprietary, Southwest Airlines. Russ Bacher stated that one reason Southwest Airlines was making money was that the airline has significant income from CIA-generated business that shows as income on its records, but the source of the income was bogus. Connections between the CIA and those looting America's financial institutions. Russ Bacher described the relationship between the CIA proprietaries and the Keating Group, adding, "The Keating Group is a very small group. There is a much larger group that we dealt with, of which Keating was only 126. apart." In response to my question as to why the Keating Group would work with the CIA, Russ Bacher stated, "To keep the heat off their backs for one. And number two, some of the companies that were involved were actually proprietary operations." Russ Bacher made reference to Anthony Russo, an officer in Indian Springs State Bank, who had financial interest in a CIA proprietary airline, Global International Airways. In 1982, the airline owned by Farhad Azima, an Iranian-born naturalized U.S. citizen, had a fleet of 14 jetliners, making flights to remote airstrips in Central America, carrying military equipment outbound from the United States and often carrying drugs on the return flights. Global flew shipments for CIA operative Edwin Wilson and his company, Egyptian American Transport and Services Corporation. Well-known national figures involved with Global included Thomas Kleins, Theodore Shackley, Richard Secord, Hussein Salem, and others. Bogus bearer bonds. Russbacher described another ongoing CIA operation inflicting hundreds of millions of dollars of losses upon U.S. financial institutions. In this operation, CIA proprietaries obtained loans from various financial institutions on the basis of pledged bearer bonds, all of which were bogus. After obtaining the loans, some CIA proprietaries looted the assets and then filed Chapter 7 or 11 in federal courts where they had control over bankruptcy judges and trustees and were represented by covert Justice Department and/or CIA law firms or fronts. Russbacher was cautious in divulging the secrets of CIA operations, even though he was trying to blow the whistle on some of its worst and most damaging activities against the United States. As time passed and with my constant probing into different areas of CIA activities, and as Russbacher learned that other CIA operatives gave me information which he had withheld from me, he gradually gave me more data. In early 1993, as I learned the operational names of many of the CIA operations from other sources, including Trenton Parker and Michael Riconosciuto, Russbacher opened up and gave me code names and data. He stated that different divisions or groups within the CIA ran parallel operations and had different names for similar activities. Some of them include the following: Operation Interlink. Operation Interlink was the code name for an operation involving financial institutions, whose goal was to raise money for covert CIA activities, and laundering the funds into secret CIA offshore bank accounts. Operation Cyclops. Operation Cyclops was the name used by the Pegasus unit of the CIA and was an overview over most other Pegasus operations. It included all types of covert financial operations including proprietaries involved in the HUD and the savings and loan programs, and bogus bearer bonds. Operation Moth. Operation Moth was one of the agency's names for the operation involved in the savings and loan fraud. Operation Goldbug. Operation Goldbug involved the overall scheme of generating money through various financial activities. Under Operation Goldbug were a number of other 127 operations. Operation Goldbug was the development of national and international financial programs to develop sources of income which would be available on a regular basis to support and carry out covert CIA activities domestically and internationally. Russbacher incorporated and operated over a dozen CIA proprietaries, and outlined the tactics used to loot companies of their assets. When used against savings and loans, Russbacher's section of the CIA gave it the name of Operation Moth. The highly secret Pegasus group within the CIA gave this program the name of Operation Goldbug. The intent of both groups and operations was to loot the assets of targeted financial or other institutions and wealthy people. The overall operation that targeted other companies was called Operation Goldfinger. Operation Thunder. Operation Thunder was another name for a CIA covert operation that included the HUD and savings and loan fraud, bogus bearer bonds, and other financial schemes. Russbacher stated that the home base for Operation Thunder was New Orleans and was initially located in a private CIA proprietary. He stated that today the cover for the operation is Telemark Communications, one of the biggest companies in the United States and a CIA proprietary. As with other CIA proprietaries, the top management consisted of agency people who had liaison with CIA field people who were contract officers or agents, and particularly attorneys and law firms. Russbacher described the heading sheet on correspondence pertaining to Operation Thunder. On the very top of the sheet would be the words, Operations Memorandum. Classification, Top Secret, SOG SI/6 copy number, 4 SOG/Alpha/Detachment TSTSQ/SOG D/F, 701 FP 3999689 Staging Area, New Orleans, Louisiana. Operation Blue Thunder. Operation Blue Thunder related to the destruction of institutions, including taking them over or forcing them into Chapters 7 and 11. After taking them over, the CIA would take over the corporation's license rights. Basically, it destroyed companies and picked up the assets at fire sale prices. Operation Fountain Pen started with Bank of Zaire, a CIA proprietary, buying banks, corporations and other financial institutions with bogus bearer bonds, treasury bonds, or duplicate issues. Bogus bearer bonds. Several of the covered CIA operations used bogus bearer bonds that had a 20 or 25-year due date and were used as collateral for multi-million-dollar loans. After obtaining the loans and laundering the money into other secret proprietaries or offshore financial vehicles, the companies would often file Chapter 7 or Chapter 11. The lender would then think it was covered by the bonds given as collateral, and they would not find them to be bogus until many 128 years later. In some cases, the CIA proprietary would make interest payments on the loans secured by the phony bonds. The primary criminal act in those cases would be using forged certificates to obtain a loan. Aiding and abetting by state officials. Russbacher stated that in 1986 some of the CIA financial institutions he operated were compromised, that connections between the secret proprietaries and members of Congress were in danger of being exposed, and the decision was made to shut them down. He told how Justice Department and CIA personnel conspired with Missouri officials to remove all traces from the state records that the CIA corporations had been incorporated as Missouri corporations. Referring to the shutdown of several CIA proprietaries linked to the 1986 downing of a CIA aircraft over Nicaragua, the famous Hasenfuss flight, Russbacher stated, "All records that were available to the Department of State or to the Attorney General's office have been seized or closed to where the public cannot get hold of them." Money path for bribing federal MS judges, trustees, law firms. I was prompted to ask Russbacher about payoffs to federal judges after private investigator Stuart Webb heard of a bribe connection between U.S. District Judge Sherman Feinsilver in Denver and a corporation in Ireland. After he passed the information along to me, I questioned some of my CIA contacts to determine if they knew anything of it. In response to my questions, Russbacher explained the path of money for bribing federal judges, trustees, law firms, and attorneys. Russbacher stated that the money for these payoffs came from a company located in Dublin and incorporated in Ireland, called Shamrock Overseas Disbursement Corporation. Its telephone is listed as Shamrock Overseas Courier Service. The function of this company was to place money at regular intervals into numbered bank accounts for the recipients to draw upon. Russbacher chuckled as he stated that the chief executive officer at Shamrock Overseas Disbursement was the same person with whom he had worked at other CIA proprietaries, Donald Lutz. Russbacher and Lutz were on the management staff of various CIA proprietaries, including Red Hill Savings and Loan and Hill Financial located at Red Hill, Pennsylvania, and at Silverado Bank Savings and Loan in Denver. Russbacher stated that the routing of the money funded by Shamrock was from the Netherlands Antilles. And in turn came from Grand Cayman, that in turn came from Southern Bank in Florida, that in turn came from Southern Savings and Loan in Illinois, which in turn came from National Brokerage Company. Where does the money originally come from? Is it from stolen Chapter 11 assets? I asked. Russbacher replied, "That's part of it. It is a conglomeration of funds. It is what we call an all-purpose account. Arms shipments, the other stuff that we were transporting back and forth. It is what we call the divisible surplus." I asked if the federal judges he referred to as recipients of these funds were only bankruptcy court judges, to which Russbacher replied, "No, that's not true. You have to include the DJs too." 129. How is it determined the amount that each judge will get, and what judges are paid off? I asked. Russbacher replied, "It is predetermined. If you will remember from one of my earlier tapes, I told you that the judges receive their funds regardless of whether they have heard a case in 6 months or not. How do they determine which judges are recipients? What qualifies them to be on the payroll?" Russbacher replied, "The fact that they work hand in hand with the trustees, and they grant us full power to basically do what we want in Chapter 11, 13, and 7 proceedings. Are there any other similar corporations in the United States like Shamrock? No, Rodney, they are all funded from Shamrock. In other words, if you pull the plug on Shamrock, you have it all. Russbacher explained how the recipients pick up the money. They can get it overseas and pick it up, or they can go to Toronto and pick it up there, at the Royal Bank of Canada. Russbacher stated, when they go in to make a withdrawal, they request to see the president or chief account officer. Russbacher explained that the scheme is part of Operation Woodsman, explained in earlier pages. Russbacher explained that the recipient's available funds will be found on the bank's terminal screen and that all they have to have is the account number. No ID is required. Just give them the account number and the 4-digit identification number. Russbacher stated that Royal Bank of Canada, manufacturers Hanover Bank in New York, and Valley Bank in Arizona, cooperate in this scheme. Russbacher repeated what he had told me in the past, that funds would also be dispersed to the recipient judges, trustees, or law firms at gambling casinos, including MGM, Harrah's and Resort in Atlantic City, and Frontier, Stardust, and Horseshoe in Las Vegas. The CIA gave the money to the casino, which in turn gave gambling chips to the recipients when they arrived, after which the chips are cashed in for money. In some cases the casinos report the money as winnings and income tax withheld. Would your knowledge of this operation be because you were with NBC? I asked. Yes, because we made deposits and withdrawals through that route, he replied. For Black Flag File, Russbacher stated that he had seen the list of recipients in this scheme on the computer database while he was at the CIA headquarters at Langley, explaining that the database is called the Black Flag Files. He stated that the database is on a Cray computer accessed from any government Sentry terminal by typing in an identification entry number. After a flag shows up on the screen, typing in the access code, 3A46915W. I often asked Russbacher to accompany these statements with a declaration as to their truthfulness, and I did during this questioning. He had also given me declarations attesting to the truthfulness of written information. Russbacher replied, sure. All the information that we have discussed on this date, May 17, 1993, from approximately 2020 hours Central Daylight Time, the declaration made to area code 510-944-1930, Rodney Stich, by Gunther Karl Russbacher, 44840-417, Captain USN, is true and correct as to the best of my knowledge and belief. Where is the money? Losses of approximately $500 billion have been the estimated direct cost of just the savings and loan debacle. But where did the money go? It has never been sought or located. The theft of $2 billion by Lincoln or $2 billion by Silverado is a long way from $200 to $500 billion. Neither Congress nor the Justice Department has made any attempt to determine where this money went. Finding it would relieve the American public of a debt load that is affecting the American economy, resulting in a reduction in benefits to individual Americans, thereby causing a staggering tax burden. There is no way that such a huge sum simply evaporated without a trace. My CIA sources tell me that many of the funds looted by the CIA, organized crime, and such groups as the Denver Group have been hidden in offshore financial institutions. Some of the funds that have gone overseas have returned to the United States through foreign shell corporations, buying up vast quantities of U.S. real estate and assets. One of the many ways in which crime money is reportedly hidden, investigator Stuart Webb heard from one of his sources that hundreds of trusts are filed with the state of Colorado that contain huge amounts of money looted from the HUD and savings and loan frauds, and also from drug money laundering. He and Russbacher said many of the trusts were filed in the county recorder's office for Baca County in southeast Colorado. In seeking further information, I asked another CIA source, Gunther Russbacher, do you know anything about the Baca trusts? He replied, how in the hell did you find out about those? Russbacher was especially well informed. He told me that many of the trusts were set up by Denver attorney Norman Brownstein, a key member of the Denver Group involved in the HUD and savings and loan scandals. These trusts were reportedly set up for the benefit of such insiders as Larry Mizell, Leonard Millman, MDC Holdings, Richmond Homes, and hundreds of other related legal holdings. Most of the actual funds associated with these trusts are reportedly located outside the United States. He said that he himself had filed trusts in Baca County for his children. Russ Bacher said that the location of the money covered by these trusts, which he stated amounted to billions of dollars, were located in offshore financial institutions. This money includes the billions of dollars stolen from the HUD and savings and loan programs, the billions looted every year from Chapter 11 assets, drug profits, and the other dirty schemes involving the characters listed within these pages. If this information is correct, and if sources of hidden money divulged home by my CIA sources were traced, possibly large amounts of the huge losses inflicted upon the American people could be recovered. 131. Billions of hidden taxpayers' money. Russ Bacher had several times stated in response to my questions that many billions of dollars of money obtained by CIA proprietaries from the American public were hidden in offshore financial institutions. In Colorado there are located well over 1,000 trusts hiding many billions of dollars looted from the American public. Continued looting of America. Many of the same crooks who caused billions of dollars in losses were reaping profits through their inner knowledge and political connections, enabling them to manipulate the agency responsible for selling off assets of the seized savings and loans, the Resolution Trust Corporation. While waiting for Senate confirmation as Clinton's nominee to head the RDC, Stanley G. Tate announced that upon being confirmed he would be exposing ubiquitous mismanagement, waste, and fraud at RDC. Tate told reporters 5 that he planned to release a 36-page statement during the nomination hearings supporting his charges. Tate had discovered the corruption while holding a temporary position on the board overseeing the RDC. Senator Donald W. Regal, Jr., one of the many senators who ignored my reports of the corruption in federal government, refused to conduct confirmation hearings for the RDC nominee. While Regal blocked Tate's confirmation, others were making death threats against the nominee. As if these acts were not enough, anonymous attacks were made upon Tate by RDC employees. Media sources wrote articles intended to block his confirmation. The coordinated campaign succeeded. Tate withdrew his acceptance of the nomination on November 30, 1993. Again, public ignorance permitted the same scum to continue looting America. Relief for felons. The conduct of such savings and loan operators as Don R. Dixon and Edwin T. McBurney caused billions of dollars of losses that the American taxpayers will be paying on for many years. They used taxpayer funds for sexual parties, to hire prostitutes, enjoy lavish lifestyles, none of which came out of profits. There weren't any. In 1993, McBurney was sentenced to 15 years in prison and Dixon was sentenced to 2 consecutive 5-year terms. In July 1994, Justice Department attorneys and a federal judge, Robert Maloney, cut 10 years from Dixon's sentence, causing his release that same year, after serving a fraction of his prison sentence. McBurney was scheduled for release shortly thereafter. The excuse used was good behavior. But there isn't much else that can occur in federal prison. It is a standard practice where the CIA or some other government agency is implicated and a defendant protects this relationship, that a reduction in prison sentence is promised and then carried out at a later date when media attention no longer exists. An inordinate amount of the huge savings and loan losses occurred in Texas, where the RDC recovered only about 5 cents on every dollar of the losses incurred. 6. Despite the many people committing the fraud, the RDC issued 115 Associated Press, December 1, 1993. 116 New York Times, July 23, 1994. 132. Only about 24 subpoenas as part of their investigations, which are necessary to follow the money trail to learn where the money went, such as bribes to politicians, kickbacks, money laundering to offshore bank accounts. The RDC did not issue any subpoenas in its investigation of 86 of 137 failed Texas savings and loans. Comparing this with the investigation into Madison Guaranty Savings and Loan as part of the Whitewater investigation, over 160 grand jury subpoenas were issued solely by special counsel Robert B. Fisk. Feeble investigations. If the RDC had issued the subpoenas required by the nature of the savings and loan crimes of the 1980s, it is probable that the involvement of the CIA and many political figures would have been identified. Also, the way the RDC handled the sales of the seized savings and loan assets made possible even more looting of the American taxpayers, as many of the same crooks purchased the seized real estate for pennies on the dollar. A New York Times article headed, "The R.2.C let crooked thrift owners get away," stated in part, the failures of the RDC to properly pursue the crooked parties, or to obtain maximum money for the seized thrifts, were too purposeful to be simply gross incompetence or negligence. Because of the involvement of people from both the Republican and Democratic parties, none pursued the needed investigations to determine where the enormous amount of money went in the gory looting of U.S. taxpayers. Roger Altman, involved in the Whitewater matter, was Deputy Secretary of the Treasury from April 1993 until March 1994, and within a month of taking that position he reversed the RDC's attempt to get Congress to extend the federal statute of limitations for prosecuting savings and loan wrongdoing. Altman said that the RDC no longer needed the extension, when actually this was obviously not correct, since there was virtually no investigation of the big-time wrongdoers. Altman commissioned a task force that issued a report to Congress defending the RDC investigations and belittled the loss to the American public by the Texas savings and loans. The New York Times article of July 23, 1994, stated that a former chief RTC investigator in Texas told Congress last month that this was a whitewash of a national scandal. Former Texas Senator Lloyd Bentsen and then Treasury Secretary, and Altman, campaigned against extending the federal statute of limitations, ensuring that many of the savings and loans thieves would be protected against criminal prosecutions, and that the recipients of the looted money not be discovered. Fraud was no secret. It is important to recognize that the looting of the savings and loans were a secret only to the people that would have to pay, and that is the American public. Thousands of government personnel, including investigators in the various divisions of the U.S. Department of Justice, including the FBI, the many CIA personnel throughout the United States, and others, could not have been unaware that this massive fraud was going on. Possibly the CIA involvement in the looting of the savings and loans, the HUD program, and other areas still to be described, was the reason that the criminal activities were covered up. 133. There is no more powerful government agency for cover-up and obstruction of justice than the people in control of the United States Department of Justice, the same people who covered up every major scandal and subversive activity described within these pages. I first discovered this practice while an FAA inspector, and in the subsequent years this obstruction of justice became even more obvious. Adding to savings and loan looting shortly before this book went to print, I started learning about another scam for which Americans will someday have to pay. This involved HUD mortgage insurance that was paid by the buyers in escrow for the full life of the loans. The money was then siphoned off and the insurance never purchased. Formerly, the buyer of HUD properties paid their insurance premiums on a monthly basis with their mortgage payments. But in 1983, the same Congress that made possible the looting of the savings and loans passed legislation known as HURA that required upfront payment for years of mortgage insurance premiums. The intended looting of these funds is the most probable explanation for this change. Massive theft of these funds then occurred, with government cover-up of the scheme. Among the companies involved in these activities were the American International Group, which was the head of hundreds of companies and trusts throughout the world. Among the reinsurance companies controlled by AIG were Transatlantic Holdings and Putnam Reinsurance. The HUD mortgages for which upfront mortgage insurance premiums were paid were put into pools of mortgage loans with Government National Mortgage Association, which were then sold off on the secondary market to investors. When large numbers of foreclosures occurred during the 1980s, huge losses were incurred when the mortgage insurance did not exist to pay for the financial losses. CIA asset Gunther Russbacher described to me how he discovered the scam while he headed the CIA's Red Hill Savings and Loan. They were using reinsurance companies with policy premiums that were never paid. Money was paid for the reinsurance, but it was never paid. The policy money, the premiums, were never paid into where the policies were active. American International Groups was one of the big ones. Transatlantic Holdings was involved, as well as Trans-Pacific Holdings. Maurice Greenberg, a close associate of Denver's Leonard Millman, headed some of these companies. Dublin International Insurance was part of AI. We insured Putnam and Company. Secrecy on the basis of national security. It is probable that the CIA involvement in this scam is what kept the Justice Department from prosecuting those guilty of the mortgage premium insurance fraud, using the national security excuse for withholding this knowledge from the public. As in other scandals, it pays to have friends in the right places to act as damage control. In 1997, according to Standard & Poor, former Senator from Texas, Lloyd Bentsen, and Carla Hills, were officials in the Department of Housing and Urban Development, keeping the lid on this scandal. Chapter 9. October Surprise. Presidential elections. It included payment of bribes to enemies of the United States who held 52 Americans prisoners, seized at the American Embassy in Tehran on November 4, 1979. Shiite Muslim militants attacked and seized the embassy in Tehran, taking the Americans hostage. The attack upon the American embassy occurred several months after the Shah of Iran was overthrown and power seized by the Ayatollah Khomeini. The American hostages were subjected to 444 days of brutal conditions, including mock executions. If this scheme had not been carried out, the Americans would have been released months earlier. Intent of the scheme. The intent of the scheme was to alter the presidential elections to bring about the defeat of President Jimmy Carter and to elect presidential nominee Ronald Reagan. This was accomplished by blocking the release of the American hostages, causing many Americans to be displeased with President Carter, increasing the chances that Carter would be defeated at the polls. Months of negotiations to effect the release of these hostages went on between the government of the United States under President Jimmy Carter and the government of Iran. Early in 1980, the U.S. tried a military mission called Operation Desert I to free the hostages, but it failed miserably in the Iranian desert, resulting in the deaths of 8 Americans. While the U.S. military was preparing another rescue try, simultaneously negotiating to obtain the hostages' release, the Reagan-Bush team sabotaged the efforts by making public the hostage rescue plans and warning the American people that Carter was preparing to exchange arms for hostages. One effect of these tactics that were part of October Surprise was the dispersal of the American prisoners throughout Iran, making rescue all but impossible. Or Surprise is the name given to a scheme that corrupted the 1980 October Surprise 35. Losing the election. If the hostages were freed, the American public was becoming increasingly disenchanted with Carter, affecting the outcome of the 1980 presidential elections. Analysts in the Reagan-Bush team estimated they would lose the election to President Jimmy Carter if the American hostages were released prior to the November 11, 1980, election. After the military rescue mission failed, the United States renewed negotiations for release of the 52 American hostages. The Iranians demanded that President Carter release U.S. military equipment that had been ordered and paid for by the Shah of Iran before Iran would release the hostages. Despite pressures against an arms for hostages swap, in mid-1980 President Carter secretly agreed to Iran's terms. Carter agreed to exchange $150 million in previously ordered and prepaid military equipment in exchange for the release of the hostages. Iran desperately needed the military equipment after Iraqi President Saddam Hussein attacked Iran in September 1980. Sabotaging the United States of America. While Reagan and his camp were charging Carter with an arms for hostage negotiations, the Reagan team, headed by former OSS officer William Casey, entered into secret negotiations with Iranian factions. Casey and other members of the Reagan-Bush team met secretly with Iranian factions, offering bribes in the form of money and U.S. arms if the Iranians continued the imprisonment of the American hostages until after the November 11, 1980, elections. A series of secret meetings were held between the Reagan-Bush team and the Iranian factions in European cities, with the final meeting occurring on the October 19, 1980, weekend in Paris. The Iranians demanded that either Ronald Reagan or George Bush personally appear in Paris to sign the final agreement. Carrying out this scheme required secrecy and massive cover-ups by many in the United States and in France. Various interests wanted Carter out. There were special interest groups wanting President Carter removed from office. Among them was the Central Intelligence Agency, which suffered serious losses to its clandestine operations when Carter ordered the dismissal of large numbers of CIA operatives in 1977. This wholesale firing of agency employees became known as the October Massacre. George Bush, who had CIA connections since the late 1950s, had been director of the Central Intelligence Agency in 1976 until Carter assumed the presidency and replaced him with Stansfield Turner. The Reagan-Bush team promised the Iranians billions of dollars of U.S. military equipment and $40 million in bribes to individual Iranians involved in the scheme. The Reagan-Bush team promised to include arms merchants in the lucrative deal and to include Israel as intermediary in the profitable arms sales. Carter had refused to deal through arms merchants. He limited the shipment of arms to what had already been purchased. Israel was not included in the sales. The secret and treasonous deal offered by the Reagan-Bush team profited everyone, it seemed. The only people who suffered were the 52 American hostages, held captive months longer, and the American people, who felt the fallout in many ways. 136. Included in Reagan campaign rhetoric was his promise to get tough with the Iranians, saying he would never negotiate with terrorists. Simultaneously, he and his group were bribing the Iranians to continue the imprisonment of the hostages. The plan worked. The American public believed the disinformation put out by the Reagan-Bush team. Americans, kept ignorant about the truth and dissatisfied with Carter's inability to get the prisoners released, elected a president and vice president who had engaged in a covert scheme involving the CIA. Within an hour of Reagan's inauguration on January 20, 1981, the Iranians allowed an aircraft to leave Tehran airport with all but one of the 52 American hostages on board. The flight was pre-arranged to take off immediately after the Iranians knew that Reagan and Bush had taken their oaths of office. The deal is off. When a White House aide told President Reagan that one of the hostages had not been released, Reagan was heard. To respond, tell the Iranians that the deal is off if that hostage is not freed. President Ronald Reagan and Vice President George Bush held widely televised homecoming celebrations for the American hostages, saying all the right things about the sufferings the hostages endured. Reagan never divulged that he and his team were responsible for many months of additional imprisonment and suffering. Neither the hostages nor the American people knew about the Reagan-Bush team conspiracy. It took the cooperation of many people in the United States and Europe to carry out the scheme. Israel's Mossad, acting as a well-paid middleman in the transfer of the arms from U.S. military warehouses to Iran via Israel, played a major role. Without their cooperation, the scheme probably would not have worked. It also required the cooperation of the French Secret Service and the government of France, which provided security for the secret Paris meetings. It required the cooperation of officials and people in the Central Intelligence Agency, the U.S. Department of Justice, including the FBI, Secret Service, U.S. attorneys, the Department of State, many members of Congress, among others. It also required the media to cover up. My CIA sources said that the $40 million bribe money came from the committee to re-elect the president. Damage control. Many participants in the October surprise scheme were rewarded with key positions in the U.S. government. Many of these same people engineered or became part of other major scandals that were likewise kept from the American public. The October surprise plot was the genesis to the Iran-Contra affair, and indirectly to the INSLAW, BNL, and Iraq-Gate scandals. To protect the incoming Reagan-Bush team and the many federal officials and others who took part in October surprise, the Reagan-Bush team placed people, including those implicated in the activities, in control of key federal agencies and the federal courts. Some, like attorneys Stanley Sporkin, Lawrence Silberman, and Lowell Jensen, were appointed to the federal bench, defusing any litigation arising from October Surprise or its many tentacles. Attorney William Casey was appointed director of the Central Intelligence Agency. Attorney Edwin Meese, Reagan's campaign manager, was appointed to the highest law enforcement office in the United States, U.S. Attorney General, ensuring that there would be no prosecution of the group. Organized crime never had it so good. The facts slowly surfaced. Although the details of the secret agreement were known throughout Europe, the establishment media in the United States kept the lid on the scandal. But the facts started coming out. A Miami Herald article 8 related statements made by CIA operative Alfonso Chardy describing a secret meeting in early October 1980 between Richard Allen, Lawrence Silberman, Robert McFarlane, and Iranian factions. Allen was foreign policy advisor to President Reagan, and Robert McFarlane was an aide to Senator John Tower on the Senate Armed Services Committee. In 1987, Abul Hassan Bani Sadr, the president of Iran during the hostage negotiations, wrote a book published in Europe. 9 describing his knowledge of the October Surprise scheme. The information he had received as president disclosed the secret agreement with the Americans, even though he was kept out of the loop by Hashemi Rafsanjani, one of Khomeini's chief lieutenants and later Speaker of the Iranian Parliament. In 1988, Playboy magazine published an in-depth article on the October Surprise scheme. In what would become a pattern of killings that coincidentally protected high U.S. officials, one of the authors, Abby Hoffman, was killed shortly after bringing the article to Playboy. The 8-page article, An Election Held Hostage, detailed many of the events surrounding the scheme, as did a 10-page Esquire article entitled October Surprise. A former member of the Reagan-Bush election team, later a member of the White House staff, Barbara Honegger, authored a 1989 book October Surprise, * degree based upon knowledge she gained as a White House insider and subsequent investigator. Honegger left the Reagan camp when she became disillusioned with certain practices. Living in Monterey, California, she and a friend, Raelan Dyer, worked together researching the October Surprise story. Raelan was the widow of a former professor and dean of the physics department at the Naval Postgraduate School in Monterey, California. She later married a deep-cover, high-ranking officer in the Office of Naval Intelligence, Gunther Russbacher, who was assigned to the Central Intelligence Agency. Unknown to her at the time, her new husband played a key role in the October Surprise operation. Ironically, she initially found out from me about her new husband's role in the matter she and her friend, Honegger, had investigated. More about this in later pages. In 1991, Bani Sadr authored another book describing the October Surprise operation, this time published in the United States, My Turn to Speak. On April 15, 1991, Frontline aired a television show addressing the October Surprise, which was followed the next day by an article in the op-ed section of the New York Times written by Gary Sick, describing his knowledge of October Surprise. Sick authored a book published in 1991 that copied Barbara Honegger's title, October Surprise 2. Both October Surprise ebooks relied upon statements made by dozens of people who were part of the operation or witnesses to it, and who had nothing to gain and much to lose by disclosing what they knew. Ari Ben-Menashe, a former member of Israel's secret intelligence agency, the Mossad, described in his 1991 book Prophets of War the role he and the Mossad played in October Surprise, including meetings he attended in Madrid, Barcelona, and Paris. Ben-Menashe was heavily involved in various secret activities with the Mossad and the CIA, and was one of the first to expose the Iran-Contra activities, for which October Surprise served as the genesis. Ben-Menashe stated that he was a member of the Mossad's advance team working with the French government, which arranged meetings between William Casey, George Bush, and the Iranian factions, including the meetings on the October 19, 1980, weekend in Paris. Ben-Menashe related that he and others on the Israeli team stayed at the Paris Hilton Hotel, meeting with various members of the Iranian factions, while waiting for George Bush to arrive from the United States. He stated that on Sunday, October 19 at approximately 11 a.m., the Ayatollah Mehdi Karoubi and his bodyguards appeared in a room on the upper floor of the Hotel Ritz, where Israeli and French intelligence agencies were waiting for Bush to arrive. They were followed several minutes later by George Bush and William Casey. The meeting lasted about 90 minutes and a final agreement was reached, whereby the Iranians were to be given $40 million bribe money and large quantities of arms would be sold to them. In exchange, the Iranians would continue to imprison the 52 Americans until after the November 1980 presidential election and the January 1981 inauguration. Justice Department obstruction of justice. CIA contract agent Richard Brannicky testified in U.S. District Court at Denver in 1988 on behalf of another CIA contract agent, Heinrich Rupp. The purpose of the testimony was to show that Brannicky's friend, Rupp, was a CIA contract agent, and that the offenses for which Rupp was being charged were offenses committed under orders of the CIA. Justice Department prosecutors had charged Rupp with money offenses at Aurora Bank in the Denver area. During Brannicky's testimony, he described other CIA activities, including his role in the October 19, 1980, weekend flights to Paris, in which both Brannicky and Rupp took part. Brannicky testified that he saw George Bush and Donald Gregg in Paris on the October 19, 1980, weekend. Brannicky had nothing to gain by revealing the October surprise scheme, and much to lose if he was lying. Justice Department officials already knew of the October surprise activities. U.S. Attorney General Edwin Meese had been on the Reagan-Bush presidential campaign and knew of the criminal activities. Now he held the top law enforcement spot in the United States. Instead of performing his duty, he engaged. 121 Random House. October Surprise 139. In many criminal acts, including cover-up, aiding and abetting, misprision of felonies, obstruction of justice, subornation of perjury, and others. He then compounded these crimes by falsely prosecuting an informant to silence and discredit him, compounding his earlier obstruction of justice. Instead of prosecuting the guilty people in the October surprise scheme, Justice Department officials and prosecutors responded to Brannicky's testimony by charging him with perjury for making the statements to the court. This false charge made Justice Department attorneys guilty of felony persecution of an informant under federal criminal statutes, 22 felony cover-up, and obstruction of justice. Justice Department subornation of perjury. The perjury trial was conducted in Portland, Oregon, where Brannicky resided. Justice Department prosecutors brought Donald Gregg, then ambassador to South Korea, to testify that he was not in Paris on the October 19, 1980, weekend, even though the prosecutors knew Brannicky was telling the truth and that Gregg was lying. They encouraged Gregg to lie under oath, testifying that he was swimming at a beach in Maryland with his family on that weekend. Justice Department prosecutors produced pictures of Gregg and his family in bathing suits on the beach in bright sunshine. They knew the snapshots they were submitting to the court were not taken on that cold October 19 weekend. Encouraging someone to commit perjury is the crime of subornation of perjury. Brannicky's attorney called a witness from the Weather Bureau who testified that the sky was overcast during that entire weekend. Justice Department prosecutors produced 2 Secret Service agents. 3 to testify that Bush never left the Washington area during the October 19, 1980, weekend. But they were vague in their testimony and failed to produce the Secret Service logs showing Bush's activities during a 21-hour period from Saturday afternoon to Sunday evening. The Secret Service agents could not state where Bush was from 9:25 p.m. on Saturday, October 18 until Sunday at 7:57 p.m. My CIA sources told me that several Secret Service agents were on board the BAC-111 aircraft that flew Vice Presidential nominee George Bush to Paris during the missing 21 hours. Secret Service records, if they are accurate, indicate that Bush gave a speech at 8:40 p.m. on Saturday, October 18, 1980, at Widener University in Delaware County, Pennsylvania, and then did not show where Bush was until Sunday night, October 19, 1980, when Bush gave his speech to the Zionist Organization of America at the Washington Hilton Hotel, arriving an hour late for his 7:30 p.m. scheduled appearance. I obtained sequestered Secret Service documents showing Bush flying into Washington National Airport at 6:37 p.m. Sunday evening. Perjury by the Secret Service? In addition to lying about Bush's whereabouts, the Secret Service agents testifying in Brennicke's trial withheld the fact that several Secret Service agents were on the plane that carried Bush to Paris during that October 19, 1980 weekend. Blackmail of the United States. As could be expected, when the Reagan-Bush team took office they were then subject to blackmail by Iran, Iraq, Israel, and anyone who had knowledge of October Surprise. After Reagan and Bush took office, the Iranians received huge quantities of military equipment, many times more than they could have received had they completed the agreement with the United States government under President Carter. In 1982, the Reagan-Bush team took Iraq off the list of terrorist states despite the strong protests of intelligence organizations in the United States and Europe. Israel received huge quantities of military supplies and aid, much of it unknown to the American public, who will be paying the bill for years. October Surprise also adversely affected the military preparedness of the United States and its European allies. To obtain the arms for Iran promised at Paris, military equipment was stolen from U.S. warehouses in Europe and sent to Iran via Israel. CIA confidential sources. In later pages, I describe how I met the CIA sources who gave me many of the specific details of the October Surprise scheme. Briefly, they told me in their sworn declarations that October Surprise was primarily a CIA operation, engineered and carried out with CIA personnel and funds. William Casey, a private citizen and covert CIA operative, met several times with Iranians at different European locations in 1980. One of the key meetings occurred at the PepsiCo International Headquarters building in Barcelona, Spain in late July 1980. One of my CIA sources was present with Casey at that meeting, arranging for procurement and shipment of the arms from various European locations to Iran via Israel. The final meeting occurred in Paris on the October 19, 1980, weekend. Bush flew to Paris from the United States on October 18, 1980, on a BAC 111 owned by a member of the Saudi Arabian family. My CIA contacts have said that the pilots on that flight were Gunther Russbacher, Richard Brennicke, and an Air Force major. The BAC 111 reportedly departed Washington National Airport for nearby Andrews Air Force Base on Saturday evening, October 18, 1980. It then departed Andrews at approximately 1900 hours p.m. EST, *4 for an airport on Long Island in the New York City area, arriving there at 1945 p.m. The BAC 111 landed shortly before the arrival of a Gulfstream jet owned by UNOCL, from which William Casey deplaned. Casey then joined the passengers on the BAC 111 for the flight to Paris. The BAC 111 departed Mitchell at 2000 hours p.m. for Gander, Newfoundland, arriving there at 21:20 p.m., where it refueled for the flight over the North Atlantic. It departed Gander at 21:40 p.m. EST for Paris, arriving at Le Bourget Airport at 3:40 EST. UNOCL's Gulfstream flew non-stop from Mitchell Field to Paris and was waiting at the airport in London when the BAC 111 arrived. Heinrich Rupp was one of the pilots on the UNOCL Gulfstream. In Paris, the plane was met by a fleet of limousines to carry the passengers to their destinations. George Bush and William Casey went straight to the meetings then in progress. At the Paris meetings were numerous Iranians and members of Israel's Mossad, including Ari Ben-Menashe. A $40 million bank draft on a Luxembourg bank was given to the Iranians as bribe money and a part of the overall agreement, which consisted also of the shipment of arms to Iran. CIA operative Michael Reconassi Utto played a key role in arranging for the wire transfer of these funds. Because it was necessary for Bush to return to the United States quickly in order to attend a late Sunday evening speech at the Washington Hilton Hotel, the CIA provided an State Route 71 aircraft. This plane departed from a military field near Paris at approximately 1450 European time and took approximately 1 hour and 44 minutes to McGuire Air Force Base in New Jersey, arriving there at approximately 10:50 a.m. EST. Later that day, Bush boarded the same BAC 111 that had taken him to Paris and then flew into Washington National Airport. The Secret Service reports that I obtained showed Bush arriving at Washington National at 6:37 p.m., in the BAC 111 and then proceeding with Secret Service escort to the Washington Hilton Hotel, where he gave a speech. CIA code name for October Surprise. As will be explained more fully in later pages, most CIA operations have code names, and the code name for the CIA October Surprise scheme was Operation Uravan. Strong circumstantial evidence showing October Surprise existed, even discounting testimony from the many people who were involved in one way or another with October Surprise. The circumstantial evidence is far in excess of that used by federal and state prosecutors to convict a person of a crime or to sentence the person to death. The facts exposed by investigative media articles and books were of sufficient magnitude to make President Nixon's Watergate cover-up child's play. The factors indicating that October Surprise did in fact occur include: 1. Statements by former President of Iran, Bani Sadr, whose 1987 and 1991 books detailed the secret agreement between Iranian factions and the Reagan-Bush team. 2. Statements of numerous people given to Barbara Honegger and quoted in her 1989 October Surprise, enlarged upon what she learned as part of the Reagan-Bush team. 3. Statements of numerous people given to Gary Sick and quoted in his 1991 October Surprise. 4. Sworn testimony by CIA contract personnel Richard Branicki and Heinrich Rupp in the U.S. District Court at Denver in 1988. 142. 5 statements of numerous people given to the authors of various newspaper and magazine articles. 6 statements made to the press by Ari Ben-Menashe, a former high-ranking Mossad staff officer, who was present at several of the secret October Surprise meetings. 7 circumstantial evidence in the sequence of events that occurred, including the sudden withdrawal of Iran from further discussions when the United States under President Carter agreed to the terms proposed by Iran, and the release of the American hostages within minutes of President Reagan's inauguration. 8. The implications of guilt by the pattern of cover-ups. This is not the end of the October Surprise matter, more follows. Gunther Russbacher. Chapter 10. CIA Whistleblowers. Formerly employed by various U.S. intelligence agencies, some of whom had been silenced by Justice Department prosecutors and federal judges. Over a period of 6 years, and continuing at this time, over 1,000 hours of deposition-like questioning of these people occurred, divulging government corruption beyond the wildest imagination of the average American. These people divulged to me the specifics of deep-cover criminal activities that were and are inflicting unprecedented harm upon the United States and the American people. Despite my personal knowledge of government corruption, commencing while I was a federal investigator, I would probably not have believed what I was told if such a great amount of time had not been expended obtaining specifics and confirmation from other deep-cover sources. Much of what they told me was supported by documentation. Further, highly detailed and documented exposé books and articles helped support the existence of this misconduct. Ironically, it was the corrupt actions by renegade Justice Department attorneys and federal judges in the Ninth Circuit Federal Judicial District, 3. that brought me into contact with these people. One of the standard tactics employed to keep the lid on the various scandals and to silence or discredit whistleblowers is to falsely charge the person with a federal crime. This is usually followed by seizing his or her assets, depriving the person of funds for legal defenses. Court-appointed attorneys are then furnished, who routinely provide a weak defense so as to protect those in power. Justice Department persecution backfired. Justice Department prosecutors and federal judges tried to silence me by the sham judicial action in the California courts and the voiding of all state and federal protections needed to defend against the scheme. When I sought to protect 144 myself, the coalition of corrupt Justice Department prosecutors and federal judges sentenced me to prison, just as they did when I sought to expose the criminal activities in which they were involved. There is a certain risk in sending a citizen to prison who is determined to blow the lid on these subversive and criminal acts and who is also an author. Virtually nothing has been written about whistleblowers or concerned citizens who blow the whistle on hardcore criminal acts by federal personnel, especially federal judges and their legal cohorts in the Justice Department. All whistleblowers fare poorly, but none fare as badly as those who expose corruption in the powerful Justice Department and federal judiciary. It was in prison that many former CIA contract agents educated me about corrupt CIA and Justice Department activities. I met people in prison who, incarcerated for various political reasons, were former CIA operatives or assets operating covert CIA proprietaries, including airlines, banks, and savings and loans. Either their CIA cover was exposed and the CIA and Justice Department chose to make them scapegoats, or the imprisonment was to agents potential whistleblowers or witnesses. Whatever the reason, CIA and Justice Department officials acted in unison with federal judges, eliminating people who constituted a threat of exposure. The standard tactic is to charge the targeted individual with a federal offense for some act they were ordered to perform by their CIA handlers, deny them adequate legal counsel, deny them the right to have CIA witnesses testify on their behalf, and deny to them the right to present CIA documents. A standard and sham excuse for denying these defenses is that they are not relevant to the immediate charge, when the matter of who gave the person his or her orders is absolutely relevant. From 200 to 300 former CIA operatives or contract agents had been sentenced to prison by Justice Department prosecutors during the 1980s on charges arising out of the covert activities they were ordered to perform by their CIA bosses. It was their unanimous belief that the prosecution of these CIA operatives was either to silence them or to discredit them if they talked about the operations. It was in prison that I first met Gunther Russbacher, a CIA deep cover high-ranking operative. The hundreds of hours of statements given to me by Russbacher, and my book writing and radio and television appearances, brought me into contact with other former deep cover personnel and investigators. The 1,000 and more hours of information gathered during the last few years revealed a convoluted web of intrigue that is bizarre, and irrefutable. Compounding the judicial persecution, if the facts in these pages ever motivate enough people to rebel and throw out the crooks, a tongue-in-cheek gratitude should be given to the crooked judges and Justice Department attorneys that sent me and others to prison to silence us. And these should especially include U.S. District Judge Marilyn Patel at San Francisco, one of the most corrupt judges I have ever encountered. Her retaliation against me for reporting the criminal activities in Chapter 11 courts made it possible for Russbacher and me to meet. CIA Whistleblowers 145. Gunther Karl Russbacher. Russbacher's parents were members of the Habsburg Group of Austria, and his father was an Austrian in German intelligence during World War II. In 1950, the U.S. government offered many of these intelligence officers the choice of either being prosecuted for war crimes or going to the United States and infiltrating various U.S. intelligence agencies. Russbacher's parents were among those who accepted the move to America. In 1950, the Russbacher family moved to the United States, living in Oklahoma City, Oklahoma, and then went to Fallon, Nevada. When Russbacher reached the age of 17, he entered the U.S. Army, later joining the U.S. Navy, and in 1967 received his Navy pilot wings at Pensacola. He then went on to the Naval Air Station at Jacksonville, Florida. Approximately a year later, Russbacher received pilot training in the State Route 71 at Bale Air Force Base and flew many State Route 71 missions for the CIA. During his CIA activities he was given numerous aliases and service and social security numbers. In 1969, Russbacher was attached to the Office of Naval Intelligence and Sheepdip 232 into the Central Intelligence Agency. He had 2 tours of duty in Vietnam. During his first tour, as a fighter pilot, he was shot down and returned to Fitzsimmons Hospital in Denver for extensive hospitalization. Upon his discharge from the hospital, the CIA sent Russbacher back to Vietnam, where he engaged in various covert activities, including attempting to rescue prisoners of war. During one of these attempts, he was caught and spent about a year in a North Vietnam prison camp until he again escaped. During his imprisonment, Russbacher was tortured, including pulling out his fingernails. The CIA sent Russbacher to Afghanistan in the early 1970s, helping the Afghan fighters against the Russian-backed Kabul government. During this period he helped transfer CIA funds to the newly created Bank of Credit and Commerce International. These CIA funds, and those supplied by Bank of America, were a significant source of capital for that bank. The CIA then put Russbacher into the financial field, starting in Operation Cyclops, a program where CIA operatives are placed into financial institutions to learn the business. He subsequently started up and operated during the late 1970s and 1980s several covert CIA proprietaries in the United States, including savings and loans, mortgage companies and investment companies, dealing in money laundering and other covert CIA activities. For more than 2 decades of CIA operations, the CIA had given him over 30 aliases for different covert operations. He also had various nicknames including Gunsel and Gunslinger. When undergoing flight training in the State Route 71, including at Bale Air Force Base, he used the alias Robert Beller, and the rank of an Air Force LT. Colonel. When operating covert financial institutions, his usual alias was Emery J. Pedden with occasional use of Robert Andrew Walker. 146. Or both. When he wanted to control 2 positions within a company, he used 2 different aliases. With Red Hill Savings and Loan and Hill Financial, he used Emery J. Pedden for his role as chairman of the board and Robert A. Walker as chief executive officer. He also used his real name, Gunther Russbacher. Russbacher and I spent hundreds of hours dissecting the mechanics of CIA operations during the past 4 years, some of it sworn declarations when I thought to ask, and I received numerous written declarations from him. Russbacher described some of the CIA-affiliated companies or fronts that he operated and their covert business activities. He also mentioned moving money from Silverado Bank Savings and Loan in Denver to start up other covert CIA operations, including Red Hill Savings and Loan and Hill Financial in Red Hill, Pennsylvania. Several times during the years, Russbacher expressed regret to me for having committed some of the things that he was ordered to do by his CIA bosses, including his role in assassinations, both in foreign countries and in the United States. As I became a confidant to other deep-cover high-ranking CIA/ONI operatives, I learned that assassination teams were part of their official activities and not simply done by rogue elements. Russbacher described the various factions operating within the CIA, each with its own agenda and often running similar parallel operations. He fell out of grace with the CIA in the late 1980s for various reasons. Because of Russbacher's role in many CIA activities that implicated high federal officials and his knowledge of criminal activities by the CIA, federal judges, Justice Department officials, and others, Russbacher posed a serious threat to those in control of key segments of the federal government. He was the smoking gun in many national scandals, the exposure of which could create a national emergency. Sequence of sham charges. In late 1986, the state of Missouri filed charges against Russbacher for allegedly writing checks to an alias, upon an account that had inadvertently closed, for allegedly defrauding several people out of $20,000, when the money had actually been returned to them, and for allegedly selling unregistered securities. These alleged offenses occurred while he was operating a CIA proprietary known as National Brokerage Company in Clayton, Missouri and Southwest Latex Supply. Russbacher said that no one ever lost any money since people were always compensated for their losses. The charges were not pressed, and Russbacher was not arrested. In August 1989, Russbacher used a CIA Learjet based at Hayward Airport in California to fly his prospective bride from Seattle to Reno, where they were married, and then back to Seattle. Personal use of government aircraft is not exactly an unknown event, but in this case Justice Department prosecutors, representing Faction 1 of the Central Intelligence Agency, chose to charge him with misuse of government aircraft and fuel. Over a period of years I learned of many instances where one government agency seeks to charge an agent of another agency with a federal crime. Another reason for charging Russbacher with an offense was that he married shortly after signing his latest CIA secrecy agreement, in which he agreed not to marry for the next 2 years. On August 30, 1989, Russbacher married Ray Allan. CIA whistleblowers 147. Dyer, the widow of a former professor 23 at the Naval Postgraduate School in Monterey. Among the naval personnel that Ray Allan had met at the school while her husband was alive was Gunther Russbacher, having first met him in 1982. Several weeks before the marriage, Russbacher requested permission to marry from his CIA bosses. Permission was necessitated by his CIA secrecy agreement barring him from marrying for 2 years after its latest signing. Russbacher was verbally advised that this approval would probably not be forthcoming because Ray Allan was an activist of the 1960s and had sought to expose the October Surprise operation in collaboration with Barbara Honegger, who authored the book, October Surprise. Ray Allan had met Russbacher for the second time in August 1989 while she was traveling in Oregon with her mother, Bess Smith. Several days later, Russbacher called and proposed marriage. After she accepted, Russbacher called the crew of a CIA proprietary aircraft charter operation, Jet Charter International, based at Hayward, California, instructing them to pick him up at Sacramento Municipal Airport and fly him to Boeing Field in Seattle. After the plane was serviced by Flightcraft in Seattle, the Learjet departed for Reno with Russbacher and Ray Allan on board. After arriving in Reno they were married, and immediately flew back to Seattle. From Seattle the Learjet pilots, Don LaCava and Jan Pearson, both of whom had served with Russbacher in Central American activities, flew to Modesto, California. The Russbachers then drove to Bess Smith's home in Newman, California. Within days after the marriage, FBI agents burst into Bess Smith's home in Newman, arresting Russbacher, falsely charging that he kidnapped his wife's niece, Jennifer Smith. 734 The FBI agents told Ray Allan and her mother that Russbacher was a con artist, marrying women all over the country and then taking their money. The FBI agents stated that Russbacher was committing all types of fraud throughout the United States. They stated he had no association with the government and was a pathological liar. The FBI agents were so convincing in their lies that they almost had Ray Allan convinced. The kidnapping charges were dropped on December 1, 1989, but the state of Missouri took custody of Russbacher on 1986 charges that he had misappropriated $20,000 through bad checks and sold securities without registering the transaction with the state. Russbacher was denied bail. During trial, the judge declared a mistrial. Waiting for the next trial, which was repeatedly delayed, Russbacher remained in the harsh surroundings of St. Charles County Jail in Missouri. His attorney, Timothy Farrell, and the Missouri County prosecutor, John P. Zimmerman, pressured Russbacher to sign a plea agreement, claiming it would put all of the charges behind him. Russbacher verbally agreed to an Alford agreement, or nolo contendere, wherein Russbacher did not plead guilty but agreed to certain conditions to avoid trial. Russbacher's attorney appeared more interested in appeasing the judge and the prosecutor and failed to provide the defenses expected of even a half-baked attorney. When Russbacher entered the courtroom on July 16, 1990, the terms in the written plea agreement, which he had never seen before, were very different from what his attorney and the prosecutor had stated earlier. Russbacher was pressured to sign the agreement, stating he would then be set free. Under the pressure of a year in a county jail and the promise of a return to his CIA status, Russbacher signed the papers. During questioning by Judge Lester Duggan, Jr., Russbacher told the judge that he was not pleading guilty but exercising an Alford plea. but the judge entered into court records that Russbacher pled guilty to the offenses. Unaware of the pitfalls of probation, the wording of the plea agreement was such that he could be incarcerated again whenever it suited Missouri prosecutors, who were working hand in hand with Justice Department and CIA personnel. Russbacher either did not realize it at the time, or he was desperate to get out of jail. The terms of the plea agreement required Russbacher to remain silent concerning any CIA activities. Under the terms of the probation agreement, Russbacher could be returned to prison to serve 21 years, even though there was never a trial on the original charges, if he violated any of the terms of the plea agreement. Almost anything he did for the CIA violated the conditions of the plea agreement, including trips outside of the St. Charles area and failure to report regularly to his probation officer. No snitching. One paragraph of the plea agreement was obviously meant to keep Russbacher from testifying at any congressional or other government inquiry. Paragraph number 5 read, that the defendant enter into no agreements with any governmental or other agency to provide information concerning crimes or bad acts. No snitching for anyone. This agreement was signed by the Missouri Assistant Prosecuting Attorney, John P. Zimmerman, by Russbacher's attorney, Timothy Farrell, and St. Charles, Missouri Judge Lester Duggan, Jr. This was another version of the tactic that federal judges and Justice Department prosecutors inflicted upon me, seeking to silence my exposure activities. The terms of the plea agreement were also spelled out in a July 2, 1990, letter by St. Charles County Assistant Prosecuting Attorney John P. Zimmerman to Russbacher's attorney, repeating the exact words in the plea agreement. There was a determined effort to silence Russbacher, using state officials to carry out the intent of federal officials. Item number 7 provided that Russbacher not leave the St. Louis area without written permission from his probation officer. But Russbacher's CIA duties required that he immediately leave the area, which he did. The plea agreement also required Russbacher to make weekly reports to the probation officer, which he never did. Nothing was said about it until several years later when Justice Department officials wanted to silence Russbacher. Ultra-secret operation. The CIA had an important task for Russbacher to perform upon leaving prison. He was needed for an ultra-secret project associated with the Bush administration's dealings with Iraq's Saddam Hussein. The signature of Russian President Mikhail Gorbachev was needed on a secret agreement prepared and signed by President George Bush. Russbacher stated that the agreement provided that Russia not intervene if the United States attacked Iraq in the near future. Russbacher spoke Russian, had been assigned to the U.S. Embassy in Moscow in the 1970s and mid-1980s, and knew President Gorbachev personally. The signature and agreement had to remain secret. Russbacher's handlers instructed him to proceed to Offutt Air Force Base for a top-secret briefing. Immediately upon release from prison at St. Charles, Missouri, on July 16, 1990, Russbacher and his wife drove to Offutt Air Force Base. They arrived there on July 18, where SINPOC authorization permitted them to occupy living quarters at this high-security Air Force Base. Russbacher was briefed about the mission in which he was to be involved. Among those present at the meeting were Brent Scowcroft, National Security Advisor, and CIA Director William Webster. Gunther Russbacher and his wife departed Offutt on July 21, 1990, driving to Reno, where they stayed at the Western Village Inn and Casino in nearby Sparks, awaiting further orders. Late in the afternoon on July 26, 1990, Russbacher boarded a CIA Learjet at Reno, which took him to Crow's Landing Naval Air Station, where 4 CIA State Route 71 aircraft were being readied for a non-stop flight to Moscow, carrying out the plans reached at Offutt. Russbacher described the in-flight refueling of the SR-71s on their transpolar flight to Moscow, with the first one occurring northeast of Seattle and the second refueling by Russian tankers as they approached the USSR. Russbacher identified one of the passengers in the State Route 71s as National Security Advisor Brent Scowcroft. Russbacher was the only person on the 4 aircraft who spoke Russian, and his previous contacts with Gorbachev was valuable to the success of the mission. Russbacher told me of handing the secret agreement to Gorbachev, obtaining Gorbachev's signature on one of the agreements, and then flying back to the United States, along with 2 of the other CIA aircraft. One State Route 71 was left for the Russians, along with a flight crew to check out Russian pilots. It is believed that one of the flight instructors was a former Air Force chief flight instructor from Vail Air Force Base in Marysville, California, reportedly Abe Cardun. The aircraft refueled twice in the air on the return flight, and the 3 SR-71s landed at Fallon Naval Air Station on July 26, 1990. On July 25, 1990, the day before Rusbacher obtained Gorbachev's signature, U.S. Ambassador April Glaspie assured Iraq's Saddam Hussein that the United States had no interest in its conflict with Kuwait. These assurances were interpreted by Saddam Hussein as clearance to invade Kuwait, which he did several days later. This sequence of events almost suggests that Saddam Hussein, 150, was encouraged to attack Kuwait while the United States waited to retaliate. Upon landing at Fallon Naval Air Station, a Navy helicopter flew him to Reno, at which time he took a cab to the motel where his wife was waiting. While at the motel waiting for further instructions from his CIA bosses, Rusbacher received telephone instructions on July 28 from Admiral George Raeder, instructing him to report to Castle Air Force Base for a debriefing on the Moscow flight. Raeder further advised Rusbacher that he would be promoted from captain to rear admiral, and that Rusbacher should get the proper uniform and a rear admiral's cap at nearby Fallon Naval Air Station, which he did. Bizarre as the Moscow flight sounds to people living a normal life, it must be remembered that the CIA deals in the bizarre. I talked to Ray Alan, who saw the CIA Learjet and 3 CIA SR-71s land. She saw Rusbacher enter the Learjet, which immediately departed. I talked to Bess Smith, Ray Alan's mother, who lived in Newman, near the Crow's Landing Naval Air Station, and who was present at the Navy base during the preparation of the SR-71s. She saw Rusbacher get in one of the aircraft. During the debriefing at Castle Air Force Base, she was in one of the adjoining bedrooms and saw the people receiving the debriefing from Rusbacher. The answers Bess Smith gave to my questions showed she wasn't fabricating what she saw. She was a kind, motherly person, who could not fabricate the facts that she witnessed. I also talked to the State Route 71 pilot and former instructor at Vail Air Force Base, Abe Cardun of Tacoma, Washington. Cardun, while being circumspect, made statements indicating he was one of the pilots on the flight and that he was the State Route 71 instructor who remained behind in Moscow to check out the Russian flight crews. The Rusbachers arrived at Castle Air Force Base on July 29, 1990, and SINPOC authorization was again waiting from the Navy, permitting them to be billeted there for several days. Rusbacher's CIA handlers debriefed him in his apartment-size accommodations while Ray Alan and her mother were sleeping in one of the 2 adjoining bedrooms. After the debriefing, Rusbacher waited to receive his promotion to Rear Admiral. Up to this point he had not worn his Navy uniform, which was hanging in the closet in a protective bag. While Rusbacher debriefed his CIA people, Bess Smith walked into the kitchen from her bedroom and exchanged greetings with the people there. On July 31, 1990, the morning after the late evening debriefing, FBI agents burst into their living quarters, arrested Rusbacher for allegedly impersonating a naval officer. He was then incarcerated at the Fresno County Jail while awaiting trial. Justice Department prosecutors soon dropped the charge, but U.S. Attorney David Levi at Sacramento filed new charges. He alleged that Rusbacher misused government aircraft, fuel, military facilities, and purchase orders associated with the flights to Seattle and Reno when Rusbacher married Ray Alan. During the trial, FBI agent Rich Robley testified that Rusbacher had worked for the government, and it looked favorable for an acquittal. Before reaching the jury, U.S. District Judge Leonard Pierce declared a mistrial, which was followed by months of delaying tactics by Justice Department prosecutors as they prepared for another trial. Meanwhile, Rusbacher languished in jail. When Rusbacher stated he would fight the charges, U.S. Attorney David Levi threatened to charge Russ Batcher's wife and mother-in-law with unlawfully trespassing on Offutt and Castle Air Force bases and requests 6 months in prison for each of them. Despite the constitutional requirement of a jury trial, federal judges have held that 6 months imprisonment permits eliminating that constitutional protection, allowing federal judges to imprison a citizen without a jury trial. In this way, a federal judge, who is often a former Justice Department attorney and usually works in unison with the prosecuting attorney, can sentence a person to 6 months in prison on fabricated charges. This 6 months imprisonment often destroys a person financially and inflicts great personal harm upon the individual and family. This unconstitutional imprisonment without a jury trial occurs frequently. It was done to me in retaliation for reporting the federal crimes in which federal judges and Justice Department attorneys were implicated. The U.S. Attorney promised Russ Bacher that he would receive only a 3-month prison sentence if he pled guilty, and Russ Bacher agreed. However, U.S. District Judge Pierce refused to honor this agreement and sentenced Russ Bacher to 20 months in prison. After several months in the county jail, Russ Bacher was transferred to the federal prison camp at Dublin, California. That is where I met him. Russ Bacher and I had a good relationship, possibly due to our prior Navy piloting background. At first, Russ Bacher was very guarded in what he told me about CIA operations. He described his activities in Central America with the CIA, including Oliver North's involvement, and the disdain that CIA and other people had for North's incompetence and involvement in drug trafficking. My life wouldn't be worth a nickel. At first, there were many CIA operations Russ Bacher wouldn't disclose to me. When I pressed him for details, he stated, "My life wouldn't be worth a nickel if I talked about the hush-hush things." A few weeks after we had met, I was released 2:35 December 10, 199-0236 and returned to my home in Alamo, California. Russ Bacher started calling me from prison, and our discussions about CIA and other covert activities continued. Much of the time I asked specific questions about CIA activities and he responded, similar to a deposition. I thought that Jay had discovered major criminal activities while an FAA investigator, but it was child's play compared to what I subsequently learned. Through my contacts with Russ Bacher, I became acquainted with other deep-cover CIA operatives and contract agents, DIA personnel, and former police and private investigators. This small group had information about virtually every dirty covert activity of the CIA. The education was priceless and made possible the exposures described within these pages. Russ Batcher's health problems necessitated his transfer to the federal prison at Terminal Island near Long Beach, California. But our almost daily telephone conversations continued, going further into CIA activities in which he had been involved. Russ Batcher's CIA status and his credibility were proven to me not only by the hundreds of hours of questioning but by the statements given to me by other deep cover operatives or contract agents, some of whom hadn't seen Russ Bacher for years. October surprise rumors about the October surprise scheme started surfacing in the media in late 1990, causing me to ask Russ Bacher if he had any knowledge of it. He replied that he was well familiar with the details and that he was part of the operation. But he would only make a few general statements about it. But this suddenly changed. During an early morning telephone conversation on April 30, 1991, Russ Bacher said that 3 Office of Naval Intelligence officers were coming to Terminal Island that afternoon and he would be flying with them to Monterey, California on a special assignment. The flight from Long Beach to Monterey would be in a Learjet, after which a Navy helicopter from the Naval Air Station at Alameda, California would take them to Fort Ord and then on to Santa Cruz, landing at the college. Russ Batcher's CIA faction occasionally extracted him from prison for short periods of time. But something happened. Shortly before midnight, my telephone rang. It was Russ Batcher's wife, Raelan. She sought my help to determine if her husband was on a helicopter that reportedly crashed several hours earlier at Fort Ord. She had been expecting her husband to arrive at Santa Cruz by Navy helicopter, and when she saw on television that a helicopter had crashed at nearby Fort Ord that evening, she became worried. Rayolan had contacted a friend who was CIA chief of station at St. Louis, nicknamed Rabbit, who in turn phoned an FBI contact in California. The CIA station agent then called Rayolan, advising her that a Navy helicopter at Fort Ord had blown apart in the air and that there were no survivors. But he didn't know who had been on board when it crashed. Russ Batcher's wife asked me to call my FAA contacts to find out if her husband was one of the fatalities. "I've been drugged." While Russ Batcher's wife and I were talking, Russ Bacher came on the line, calling from federal prison at Terminal Island. He exclaimed, "I've been drugged." Russ Bacher explained that he had coffee at approximately 2:30 with the admiral whom he had been expecting. Russ Bacher said that the admiral advised that he would return in about an hour and a half to take him to Santa Cruz. After drinking coffee with the admiral, Russ Bacher suddenly felt drowsy and went back to his cell and fell sound asleep. Shortly after 10 p.m., Russ Bacher woke up when a prisoner shouted that he had an emergency phone call from his wife. He called his wife and the call came through as she and I were talking. Russ Bacher described what happened, stating that he felt the Navy admiral deliberately drugged him to prevent him flying back, and may have done so thinking there was a plot to kill Russ Bacher, and in that way protect him. "Your life may depend on you going public." I warned Russ Bacher that the information he possessed put his life in danger, which would continue until he disclosed this information to others, and the information made public. "Your life may depend on you going public," I added. Russ Batcher's knowledge threatened to expose the people involved in October Surprise and many other criminal activities implicating the CIA, members of Congress, federal judges, and others. It was now about midnight and Russ Bacher was still groggy. I suggested that he call me the following morning when his mind was clear and give me a sworn declaration of events surrounding the October Surprise operation. I said that I would record his statements and have the recording transcribed, after which I would send portions of the transcript to members of Congress. Revealing major crimes when Russ Bacher called the next morning, I said, "I need to know the specifics on the flight to Europe, including who was on board the aircraft, who stayed at what hotel, where did the flight start from, and where did it land en route." What he stated on that first questioning session was repeated many times during the next few years as other segments of that and other operations were detailed. This was the start of discoveries continuing to this date, of treasonous, subversive, and criminal acts implicating many federal officials. The information and documents I obtained enlarged upon the hardcore criminal misconduct that I had already uncovered. A partial extract of Russ Batcher's first declaration reads as follows. "My name is Gunther Russ Bacher. I am a captain in the United States Navy. My service number is 440-40-1417. My current location is the Federal Correctional Institution, Terminal Island. I am a federal prisoner, awaiting appeal on a charge of misuse and misappropriation of government properties, misuse of government jets, and misuse of government purchase orders for purchase of fuel. That is my current situation. The date today is May 1, 1991. The time of this interview is 0824. Now that we have the formalities underway, Rodney Stich, we can talk." "Who were the pilots?" I asked. "On the flight deck were pilots Richard Brennicke, an Air Force pilot, and I was the command pilot." "Who was in the cabin?" "In the cabin were George Bush, William Casey, Robert Gates, Donald Gregg, and others." In later sessions, I asked Russ Bacher to provide a more complete list of the passengers on the BAC 111 flight. He stated that other passengers included several Secret Service agents assigned to Vice Presidential candidate George Bush, George Cave, Richard Allen, Senators John Tower and John Heinz, Congressman Dan Rostenkowski, Jennifer Fitzgerald. 154. Of the State Department. "What type of plane were you flying?" I asked. "The plane was a BAC 111, and we departed from Andrews Air Force Base, to New York, to Gander, and then on to Paris, landing at Le Bourget." "At what stage of the flight did you see the passengers?" T went back into the cabin after taking off from Gander. Where did the crew stay while in Paris? We stayed at the Florida Hotel in Paris. How long did Bush stay in Paris? Bush only remained a few hours. Did you fly the same plane back? I asked. No, I didn't. I flew the man back in the SR-71. Are you qualified in the 71? Rodney, I flew the 71 for 18 months. Where did the 71 refuel, recognizing that the state route 71 could not fly from Paris to the United States without refueling? The refueling occurred approximately, I would have to say, 1,800 to 1,900 nautical miles into the Atlantic. We were met by a KC-135. Where did you land on the return flight? McGuire, Russbacher replied. How long did the flight take? The flight took 1 hour and 44 minutes. What time did you arrive back at McGuire Air Force Base? We arrived at McGuire Air Force Base approximately 10:50 a.m. the following morning. Who were some of the people you saw in Paris? Adnan Khashoggi, Hashimi Rafsanjani. Rafsanjani was the Ayatollah's henchman and the second in command. Please look who is in command now, Rafsanjani. In response to my probing questions, he provided additional data, including rudimentary piloting activities, conversations, airports, and other data that would be hard to fabricate. Russbacher described the route of flight from Washington to New York, to Gander, and then to Paris. He gave specifics that might be meaningless to anyone but a pilot who had been to the airports he described, which provided further confirmation that he was telling me the truth. After arrival in Paris, Russbacher went to the Hotel Florida and had been asleep only a short time when he received a call from the CIA station chief in Frankfurt, advising him that an State Route 71 was being flown to Paris for him to fly back to the United States. The State Route 71, with vice presidential candidate George Bush as a backseat passenger and Russbacher at the controls, departed from a military air base near Paris 2:50 p.m. European time. The State Route 71 was refueled about 1,800 miles from Paris over the North Atlantic by O.S. Air Force tanker. He landed at McGuire Air Force Base in New Jersey at 10:50 a.m. Eastern Standard Time. After Bush left the aircraft, Russbacher flew the State Route 71 to Andrews Air Force Base. Going back to the October surprise operation, I asked Russbacher, what do you know about the first meeting in Madrid between Casey and the Iranians that reportedly occurred in July of 1980? The Madrid meeting was more of a diversionary tactic. The actual meeting occurred in Barcelona. I was in Barcelona at the time of the meetings. I was there at the PepsiCo International Headquarters building. I gave you the guy's name that was our interface there. Vantyne. That was approximately what month? I asked, to make sure we were talking about the same meetings. That was in late July of 1980. This is the meeting or meetings in which William Casey met with some Iranians. That is correct. That was with Hushang Lavi and Rogovin. 237 Referring to all of the reports of Casey having been in Madrid, I believe you stated that Casey was never in Madrid. T said that the meetings, the top-level high-speed meetings, did not take place in Madrid. The suites and conference rooms and everything were rented and cared for. However, the meetings took place, and the people stayed, at the Hotel Princess Sofia, SOFIA, in Barcelona. I responded, and was this at the same time that he was supposedly in Madrid? Right. It was a little subterfuge upon the part of the government. But the actual meetings took place in Barcelona. They took place at the PepsiCo International Headquarters building. And you were there in town with Peggy. That's right. I was there at the meetings. So you know what was stated at the meetings. This is where the first discussions were coming up as to what type of arms and munitions that the Iranians wanted. And who was there besides William Casey? Was that Robert McFarlane? Yes it was. You previously stated that in Barcelona the meetings were held at the hotel, but then you also mentioned in one place about them being held at the PepsiCo plant. Can you explain that? Right. The day's meetings were held over at the PepsiCo International Headquarters buildings. That was the main meetings then? Did you have any at the hotel that you mentioned? Yes. What part did Van Tine play in the meetings? Did he more or less coordinate the meetings? Facilitator. Yes. Realizing that PepsiCo surfaces in numerous CIA activities, including drug processing in the Far East, I asked Russ Bacher, was PepsiCo a CIA proprietary corporation? No, but they have close connections to each other, they work together. A few more questions on the Barcelona meeting, 3 asterisk just to get clarified in my mind. Why did they have to use Madrid 239 as a diversionary point when they were trying to cover up for the whole operation? There were also high-level meetings going on in the Spanish cabinet at the same time. It would be easier to hide under the cloak of secrecy as to what transpired in Madrid at that time, without going in and having to create a brand new cover for the meeting in Barcelona. Can you give me the details on the hour of the day and how long the meetings lasted? I would estimate, according to my recollection, that the meeting began about 10 o'clock in the morning, and lasted probably until 1 o'clock, at which time they broke for lunch, and the meeting reconvened from about 3 to 6 p.m. Was it a one-day meeting? No, 2 days. The first day was full of meetings, and the second day was only about 3 hours long. What was your role at that meeting? The only part that I took part in was to set up a centralized command in Vienna, which would involve being able to draw large containers and to allow freighting weapon containers, and so on. From the Reforger stores. 24 From the Reforger stores, through Austria, and down by rail. Would presume, referring to some comments you made about Austria being unhappy, were they to be notified when military shipments went through their country? Was a total no-no. 4. Even when it is ordered by the United States. 242 The United States cannot order anything. Austria is a sovereign republic. We made weapon shipments from the early contacts with the Iranians through Switzerland. We railed from Zurich to Vienna, and from Vienna on down. You said the people at the meeting were Casey and McFarlane. Were there any other Americans there? Think Allen was there for a couple of hours. And on the other side there was Hushang Lavi, and I think you mentioned Rogovin. VZI Rogovin was the attorney for Lavi, wasn't he, mice? Was there anyone else there? There were several other people. But the individual I dealt with primarily was Mr. Peter Van Tine. What was his position? Peter Van Tine was Executive Vice President for PepsiCo International. I might add that part of the reason I was there was that I was to set up a large production warehouse and production corporation in Vienna. We are talking about an extremely large warehouse where we could hold container shipments until transshipment took place. We were withdrawing military weapons and munitions from Switzerland, including Swiss military manufacturer Oerlikon. We were drawing stores from Germany. We were also drawing stores up from Italy. The shipments from Italy came up through Brenner Pass in overland containers, at which point they ended up in Innsbruck, Austria. In Innsbruck they were replaced by other containers, that were supposedly at that point moving mineral waters from Innsbruck to third world areas. Mineral water? I asked. That was what the code name was. The code name for it was seltzer water. Describing the route of the arms shipments, Russ Bacher stated he established transshipment points from Europe, especially Germany, Italy, and Switzerland. In Italy, up through Brenner Pass, from Germany into Austria. We were buying arms from Oerlikon, a corporation, a weapons manufacturer in Switzerland. We had a big warehouse, a huge one. Some went through Yugoslavia. It went through Yugoslavia for transshipment through Macedonia, down through Greece, and then to Cyprus, and then across. Hungary was a transshipment point also. At times it went through Hungary. However, most of the times it went through Yugoslavia. Because Austria was a neutral country and Hungary was a communist country, we had a choice of transshipment points. Either first from Vienna to Budapest, where they were then transferred onto trains to Yugoslavia, or directly from Austria to Yugoslavia, and Yugoslavia down into Greece, and then to Cyprus. Most of the time it went through Yugoslavia. This dialogue, and others within these pages, were repeated many times during years of conversations, letters, and affidavits. In a later written response to interrogatories, Russbacher replied in a sworn declaration. I was in attendance during the meetings held in Geneva, Switzerland, the meetings in Barcelona, Spain, the meetings held in Madrid, Spain, and the meeting held in Karachi, Pakistan. I was there as agency supply and logistics person, as well as facilitator for the governments involved. The initial meeting was held in Geneva, and was held with Ahmed Haidari and Mohammed Hussein Behishti. Mr. Cyrus Hashimi was the arms specialist present at this meeting. In order to be unknown in this field, we used the following DOS personnel as cutouts, Mr. Sam Carlton and Peter Merrill. This meeting took place 6 days after my return from Buenos Aires, Argentina, where a meeting of low-echelon state staffers and I talked to the Mossad contact man, Ari Ben-Menashe. The meeting with Ari Ben-Menashe was held on or about March 4 to the 8th, 1980. The initial meeting with the DOS persons, Hashimi, Haidari, Behishti, and myself, was held in Geneva, shortly after our return from Buenos Aires. We met in Geneva on or about March 14, 1980. The discussion centered around another version of the swap for the hostages. Mr. Adnan Khashoggi permitted us the use of his credit cards for the purpose of purchasing fuel for the aircraft. He indicated that he had specific interest in obtaining a deal for the sale or trade of arms to the government of Iran. We contacted Mr. Behishti and Mr. Haidari. Because Mr. Behishti spoke very little English, all conversations were held in either French or German. I was able to function as negotiator and interpreter for several such meetings. Looting United States military warehouses. During another probing session, Russbacher revealed when the arms and munitions started to flow. The answer was critical and helped explain how the officially elected government of the United States was rendered helpless by the coup d'état aspects of the October surprise conspirators. After the Barcelona meeting, how soon did these arms start flowing? Russbacher hesitated in answering that question. He replied, "My friend, the arms began flowing, I would say, probably in September. 24. Were you over there at that time?" "Yes, I was." Since Casey, Ronald Reagan, and George Bush, the principal parties in the October surprise conspiracy, had not held any government office at that time, and the November 1980 presidential elections had not yet occurred, the question arose as to who authorized the shipment of arms, especially since there were laws preventing the shipments, and since the shipments undermined the negotiations by President Jimmy Carter seeking to obtain the release of the 52 American hostages. Where did the authority come from to move that military equipment, since Casey and the gang held no government positions? Russbacher again hesitated, and then answered, "We were already in there. The agency was already out on the limb." 245. And bear in mind that Bush was the ex-DCI. 4 Casey had gone back to the days of Wild Bill Donovan. So you are talking about an agency coup that was already in the making at that time. What about the military? Didn't they have control of those weapons, I mean the US military? Rodney, if I tell you the shenanigans that are pulled, and the shopping that can be done at these reforger stores. 247, you would pull your hair out. I asked Russbacher who worked with him in procuring the arms and arranging the shipments. The procurement of them was handled by an associate of mine. The fellow's name was John George Fisher. He is dead. I asked Russbacher, what type of paperwork was done to get the U.S. military organizations to release the equipment? It is very simple, Russbacher replied. All you have to have is a request for transfer, which is commonly referred to as an AF series, duly signed by authorized personnel, or by an authorized officer. And, of course you need a transfer form approved for a transport form. And then you need end-user certificates. When had already put them in position. 48 What about the end-user certificate requirements? You had to show an indicer, and who was that? We had end-user certificates available. That's why all shipments went through Cyprus. By the time the weapons came to Cyprus, new end-user certificates, or the real ones, that were going to be used, then showed up. But the end-user certificates that we always provided would have been countries that were friendly to the United States. Some of them were bogus. A lot of them went down to an entity in Spain. We had some sympathetic people. Continuing, Russbacher stated, we had embassies in Madrid that provided us end-user certificates. A lot of them were embassies from North African countries, West African countries, including Liberia. Russbacher referred to the key role played by Israel in the operation, stating, we worked hand in hand with the Mossad. 24 During the next few years, I repeatedly questioned Russbacher concerning operations in which he had been directly involved, or of which he had specific details due to the nature of his work. Russbacher repeated details of the various CIA operations that we had previously discussed, oftentimes expanding on the information he had given me earlier. Israeli participation. Were there any Israel people at the Barcelona meeting? T knew there was a discussion that there were some present. Was Karoubi there? Russbacher replied, yes. In Ari Ben-Menashe's book Prophets of War and in conversations with Ben-Menashe, he stated that he was present at the Barcelona meeting. Referring to the $40 million bribe money that was reportedly given to the Iranian factions at the subsequent Paris meetings on the October 19, 1980, weekend, I asked, do you know anything about the routing of the reported $40 million bank draft that was given to the Iranians during the Paris meetings? Michael Rekanasi Utto would be the best one to answer that. The helicopter crash. I needed details surrounding the helicopter crash that had occurred the night before. Were the naval officers that you had coffee with, on the helicopter? I asked. Yes, he replied, I had coffee with one of them. What was his name? The first guy's name was Samuel Walters. And he was Navy. And that's his true name too. What was his rank? He was a captain. Did you meet the other two guys that were on it? Yes, one of them was a rear admiral. John D. Burkhart. He was in Defense Logistics. Office of Naval Intelligence. Yes. And his present job was that he was very strongly implicated in NASA and the SDI initiative. Russbacher continued, Ray called the chief of stations at St. Louis, who is a friend of ours. He made some checks and found out who was on board. Were they the ones who were to have gone back with you? Yes. Tricky business, Rodney, I don't know if you want to get into this. If I had been on that helicopter, I would be dead. Relating what his CIA handlers told him, Russbacher said. The helicopter took off yesterday carrying a rear admiral, 2 Navy captains, and it should also have carried myself. Everybody here, including the D.J., was under the impression that I was going to be on that airplane. The aircraft took off from Fort Ord with a flight to Monterey, and from Monterey they were going to discharge one of the crew who was going to stay at the FBO at Monterey. And then the aircraft was going on to Santa Cruz and land back behind the university grounds. The incident occurred about 6:18 p.m. The original incident, as it was described by the radio at Santa Cruz, was that a helicopter exploded about 200 feet above the ground. No pieces. Just general wreckage. What came out about? An hour later was that a helicopter went down with 2 FBI agents on board. There were 2 FBI agents on board, although they suffered serious injuries, they were okay. One of them suffered very serious head injuries. Somehow or other they were able to cover up for the initial flight. Rodney, they are after everyone that has anything to do with these activities. Russbacher continued, someone saved my butt last night. I don't know how many more times in the future they are going to be able to do it. You felt that something was put in the coffee. Did it just make you groggy? I went right to sleep and slept until 20 minutes of 10. So after you drank the coffee you were supposed to leave right then and there. Within an hour and a half. Then you went back to your cell and went to sleep, expecting them to call you. They never called. They never tried to wake you up. As far as I know, no one tried to wake me up. The first inclination I had that it was time to wake up was at 20 minutes of 10, people were screaming at me that I had an emergency call from the control center and that I needed to call home immediately. I'm surprised the prison officials gave you that personal service. Well, you have to also bear in mind that a little different. Well, the fact that you can get to a phone that is not monitored indicates that you are in a different category than most prisoners. Within 4 minutes of being awakened, I was on the phone talking to Ray and hearing your voice in the background. I asked Russbacher how he ended up in prison. He replied, that could be a book by itself. It dealt with repatriating some of the arms from Central America back to the United States. Referring to what was done to silence me, Russbacher stated, your case is different. It does not address a single issue. Your case addresses multi-issues. If you create sufficient fires, it is extremely difficult to determine where the fires are and how best to put them out. You pose a significant threat. You pose as much of a threat to their little game as I do to the total administration. You pose a significant embarrassment to the federal government. It isn't quite so easy to shut these people down. Confirmation of the helicopter crash and the death of a deep-cover Navy admiral. The existence of the Navy helicopter crash was kept secret by the government, as though it never happened. The absence of any report caused me to withhold further mention of it, fearing that reference to a non-reported helicopter crash would discredit the other information Russbacher supplied me. However, during a conversation with St. Louis Post-Dispatch reporter Phil Linsalata, I described the helicopter crash and qualified the information with the statement that I had no evidence to support its occurrence, that I hadn't told anyone else about it because of lack of evidence. Linsalata said that the Post-Dispatch had a reliable CIA source and that they would contact him for possibly confirming the crash. 162. Linsalata contacted me several days later, on May 4, 1991, advising that the CIA contact confirmed the helicopter crash and that a Navy admiral was killed. Linsalata stated that the CIA contact expressed surprise that the Post-Dispatch knew of the crash and the death of the Navy admiral. During another conversation on May 20, 1991, Linsalata again made reference to the statements made by the CIA source concerning the death of the Navy admiral in the helicopter crash. In response to my questions, Linsalata stated, the guy seemed shocked that I had access to this information. His shock seemed sincere. You judge the truth of what a person is saying, such as by the tone of voice. He seemed quite shocked that I had access to this information. He also made a comment that he personally knew who the ranking officer was, the brass, the admiral, and that he knew the guy. He was personally shocked that he had been killed, and that he was a nice guy. He said the admiral didn't deserve what happened. The things that he said to me made it impossible to rule out that he was simply offering the information that I gave him. The new information was given to me on his own. I didn't flush it out of him in any way. He just made comments reflecting that he knew what he was talking about. He seemed to be sincere. Cover up by St. Louis Post-Dispatch. Harry Martin, 2-degree publisher of the Napa Sentinel, 5. Called me, stating that he had just received a call from Phil Linsalata of the St. Louis Post-Dispatch denying that he had ever talked to any CIA contact about any helicopter crash at Fort Ord. Martin said that Linsalata sounded very nervous, as if he was under pressure to make that call. It appeared that the intent of the call was to dissuade Martin from making any reference to the statements Linsalata made to me confirming the existence of the crash and the death of the admiral. Martin had been one of the first media sources to respond to the notices that I had a tape and transcript of a CIA operative who had been part of the October surprise scandal. His subsequent articles were copied by numerous other papers, and members of Congress requested copies of Martin's articles. There was danger of exposing the October surprise scandal if Martin printed the statements made to me by the St. Louis Post-Dispatch reporter. Possibly to prevent this from happening, Linsalita's publisher ordered Linsalita to call Martin and deny that he had ever talked to me or to anyone else about the helicopter crash. Martin asked if had a tape of the conversation, and I replied that I did, of both the May 4th and May 20th, 1991, telephone conversations. During these telephone conversations, Linsalita went into great detail concerning the information given by his CIA sources. Warnings to forget the helicopter crash. Several days after the helicopter crash, Gunther and his wife warned me to totally forget about it, warning me that my life would be in danger if I made any reference to it or even made any inquiries. As I started to make reference to the crash during a subsequent conversation, Russbacher stopped me. No. 250 Napa Sentinel, Napa, California. 251 The Napa Sentinel had been at the forefront in exposing government scandals, including Inslaw, October Surprise, and other stories. CIA Whistleblowers 163. Rodney, don't bring that up. Don't touch that with a 10-foot pole. Because there is so much cover-up in that crash. Russbacher said, Rodney, don't even talk about it. I'm telling you. Because there is so much cover-up in that crash. Listen to me. Listen closely. And be very guarded. When Ray got a call, she called St. Louis. St. Louis in turn made a phone call and then called her back. There were 3 people on board and they are all dead. You got that? Stay away from that as far as you can. I replied, it would be important to know the details. Russbacher answered, this is not the time to know. For your own life. I'm talking about personal safety. At a later date, I discovered additional evidence supporting the existence of that crash and that assassinations were an all too common CIA tactic. Notifying the media. After I notified various media contacts that I had declarations of a CIA operative concerning the October surprise operation, journalists from all parts of the United States were calling me for further information. When these journalists contacted Justice Department and White House officials, they were told that Russbacher was a con artist, that he had a long rap sheet and was not believable. This followed the standard line when CIA whistleblowers go public. Shortly after Russbacher supplied me with his first declaration on May 1, 1991, I mailed partial transcripts to members of Congress, 2 along with a petition demanding that our testimony and evidence be received. I reminded them I was exercising Rights 253 and Responsibilities 254 under federal law and that they had a responsibility under these same laws and under federal criminal statutes to receive our testimony and evidence. I explained that I was a former federal investigator who held federal authority to make these determinations and that I hadn't lost any of my abilities to do that since leaving government. I mailed certified letters and transcripts to independent prosecutor Lawrence Walsh, who had the duty to investigate all aspects of the Iran-Contra affair, which started with the October surprise scheme. I reminded Walsh of his responsibilities under federal criminal statutes to receive my testimony and evidence and that of the CIA whistleblowers. Despite hundreds of certified mailings, each containing over 50 pages of data, no one responded. The non-response was one of the most amazing examples of mass cover-up that I had ever witnessed. But it happened time and again. My letters raised very serious charges that, if only a small fraction of them were true, would inflict enormous harm upon the United States. This refusal to perform a duty made possible the continuation of the government corruption that continues to inflict great harm upon America. As Russbacher provided me with further information and other CIA sources gave me supporting data, I sent additional petitions to members of Congress, demanding that they receive the testimony and evidence from a group of concerned CIA whistleblowers on criminal activities against the United States. I described specific facts that would be revealed. Every senator received at least 3 certified mailings from me between May 1991 and December 1992, as did the members of the House Judiciary Committee, Foreign Affairs Committee, Oversight and Investigations, Government Operations, and Aviation. Not a single reply was received. As a result of publicity generated by my transcripts and references to Russbacher on my talk show appearances, Russbacher was asked to appear on numerous radio and television talk shows, which he did from prison. Despite all this, the public remained passive, and none of those in government wanted to disturb the status quo. Escalating media and congressional disinformation. Shortly after I had first publicized Russbacher's sworn statements, the disinformation to discredit him commenced. Even author Barbara Honegger, who authored the first October Surprise book, tried to discredit Russbacher, fabricating facts that I had to address by sending out information identifying the apparent deliberate misstatements. Her tactics tended to discredit the existence of the very scandal that her earlier book sought to expose. It was as if she was being rewarded in some way to discredit the smoking gun in the October Surprise conspiracy. The charges by Justice Department officials, commencing in 1986, were to discredit Russbacher and minimize the danger to White House and other officials. Russbacher had earlier described the three factions in the CIA as often fighting each other. Faction 1 was controlled by the Justice Department and the White House under George Bush. Faction 2 was controlled by the Office of Naval Intelligence, often at odds with Faction 1. And Faction 3 was a small number of former Office of Strategic Services personnel. They are deporting Russ. Russbacher's appearances on radio and television from his prison environment threatened many people. Justice Department officials addressed this threat by seeking to deport him. Once, upon answering the phone, 55 Russbacher's wife exclaimed, "Gunther isn't in Terminal Island. He is on a flight to Oakdale, Louisiana, a federal prison where prisoners to be deported are sent." In an attempt to prevent the deportation, I phoned talk show host Tom Valentine with Radio Free America, senior White House reporter Sarah McClendon, independent prosecutor Lawrence Walsh, and appeared on numerous talk shows describing the efforts to sequester evidence relating to October Surprise. Need more information. Despite the gravity of criminal activities I listed in the petitions that I sent to Congress, the recipients did nothing. I felt that I needed more information about additional CIA crimes that would force members of Congress to respond. I told Russbacher, "I need more information." Russbacher went into great detail about other areas of corrupt CIA activities. 255 October 13, 1991. CIA whistleblowers 165. Russbacher detailed the involvement by CIA factions in the looting of savings and loan institutions and insurance companies, the CIA's role in drug trafficking throughout the United States, and much more. He furnished me with blank checks, letterheads, and incorporation papers of some of the covered CIA proprietaries he operated for the CIA, which dealt in unlawful activities. The information Russbacher gave me in hundreds of conversations was detailed and was presented in a way that I had no reason to question its accuracy. The answers to very specific questions, requiring a very detailed answer, came without hesitation. In those cases when he didn't know, he didn't hesitate to say so, even though he could have fabricated an answer. There were some areas of CIA activity he would not discuss, and information on these areas would often come to me from other sources. Russbacher did back down after refusing to answer questions concerning a certain area when another source described it to me. Then Russbacher would enlarge upon the information in a manner indicating he was well familiar with the operation. To confirm his answers, I approached the subject from a different angle many months later, and the precise detailed facts would rarely waver. His precise knowledge of people and events in many areas of intrigue was unprecedented and checked out with facts that I obtained from other sources. I was convinced that he was not a con man. He simply could not make up the vast amount of data he gave me in response to questions that covered a broad spectrum. As other CIA whistleblowers came to me, was able to obtain further confirmation of Russbacher's CIA status and of many of the events that he described to me. Even when I told him information given to me by others, such as former Mossad agent Ari Ben-Menashe, Russbacher often responded with additional information on the person which had never appeared in print. It wasn't Russbacher who sought attention. I was the one that repeatedly told Russbacher to give me information of CIA corruption so that I could force Congress and the media to meet their responsibilities. Russbacher detailed how the CIA was part of the looting of Chapter 1 assets, and how the CIA used crooked federal judges, trustees, and law firms to accomplish this. He described how the CIA covered up for some of its looted proprietaries by placing the companies into Chapter 7 or 11 where the CIA had control of the judges. He named judges, trustees, law firms and their attorneys, who were present at CIA drug and arms transshipment points in Central and South America, and especially trustee Charles Duck, who looted much of my multi-million in assets. At a later date, Russbacher gave me the name of the overseas corporation that paid the bribe money to the judges, trustees, and law firms beholden to the CIA and Justice Department gang. Russbacher described the interrelationships between the CIA and people looting the savings and loans. He described how Keating-controlled corporations hid over $300 million of depositors' money in Colorado through secret trusts and other financial mechanisms. When Jay quizzed Russbacher about the CIA's role with Charles Keating, he responded, "It wasn't just Keating. Bear in mind that we are not talking about strictly Keating-controlled corporations. We are talking about a multitude of corporations that were controlled by outside forces. Keating just happened to be one of them." 166. Removal of money from the United States. Elaborating upon the huge outflow of funds generated by CIA proprietaries through various financial scams and drug money laundering, Russbacher stated, "It is a systematic removal of funds from U.S. bank accounts. And these accounts that held large amounts of funds were then channeled to offshore bank accounts and offshore investment companies." I asked, "How are these funds identified?" "I'm talking about who would be identified as the owner of these funds. Would it be numbered accounts?" Russbacher replied, "It would be numbered or designated accounts, where you have a primary person that is allowed to make transactions. That doesn't necessarily mean that person is the only one. Presume that the CIA has numerous operatives who are authorized to place or remove funds from these accounts. There are only 10 or 12 people in the whole agency that are permitted to do that. Let's say, no more than 24 people. Are you one of those?" "Yes, I am. Or I was." Russbacher's statements as shown in these pages are but a minute fraction of the in-depth discussions between him and myself. These statements were made during late 1990 and up to the date of this book's publication. Much of the details were unknown to the general public and had not been in print. Many people confirmed to me Russbacher's CIA position, and statements made to me by Russbacher were often confirmed by statements made by others, including Ari Ben-Menashe, Michael Reconnaissy-Utto, Ronald Rewald, and other CIA-related people. Many hours were spent on what he saw firsthand as a CIA operative in Chapter 11 courts. Russbacher told of the CIA practice of using Chapter 11 courts for two primary purposes. One was to cover up for its looting of CIA proprietaries. The other was to loot the assets of small to medium-sized companies and individuals who filed Chapter 11 seeking time to pay their debts, and who had large equities. Pattern of judicial corruption in Chapter 11. Many of the victims didn't understand the blatant illegality of how the racketeering enterprise stripped them of their life's assets. The scheme follows a standard pattern, violating federal statutes and constitutional protections. The Chapter 11 judge, who almost always is a direct participant in the corrupt enterprise, orders the assets seized, usually in clear violation of law, and then appoints a trustee who promptly loots the assets, forcing the Chapter 11 case into a Chapter 7 liquidation. During liquidation, the trustee, his law IP and attorneys, and others who work together, sell the properties at a fraction of their market value. The person who sought relief in Chapter 11 then becomes the victim of one of the most outrageous racketeering enterprises in the United States. Russbacher gave me details of this racket as seen from his CIA perspective, dovetailing what I had earlier discovered as a victim and an investigator. I asked Russ Bacher if, during his CIA activities, he encountered the people who played a major role in seizing and looting my assets. His reply was startling. The federal judge who corruptly seized my assets was Las Vegas Chapter 11. Judge Robert Jones. Russ Bacher described how the CIA arranged transportation to Atlantic City for this federal judge, where letters of credit would be waiting at different casinos for him to obtain tens of thousands of dollars in gambling chips. Russ Bacher named other federal judges that he knew who were present at CIA arms and drug or other operations, including Judge Alan Yaroslavsky, a key judge in the Northern District of California, who had repeatedly protected trustee Charles Duck from his accusers. Russ Bacher later mentioned that he was a CIA asset and was on a secret financial arrangement. I asked Russ Bacher if there could be any legitimate basis for the appearances of federal judges, trustees, and law firms at the secret CIA arms and drug trafficking locations in Central America. He confirmed that there was no lawful reason for their appearances at these locations. Russ Bacher had flown to Central America CIA sites in CIA aircraft, accompanied by people such as trustee Charles Duck, attorney members of the law firms of Friedman, Sloan and Ross, Goldberg, Stinnett and McDonald 25*, and Murray. Russ Bacher had been at CIA meetings in Central America with Duck at John Hull's ranch and at Tegucigalpa, 57, as well as other locations. Referring to Duck, Russ Bacher described his presence in 1987, the last time that I had dealings with him, or came close to having dealings with him. He was there in the hotel room with me. Funding CIA through seizure of Chapter 11 assets. Russ Bacher said that Charles Duck bragged about how he looted the assets of Chapter 11 parties. Referring to Duck and the CIA looting of Chapter 11 assets, Russ Bacher stated, Duck has basically siphoned off large sums of money from his assigned cases. He appeared in different areas where we were involved. This is the nexus I have been getting across to you, between the bankruptcy issues, and agency operations. It is one of the funding vehicles for the company. Russ Bacher stated that the worst Chapter 11 corruption was in federal courts located in the San Francisco, Los Angeles, Chicago, and St. Louis areas. He added, "Let me tell you like this. St. Louis is notorious on Chapter 11. What it amounts to is, one of the bankruptcy judges in each one of the districts gets definite remuneration from the CIA. Typical startup of CIA proprietary." Describing one of the ways in which the CIA proprietaries generate money, Russ Bacher stated, most of them were limited partnerships. The funds would have been from the CIA to start with. 58 What they did, they allegedly put a private offering together, and the subscribers for the private offerings were already in place before the offering was even written up. Each one of these people who subscribed to the offering brought in agency funds. Russ Bacher stated, the corporation or limited partnership would issue corporate paper or whatever, and that's how more funds were created. They used the initial funds for the funding of the Ltd partnership strictly as a collateral vehicle for large-scale loans. He continued, if we go in, for instance, with $1 million or $500,000 each on a limited partnership, and there are 10 of us, let's say we have anywhere from $5 to $10 million in capital assets in the limited partnership, that, along with a good financial statement, and what we plan to do with the limited partnership, can earn us the right to a $30, $40, $50 million loan. Do you see what I am saying? Russ Bacher described what usually happened after obtaining multi-million-dollar loans. The people default on the non-recourse loans after the money is pulled out, stating, generally it was strictly default. We pulled money back out and we would end up with 30, 40 million. Russ Bacher added, that particular company would file Chapter 11 in courts where we had control of the judges. Other CIA sources. Initially, Russ Bacher was my best source of information. As I became known in the relatively small intelligence community, other concerned intelligence agency operatives came to me, describing the corrupt activities they had observed or been ordered to participate in. Mossad CIA Cross-Heck. Adding to the large amount of information supporting Russ Bacher's statements was an interesting dialogue between a former Mossad agent, Ari Ben-Menashe, and Russ Bacher. I arranged for several conference calls between these two former intelligence officers and encouraged them to exchange experiences. In one instance, Russbacher told Ben Menashe of his friendship with the Mossad station chief in Vienna, Heinz Tock, a name that would be known to very few people, and then primarily the Mossad. This was one example of Russbacher's intimate knowledge of covert activities. He would not have known this unless he actually was a high-level operative in the CIA. I talked for many hours to the wives of several operatives who related facts to me as seen from their perspective, corroborating what their husbands told me. I had frequent conversations and written communications with many other former CIA and DIA operatives, including Michael Reconassi Utto, 59 Russell Bowen, copyright Trenton Parker, 6. Ronald Rewald, registered Basil Abbott, 2 copyright 3 Charles Hayes. Edwin Wilson, 264 Michael Maholey, Bill Tyree, and others. I was in direct contact with law enforcement people whose investigative functions brought them in contact with CIA activities, especially CIA drug trafficking. These included Jim Rothstein, 765 Ted Gunderson, 26 and others. This vast amount of data, plus what I discovered, developed into a mosaic-like depiction of sordid intrigue, deception, and murder, portraying the worst pattern of criminal activities ever reported against the American people. My phone was used for hundreds of hours of three-way conference calls between CIA and DIA personnel, their wives, a Mossad agent, and even Ross Perot. Often the conversations were of the nature of one pilot describing to another events that they experienced, each one knowing that any fabrication would be recognized by the other. My position was like a secret mole inside covert CIA activities, adding to the discoveries I made while a federal investigator and while being victimized in one of the many criminal enterprises. As a former federal investigator holding federal authority to reach conclusions based upon the facts uncovered, based upon the 15 years of book publishing, and based upon what I had personally observed, the evidence was overwhelming. The American people are being systematically defrauded by a well-entrenched group in the federal government. Continual Justice Department attempts to silence Russbacher. Russbacher was scheduled to be released December 23, 1991. At that time he would pose a greater threat of exposing October Surprise, Inslaw, and numerous other major criminal enterprises implicating White House and federal officials and ongoing criminal operations. Justice Department prosecutors used another tactic to keep Russbacher in prison. Shortly before Russbacher was scheduled for release, Justice Department attorneys notified Missouri authorities that he had been charged with impersonating a naval officer at Castle Air Force Base. The attorneys induced them to revoke Russbacher's parole arising from the sham charges for which Russbacher had never had a trial and for which he was induced to enter an Alford plea. Russbacher was transported to St. Charles, Missouri for a February 7, 1992, hearing on revocation of his parole on the charge of impersonating a Navy officer. Missouri Judge Donald E. Dalton refused to allow him to call CIA personnel who could attest to his being a covert CIA operative on assignment from the Office of Naval Intelligence. However, he did allow Russbacher to call witnesses from Offutt and Castle Air Force Base, who testified that Russbacher and his wife were billeted there and that the authorization came from Navy SINPOC. The witnesses provided the authorization numbers. This testimony and the Air Force records were strong evidence that Russbacher was on official duty with the United States Navy. Dalton disregarded the evidence that Russbacher was a covert intelligence officer. He ignored the fact that there had never been a trial on the underlying money offense charge, that there was no evidence presented to show that Russbacher had committed any of the acts charged, or that anyone suffered any financial loss. The judge revoked Russbacher's probation and ordered him to start serving the 21-year sentence that had been rendered in 1990 when Russbacher was encouraged to enter an Alford plea. Russbacher and I continued our almost daily telephone conversations discussing the specifics of CIA operations in which he was involved. As he became more discouraged, he loosened up and gave me more information about CIA/ONI covert activities, most of which were continuing. Russbacher's health was failing due to an urgent need for coronary bypass surgery. Rayalan, his wife, and I, and other people, worked for his release. I urged to get the first printing of Defrauding America published, with the intent of using the book as the basis for appearing on radio and television shows. In this way publicity would be focused on Russ Bacher and other CIA scapegoats. The primary intent was to make the American people aware of the well-orchestrated criminality involving government personnel, and to motivate them to take action. That was naive. The statements made to me by Russ Bacher that are quoted here are only a small fraction of what he disclosed. Over 200 audio tapes are filled with his answers to my questions given over a 4-year period. His precise and sophisticated knowledge of names, dates, and places exceeded anything that I had experienced before or after this time period. In subsequent books, other areas of CIA activities will be described, which Russ Bacher and other deep cover operatives described to me. Russ Bacher's attorney, Robert Fleming, had filed an appeal of the charges against Russ Bacher, and in 1994 the appellate court overturned the conviction which had kept Russ Bacher in prison, causing his release. The prosecutor refiled charges against Russ Bacher and served Russ Bacher before he was released from prison, requiring Russ Bacher to appear for a hearing. Instead of appearing, Russ Bacher went back to his native Austria. Missouri then filed a warrant for Russ Bacher's arrest, ensuring that Russ Bacher would be arrested if he returned to the United States. For reasons not clear to me, Russ Bacher returned to the United States in 1997 and was promptly arrested. After a few months in county jail in Missouri, a closed-door hearing was held, followed by Russ Bacher being deported to Austria, accompanied by 2 INS agents, apparently to be sure he did in fact arrive in Austria. In 1994, I made contact with Oswald L. E. Winter, a former deep-cover CIA operative who spent 30 years with the agency and primarily as a disinformation expert. He played a cover-up role in the October surprise operation. He and several associates were responsible for removal of incriminating records from such locations as hotels, cab and limousine companies, and at the airport. L. E. Winter was with the CIA from 1974 to 1984, assigned to the CIA's achieves at Langley, in Europe and Israel. He was part of Operation Gladios involving the CIA destabilization of the Italian government. In 1979, L. E. Winter was assigned to ITAC, and in 1980 he was asked to get involved in the Reagan-Bush campaign, which led to his involvement in the October surprise scheme. He said that one of the government officials secretly involved in the October surprise operation was Donald Gregg, who at that time was head of the National Security Council under President Jimmy Carter. While holding this position, Gregg sabotaged the government of the United States in the operation that helped get Reagan and Bush into office in 1981. On the cleanup crew, L. E. Winter stated that he started doing advance work for logistics for the October surprise meetings held in Europe, including Madrid, Barcelona, and Paris. When I asked him if he was at the Barcelona meeting at the PepsiCo plant, he said, "I was there. I made sure that the guys I interfaced with in Spain picked up all the papers. I made sure that the landing and takeoff records from the airport were collected, so there was no evidence that the meeting occurred." When asked about the Paris meeting, L. E. Winter said, "At Paris I coordinated with French intelligence, a man by the name of Picard. I asked, at the Paris meeting, did you get to see any of the people, such as Gregg, Bush, or any of the others? He answered, yes, Bush, Gregg, Casey. Where did you see them? I saw Casey at the Hilton where he was staying. I got instructions from Casey. I saw Bush in a black embassy Chevy near the Kremlin. Did you get involved in any of the arms shipments? No, I knew that they were taken from the reforger stores without telling the European governments, our NATO allies, and shipping them to Iran. They later used me to do some misinformation about that." Chapter 11. October Surprise Cover-Up. Surprise operation and the other corrupt activities associated with it through a pattern of disinformation and the withholding of evidence. The establishment media sought to discredit the CIA whistleblowers who could prove the existence of the October surprise operation. They fabricated reasons to discredit a group of former CIA and Mossad intelligence agency personnel who were personally involved in the operation, and who had nothing to gain by giving testimony, and had much to lose, including criminal prosecution. These sources were willing to risk their safety and freedom to expose the corruption against the American people. The investigating committees and the establishment media gave absolute credibility to the statements of those who were part of the treasonous and criminal activities, and who faced impeachment and prison terms if the charges were proven. In this way, as a matter of law, members of Congress and the media became co-conspirators. The Village Voice discredited the testimony of CIA contract agent Richard Brannicky because it found 10-year-old credit card slips for Brannicky that were made in Portland, Oregon on October 18, 1980. These credit card slips were found by Peggy Robaum, who went to Portland where Brannicky resided, from her home state of Connecticut, for the sole purpose of becoming involved with Brannicky. Later, she was hired by the House October Surprise Committee to investigate the October Surprise allegations. My CIA sources state that the signatures on the credit cards were not Brannicky's signature and that it is standard practice for CIA people engaging in covert operations to cause a record to be established showing them to be elsewhere. CIA contract agent, Michael Riconosciuto, a close friend of Brannicky. T.S. mainstream media in the United States kept the lid on the October 174, who also resided in the Portland area, stated to me that Brannicky's credit card was used by a friend during that weekend. The same mainstream media discredited CIA operative Gunther Russbacher, the pilot who reportedly flew George Bush and others to Paris on the October 19, 1980, weekend, and then flew Bush back in and State Route 71. Former, and probably current CIA asset, Frank Snepp, wrote an article in the Village Voice stating that Russbacher didn't even know how to start the engines of an State Route 71. This article was then repeated over and over again by the media until the lie was taken as truth. He had obtained a copy of the formerly secret State Route 71 manual, studied its 1,000-plus pages, and quizzed Russbacher on the operation of the aircraft, including the starting procedures for the engines. I was qualified to determine his competency in this area since it was my job for many years to conduct pilot competency checks for airline pilots on jet aircraft. Russbacher certainly knew how to start the engines on State Route 71. The start-up procedures are quite different than other jet aircraft, but amazingly simple. A Newsweek article, 6 fabricated facts to discredit the October surprise charges, stating on its cover, the October surprise charge, treason, myth. It misstated and omitted facts so as to support the front page cover. The magazine sought to discredit the testimony of former Mossad agent Ari Ben-Menashe, who was present at the Madrid, Barcelona, and Paris meetings. Authors of several books and many magazine and newspaper articles found Ben-Menashe credible and quoted him in their writings. Gary Sick quoted him numerous times in his 1992 October Surprise book, as did Seymour Hersh in the Sampson Option. Russbacher said to me many times that he saw Ben-Menashe at the Barcelona meetings. The establishment media sought to discredit Ben-Menashe by stating he was only a low-level file clerk who never left Israel. Denying the existence of the October Surprise operation required undermining the credibility of these whistleblowers and informants who were present. Newsweek portrayed Ben-Menashe as being a shadowy, Israeli exile, a former translator for the Israeli government, does not seem to check out. Perhaps they expected an espionage agent to live the life of a nun. Time magazine also joined the disinformation tactics. Its October 28, 1991, issue called Ben-Menashe a veteran spinner of stunning if true but yarns, and a fabricator. An 11-page deceptive article in the New Republic was entitled The Conspiracy That Wasn't, with the subtitle, The Hunt for the October Surprise. The deceptive article, written by Stephen Emerson and Jesse Furman, stated in part, the conspiracy as currently postulated is a total fabrication. Almost every source cited by Sick or Frontline has been indicted or was the subject of a federal investigation prior to claiming to be a participant in the October Surprise. Ben-Menashe authored the 1992 publication of Prophets of War 27 subtitled Inside the Secret U.S. Israeli Arms Network, which contained copies of Israeli government documents showing Ben-Menashe as a high-level staff officer for Israel's Mossad and military agencies. The CIA's media Wurlitzer. The CIA has many media personnel on its payroll to plant stories or discredit charges against it. The agency secretly pays out large sums of money for articles and books to be written on the CIA's behalf. Its control over the media is like a Wurlitzer, orchestrating and manipulating all segments of the written or broadcast media. The CIA uses taxpayer funds to control reporters and publishers of newspapers, magazines, and books. Serious implications. The evidence supporting the October surprise charges required impeaching President George Bush and filing criminal charges against key officials in the executive, legislative, and judicial branches of the federal government. Never in the history of the United States was there such a serious criminal conspiracy inflicted upon the United States by people in control of the White House and government. There was no comparison between the relatively minor cover-up of Watergate and the hard crimes associated with October surprise. The media exaggeration of Watergate inflicted immense harms upon the United States. The media cover-up of October surprise inflicted far greater harm upon the United States, but in a form not recognized by the uninformed American public. October surprise was many times more serious, involving people scattered throughout the three branches of the federal government. Failure to deny the existence of October surprise could cause mass impeachments, criminal prosecution, and awaken the American public to the criminality in government. The fallout would affect both political parties. Consider the difference between the political turmoil associated with exposing the October surprise crimes and the seeming tranquility following its cover-up. The surface tranquility, however, hid the hardcore corruption and harm that continued to be inflicted upon the American people in ways not recognized by the public. We couldn't stand another disgraced presidency. The cover-up by some of the media was for reasons other than protecting the guilty or vested interests. Several syndicated columnists, including Jim Fain of Cox News Service, explained the reason for the October surprise cover-up in an April 23, 1991 column. A consensus grew that we couldn't stand another disgraced presidency. Democrats in the bungled congressional hearings said as much. One of the tactics used to discredit October surprise and other scandals was to discredit and make a mockery of those who describe the criminal acts and who use the word conspiracy. This tactic plays upon the ignorance of the public as to what constitutes a conspiracy. A conspiracy exists in almost any type of crime and consists of two or people agreeing to do one or more acts. There is obviously no shortage of conspiracies anywhere, even though the standard disinformation tactic is to ridicule anyone who makes reference to a conspiracy. Another cover-up tactic is to discredit statements or charges made by someone accused of a federal offense, calling him or her a felon and a person whose statements cannot be believed. Many CIA operations have been criminal under law, making it easy for Justice Department officials to silence any potential CIA whistleblower by charging them with committing a crime. Using this argument, the only witness who could be considered reliable would be someone like a nun, someone who couldn't possibly have access to information about criminal activities. However, when the shoe is on the other foot and Justice Department prosecutors are trying to sentence a person to prison, they not only use the testimony of felons but even reward them for their often fabricated testimony. Paid testimony comes in the form of pardons from earlier convictions, dropping of pending charges, money, including supporting the witness for years in the Witness Protection Program. If witnesses didn't testify as Justice Department prosecutors wanted, they would face long prison terms or other consequences. In addition, they don't have to worry about prosecution for perjury. The only law enforcement agency holding authority to prosecute them wanted them to commit perjury. In the criminal trial against mafia figures Gotti and Thomas Gambino, long prison sentences were based upon the testimony of other felons, who were rewarded for their testimony through sentence and charge reductions. Great Pretense President George Bush, speaking before an audience of nearly 3,000 delegates to the National Convention of the Fraternal Order of Police, the nation's major police labor organization, stated, "The time has come to show less compassion for the architects of crime and more compassion for its victims. Our citizens want and deserve to feel safe. We must remember that the first obligation of a penal system is to punish those who break our laws. You can't turn bad people into saints. So much for hypocrisy." The initial media attention to October surprise forced the Senate and House to form committees supposedly investigating the charges. But the Republican members of the House and Senate vigorously opposed any investigation, afraid of what would be revealed. When continuing media pressure forced an investigation, safeguards were installed, including bringing people from other government agencies that could be counted upon to ensure a cover-up. These investigators then barred witnesses who would expose what was being investigated. They conducted closed-door hearings of witnesses, preventing the public from making their own decision as to the truthfulness of what was written in the final reports, or what was omitted. By omitting key testimony, the final report would be a farce. Another tactic is to label key witnesses as unreliable or discredited, as was done with U.S. and Israeli intelligence agency witnesses, Mossad agent Ari Ben-Menashe, CIA contract agent Richard Brennicke, and deep-cover CIA operative Gunther Russbacher. These witnesses had no reason to lie. They were not at risk because of the role they played in the October surprise scheme. Instead, they risked persecution by Justice Department prosecutors if they testified falsely. In a catch-22 scenario, they knew that they faced false prosecution from Justice Department attorneys even if they testified truthfully and disclosed government corruption. Brennicke discovered this when he testified during a Denver hearing about George Bush and Donald Gregg's trip to Paris, which Justice Department attorneys sought to cover up. Trojan horses. In 1991, the Senate refused to conduct an investigation into the October surprise charges, but the Senate Foreign Relations Committee conducted a small-scale investigation with virtually no staff and very little funding. The Senate committee selected attorney Reed Weingarten to be special counsel controlling the investigation. He was formerly employed by the U.S. Department of Justice and could be expected to protect the Justice Department's cover-up and involvement in the October surprise operation. Immediately after Weingarten was named special counsel, I sent to him portions of the transcript of Russbacher's sworn declarations which described details of the October surprise operation. They now had Brennicke's sworn statements in the Denver U.S. District Court and Russbacher's declarations. The committee refused to respond to my petition and refused to receive Russbacher's and Brennicke's testimony. A key member of the Senate committee was Cecilia Porter, on loan from the GAO's Office of Special Investigations. Her previous investigation into October surprise discredited key witnesses, including Richard Brennicke, and then she helped write a report claiming that the October surprise scheme did not exist. The chief investigator on the Senate October Surprise Committee was an agent from the Treasury Department's Secret Service, a federal entity that played a major cover-up role in the October surprise operation. The chairman of the Senate October Surprise Committee, Senator Terry Sanford, was formerly the attorney for Earl Bryan, one of the principal participants in the October surprise scheme. Bryan was a CIA asset involved in numerous corrupt CIA and Justice Department activities, including the Inslaw affair. Blocking the investigation, the senators on the committee placed numerous restrictions on the investigation, which were admitted in their final report. Imposed travel restrictions, barring the investigators from traveling to Europe, the travel necessary to obtain the testimony of numerous people identified with the October surprise operation. The report stated that Senator Jesse Helms, ranking minority member of the committee, served notice to Chairman Claiborne Pell that he would not authorize any such foreign travel. The report stated that special counsel was denied authority to travel abroad, thereby precluding the possibility of interviewing Iranian exiles in Europe, Israeli public officials and intelligence operatives, international arms dealers, and prominent Iranian political figures such as Hashemi Rafsanjani and Mehdi Karoubi, who may have knowledge relating to the allegations at issue. Denied subpoena power to the investigators that was needed to compel the attendance of witnesses or the production of documents. the investigators had to submit their request for subpoenas to the full committee of senators and obtain majority approval for the chairman of the committee to sign the subpoenas. The Republicans on the committee were primarily responsible for this restriction. This awkward restriction was further compounded by the senators refusing to approve many of the subpoenas. Out of 47 witnesses and 15 entities for which subpoenas were requested, the senators refused to issue 44 of them. Without subpoenas, many government agencies, directed by Justice Department officials, refused to provide important testimony or evidence. * limited the funds and the time for completing the investigation. The Senate October Surprise Committee spent only $75,429 by the time it issued the November 19, 1992, report. In comparison, Iran-Contra independent prosecutor Lawrence Walsh spent over $40 million and 6 years investigating White House personnel to determine who withheld evidence from Congress. Compare the $40 million spent for the relatively minor offenses of determining who withheld evidence to the $75,000 spent to investigate the treasonous and subversive criminal acts involved in the October Surprise operation. More evidence. In June 1991, the committee took the testimony of Ari Ben-Menashe behind closed doors. Ben-Menashe described his presence at the various October Surprise meetings in Spain and France, including the presence of George Bush at the Paris meetings. His testimony was dynamite, describing in a credible manner the specifics of what he had witnessed in the October Surprise scheme. The American public was deprived of this information. Their massive ignorance and indifference to government misconduct made the sham investigation possible. The Secret Service refused to allow the committee to question their agents who personally followed Bush during the October 19, 1980, weekend. Instead, they limited the questioning to Secret Service agent Leonard J. Tanis, who had not seen Bush on that October 19, 1980, weekend and had simply read the agent's reports placed before him. If the reports were altered, his testimony would be based upon the altered documents. Tanis' lack of knowledge was revealed during questions about contradictions in his statements. Tanis testified, evidently, "I've either mixed up the date or something." If he was deliberately perjuring himself and his testimony shown as false, it would be easy to state he had the dates confused. Secret Service officials were covering up. The refusal to allow the Secret Service agents who were with Bush to testify could only be to hide his actual whereabouts. Additional confirmation from Mossad agent. In his book Prophets of War, author Ari Ben-Menashe described his role as a Mossad agent in the transfer of bribe money for Iranians as part of the October Surprise conspiracy. He also detailed the partial diversion of these funds to Earl Bryan, a friend and business associate of California attorney Edwin Meese. Meese was rewarded for his treachery in October Surprise by being appointed Attorney General of the United States, and was able to block any subsequent investigation, and retaliate against any whistleblower. October Surprise Cover-Up 9. Ben-Menashe described receiving $56 million from the Saudi ambassador in Guatemala and leaving $4 million of this in the CIA-related Valley National Bank of Arizona in a bank account belonging to Earl Bryan. Ben-Menashe's boss, Director of Israel Defense Forces / Military Intelligence Yehoshua Sajai, explained that it was CIA money and that the Saudis helped arrange the banking and transfer. Ben-Menashe wrote that this money came from Central America drug deals involving some Israelis and the CIA. Ben-Menashe described being met by CIA Deputy Director Robert Gates at Miami, who then went to Phoenix to ensure that Earl Bryan got his bribe money. Ben-Menashe described how Bryan was involved in other secret deals involving the CIA and other U.S. agencies. Ben-Menashe wrote that bribe money was given by the CIA to the West Australian Labor Party for allowing Australia to be used in the transfer of arms to Iran following the October Surprise Agreement. He stated that Richard Bobbian, a CIA contract agent, received a $6 million check from Earl Bryan, who was acting on behalf of a CIA cutout. Hadron and Earl Bryan figured prominently in a later scandal given the name of Inslaw. The CIA connections help explain how they avoided criminal prosecution and how Attorney General Edwin Meese, deeply involved in these criminal activities, protected all parties involved, and misused the Justice Department to persecute and imprison informants. George Bush, CIA asset. George Bush was a necessary participant in the October surprise scheme because the Iranians wanted final approval by either presidential candidate Ronald Reagan or his running mate, George Bush. Bush was far more capable of carrying out this type of covert operation. He had been the director of the CIA in 1976 and 1977, and a CIA operative since at least 1960, prior to the assassination of President John F. Kennedy. A document dated November 29, 1963, from John Edgar Hoover, Director of the FBI, to Director of the Bureau of Intelligence and Research in the U.S. Department of State, identified Bush as a CIA asset. Referring to information given to the CIA, FBI Director Hoover wrote of the person providing the information, "The substance of the foregoing information was orally furnished to Mr. George Bush of the Central Intelligence Agency and Captain William Edwards of the Defense Intelligence Agency on November 23, 1963, by Mr. W.T. Forsyth of this Bureau. Houston on November 22, 1963, advised that George H.W. Bush, a reputable businessman, furnished information to the effect that James Parrott has been talking of killing the president when he comes to Houston. A check with Secret Service at Houston, Texas revealed that 180 agency had a report that Parrott stated in 1961 he would kill President Kennedy if he got near him. The Senate October Surprise Report. The Senate October Surprise Committee issued its report on November 19, 1992. It is a standard tactic for a good liar or an attorney to admit certain things to establish a facade of honesty and then follow with lies to complete the cover-up. The report properly identified the severity of the charges, a standard practice to give the impression of credibility by admitting one or more facts. The report then proceeded to discredit the witnesses whose testimony proved the existence of the October surprise scheme. The witnesses being discredited had nothing to gain by giving false testimony, and much to lose, but this basic reasoning was ignored. The report gave absolute credibility to federal officials who would have been impeached and prosecuted if the charges were proven true. This report was prepared by former Justice Department Attorney Reed Weingarten. The report met the definition of cover-up. The committee refused to receive the testimony of Gunther Russbacher. They called him an imposter and refused to address the transcript of his sworn declarations that I sent to them. The report discredited Russbacher by making reference to an attorney friend, Paul Wiltshire, who reportedly failed to produce a copy of a video 24 that allegedly existed of an State Route 71 flight from Paris to Andrews Air Force Base on the October 19, 1980, weekend. The failure of someone else to produce a copy of a videotape had nothing to do with the importance and credibility of Russbacher's testimony. Richard Brannicky gave sworn statements to a U.S. District Court in Denver in 1988, describing his role in the Paris October surprise meetings. His testimony coincided with statements and testimony of other people. Without requiring Brannicky to testify, the committee's report discredited the former CIA contract agent on the basis of newspaper articles, primarily those written by former or current CIA operative Frank Snepp. The report said, on the basis of these published reports, and on the Gauss inquiry, this investigation determined that it would not be fruitful to devote further resources to pursue evidence originating from Brannicky. On a matter of such urgency, investigators don't ask a key witness to testify, he is ordered to do so. Brannicky had been threatened, just as CIA contract agent Reconnaissance Otto had been threatened, by Justice Department attorneys not to testify. Under these conditions, Brannicky had no alternative but to decline a voluntary request for testimony. The Congressional Committee report also sought to discredit Brannicky on the basis of 10-year-old credit card slips showing that someone made charges on his credit card in Portland, Oregon on October 18, 1980. Obtaining Brannicky's testimony would have clarified the matter of the credit cards. Barbara Honegger, author of the first book bearing the title October Surprise, reportedly had the signatures on these controversial credit cards examined by a handwriting expert, who stated they did not compare with Brannicky's signature. She reportedly stated this fact to Lawrence Barcella, head counsel of the October Surprise Committee, in December 1992. Several years earlier, Honegger had questioned people present at the places covered by the credit card receipts, who knew Branicki. They stated that Branicki was not at the places shown by the credit cards, and had not signed the credit card slips. The General Accounting Office had earlier discounted Branicki because he refused to participate in any hearings, conveniently ignoring the fact that Justice Department employees had threatened Branicki, warning him that he would suffer the consequences if he testified. Branicki had been a CIA contract agent carrying out CIA-covered activities, which included drug trafficking. Any one of these CIA-ordered activities could be used for subsequent prosecution by Justice Department attorneys. He saw what happened to CIA contract agent Michael Reconnaissance and to many other CIA assets who were sent to prison on trumped-up charges solely to silence them. Branicki saw the discrediting and cover-up tactics by the mainstream media and the cover-up by the entire Senate and House. He was certainly smart enough to recognize that the safest approach was to say nothing. The Senate report discredited the testimony of Jamshid Hashimi, an arms merchant present at meetings between William Casey and Iranian representatives in Madrid in July 1980. I had obtained secret CIA and State Department documents showing Hashimi's involvement in the Arms for Hostages operation, in which government officials expressed confidence in his credibility. Copies of these reports, sent to the Senate and the House October Surprise Committees, were ignored. The report stated of Mossad agent Ari Ben-Menashe and other witnesses, none of whom had reason to lie, that they have proven wholly unreliable. This decision was based upon their testimony having contradicted the testimony of those who were part of the October Surprise conspiracy. I sent the Senate committee copies of Secret Service reports showing Bush flying into Washington National Airport on Sunday evening, October 19, 1980. These reports disputed Secret Service reports furnished to the committee. I had obtained the reports from Russ Bacher, who had received them while he was assigned to the CJA at Langley in 1981. They had been sent by the Secret Service to the CIA shortly after the events occurred and before the Secret Service found a need to alter the reports years later. After discrediting the sworn testimony of people who were innocent participants in the October Surprise operation, after placing irresponsible restrictions on the investigation, and after encountering great numbers of people who refused to testify, the Senate committee held there was no such scheme. 182. The vast weight of all available evidence including sworn testimony from Secret Service agents assigned to protect Bush, extensive Secret Service records and logs, as well as statements by campaign staff indicates that Bush did not travel to Paris in October 1980 or, for that matter, at any time during the 1980 presidential campaign. The committee report referred to former President Reagan's refusal to cooperate, stating that the investigators were disappointed by President Reagan's declination of the request for an interview. President Reagan's written reply was wholly inadequate to explain his offhand but apparently relevant comment to a reporter that he had acted in some fashion as a candidate in connection with the hostage crisis. The report identified the refusal of the FBI to cooperate, the history of the FBI's handling of evidence in this case from the disappearance and discovery of the Pottinger tapes, to the disappearance and discovery of the entire Hashimi electronic surveillance, to the discovery of an 8-day period in which the Hashimi New York wiretaps were apparently discontinued is a curious one. It is not typical for the FBI to simply lose evidence. Basically, the committee sought to support its cover-up decision that there was no October Surprise operation and that George Bush had not gone to Paris, based upon the following, Secret Service reports purporting to show that Bush never left Washington during the October 19, 1980, weekend. But the Secret Service agents were barred from testifying, and Secret Service agents were reportedly on the BAC 111 to Paris and would be implicated in a coup against the United States. October Surprise was a coup. Secret documents that I later obtained indicate these were altered. From my experience as a federal and private investigator, I have found that it is a common practice for Justice Department attorneys and the CIA to falsify documents. A government accounting office investigation that concluded there was no evidence of the reported October surprise operation. I had repeatedly contacted GAO for the prior 2 decades with hard evidence of criminal activities I uncovered first as a federal investigator and later as a victim in Chapter 11 proceedings, and they refused to investigate. The GAO refused to question any CIA operatives and contract agents who were part of the October surprise operation. The testimony of White House personnel implicated in the criminal activities, who faced long prison terms if convicted of the crimes in which they participated. The committee wrote, "No credible evidence has been found to indicate that high-ranking Republican campaign figures or other prominent American political officials including Bush, Casey, Robert McFarlane, Robert Gates, and Richard Allen attended any October 1980 Paris meetings." Moreover, the special counsel has concluded, after a review of Secret Service records and testimony from Secret Service agents, that candidate Bush was in the United States through October 1980. Cover your rear tactics. Should the cover-up backfire, the Senate October Surprise Committee sought to cover their rear ends. The report stated that certain obstacles existed to determining the truth of the October surprise charges. The investigation was handicapped by several factors which made reaching final conclusions an almost impossible task. There were certainly obstacles, and many of them deliberately put in place by the investigating committee. The SIR tactics included the following: the investigation was hindered by the unavailability of certain key witnesses. Key witnesses who would have implicated themselves refused to cooperate, including Ambassador to South Korea Donald Gregg. The report stated that Gregg declined to be interviewed by the investigators. The great harm inflicted upon the United States demanded ordering him and every other relevant witness to testify. The senators refused to issue a subpoena for the testimony of former President Ronald Reagan. They satisfied themselves with a letter from Reagan's attorney, John A. Mintz, who wrote that he has no recollection or other information relevant to the issues raised in any of your questions. Refusal by the Reagan Presidential Library to produce requested records until after the investigators had already been reassigned and the investigation completed. The report admitted that lack of funds and personnel greatly hindered the investigations, forcing investigators to rely upon other federal agencies to conduct an investigation, even though those agencies were implicated and engaged in a cover-up. The Treasury Department refused to allow the investigators to question the Secret Service agents who had actually been with Bush during the time in question. There would be no reason for refusing to allow these low-level federal employees to be questioned, other than to cover up. The family of former CIA Director William Casey impeded the investigation by delaying and refusing to provide his personal and business records, including his diary and passport. Failure of Donald Gregg, who was on the flight to Paris on October 19, 1980, to pass a lie detector test. The Senate October Surprise Committee gave Gregg the test. He failed it. But rather than call the test a failure, the committee report stated that Gregg's response was lacking in candor. CIA assets Gunther Russbacher and Richard Brennicke, and Mossad's Ari Ben-Menashe, had stated that Gregg was at several October surprise meetings in Europe. There was far more evidence showing the October surprise charges to be true than existed in many criminal cases resulting in sentences of death. The testimony of criminals, paid to give testimony wanted by the prosecutors, is sufficient to result in lifelong incarceration or death and accepted by the media, the courts, and the Justice Department. But the testimony of whistleblowers exposing corruption by federal officials, who risk perjury charges and prison if they're 184. Courageous testimony is proven false, is not accepted by those interested in cover-up. People who testify falsely, in response to pressure from Justice Department attorneys, are assured of freedom against perjury charges. If people refuse to testify as Justice Department prosecutors want, they suffer consequences that can often destroy their lives. Testifying falsely, as requested by Justice Department attorneys, is rewarded. Criminal charges against them may be dropped. If in prison, they may be paroled. they may be put in the witness protection program and supported financially. On the other hand, patriotic Americans seeking to testify about government corruption face fraudulent perjury charges and prison. House investigative team. In response to media pressure, the House of Representatives on February 5, 1992, created a task force to report on the October surprise operation. The House committee repeated the age-old practice of staffing the committee with people who would carry out the cover-up. Its chief counsel, Lawrence Barcella, Jr., followed the standard practice of former Justice Department attorneys of protecting Justice Department officials who were implicated. He had a history of protecting federal officials who had committed criminal acts against the United States. Barcella had covered up for a CIA operation that went sour, in which the CIA was secretly supplying Libya with war supplies. Justice Department prosecutors charged CIA operative Edwin Wilson with illegal arms sales to Libya that the CIA had earlier sanctioned. Barcella was the Justice Department prosecutor who prosecuted Wilson and ensured that the CIA involvement did not surface. Barcella was the attorney for Lynn Nofchiger, President Ronald Reagan's chief political advisor during the 1980 presidential campaign. He was also a member of former Senator Paul Laxalt's Nevada law firm when Laxalt was Reagan's campaign committee chairman in 1980. If the October surprise conspiracy did in fact occur, these men could be expected to know about it and, at the very least, be guilty of felony cover-up. The same could be said of Barcella. Barcella was one of the key public relations or cover-up men for the corrupt bank, BCCI, and one of its most forceful apologists. Attorneys Clark Clifford and Robert Altman hired him to deceive the American public through aiding and abetting the criminal acts of that rogue bank. Barcella was one of 4 attorneys who requested Senator Orrin Hatch to give a speech on the Senate floor in defense of BCCI, seeking to block a congressional investigation into the criminal activities of the bank. Barcella was known to be a friend and protector of the U.S. intelligence community while he was a federal prosecutor. The October surprise charges that Barcella was entrusted to investigate threatened to expose the CIA operation and the cover-up by his former Justice Department bosses. After the BCCI scandal broke, Barcella was asked about BCCI's compliance with U.S. banking laws, to which he falsely replied, BCCI's policies and procedures were consistent with industry norms in the countries in which they. October surprise cover-up 185. Were operating. 275. This bank inflicted the biggest bank fraud in the world's history. It had long been established that BCCI was engaging in criminal activities, drug money laundering, financing of terrorists, secret takeover of U.S. banks, and bribing of government officials wherever it operated, including the United States. Another investigative committee member was Richard Peterson, who was involved in other cover-ups of government corruption. In early 1992, Peterson threatened Garby Leon and Rayalan Russbacher during a telephone call, warning them to cease further activity in the October surprise matter. 76. Shortly after the House October Surprise Committee was formed, I submitted several petitions to its chairman, Congressman Lee Hamilton. Enclosed my declaration and a partial transcript of Russbacher's declarations giving specific details of the October surprise operation in which Russbacher was involved. Hamilton and the committee repeatedly refused to respond to these petitions. Circumventing congressional cover-ups, I submitted numerous documents to the House committee showing that the October surprise operation existed. Several of the copies indicated that the Secret Service was lying about the whereabouts of George Bush on the October 19, 1980, weekend. One Secret Service report dated October 30, 1980, reported that Bush arrived Washington National aboard a UAE BAC 111 charter at 8:25 p.m. Another dated February 17, 1981, was titled, Visit of George Bush to Capitol Hilton Hotel, Washington, D.C. on October 19, 1980. A report directed to Stuart Knight, Director, U.S. Secret Service, Washington, D.C., stated, on October 19, 1980, at 8 p.m. nominee Bush arrived via motorcade at the Capitol Hilton Hotel. Nominee Bush attended a dinner in the main ballroom. No evidence, no witnesses called. In July 1992, the Hamilton Committee released an interim report stating there was no evidence that Bush was in Paris or that there was any support for the October surprise charges. The Hamilton Committee didn't obtain testimony of any of the parties willing to testify that would prove the existence of the scheme and Bush's presence at the Paris meetings. The only parties the committee questioned were two Secret Service agents who guarded vice presidential candidate Bush when Bush was reportedly in Paris. The agents stated that Bush had not been in Paris during the October 19, 1980, weekend. In later pages it is shown that Secret Service agents were on the flight to Paris and that they lied. Congressman Hamilton had close ties to President Reagan's aide, Brian. Hamilton had close ties to CIA operative John Hull, who operated an arms and drug transshipment point on his ranch in Costa Rica. Hull is wanted by Costa. 275 false prophets, Peter Truell and Larry Gerwin, Houghton Mifflin Company. 276 told to the author in conversations with Garby Leon and Rayalan Russbacher. 186. Rican authorities on drug and murder charges. He also had close ties to Dan Quayle while Quayle was a U.S. Senator from Indiana. Hull is being protected in the United States by CIA and Justice Department officials. Again putting Congress on notice, I wrote to Congressman Hamilton on November 27, 1992, enclosing copies of the Secret Service reports, stating that they showed Vice Presidential nominee George Bush arriving in Washington, D.C. on a United Arab Emirates BAC 111 at approximately 8:00 p.m., and his departure for the Washington Hilton Hotel. I emphasized the significance of the documents, writing that they showed Bush and Secret Service agents were lying when they stated Bush had not left the Washington area on the October 19, 1980, weekend. Arguably, those secret reports had less significance in establishing Bush's Paris presence than the sworn testimony of CIA operatives Russbacher, Brennicke, and Reconnaissance Otto, or former Mossad agent Ari Ben-Menashe. Treasury agent Richard Peterson called me several days later, asking where I obtained the Secret Service reports. He said those reports were forgeries, that the date of October 19, 1980, had been altered from the October 18, 1980, date he had on his copies. He stated that the airline identification had been changed from United Airlines to United Arab Emirates. I responded that I would check my source and get back to him. If this was correct, the committee had a responsibility to look at my documents and question the person who gave them to him. It is a federal crime to falsify government documents. If Peterson actually thought that my copies were forged, he had a duty to obtain my testimony to determine where I obtained the documents. They never asked. I asked Peterson why the committee didn't call Gunther Russbacher to testify. He said Russbacher was a phony and an imposter, that he was charged in Oklahoma City with being mentally unbalanced, that he had been in prison from 1976 to 1983, and could not have been involved in October surprise. Further, that Russbacher's attorney friend, Paul Wiltshire, had set up conditions they could not meet. Several times I had told Russbacher that Wiltshire's demand for immunity was giving the committee an excuse for not calling him to testify and that there was no reason to ask for it. Russbacher didn't need immunity if the questions were limited to the October surprise flights. Because of his widespread involvement in CIA-directed activities such as money laundering, drug trafficking and bank fraud, he was subject to prosecution, especially if the CIA pulled the standard disavowal on him. Russbacher could raise the immunity issue if the questioning went into areas other than October surprise, which was unlikely. However, Wiltshire's request for immunity was no excuse for the October Surprise Committee not to obtain Russbacher's testimony. The October Surprise offenses were of such great importance that prejudgment of Russbacher's credibility and refusal to obtain his testimony was out of order, but consistent with the cover-up pattern. I asked Peterson if he had read Ben-Menashe's recently published Prophets of War, stating that the book contained copies of Mossad documents showing Ari Ben-Menashe to be a high staff officer with Israel's intelligence agency. Peterson responded, Ben Menashe had been discredited, without providing any support. It was obvious that Peterson was determined to discredit anything and anyone who supported the October surprise charges. I contacted Rusbacher for a history of the Secret Service reports he had given me that did not coincide with reports the investigative committee had. He said the Secret Service sent copies of those reports to the CIA at Langley, Virginia shortly after they were filed, and they were routed through him while he was at CIA headquarters. Rusbacher advised that the initials RA in the upper right-hand corner of the documents stood for Robert Andrew Walker, one of his CIA-provided aliases. I sent the following letter to Congressman Hamilton. This letter makes reference to a telephone call that I received from Agent Richard Peterson, who is a member of the House October Surprise investigation, and who was borrowed from the Treasury Department's Secret Service, and puts you on notice of the following facts. These comments are in response to Mr. Peterson's recent phone call to me. 1. Agent Peterson telephoned me recently in response to the letter I sent to you and the attached copies of Secret Service agent reports showing Vice President nominee George Bush arriving at Washington National Airport at 18:35 on October 19, 1980, and a motorcade to the Washington Hilton. The significance of that time and date is that it shows Secret Service agents and George Bush, among others, lying when they stated that Bush had not left the Washington area on the October 19, 1980 weekend. 2. Mr. Peterson stated that the multi-page Secret Service agent reports which I sent to you had been altered. He stated that his copy shows October 18, 80 as the date that Bush flew into Washington National Airport, while my copies show October 19, 80 as the date. The significance of this is that the Secret Service and George Bush claim Bush never left the Washington area during the October 19, 1980 weekend, and that if the flight into Washington occurred on October 19, 80, it would show both the Secret Service and George Bush were lying and obstructing justice. Further, even if the flight arrived in Washington on the evening of the 18th, for argument, it appears that this conflicts with the schedule reported by Bush and the Secret Service. 3. Mr. Peterson stated that whoever altered the document would be guilty of a federal offense, and he asked me where the documents came from. I had found these Secret Service agent reports several months ago in the inflow of papers that I receive in the mail, by fax, and sometimes given to me. I don't usually keep track of who has sent or given to me any particular papers. I knew. 188. That numerous people have the same copies that I sent to you, and which are the subject of Mr. Peterson's questions. 4. Seeking to establish the history of the documents, I questioned CIA operative Gunther Rusbacher about them. He stated that the reports were received by him while he was working as a CIA operative at CIA headquarters in Langley, sometime after he had played key roles in the October surprise operation. He stated to me that he placed the initials of one of his CIA-provided aliases, RA, on the upper right-hand corner of several of the Secret Service reports. He acknowledged to me that the dates shown on my reports are the same dates as on the reports that he initialed while in his capacity as a CIA deep cover operative. 5. If your October Surprise Committee was an investigative committee instead of a whitewash committee, the answers could be obtained by having the CIA operative, Gunther Rusbacher, testify in open-door hearings. That same operative can testify to the details of the October surprise operation, including where the meetings were held in which he participated, when the shipment of arms commenced, how the arms were stolen from U.S. reforger stores, the part played in the treasonous activities of the CIA and high White House officials, and others. He can also describe other patterns of corrupt activities, including the CIA looting of financial institutions, CIA drug trafficking within the United States, CIA participation in looting of Chapter 11 assets as part of a vicious racketeering enterprise preying upon American citizens and small businesses who exercise Chapter I-1 protections, and other racketeering enterprises implicating federal officials. He can also testify to the Secret Service agents that were part of the October surprise operation, along with White House officials, people who are now federal judges, members of Congress who participated, including Senators John Tower and John Heinz, among others. 6. Sworn declarations given to me by CIA informants indicate that 4 or 5 Secret Service agents accompanied the group of Americans who traveled to Paris for the October 19, 1980 weekend meetings that finalized the October surprise operation. The involvement of the Secret Service, the CIA, members of President Carter's staff, and others, in the subversive acts against the United States may constitute one of the worst criminal conspiracies ever exposed against the United States, and surely constitutes an unpublicized coup. Having a Treasury Department agent play a major role in the October surprise investigation, when Treasury Department agents assisted in carrying out the coup or scheme, is typical of congressional investigations, but hardly meets the definition of an investigation. 7. Mr. Peterson stated that the Secret Service reports were not confidential or secret but simply not released. However, various news media sources claim they have copies of the reports, and presumably this supports his statement indicating that the reports are not classified. Lam requesting copies of the reports that your committee has in its possession, and any other reports commencing from Friday, October 17, 1980 through October 20, 1980 Monday. Signs of cover-up by your committee. 8. In response to my comment that Ari Ben-Menashe's credibility has been established by the copies of Mossad documents in his recently published book, Prophets of War, Mr. Peterson responded that he was totally discredited. Ari Ben-Menashe testified before congressional committees that he was present at several of the October surprise meetings, and saw George Bush, William Casey, Robert McFarlane, Donald Gregg, among others, at these meetings. He knew he would be charged with perjury if he lied, and he had nothing to gain. His recent book, Prophets of War, include Mossad documents showing him to be a high staff officer possessing details of the October surprise operation that dovetails with the testimony offered, and the investigative findings of numerous journalists and authors. 9. In response to my question as to why the testimony of CIA contract agent Richard Brannicky was not accepted, Mr. Peterson responded that he was totally discredited. But Brannicky knew that he would probably be charged with perjury if he lied. He had nothing to gain by his testimony before a U.S. District Court judge in Denver in 1988. He was simply trying to show that he, and Rupp, who was on trial in the Aurora bank fraud case, were CIA contract agents. Further, his testimony coincided with other CIA operatives, with dozens of people who described their part in the October surprise operation to various investigative journalists and authors. They, like Brannicky, had nothing to gain by their statements. 10. In response to my question about why the committee did not accept testimony from CIA contract agent Michael Reconnaissance, Mr. Peterson totally discredited him. Again, as with Brannicky, Reconnaissance gave sworn testimony concerning the October surprise operation, and he knew that he faced perjury charges if he gave false testimony. He had no reason to lie. He testified to assisting in the relay of the $40 million bribe money in the October surprise operation. 11. In response to my question asking why the House October Surprise Committee didn't have CIA operative Gunther Russbacher testify, Mr. Peterson justified refusing to allow Russbacher to testify on the basis that Russbacher had been continuously in prison from 1977 to 1983, and thereby couldn't have been part of the October surprise operation. But Russbacher has given me sworn declarations that he had not been in prison continuously during this time, and only was imprisoned for short periods to provide a background for his covert CIA activities with factions in Europe and the U.S. underworld. Further, Russbacher would not risk further imprisonment from perjury charges and could be expected to testify truthfully. I already have hundreds of sworn statements by Russbacher, describing the specifics of the October surprise operation, which he have personally checked out with Ari Ben-Menashe, and through contacts with various personnel reportedly implicated in the European meetings associated with the October surprise operation. 12. Mr. Peterson stated awareness of the State Route 71 videotape described by Paul Wiltshire, on the purported flight from Paris in which Gunther Russbacher was reportedly the pilot and George Bush the passenger. Your committee could have proved or disproved the existence of that videotape by requesting the tape from the archives at Camp Meade, Maryland. You never did that. 13. Gunther Russbacher, CIA operative and captain in the U.S. Navy and Office of Naval Intelligence, has offered to testify under oath to your committee and others, describing his role in the October surprise operation, knowing that 190. He would be charged with perjury if he lied. Congressman Hamilton and his committee knew he offered to testify and that Russbacher would undoubtedly not risk a prison term to lie, especially when it would not be to his benefit to testify. 14. I provided to your committee a partial transcript of sworn declarations by Gunther Russbacher, describing details of the October surprise scheme, claiming that he was at several of the meetings, and that he arranged for the procurement and shipment of arms following the Barcelona meeting. I am prepared to testify to what Russbacher stated to me during the past 2 years concerning his role in the October surprise CIA operation. As a former federal investigator, I am quite competent to evaluate the sincerity and truthfulness of almost 300 hours of statements. Russbacher has offered to testify to a congressional committee, including that chaired by Congressman Hamilton, knowing that he would be charged with perjury if he lied. 15. Your group has ignored the statements made by former Iranian President Bani Sadr in his 2 books describing details of the October surprise operation. Presumably he too is totally discredited. 16. Lam, a former federal investigator who held federal authority to make certain determinations. I witnessed a pattern of hardcore federal crimes perpetrated by federal officials. He have government documents showing the crimes to exist. Arrested at Castle Air Force Base for allegedly impersonating a naval officer, after debriefing his CIA superiors concerning a secret flight of SR-71S to Moscow on July 26, 1990. Informant and whistleblower Rodney Stich, repeatedly threatened and imprisoned since mid-1987, as corrupt federal judges and Justice Department prosecutors retaliated against me for filing federal actions reporting the federal crimes. Ari Ben-Menashe, high-ranking officer in the Mossad, possessing information concerning the October surprise operation and other corrupt acts against the United States in which present federal officials were implicated. He was falsely charged by Justice Department officials in an attempt to silence and discredit him. The criminal mindset of those now in control of the Justice Department, and in control of the federal judiciary, is reflected by these repeated prison sentences inflicted upon informants and whistleblowers, in retaliation for reporting the criminal activities previously brought to your attention, to Congressman Hamilton's attention, and to every senator in the U.S. Senate. Since 1987, and continuing at this very moment, corrupt federal judges and Justice Department prosecutors are threatening to put me in federal prison in retaliation for filing a federal action reporting certain segments of the criminal activities that I have repeatedly brought to the attention of your committee and others via petitions. My findings and determinations have considerable credibility, former federal investigator holding federal authority to make such determinations, possessing evidence supporting many of my charges, including judicial records which establish the felony persecution of informants and victims by Justice Department prosecutors and federal judges. Private investigator for many years, expanding my investigations into other and related areas of criminal activities against the United States and its citizens. Author of several books exposing government corruption through specific examples, based upon hard evidence and judicial records, having devoted thousands of hours and many years of investigations to this cause. Victim of the criminal activities seeking to obstruct justice, as rogue Justice Department personnel, federal judges, cooperating law firms and attorneys, targeted me for the past decade, misusing the judicial process, blocking my reporting of the crimes, and retaliating against me for exposing the criminal activities of which they were a part. These crimes were committed while a majority of the U.S. Senate and House withheld their duty to act, and thereby became accomplices. Statements and sworn declarations given to me by deep-cover CIA operatives and contract agents, describing the pattern of criminal activities that I have made reference to in prior petitions to members of Congress and which I have entered into judicial proceedings. * Over 1,800 radio and television appearances since 1978, in which my reports of corruption have been given major credibility. * Judicial records confirm many of my charges, especially relating to criminal acts related to a series of airline crashes, the pattern of corruption in Chapter 11 courts, the pattern of felony cover-up and felony persecution of informants by Justice Department personnel and federal judges. Obstructing justice and misstating the facts. Federal crime reporting statutes make it a federal offense if any person, knowing of a federal crime, does not promptly report it. 3 Justice Department personnel and federal judges have perverted this requirement by retaliating against informants, whistleblowers, and victims who seek to report aspects of these various criminal activities. It is a federal crime if anyone retaliates against an informant or victim, as Justice Department prosecutors and federal judges have done. It is a federal crime for a federal officer, such as a member of Congress or a congressional committee, to refuse to receive evidence offered by an informant or victim. Determination of which secret service report is correct. As part of the long-time effort to expose the escalating pattern of criminal activities against the United States by corrupt federal officials, I have repeatedly discovered federal officials falsifying documents, covering up for documents, misstating the facts, showing that perjury by federal personnel and falsified federal documents are normal cover-up tactics. In evaluating whether Congressman Hamilton's copy of the Secret Service reports, or my CIA-related Secret Service reports, are accurate, the following actions should be taken. Obtain the testimony of Gunther Russbacher concerning these reports, in open hearings, and giving the media access to him before and after his testimony. Allow the CIA operatives to testify, and compare their testimony, as it relates to October surprise and peripheral activities. Obtain the sworn testimony of the Secret Service agents who were with Bush from October 18 through October 20, 1980, in open hearings, making it clear that the Justice Department and an independent prosecutor will prosecute for criminal perjury if the statements are false. Consider the overwhelming pressures upon Secret Service agents to lie concerning their observation of Bush's activities from October 18, 1980 to October 20, 1980, and their knowledge of the October 19, 1980 report date. Obtain CIA records and testimony relating to the routing of the Secret Service report that Russbacher initialed. Obstruction of justice by the House Investigative Committee. It is my evaluation that Congressman Hamilton's October Surprise Committee will continue to cover up and obstruct justice in relation to the October Surprise matter. Agent Peterson, on loan from the Treasury Department, seeks to protect the Secret Service's involvement in the October Surprise operation. Credible witnesses such as former Mossad staff officer Ari Ben-Menashe, CIA contract agents Richard Brannicki and Michael Reconnaissance, who testified under risk of criminal perjury charges, were dismissed by simply calling them not creditable, and giving sham reasons that only a gullible public could swallow. Credible deep cover CIA whistleblowers, such as Gunther Russbacher, are not given the opportunity to testify, eliminating one of the primary sources of establishing the existence of the October Surprise operation and its many. 294 Gunther Russbacher, Michael Reconnaissance, Richard Brannicki. 216. Tentacles. Conducting closed hearings to prevent the public discovering the crimes against the United States on the basis of testimony offered, or the refusal to ask questions that would result in the answers establishing the crimes. This is a standard congressional tactic of many years. Aiding and abetting the felony persecution of informants by corrupt Justice Department officials and federal judges, as a part of the pattern of felony obstruction of justice by congressional investigative committees. Refusing to receive testimony and evidence relating to the petition that I submitted, including the declarations of Russbacher and myself, describing the criminal activities that both of us discovered while we were federal employees. Obstruction of justice by the Senate Investigative Committee. As a former federal investigator, my evaluation of the November 19, 1992 Senate October surprise report is that it is a blatant and felonious cover-up, misstating the facts, omitting key facts, refusing to have key witnesses testify, for the purpose of cover-up, and of course, obstructing justice. The report discredits the many witnesses who testified to what they witnessed in their participation in the October surprise operation. They had nothing to gain by their testimony and risked imprisonment on charges of perjury. Many knew the fate of Richard Brennicke and Michael Reconnaissance when they testified, and yet they had the courage to come forward. Deep cover CIA officer Gunther Russbacher is suffering greatly from his attempts to report the great crimes committed against the United States in the October surprise and other criminal activities. I have been stripped of my multi-million-dollar assets and have been subjected repeatedly, and at this time, to criminal contempt of court in retaliation for seeking to report the crimes that you cover up, and for seeking relief from the great harms inflicted upon me by criminal misuse of the agencies over which you have oversight responsibilities. These criminal acts and outrages reflect the subversive activities rampant in the United States and made possible by your cover-up. My book describes the felony cover-up by members of Congress, Justice Department personnel, others, including independent prosecutor Walsh, and describes the criminal aiding and abetting of activities that are destroying the United States form of government from within. Responsibilities of members of the committee ** obtain Russbacher's testimony in open hearings. He has repeatedly stated, and reconfirmed it today, December 26, 1992, that he is ready to testify concerning ** the CIA origin of the Secret Service reports that I mailed to Congressman Hamilton, ** the specific details of the October surprise operation in which Russbacher was ordered to participate by his CIA superiors, including meetings in Barcelona and Paris, the shipment of arms after the Barcelona meetings, where the arms were obtained, how they were shipped, names of people involved in the shipping of the arms, names of those on the BAC 111 to Paris. Iran-Contra on the October 19, 1980 weekend. With immunity, he would be willing to testify to other activities in which he was ordered to participate, that have inflicted great harms upon the United States. These activities include looting of financial institutions, CIA drug trafficking in the United States, the CIA role in the BCCI banking scandal, and others. Obtain my testimony and evidence in open hearings, relating to the direct and indirect knowledge that I have of these criminal activities. Obtain the testimony of other CIA operatives, whose testimony would reinforce that of other informants. Include as part of your investigation the contents of my manuscript which shows the intricate relationship between the various criminal activities. This is a request that you include in the final report of your October surprise investigation the comments made in this and earlier letters. Enclosures. October 3, 1980 CIA, proposal to exchange spare parts with hostages. October 9, 1980 Department of State, approach on Iranian spares. October 21, 1980 Department of State, talk with Mitch Rogovin. October 29, 1980, two related items on Iranian military supply. October 1980 Secret Service reports, Bush's security detail. June 3, 1983 CIA, release of hostages. July 5, 1985, new developments on channel to Iran. August 19, 1985, status of Hashimi Elliott Richardson contact. Walsh refused to receive my testimony and evidence, and that offered by Gunther Russbacher. He also refused to act, or even make reference to boxes of documents sent to him by Arkansas and congressional investigators proving the existence of massive drug trafficking into the United States as part of the Contra operation. Silencing the Christic Institute. The public service-oriented Christic Institute based in Washington, D.C., investigated the atrocities associated with CIA activities in Central America and filed a federal lawsuit against White House officials who were implicated. Their complaint stated numerous federal causes of actions invoking mandatory federal court jurisdiction. but the Christic Institute encountered the same judicial obstruction of justice that I had encountered, and similar retaliatory actions. 218. The U.S. District Judge unlawfully dismissed the case and then ordered the Christic Institute to pay $1 million damages for having exercised their constitutional and statutory right to file the action and report the criminal activities. The Christic Institute filed an appeal and was ordered to pay additional sanctions for exercising that right. The justices of the U.S. Supreme Court approved this judicial misconduct by refusing to provide relief, just as the Supreme Court justices had done to me. Eliminating the independent prosecutor toward the end of 1992, as the number of crimes directly involving federal officials escalated to an unprecedented number threatening Justice Department and White House officials, as well as members of Congress, the independent prosecutor authority was allowed to expire. Congress refused to renew it. Republicans were under great threat of exposure from a decade-long pattern of corruption, and they threatened to filibuster if a vote was taken to renew the legislation. Democrats were also threatened for their role in numerous scandals and didn't press the matter. Further, the legislation carried a provision that members of Congress could also be investigated by an independent prosecutor. Final report by Independent Prosecutor Walsh. The final report by Independent Prosecutor Walsh was sent on August 5, 1993, to a special tribunal of the Federal Appeals Court in Washington, D.C. Copies of the report were sent to the parties named in the report with an opportunity to object. The special tribunal, headed by Judge David B. Sent L., gave these parties until December 3, 1993, to raise objections to Walsh's findings. Walsh's report, avoiding the ugly nature of the ongoing criminality, did identify some of the parties. The report stated that President Reagan, former Attorney General Edwin Meese, and former Defense Secretary Caspar Weinberger engaged in a broad conspiracy to conceal the criminal activities. Walsh avoided revealing to the American people the ugly side of the Iran-Contra affair, including the massive drug trafficking into the United States by U.S. intelligence agencies and the Mossad. The CIA drug smuggling into the United States has greatly contributed to the worst crime wave America has ever experienced. Documentation relating to Operation Magpie, the secret, unlawful arms for hostages conspiracy, carried the code name Operation Magpie. One CIA document dated May 20, 1986, signed by CIA Director Bill Casey, related to a flight from Tel Aviv to Tehran which received considerable congressional attention. This was the flight carrying a cake and dueling pistols for Iranian officials. A key reference was to the two pilots who would fly the plane from Israel's Ben Gurion Airport to Tehran. These two pilots were John Robert Siegel and Gunther Karl Russbacher. The memorandum, written 6 months before the U.S. press publicized the Iran-Contra activities, showed George Bush as receiving a copy. Bush repeatedly denied knowing anything about the arms for hostages until after the November 1986 media publicity. Another document from the National Security Agency dated May 30, 1986, relating to Operation Magpie, written by Oliver North to Admiral John Poindexter, NSA, showed Vice President George Bush being advised of the Iran-Contra 29 operation. Still another document, this one from the Israeli government, identified Gunther Russbacher as one of the pilots on Operation Magpie. The Israeli letter listed the names of U.S. personnel who were at Tel Aviv's Ben Gurion Airport in May 1986. There was also the record from Offutt Air Force Base at Omaha, Nebraska, describing Russbacher's stay at that high-security base, listing him as captain in the U.S. Navy and showing the authorizing government agency as SINPOC, along with his serial number, 441-41417. Almost all these documents, showing Russbacher as a key officer with the Office of Naval Intelligence, were known to members of Congress who stated Russbacher was a phony. They were known to the prosecutors and officials in the U.S. Department of Justice, who continued to prosecute Russbacher. I brought them to the attention of state officials in Missouri who had caused Russbacher's imprisonment on the sham charge that he was impersonating a naval officer. The establishment press knew about the documents and maintained their usual duplicity of silence. Gunther Russbacher, Bristol, England, August 1997. 220. National Security Agency. Central Security Service. Port G60RSE at Mead, Mary Lang 80786-0000. August 22, 1985. Robert C. O'Farlane. Waddy O'Neill Security Advisor. Old Executive Office Building. Room 306 Confidential Washington, D.C. 20506. Re. WAG PIB. Dear Mr. Mopelane. TNE Firat transaction on August 17, 1985 involved TLE whale of 100 tow missiles. In return for the release of an undetermined number of United States citizens held hostage in Lebanon. The missiles were to be provided from the weapons stock of the Israeli Defense Forces. We have agreed to replenish the Israeli weapons stock after the transaction with Iran is completed. As of August 20, 1985, our DC-8 transport aircraft, piloted by Gunther K. Russbacher ONI, and John R. Siegel, along with Robert Hunt, Oliver North, and George Cave, flew from Israel to Iran loaded with 96 tow missiles. Contrary to the agreement, as you know, none of the hostages were released. Manikur Ghorbanifar contended that the tows were mistakenly delivered to the commander of the Iranian Revolutionary Guard rather than to the Iranian faction for whom they were intended. Please respond to any clarifications. Yours Tsudi. Beg Khan. Pod, On M. Poindexter Deputy Director Waddy O'Neill Security Council. COS VP Bush William Casey. AMP/AB. August 22, 1985, document from National Security Agencies John Poindexter to Robert McFarlane referring to the sale of missiles to Iran. Gunther Russbacher and Robert Hunt, two of my contacts, are named in the document. A copy was sent to Vice President Bush, who assured the American public while Vice President and President that he knew nothing about the arms for hostages conspiracy. Iran-Contra 22. National Security Agency. Central Security Service. Fort George G. Meade, Maryland 20755-6000. September 20, 1985. Robert C. McFarlane. National Security Advisor. Old Executive Office Building. Room 306. Washington, D.C. 20506 Confidential. Re. Magpie. Dear Mr. McFarlane. Despite the failure of the first arms transaction, the Iran initiative was continued. Our negotiators agreed, the United States, through Israel, would provide Iran with 400 tow missiles. In return, the Iranians would arrange for the release of any U.S. hostage, except for Buckley. The transaction was to take place in the same manner. IDF Pound Israel would provide the missiles and the U.S. would later replenish the Israeli supply. Lt. Col. Oliver North and Lt.J.G. Robert Hunt, on staff to the National Security Council, who in their official capacity were to make the necessary arrangements to receive any hostages who might be released. On September 15, 1985, a DC-8, piloted by Gunther K. Russbacher and John R. Siegel along with Oliver North and Robert Hunt, Howard Teicher, flew to Tabriz, Iran, loaded with 408 tows. On the same day, American hostage Benjamin Weir was released in Beirut on information and belief. This transaction was effected to demonstrate the ability of the negotiators on each side to deliver by providing tow missiles and releasing a host to you respectively. On September 17, 1985, Manikur Ghorbanifar paid $290,000 to the Israeli intermediary to cover the costs of transporting the tows. The following day, Iran paid $5 million into Ghorbanifr's Swiss bank account at Credit Suisse, No 913-216-83-7. Any further clarifications or changes should be acknowledged. Sincerely, _ ZLAP PE Olupal On MZ Poindexter. Deputy Director. National Security Council. CC, VP Bush. William Casey. JMP/SV. September 20, 1985, document describing the arms for hostages scheme showing Israeli involvement, identifying as ONI, Gunther Russbacher and Robert Hunt, and informing Vice President Bush of the scheme. United States Governor. Memorandum May 20, 1986. Bill Casey HQ. CIA. Russbacher Carl Gunther ONI. Siegel Robert John CIA. John Poindexter NSA. Re. Operation Magpie. Please be advised these men will meet with agents Rahert FRNT Kant. Bud McFarlane NSA. Oliver North NSA. George Cave CIA and Howard Teicher also CIA. They will give complete briefing at Tel Aviv Ben Gurion Airport. Pilot selection is now finale. If you have any questions please call me soon. We leave Sunday the 25. I'm keeping my fingers crossed. Omi ICL. 7A CAD of Real Casey CIA. VP. Bush. May 20, 1986, document from CIA Director Casey to Admiral Poindexter, listing the names of intelligence personnel involved in the arms for hostages scheme including Gunther Russbacher and Robert Hunt, and showing copy sent to Vice President George Bush. Iran-Contra 223. United States Government. Memorandum date, May 22, 1986 Arm or John M. Poindexter. Ev Sect, Mag PIB Profs, 31305B89. 7 William J. Casey, HQ. CIA. Bill. This is a note for the funds that Oliver North and Robert Hunt have worked out on behalf of the Iranians to deposit $15 million into an enterprise bank account, and an additional deposit of $1.46 million was made to the enterprise account to cover 508 additional tows which were to be provided to Israel as replenishment for the previous Israeli tow shipments. Of the approximate $16.5 million, the enterprise received for this hardware, the agents caused only $6.5 million to be paid to the United States to cover the cost of the IAWK spares parts and the 508 tows, leaving a profit for the enterprise of almost $310 million. If you have any questions, please call me at the Executive Office Building. Yours truly. H. N. Prentila on Poindexter. CC, VP Bush QO. North. May 22, 1986, document from Poindexter to CIA Director William Casey describing receipt of money from the sale of missiles to Iran, the profits, and the deposit of funds by Oliver North and Robert Hunt into a private bank account. 224. United States Government. Memorandum Pave, May 27, 1986 Met, Mr. John M. Poindexter, NSA. U.S. CRO. Mag PIB Props, 31305B90. T.E. William J. Casey, TQ. CIA. Bill, F. Several days after the last of Khashoggi's payment was deposited in Lake Resources account, number 386-43022-1, agents Robert Illunt and Oliver North worked on Alban Valves, a shell company for additional funding. They deposited $26,490 to an account named Corel. 4 days later, Lid Park Square, another account dispensed $200,000 as capital for the button account set up for Robert Illunt, Oliver North, George Cave, Elau Art Teicher, Gunther Russbacher, and John Siegel and their families. We considered the personal benefits of these agents. These accounts must be kept confidential for security reasons. Yups AE. KIF CESOE. Own Poindexter. CC, VP Bush 0. North. May 27, 1986 document to Bill Casey from John Poindexter listing the bank account number of a CIA proprietary, and showing money expended for arms. Also listed were some of the authors' contacts and their CIA/ONI status, including Gunther Russbacher and Robert Hunt. Further, The documents show Vice President Bush being kept informed of the operation. Iran-Contra 225. United States Government. Memorandum OATE, May 30, 1986. Struers Oliver 1. North_NSA, USAC MagPic. Profs, 31305386. 2, John M. Poindexter. NSA. Admiral. There has been a problem in negotiations in Tehran. Manikur Ghorbanifar had assured us thought we would be meeting with Aylas Hemi Rafsanjani and President Ali Khomeini on this trip. Instead we met with Dr. No and the Australian. During this meeting we were told that our pilots Russ Bacher, Gunther Karl and Siegel John Robert were being brought to our hotel. Agents Ilunt Robert and Cave George had spoken to Robert McFarlane and had decided to cancel negotiations due to security and nature of this trip. Please get back to me on this as soon as possible. I will call you in the morning. Semper Fidelis. RP/E will LOE. VP. G. Busy. Oliver L., North. CIA WKC. CC. May 30, 1986, document from Oliver North to Admiral Poindexter, showing Gunther Russbacher to be a part of ONI, with copy to George Bush. Significance is that Russbacher is who he said he is and that Bush lied, while Vice President and President, when he stated he did not know about the arms for hostages scheme. 226. Or PEICEORVWHHEW Vice President. Washington. June 16, 1986. Mr. John M. Poindexter Confidential. National Security Advisor. Old Executive Office Building. Washington, D.C. 20506. Dear Admiral Poindexter, I would like to take this time to offer my gratitude and appreciation for your hard work and assistance in Operation Magpie. Your negotiations on our behalf have proven to be quite effective in obtaining the release of United States citizens held hostage in Lebanon. I would like you to personally thank Robert McFarlane for his willingness, daring, and efforts in meeting with Iranian factions. I would also like you to thank the staff of the National SEC Yul Yigaun Kale, in eluding agents Y = like. Code S all cyber T no Rikusm, Iwerid at Alnt Robert Hunt for their dangerous assistance and diligence, without which Operation Magpie would never have been successful. Finally, you must offer my gratitude to the C.I.A. and their agents, George Cave, Howard Tyker, John Siegel, and Gunther Russbach. These men are dedicated and blessed with the gift of courage. They too truly believe in the pursuit of freedom for all mankind. May God bless you all. Respectfully. AEGA Lush Bush George. GB/FRCC, R. Reagan. W. Casey. June 16, 1986, letter from Vice President George Bush to John Poindexter referring to the Arms for Hostages scheme. Both Ronald Reagan and George Bush are shown as being sent a copy of this document describing part of the Arms for Hostages scheme. Reagan and Bush repeatedly stated they knew nothing about the Arms for Hostages scheme until after the November 1986 shoot-down of a CIA aircraft in Nicaragua. This lying was many times worse than Richard Nixon's cover-up of the Watergate break-in. Iran-Contra SPB. Significance of the government documents. Watergate has been cited as one of the biggest scandals in the United States government by the CIA Protective Washington Post and members of Congress. But Watergate was a two-bit burglary by CIA and White House personnel, which President Richard Nixon sought to cover up after learning about it. It took months and months of drum beating by the Washington Post and related hyperbole as to its seriousness to bring down a president who was hostile to the CIA. Either the Iran or the Contra portions of the Iran-Contra scandal were many times more serious than the Watergate affair. Not only did Ronald Reagan and George Bush cover up for these criminal activities, but they participated in them as the operations developed. Tens of thousands of people died as a result of the U.S. arming of Iran. The Contra operation included CIA-funded assassination squads intruding into the affairs of a foreign country and massive drug trafficking into the United States. Where were the Washington Post and the many other newspapers that exaggerated the Watergate affair? Where were members of Congress who piously condemned President Nixon? They were engaging in felony cover-up and obstruction of justice, and the public has paid and is still paying the price for the crimes of their leaders. Stealing aircraft. One of the little-known criminal activities involved with the arms and drug trafficking aspect of Iran-Contra was the theft of single and twin-engine general aviation aircraft. After the aircraft were stolen, the registration numbers would be altered and then would be used for hauling arms to Central America and drugs on the return trips. Gunther Russbacher had first told me about this operation. A former Federal Aviation Administration security investigator, Kurt Rodriguez, also described the practice. He had discovered that many of the crashed drug-carrying aircraft had their manufacturer's identification plates removed, and then installed on aircraft stolen. Rodriguez discovered this problem as he discovered single and twin-engine aircraft involved in drug trafficking. He told me that his FAA supervisors ordered him to stop investigating this matter, and not to make any reports relating to it. Rodriguez stated that when he ran an aircraft search through the FAA registry in Oklahoma City, on certain aircraft, Justice Department personnel would be notified of the check. He would then be ordered to halt his investigation. He felt that these aircraft were used by the CIA and other intelligence agencies for drug trafficking. Oklahoma City investigative reporter and talk show host Jerry Bowen also discovered the practice of stolen aircraft used by the CIA. Former CIA asset Terry Reid, who conducted flight training in Arkansas of Contra pilots, also writes about the practice, and that Oliver North and Attorney General William Barr were either aware of it or were involved in ordering the operation to occur. The CIA used their inside contacts with the FAA to determine what substitute aircraft registration numbers to use. 228. Project donation. In some cases, the theft of the aircraft occurred with the owner's permission. The scheme worked like this: the CIA would instruct people owning insured airplanes to report them as stolen, after allowing CIA personnel to take the aircraft. The owner would report the theft to the insurance company and then collect the insurance proceeds. This plan appealed to aircraft owners who had trouble selling their aircraft and wanted their equity out of it. This was called project donation. I remember seeing advertisements in various aircraft newspapers such as Trade A Plane seeking people who wanted to donate their aircraft. Reid describes how Oliver North explained the operation to him in 1983 when they met in Oklahoma City. In some cases, the insurance would be carried directly or indirectly by an insurance company that was a front for the CIA. When the donated aircraft disappeared, the theft would be reported to the insurance company holding the original policy and then charged to the CIA-controlled insurance company which had earlier purchased the theft portion of the original policy. It is a common practice among insurance companies to buy the insurance coverage from an unsuspecting insurance company that issued the original policy. Chapter 13. CIA Review. Act while Harry Truman was president. The primary purpose of the legislation was to centralize intelligence material gathered by U.S. intelligence agencies. This need was made obvious by the disaster at Pearl Harbor in 1941. The Pearl Harbor debacle resulted in 2,500 deaths, loss of many ships and aircraft, and allowed Japan to escalate the global conflict that resulted in millions of deaths and atrocities. If White House and military officials had used street smarts in defending against that Pearl Harbor attack, Japanese aggression could have been prevented or halted. Of course, even then, the intelligence was available to people with a duty to react, but as usual, they didn't react. Even when radar showed hundreds of planes approaching Hawaii from the northwest, nothing was done. The same can be said of the many Japanese messages that were decoded, showing that an attack was imminent. I was a young Navy radio man in a PBY squadron at that time, and saw the ineptitude that is no rarity in American culture, and certainly more so today. The Central Intelligence Agency is referred to by CIA personnel as the company, the agency, or the CIA, and these terms are used throughout these ages. 5. Intent has been repeatedly negated. The Aldrich Ames spy scandal is only one instance of how the CIA has failed in its legislated duties. This failure could have, and may still bring about, catastrophic harm to the United States if a sufficiently powerful adversary took advantage of the internal CIA problems. As a result of Ames' treasonous acts, and the CIA's failure, or refusal, to halt Ames' activities, the CIA knowingly passed on to high-level planners in the United States information that the CIA knew was not accurate. In evaluating the competency of the CIA to gather and evaluate intelligence, consider its competency or willingness to halt the incredibly harmful acts of this top agent. The CIA knew it had a spy in its top-level ranks, with access to highly sensitive documents and information. It surely knew that national security was being seriously harmed. It knew that, Ames had paid $540,000 cash to purchase his home. Ames drove a Jaguar whose $60,000 cost equaled his yearly salary. Ames frequently charged as much as $30,000 monthly on his charge account. Ames had been filmed several times by FBI surveillance cameras entering the Russian embassy in Washington. Other CIA agents had reported for several years suspicious conduct by Ames. The CIA conduct appeared to be protective of Ames. Not only were these warning signs of substantial income other than from government employment ignored, but lie detector tests omitted any questioning of these telltale signs. Under these conditions, it is obvious that the telltale signs warning of the Japanese Pearl Harbor attack would go unheeded. Paper checks and balances. The National Security Act provided for checks and balances that have become meaningless. The Act required that the National Security Council authorize any covert action taken by the CIA. The Council is composed of the President of the United States, the Vice President, Secretary of State, and Secretary of Defense. The CIA can lawfully perform only those operations specifically authorized by the National Security Council. In practice, the CIA either does not inform the NSC of its covert operations or notifies it after the operations have commenced or been completed. National Security Act. The National Security Act establishing the CIA authorized and limited the agency to certain functions. Portions of the Act state, powers and duties. For the purpose of coordinating the intelligence activities of the several government departments and agencies in the interest of national security, it shall be the duty of the agency, under the direction of the National Security Court, to advise the National Security Council in matters concerning such intelligence activities of the government departments and agencies as relate to national security, to make recommendations to the National Security Council for the coordination of such intelligence activities of the departments and agencies of the government as relate to the national security, to correlate and evaluate intelligence relating to the national security, and provide for the appropriate dissemination of such intelligence within the government using, where appropriate, existing agencies and facilities, provided that the agency shall have no police, subpoena, law enforcement powers, or internal security functions. Provided further that departments and other agencies of the government shall continue to collect, evaluate, correlate, and disseminate departmental intelligence, and provided further that the Director of Central Intelligence shall be responsible for protecting. CIA Review 231. Intelligence sources and methods from unauthorized disclosure, to perform, for the benefit of the existing intelligence agencies, such additional services of common concern as the National Security Council determines can be more efficiently accomplished centrally, to perform such other functions and duties related to intelligence affecting the national security as the National Security Council may from time to time direct. Unheeded warnings. The lawful functions and restraints given the CIA by the statutes have been violated almost from its inception, and warnings about the CIA problems have gone unheeded. President Harry Truman warned the American people of the CIA danger, stating as quoted in the December 21, 1963, Washington Post, "For some time I have been disturbed by the way the CIA has been diverted from its original assignment. It has become an operational and at times a policy-making arm of the government. I never had any thoughts that when I set up the CIA that it would be injected into peacetime cloak and dagger operations." Some of the complication and embarrassment that I think we have experienced are in part attributable to the fact that this quiet intelligence arm of the president has been so removed from its intended role that it is being interpreted as a symbol of sinister and mysterious foreign intrigue and a subject for Cold War enemy propaganda. Truman's warnings were echoed by President Dwight Eisenhower as he was leaving office, warning the American people of the dangers posed by the military-industrial complex, of which the CIA is a part. A secret government instead of the CIA being primarily an intelligence gathering and coordinating agency acting under the National Security Council, the CIA has become so powerful that it can destroy any politician who seriously questions its activities. This is especially true when combined with the criminal misuse of power by Justice Department attorneys and federal judges. The average American is unaware of the gravity of the CIA's criminal activities, thanks to the orchestrated cover-up and disinformation by the establishment media. The corrupt mindset has existed for years. Initiating wars, as in Vietnam, and assassination operations, as in Vietnam and Central America, are routine. Engaging in drug trafficking in foreign countries and the United States, a key reason for worldwide proliferation of drugs, is the type of criminal activities this dangerous agency considers proper. It conspires with underworld figures including the Italian and Jewish mafia to carry out all sorts of criminal activities. Although the CIA is not permitted by law to operate within the United States, it has done so. It has engaged and is engaging in many forms of criminal activities against the American people. Through fronts, cutouts, and proprietaries, the CIA has defrauded all types of U.S. financial institutions, including savings and loans, banks, and insurance companies. The CIA is a major player in the looting of Chapter 11 assets, making the exercise of Chapter 11 statutory protections a trap for unwary Americans. 232. The CIA has corrupted the election process in the United States and in foreign countries. The CIA's October surprise operation corrupted the 1980 presidential election and placed into office a group that embarked on a barrage of criminal activities. The CIA-related Watergate affair caused removal from office of President Richard Nixon. The JFK assassination, with its strong CIA overtones, removed another president elected by the people. U.S. presidents who incur CIA wrath opposing the CIA has been dangerous, possibly even fatal, for presidents of the United States. President John F. Kennedy, recognizing the dangers of the CIA before his assassination in 1962, threatened to muzzle the CIA after the Bay of Pigs fiasco and stated his intention to pull U.S. personnel out of the CIA's Vietnam operation. There is considerable circumstantial evidence indicating CIA involvement in Kennedy's assassination. When the many ugly acts of the CIA are recognized, assassinating a president of the United States is not far-fetched. President Richard Nixon, recognizing the dangers of the CIA, stated his intention to rein in the agency. It was the CIA-related Watergate affair, augmented by the panic-generating antics of CIA's friends, including the Washington Post and reporter Bob Woodward, that expanded President Nixon's after-the-fact cover-up of the relatively minor break-in into a major scandal that brought the U.S. government to a standstill and global disgrace. Compare the after-the-fact cover-up by Nixon with the massive cover-ups committed by CIA-affiliated President George Bush and the silence by the same Washington Post and Bob Woodward. President Jimmy Carter suffered at the hands of the CIA after he fired many of its covert operatives in 1976. Carter was a threat to the CIA, and they retaliated against him several years later by engineering the October surprise scheme, which helped ensure Carter's defeat in the November 1980 presidential election. Benefiting friends Ronald Reagan and George Bush, who benefited from the CIA's October surprise, were the only presidents of the United States since before President Kennedy who were not adversely affected by CIA tactics. Bush was director of the CIA in 1975 and 1976, and reportedly a CIA agent since 1960. Reagan and Bush, and those who aided and abetted these acts, were beneficiaries of the CIA October surprise operation and other CIA dirty tricks. Nazi influence affecting the United States. After World War II, many former Nazi intelligence officers were brought to the United States and placed into various intelligence agencies, including the Office of Naval Intelligence and the Central Intelligence Agency. Many had been given the choice of being prosecuted for World War II war crimes or joining the U.S. military and intelligence agencies. This practice was called Operation Paperclip. These former Nazi officers gained key covert positions in the CIA and other intelligence agencies, engaging in activities that inflicted great harm upon the United States. This Nazi influence could explain the enormous harm inflicted upon the United States by the CIA. Russ Bacher arrived in the United States as the young son of a recipient of this program. CIA Review 938. In Blowback, author Christopher Simpson describes how the U.S. officials secretly brought into the United States under this program people such as Klaus Barbie, not only in spite of their atrocities performed at Nazi extermination camps, but because of this experience. Expose books by insiders. Many books have been written by former CIA insiders describing the agency's covert activities and misuse of power. In Secret Team 2%, written by CIA insider Colonel Fletcher Prouty, he describes his discoveries during many years as Chief of Special Operations with the U.S. Joint Chiefs of Staff. Prouty writes, "The CIA is the center of a vast mechanism that specializes in covert operations, which is, of course, obvious to anyone with a basic knowledge of CIA activities." Prouty writes, "The CIA is the willing tool of a higher-level secret team, or high cabal, that usually includes representatives of the CIA and other instrumentalities of government, certain cells of the business and professional world and, almost always, foreign participation. CIA plants everywhere," referring to news management that enables the CIA to escape unfavorable publicity. Prouty writes about the media's reliance upon CIA news handouts and the infiltration of the media by CIA personnel. Leaders of government and of the great pressure centers regularly leak information of all kinds to columnists, television and radio commentators, and to other media masters. Will be skillfully leaked to the press and to selected businessmen, designed especially for Periscope in Newsweek, or perhaps for its old favorite, Joe Alsop. Advanced top-level information is a most valuable and saleable commodity. To defuse any criticism or exposure of the CIA's unlawful activities, the CIA has people widely dispersed throughout the U.S. government and industry. Prouty writes, "There are CIA men in the Federal Aviation Administration, in state, all over the DOD, and in most other offices where the CIA has wanted to place them. Few top officials, if any, would ever deny the agency such a service, and as the appointive official departed, and his staffs came and went, the whole device would be lost with only the CIA remembering that they were still there. Many of these people have reached positions of great responsibility." Church Committee Report. A congressional investigation of the CIA resulted in a 1976 Church Committee report which stated in part in the sections that were not kept from the American public, for financial support to individual candidates, subsidies to publications including newspapers and magazines, involvement in local and national labor unions. All of these interlocking elements constituted the fundamentals of a typical political action program. Elections, of course, were key operations, and the agency involved itself in electoral politics. 295 The Secret Team, L. Fletcher Prouty, Institute for Historical Review, Costa Mesa, California. 234. On a continuing basis? Degree. The agency was also establishing close links with both book publishing houses and media organizations in the U.S. at this time. Altogether, from 1947 until the end of 1967, the CIA produced, subsidized, or sponsored well over 1,000 books. Approximately 20% of them were written in English. Many of them were published by cultural organizations backed by the CIA. The agency was also conducting extensive operations with newspaper, magazine, and television organizations. It maintained liaison relationships with about 50 American journalists or U.S. media organizations. They are part of a network of several hundred foreign individuals around the world who provide intelligence for the CIA and at times attempt to influence foreign opinion through the use of covert propaganda. A key reason why American public remains illiterate about CIA and other government corruption. In an article written by columnist Carl Bernstein, he wrote that the CIA and the media had more than 400 American journalists carrying out assignments for the agency. My CIA contacts confirmed that the CIA has hundreds of paid journalists and management working in U.S. and worldwide media sources, providing protection against disclosures, disinformation requested by the agency, and providing national leaders with false information upon which to base national policy. With this type of support, it is improbable that the American public will ever learn or be convinced of the sinister subversive and criminal activities by people who have taken over control of key government entities. High-level CIA personnel are able to control other government agencies in carrying out its oftentimes corrupt activities. The CIA infiltrates customs and other agencies, blocking the checks and balances that could otherwise threaten the various CIA operations. Criminal activities in which the CIA or other federal officials may be involved can be kept from the American public. These areas include what has already been described and what has yet to be described, including, for instance, CIA involvement in October Surprise, the HUD and savings and loan scandals, looting of Chapter 11 assets, INSLAW, BCCI, Iraqgate, defrauding U.S. financial institutions, drug trafficking in the United States, and other criminal activities. Throughout these pages it will be seen that these paid media sources were instrumental in covering up these crimes. Failure to report crimes against the United States. If the CIA had not, itself, been involved in many of the corrupt activities, its vast intelligence network should have discovered the criminal activities against America. Other government agencies whose vast investigative powers probably discovered these crimes include the FBI, its parent the Justice Department, Customs, DIA, and others. How could such vast safeguards not have discovered these crimes? Were they incompetent? Were they either part of the criminal activities, or blocked by the top law enforcement officer, the U.S. Attorney General, from doing so? As shown in these pages, the Justice Department has been made into a vast criminal enterprise. Hundreds of thousands of deaths. Former CIA agent Fletcher Prouty tells how the CIA got the United States embroiled in military conflicts, including the Korean and Vietnam Wars, that resulted in enormous casualties. Prouty tells how independently acting CIA groups initiated the conflict leading to the U.S. involvement in Vietnam. Supporting this position was the Asian scholar, Eugene Winchi. In the New Republic, what steered the nation into Vietnam was a series of tiny but powerful cabals. Prouty wrote, by the time of the Bay of Pigs operations, the CIA was part of a greater team, which used the agency and other parts of the government to carry out almost any secret operation it wanted. He continued, in this unusual business I found rather frequently that the CIA would be well on its way into some operation that would later require military support before the secretary and the chiefs had been informed. Prouty explains that the CIA contains the real power structure in the United States, and how the CIA has infiltrated other government agencies and private enterprises with people loyal to the various CIA hierarchies. Secret domestic corporations. The CIA has hundreds of dummy corporations in the United States, such as in the form of proprietaries, fronts, and cooperating assets. These include, for instance, law firms, financial companies, such as banks and bond brokerage houses, insurance companies, and airlines. The CIA can control virtually anything that occurs in the United States or any person or group, including members of Congress, state and federal judges, elections, cover-ups, and murder. Examples of the many past or present CIA proprietary airlines or assets are the following: Civil Air Transport, Air America, Southern Air Transport, Global International Airways, St. Lucia Airways, Intermountain Airways, Summit Aviation, Aero Airlines, Apex Aviation at Spirit of St. Louis Airport, Evergreen International Airlines and its related subsidiaries, Race Aviation, Ransom Aircraft, Resorts International, Flying Tiger Line, Response Air, Sea Green Air, Skyways Aviation, International Air Tours, Capital Airlines, Air Asia, Rich Mountain Aviation, Southwest Airlines. It becomes very easy for the CIA to deny blame for their acts. They simply deny any knowledge of what the front company or contract agent are doing, in addition to their standard practice of lying. There is no danger to this practice since Justice Department officials protect their lying, and their corrupt operations, and most of the mainstream media also covers for them, as well as members of Congress. CIA proprietaries. One of many ways used by the CIA to hide its activities is through the use of proprietaries. This is a corporation secretly owned by an intelligence agency that operates or appears to operate as a private company. It launders money, provides cover for CIA personnel, gathers intelligence, and facilitates covert. 236. Operations. Assassinations. Assassinations have been a routine part of the CIA mindset. In Vietnam, the CIA Phoenix program assassinated over 40,000 people. Numerous books have identified CIA operatives with the assassination of President John F. Kennedy. 2 Congressional hearings had brought out the CIA's plans to assassinate Cuba's Fidel Castro and other heads of state. Leaders of other nations and people considered a threat to the CIA's interests have been assassinated. Many people throughout the world with knowledge of the CIA October surprise operation have been killed or have mysteriously died. Francis Nguyen, who assisted in operating the covert CIA money operation known as Nguyen Hand Bank, was killed in Australia after the CIA's cover was blown, keeping him from testifying about the CIA operation. In trying to comprehend what these CIA-induced deaths mean and to equate the brutality with the CIA, think of thousands of people disemboweled, decapitated, dismembered, the napalming of children and others, and other types of brutality. 2% If the American public exercised its responsibilities, especially in the misuse of its tax dollars needed to finance these CIA outrages, many of these tragedies would not have occurred. Entire continents such as Central and South America have been converted to constant and brutal upheavals with the money and the arms given by the CIA. Death, destruction, and horror follow wherever the CIA goes. Former Mossad operative Ari Ben-Menashe described in his book the assassinations carried out by the Mossad, many of which required the specific approval of Israel's leaders. He related how Amram Nir was killed by a CIA asset to keep him from testifying to a congressional committee investigating the Iran-Contra affair that would have implicated President Reagan, Vice President Bush, Oliver North, Israel's Mossad, Israeli officials, including Shimon Peres. In later pages, assassination tactics of various CIA factions or fiefdoms are described. The CIA has its own assassination teams, as will be explained in later pages. They carry out their deadly tasks in foreign countries and in the United States. One of my CIA sources, commander of a Navy SEAL team, described how his group taught methods of assassination to various intelligence agency personnel. Gunther Russbacher did the same. It has been reported that CIA covert activities in inciting wars, revolutions, and social unrest throughout the world, have resulted in over 6 million deaths, including the 58,000 American GIs who perished in the Vietnam War. CIA hiring mass killer employed by the CIA and the National Security Council, and in frequent contact with Oliver North and George Bush, was Posada Kuriles, a Cuban who had placed a bomb on a Cuban airliner that exploded in midair after taking off from Jamaica, killing all 76 people on board. Kuriles had 297 plausible denial, Mark Lane, JFK, the CIA, Vietnam, and the plot to assassinate John F. Kennedy, L. Fletcher Prouty, act of treason, Mark North, Crossfire, Jim Mars. 298 National Weekly, Spotlight. CIA Review 937. Been convicted of the crime and imprisoned, but escaped. He was placed on the CIA's payroll, managing covert operations in El Salvador. Felix Rodriguez, a close associate of Vice President and then President George Bush, said that the CIA arranged for Kuriles' escape and then employed him in covert CIA operations. No one showed any concern for the 76 people who suffered and died a brutal death. One of Rodriguez's aliases was Max Gomez. He worked closely with Donald Gregg and George Bush, both of whom were heavily involved in the infamous October surprise scheme. Avoiding responsibility for their acts, the CIA uses various methods to avoid responsibility for its actions. One method is to use cutouts acting in place of the CIA. In this way, the CIA can distance itself from the operation if its cover is blown. The CIA makes a standard practice of sheep-dipping those people carrying out their dirty tricks, including military personnel. The person's records are removed from the military agency and placed in a special intelligence file. Fictitious records are processed showing the military person to have been released from the agency. His or her records are changed and letters sent to civilian agencies, banks, friends, indicating discharge from the service. The CIA helps the sheep-dipped person to change his credit and employment records and the many things that a person does when discharged from service. The sheep-dipped people are often eventually returned to military service, and the time spent with the CIA counts toward retirement and other benefits. An individual or a company can be used by the CIA to act on the CIA's behalf, giving the CIA plausible denial. While it is usually very profitable for an individual or company to carry out the dirty work of the CIA, it is sometimes costly. Erwin Rautenberg suffered financially from this arrangement when the CIA cut him off, leaving him with lots of unpaid bills. Air Sea Forwarders. An example of how the CIA uses established companies as a front was an air freight forwarding company in Los Angeles operated by Rautenberg, under the name of Air Sea Forwarders. The CIA asked him for help in 1956 to provide a cover for the CIA, and an agreement was reached with the CIA, allowing the agency to use his company name. Air Sea became two companies, the real one being Air Sea Forwarders, and the false one owned and operated by the CIA, but bearing the Air Sea name. This permitted the CIA to hide their shipments under the name, Air Sea Forwarders. AirAsia operated the largest airplane maintenance facility in Southeast Asia during the Vietnam War. Until 1956, the CIA proprietary worked through a company called Slick Airways. In 1975, the CIA sold AirAsia to another CIA proprietary, E-Systems of Dallas, Texas, which had government contracts exceeding $2 billion a year. In 1981, E-Systems notified Rautenberg that they were terminating their relationship with him, leaving him holding millions of dollars in unpaid bills and taxes that were the responsibility of the CIA. Rautenberg filed a breach of contract suit against E-System and against AirAsia. In November 1984, before his suit came to trial, Rautenberg met with 238 attorneys for the CIA and Justice Department at the office of his lawyer, Mickey Cantor. His own attorney and the attorneys for the CIA and Justice Department demanded that he sign a secrecy agreement, refusing him from introducing any evidence of CIA-related activities at the trial, and barred him from even making reference to the agreement. Rautenberg then sought another attorney. Los Angeles District Court Judge Richard A. Gadbois, Jr., who presided over the case, also issued a secrecy order preventing Rautenberg from presenting his evidence. Despite this order, the jury awarded Rautenberg $6.2 million in damages in 1986. In an unusual act, Judge Gadbois secretly met with CIA and Justice Department attorneys and overturned the jury's verdict. Rautenberg petitioned the U.S. Supreme Court to have the court rule that the judge's order barring submission of evidence was in error. The Supreme Court refused to rule on the request in a May 1993 decision. In the meantime, a federal appeals court ordered a new trial, which was to start after the Supreme Court rendered a decision. Rautenberg was a survivor of the Nazi death camps. He said that he had always thought that dealing with the U.S. government through the CIA was safe, thinking that Uncle Sam wouldn't let me down. The CIA's denial of involvement is willingly accepted by Congress and the establishment media over statements made by brave whistleblowers. This, combined with the absence of responsibility by checks and balances, are key reasons why whistleblowers are little known to the American public. Lying to the media, to Congress, in criminal trials to imprison CIA assets, has long been recognized as standard practice. One of the documents shown in later pages, relating to CIA operative Trenton Parker, clearly shows this practice by the statement, standard denial. Plausible denial. It is standard practice for the CIA to use contract employees and mercenaries to carry out CIA activities within the United States and abroad, and in this manner fraudulently deny any involvement. Another standard practice is for the CIA to conspire with Justice Department attorneys to charge covered employees with violating federal law, and seek long prison sentences so as to silence or discredit them. Some die in prison or are too old to cause trouble for the CIA when they are released. Silencing CIA whistleblowers. Many CIA personnel became disenchanted or outraged by the harm inflicted by the agency's corrupt activities and would like to blow the whistle, but fear the consequences. The years of CIA drug trafficking, for instance, the CIA's major involvement in looting savings and loans, its role in looting bankruptcy court assets, require that there be some mechanism in place to silence anyone who tries to blow the whistle. The mechanism includes, charging potential CIA whistleblowers with federal offenses for having performed duties ordered by their CIA superiors. This tactic has the cooperation of Justice Department officials. With the cooperation of federal judges, stripping the targeted person of his defenses, including refusing to allow him to call CIA witnesses, refusing. CIA Review 239. To provide CIA documents, stripping him of his assets so he cannot hire attorneys and investigators, assigning a court-appointed attorney whose loyalty is to the system. Justifying the refusal to permit CIA witnesses to appear, and documents to be introduced into evidence, on grounds of national security, a catch-all phrase used to block exposure of government misconduct. 2% assassinations and mysterious deaths affecting those who are exposing or who could expose an illegal operation. 3 Chapter 14. Nguyen Hand Bank. Hand Bank, with headquarters in Sydney, Australia, and branch offices throughout the Far East, Europe, and the United States. Nguyen Hand Bank was incorporated in 1976 in the Cayman Islands, a popular money laundering location. It is believed that Nguyen Hand Bank was a replacement for Castle Bank and Trust, incorporated in Nassau, Bahamas. After Castle failed, Nguyen Hand commenced operation. It had branch offices in Far East countries, laundering drug money from the Golden Triangle drug-producing area. Secondary functions were arms sales and funding covert activities, such as undermining governments and funding assassination squads. Nguyen Hand was a covert CIA financial operation comprised primarily of those with ties to the U.S. intelligence community. The primary partners were Francis Nguyen, Michael Hand, and Maurice Bernard Houghton. Vast amounts of money were hidden in assets and financial holdings throughout the world. Either to appear as a legitimate international investment operation, or to defraud people out of millions of dollars, Nguyen Hand took deposits from individuals throughout the world, money that would eventually be lost by these investors. When the cover for this CIA-related operation was blown, these funds were quickly moved to other CIA proprietaries, inflicting financial losses upon the investors and depositors. Many of the individuals putting money into the CIA's Nguyen Hand Bank were military personnel, who eventually lost everything they deposited. Exposing Nguyen Hand fraud. Nguyen Hand's cover was blown on April 11, 1980, by a reporter for Zargat, a Hong Kong financial newsletter. This required the CIA to shut down the operation and destroy evidence of its CIA links. Francis Nguyen was one of the most visible players in the Nguyen Hand operation. He was an alcoholic with a reputation for talking too much, a trait that threatened to expose the CIA's. A primary CIA money laundering operation in the Pacific area was Nguyen G.Y. role in the operation. Assassins killed Nguyen 30. Leaving his body in a car alongside a lonely road outside of Sydney, Australia. A bolt-action rifle was found alongside the body, and the scene was made to look like a suicide. An unspent bullet remained in the firing chamber of the bolt-action rifle. For an unspent bullet to be in the chamber after firing the shot that was instantly fatal, someone, other than Nguyen, had to manually operate the bolt handle. Nguyen obviously did not do this. The bullet had killed Nguyen instantly, blowing away much of his skull and scattering it throughout the car. There were no fingerprints on the gun, indicating that whoever fired the fatal bullet wiped the fingerprints from the rifle. The only identification on Nugan's body was a calling card apparently overlooked by the killers, belonging to William Colby, former director of the Central Intelligence Agency, with a meeting date written on the back. Colby was legal counsel for Nugan Hand. He also had connections to the Wall Street law firm of Reed and Priest, suggesting that this firm was a front for the CIA or a CIA proprietary. After Nugan's death, the CIA removed the funds from the various Nugan Hand offices and laundered them into other CIA operations. Misinformation commenced immediately, denying that the CIA had any connection to the rogue bank, despite the many intelligence agency officers in the operation. Before Australian authorities started an investigation, Michael Hand disappeared, along with most of the Nugan Hand records. Although the media reported that Hand had disappeared, leaving no trace, 2 of my CIA sources had been in contact with him after he fled Australia. Hand secretly surfaced in Iran, followed by his participation in the CIA Central America drug trafficking. Hand disappeared as Australian authorities sought to question him about Nugan's death, the Nugan Hand bank operation, and the disappearance of approximately $1 billion from the bank. Hand first went to Thailand under CIA cover and then showed up in Florida and the Caribbean area. One of my deep cover CIA contacts, Trenton Parker, told how he and Hand had worked together in the early 1980s. Parker's CIA faction was interested in discovering Hand's operation, and Parker met Hand in Jamaica on February 2, 1980. They then worked together on Operation Interlink and Operation Anaconda. Parker said that Hand and Vice President George Bush were in frequent contact after Bush became Vice President, and while Australian authorities were searching for Hand. Parker stated that CIA Director William Casey frequently met with Hand in Panama in the early 1980s concerning arms sales and drug trafficking. Parker stated that he and Hand took over one of the drug trafficking operations for the CIA in Central and South America. He said that Hand's experience in developing the Golden Triangle drug operations for the CIA made him useful as expanding the drug operations from Central and South America into the United States. Investigation by Australian authorities into Nugan Hand revealed the CIA's meddling in Australian affairs, inciting political unrest, intrusion into Australian. 301 January 27, 1980. 243. Elections, deception, invasion of its sovereignty, and other dirty tricks. Like most CIA-related operations, Nugan Hand Bank relied upon a pattern of fraud and deception. Large amounts of currency were moved in and out of various countries, including Australia and the Golden Triangle areas. Michael Hand was a Green Beret and a colonel in the U.S. Army, assigned to the CIA. Earlier, Hand was handling the CIA's drug business and laundered the money from the Golden Triangle area of Asia. In the 1960s, the CIA transferred Hand from the Golden Triangle assignment to Tehran, where he set up the secret police for the Shah of Iran. The Nugan Hand affair received considerable media attention in Australia, but the mainstream media in the United States said virtually nothing about the CIA operation and its implications. Australian authorities conducted numerous investigations, but in their final report they whitewashed the Nugan Hand affair. The CIA had an ongoing relationship with Australia's Security Intelligence Organisation, which probably played a role in the cover-up of Nugan Hand. One of Nugan Hand's CIA assets was John Fredericks. He suffered a fate similar to Francis Nugan. Fredericks and his bodyguard were killed in Australia. Staffed by the CIA, most of the management personnel of Nugan Hand Bank were intelligence community personnel. 3°2 When Nugan Hand shut down, most of them moved to other CIA operations, including Bishop, Baldwin, Rewald, Dillingham, and Wong in Hawaii. These players, with a long CIA and military intelligence background, included, for instance, Admiral Earl Yates, General Leroy Manor, and General Edwin Black. Many people holding check and balance responsibilities covered up for the Nugan Hand scheme. These checks and balances included the oversight agencies in Australia, the Reserve Bank in Australia that had responsibilities over Nugan Hand, Citicorp, which traded securities with Nugan Hand, taxing authorities in Australia, who were familiar with Nugan Hand's operation, the accounting firm that certified the Nugan Hand records, U.S. Consul General in Australia who knew of the CIA operation, the Premier of Australia, who had offices adjacent to Nugan Hand, Irving Trust Company, the correspondent bank for Nugan Hand in the United States, Corporate Affairs Commission in Australia that stonewalled requests for information, prominent Australian attorneys who worked closely with Nugan Hand, Australian Department of Commerce, who had considerable information about Nugan Hand's activities, Australian intelligence agencies that worked with U.S. intelligence agencies, and who knew about the rogue operations, and others. After Nugan's body was found, intense activities were initiated to destroy evidence linking Nugan Hand Bank to the CIA. Retired three-star U.S. General Leroy J. Manor, who had been head of Nugan Hand's Philippine office, tried to have the wire services block the reporting of Nugan's death. Recently retired Rear Admiral Earl P. Yates flew to Australia to direct the shredding of documents. Yates was president of Nugan Hand, and lived near CIA headquarters at Langley, Virginia. Michael Hand joined in the shredding. Maurice Houghton and his attorney, Michael Maloney, also arrived. Hand threatened lower-level employees, stating if Maloney's orders to sanitize the files before the law arrived weren't followed, terrible things would happen, your wives would be cut up and returned to you in bits and pieces. Two in a series of Wall Street Journal articles described Nugan Hand Bank as a drug and arms-related operation, staffed by CIA and military personnel. The articles stated in part, Nugan Hand Bank was deeply involved in moving funds about the world for big international heroin dealers. U.S. servicemen are big losers in failure of Nugan Hand Bank. Australia's Royal Commission on Drugs found so much evidence of drug and drug money trafficking by the CIA operation that it recommended a separate Royal Commission be appointed just for the bank's operations. But Australia's intelligence agency, ASIO, blocked an investigation, reflecting the common practice of intelligence agencies to protect each other rather than their own country. U.S. officials stymied every attempt by Australian authorities to obtain information about Nugan Hand Bank. During its investigation, the Royal Commission found that drugs were flown into a landing strip by former Air America pilot K.L. Bud King and Michael Hand. The strip was on a real estate development promoted by U.S. singer Pat Boone and financed by wealthy shipping magnate D.K. Ludwig. King, who also worked for the Boone-Ludwig project, whose testimony could have been very damaging to Nugan Hand and U.S. officials, died mysteriously in a fall. Australian authorities connected Nugan Hand not only to drug and arms transactions, but also to contract murders, of which there were several associated with Nugan Hand's demise. Australian attorney John Aston and his law firm were found to represent Nugan Hand and various drug traffickers, and the law office was used as a drop point for money to be secretly deposited and moved by Nugan Hand. 245. The Australian investigations left no doubt that Nugan Hand management was heavily involved with drug dealers, including Kun SA, the Golden Triangle's biggest opium producer. Pattern of lies. One of the most pervasive traits of CIA-related companies is the lying by government officials, including those at the CIA, the State Department, the Defense Department, and elsewhere in government. Throughout these pages, in scandal after scandal, government officials assure the public that government officials were not involved. And the public swallows these denials hook, line, and sinker. U.S. officials assured Australia's Prime Minister, Malcolm Fraser, that the United States had no connections to Nugan Hand Bank. These assurances, given routinely to Americans by their government, were, of course, lies. Vice President George Bush, while visiting Australia, also gave his assurances that the CIA wasn't involved with Nugan Hand Bank. In Australia, the CIA worked secretly with ASIO to topple Australia's Labour government led by Prime Minister Gough Whitlam. Many of Nugan Hand's records related to troop movements, hardly subjects that a bank would be interested in. Hand's death and the sudden publicity focused on Nguyen Hand Bank caused its liquidation in April 1980. With its demise, the CIA company concentrating on arms and drug sales and money laundering had to be replaced with another company. That company was Bishop, Baldwin, Rewald, Dillingham, and Wong, which is described in the following chapter. CIA redirected many of the Nguyen Hand operations to another Pacific financial institution based in Hawaii, Bishop, Baldwin, Rewald, Dillingham, and Wong. This CIA proprietary was started, operated, and funded by the CIA in 1979, using many of the same high-level people that had staffed Nguyen Hand Bank. By the end of 1980, BBRDW began setting up offices in Hong Kong, Taiwan, Indonesia, Singapore, and Australia, all former Nguyen Hand locations, staffing the offices with over 30 CIA agents, including some of the same high-level people that operated Nguyen Hand Bank. As in most CIA-related proprietaries, its key management was comprised of CIA-related personnel. 0.3% The CIA used BBRDW as an international investment company cover, with 120 employees staffing offices in 16 countries, including Hong Kong, India, Indonesia, Taiwan, New Zealand, Singapore, London, Paris, Stockholm, Brazil, and Chile. CIA personnel opened and operated these far-flung offices. For appearances, the CIA placed in charge of its BBRDW proprietary a Honolulu businessman, Ronald Rewald, who had worked for the CIA years earlier while attending Milwaukee Institute of Technology. That CIA college project was called Operation MH-Chaos, and consisted of spying on student groups during the mid-1960s. The CIA gave Rewald the alias Winter Dog. Other CIA divisions had parallel programs called Operation Mother Goose and Operation Backdraft. Rewald left the CIA after college, married, and had 5 children, and lived comfortably in a home on Lake Michigan. Business changes caused Rewald. After Nguyen Hand's cover was blown and the operation abandoned, to move his family to Hawaii, where he opened an investment consulting company under the name Consolidated Mutual Investment Corporation. It was here in 1978 that the CIA lured Rewald back into the agency and used his company as a cover. The agency felt that Rewald's athletic activities could snare dignitaries from foreign counties, and encouraged Rewald to become active in polo and other high-profile activities at which these dignitaries were hosted. Rewald became an international polo player, later using BBRDW to purchase the Hawaii Polo Club, which enabled him to cultivate friendships with many influential people throughout the world. These included the Sultan of Brunei, who later transferred $7 billion from British banks to US banks. The CIA wanted Rewald to maintain a lavish lifestyle to attract these people, and funded these activities through other covered companies, especially law firms and consulting firms. Rewald's first CIA station chief and handler was Eugene J. Welch, who was later replaced by Jack Kinchey, followed by Jack W. Rardin, all of whom coached Rewald on CIA operations. Several years later, Rewald would be the fall guy when the cover was blown on BBRDW. Covered funding for CIA proprietaries. Funding for these CIA proprietaries came from other CIA-related companies. Would send fictitious bills to them to explain why the funds were received. These companies were located in California, Virginia, Hong Kong, and Paris. Was active in numerous covered CIA activities, including, supplying arms to Taiwan, India, and other countries, which was unlawful under federal law, but carried out under CIA orders. Setting up banking and trust companies for CIA money laundering. Secretly acquiring Japan's secret plans for the Japanese high-speed surface transport by paying a $27,000 bribe to a Japanese businessman. Targeting foreign political, military and business leaders whose funds were placed in accounts alongside money obtained through clandestine CIA operations. Funding worldwide CIA operations, including assassinations. Soliciting private investors in order to appear like a legitimate international investment concern, commingling their funds with those of the CIA. During the Falklands War, Rewald traveled to Chile and Argentina under cover of playing polo, obtaining intelligence information for the CIA. Rewald was kept uninformed about the more lurid activities carried over from the Nugan Hand operation. Innocence in an area of corrupt activities. The CIA started, funded, and staffed BBRDW and its many subsidiaries. Its high-level CIA agents, including Welch, Kinsey, and Richardson, directed the sordid and illegal operations, keeping the details from Rewald. Once, when Rewald was approached by CIA agent Richard Armitage to handle drug transactions and launder the drug money, Rewald responded that the company did not have expertise in these areas and he didn't want to get involved in them. 249. The CIA's Foreign Resource Chief, Richardson, later told Rewald that CIA people in BBRDW and its subsidiaries did have expertise to handle these matters, and made reference to former Pan Am pilot Ned Avery. At a later date, Rewald described this encounter in a memo to his attorney, and added that he knew that Ned Avery, General Hunter Harris, and Richard Armitage were involved in these areas. CIA cover blown by TV reporter. Honolulu TV reporter Barbara Tanabe drew attention to BBRDW in July 1983 after receiving a tip about BBRDW irregularities. The tip was planted by Chinese intelligence agents who were dissatisfied with BBRDW's campaign seeking to frighten Hong Kong financiers to move their money out of Hong Kong to Hawaii. This attempt to move capital from Hong Kong before China took over the British Crown colony disturbed Chinese officials, and they retaliated by seeking to discredit BBRDW, not knowing it was a CIA operation. This publicity caused Hawaii officials to commence an investigation of financial activities. When a CIA proprietary is investigated by any outside agency, state, or federal, the standard practice is for Washington CIA and Justice Department officials to block the investigation. 3 For this time, however, the CIA proprietary had received too much media attention for this past practice to work. Using typical CIA tactics, the agency pulled funds out of the various bank accounts in Hong Kong, Singapore, London, Switzerland, and the Cayman Islands, transferring the money into other foreign CIA proprietaries and financial institutions. The looted assets consisted not only of CIA money, but also funds invested by private citizens residing in Hawaii and California. Before the cover was blown on BBRDW, millions of dollars were received from investors in Hawaii and California by the CIA proprietary operation. During a board of directors meeting shortly before the cover was blown, Rewald had ordered these investors to be paid off and no further private investment money taken in. This plan was shown by minutes of a board meeting. Rewald's explanation was that these funds were too much trouble, and interfered with agency operations. But after the cover was blown, and without Rewald's knowledge, the CIA removed these funds, just as it had done after the Nugan Hand Bank cover was blown. For over 12 months the local media focused considerable attention on the affair. It was Hawaii's most famous legal case. Shortly after the cover was blown, Rewald became depressed by being made the scapegoat, and the lack of support by his CIA handlers. He checked into room 1632 at the Sheraton Waikiki with thoughts of committing suicide. Before checking into the hotel, Rewald visited the office of the CIA station chief in the Federal Building in downtown Honolulu. Finding Jack Rardin out of the office, Rewald placed a message on Rardin's answering machine. 3 Jack, this is the chairman. I am checking into the Sheraton Waikiki under the name Ronald Imp. Status urgent. Mayday. I'll be waiting for your call. A bottle of codeine number 3, which Rewald contemplated taking, and a Bible, sat on the end table alongside the bed. This was not the behavior of a person intentionally engaging in criminal activities, but more the conduct of a person who was distraught at being used, as Rewald's CIA handlers had done to him. Rewald had kept highly sensitive records of key financial transactions in a green cover book, which the CIA wanted. The book contained information showing secret bank account numbers and aliases, including bank accounts for high-level people in politics and in the intelligence community in such banks as Union Bank of Switzerland, Grand Cayman's Bank, and the Hong Kong and Shanghai Bank. If this information was publicized and understood, it would send shockwaves through the government. In an effort to obtain possession of the valuable book, two CIA agents, Angelo Cancel and Richard Allen, entered Rewald's hotel room and attempted to force Rewald to reveal its location. Rewald was groggy from taking a heavy dose of the codeine tablets and wasn't responding to their requests. They dragged him into the bathroom, placed him against the tub, and plunged a knife deeply into his arms. Bleeding profusely, Rewald lapsed into unconsciousness. Unable to find the book, Allen and Cancel left Rewald to die from loss of blood. Fortuitously, a hotel maid discovered Rewald's bleeding body and he was rushed to Honolulu's Queen's Hospital, saving his life. The hidden green book. While Rewald was recovering in the hospital, he was warned by his CIA handlers to remain quiet, to say nothing, and the CIA would financially support his family. That was never done. The former CIA station chief, Kinchi, visited Rewald in the hospital and asked, "Ron, where is the green book?" "It's safe," replied Rewald. In response to a question from Honolulu detective Ed Lingo, the present CIA station chief, Rardin, claimed he didn't know Rewald, that he didn't know anything about BBRDW except what he read in the papers, and that he had no connection to either. He was of course lying. Rardin socialized frequently with EENE family and was in almost daily contact with Rewald as his CIA handler. Agents Allen and Cancel, who had tried to kill Rewald in the hotel, threatened Rewald's secretaries, Sue Wilson III and Jackie Voss, ordering them to leave Hawaii immediately and never return. Their departure would prevent them from testifying about the CIA operation. "Don't call the FBI," as the two women later discussed their problem. Sue told Jackie that if she hadn't heard from her in the next 30 days to call the local police. When Jackie asked Sue if the FBI should be called, Sue responded, "They won't help us. They're all in this together. We might be able to trust the local guys. They're not part of the system." While these events were taking place, another CIA contract agent and close friend, Thomas Wilhite of San Rafael, California, became outraged at what the agency was doing to Rewald. He said to Rewald, "There's a big cover-up going on. They've completely disavowed any knowledge of you. You are being left out to dry, pure and simple. I'm calling a press conference for tomorrow at the ranch. I'm going to tell the media everything. Tell them this is all a CIA cover-up and that you were just following orders." Rewald responded, "Tom, you can't do that. I have an agreement with the agency. They assured me that as long as keep quiet, Nancy and the children will be taken care of. They will take care of me as soon as all this cools down, so don't do this. It's not necessary." Wilhite replied, "They're lying to you, Ron. I assure you they are destroying every bit of evidence. They are shutting us all up, transferring others to who knows where. All the bank accounts are being emptied. Believe me, you are being abandoned and set up. You know what plausible deniability is all about." Before the press conference the following morning, Wilhite took his red aerobatics pit special biplane for a customary morning flight. Taking off from the grass runway on his ranch, the plane climbed steeply to 1,000 feet and then suddenly plunged to the ground. The crash killed him. The aircraft had apparently been sabotaged. Wilhite's death wasn't the only one connected to BBRDW. Two attorneys were killed in Washington as they searched for evidence linking client, President Ferdinand Marcos of the Philippines, to the CIA. A CIA agent working under Richardson through the BBRDW operation, Richard Craig Smith, had spied on the Russians in Japan and secretly pretended to the Russians to be a double agent, as directed by Charles Richardson. Now, without CIA support, he was arrested by the Justice Department and charged with the serious offense of espionage, allegedly selling secrets to the Russians. Smith's federal case was tried in Virginia, 750 F.2d 1215, and 780 F.2d 1102. Kingpin of CIA operations in the Pacific. After BBRDW's collapse, the British Broadcasting Company referred to Rewald as Kingpin of CIA operations in the Pacific. The judge aided and abetted this cover-up by issuing dozens of orders depriving Rewald of the defenses guaranteed under law. He issued gag orders barring Rewald's attorney from repeating what Rewald had told him, refused to allow the introduction of thousands of CIA documents that would show where the money came from, where the money went, and that Rewald was a CIA agent. Case records, normally available to the public, were sealed from public view. Rewald was ordered not to talk about the CIA. These measures would not have been necessary if the CIA had not been deeply involved in BBRDW. The public, especially the investors who lost millions of dollars, had a right to have access to whatever records and testimony applied to the case. Justice Department officials, seeking to protect the CIA, charged Rewald with 100 counts, including defrauding the many investors who put money into the operation and who lost their investment when the CIA looted the assets. Many of these investors blamed Rewald for their losses, apparently assuming that Justice Department prosecutors were telling the truth and would not lie. Denial of defenses by Justice Department. Justice Department prosecutors used the standard procedures to keep the public from learning about this covert CIA operation. These included, charging Rewald with the federal offense of defrauding the investors, while simultaneously protecting those who actually perpetrated the crime. Seizing all of Rewald's assets, depriving him of the funds necessary to hire legal counsel. Transferring a key CIA attorney, John Payton, to Honolulu to prosecute the case against Rewald. Payton ensured that CIA witnesses and documents were not available to Rewald. Prior to this transfer, Payton was chief of litigation for the Central Intelligence Agency, taking a demotion to become assistant U.S. attorney. Withholding evidence that would have shown that the CIA looted the assets. Engaging in various forms of deception. Denial of defenses by federal judges. Judge Fong cooperated with the Justice Department prosecutors by dismissing Rewald's experienced attorneys, Los Angeles attorney A. Brant Carruth and San Francisco attorney Melvin Belli, and appointing inexperienced legal counsel to represent Rewald. He appointed a young attorney just out of law school who had never tried any case, and who had no knowledge of the legislation relating to classified documents, CIPA .307. This lack of knowledge contributed to Rewald being denied the use of classified documents and CIA witnesses that would show the CIA controlled all of BBRDW's activities. That attorney, Brian Tamamaha, had an application for employment with the Justice Department and was simply waiting for a routine security check. Denying Rewald the right to call CIA witnesses and produce any of the thousands of CIA documents showing him as head of a covert CIA proprietary, carrying out orders as shown on hundreds of cable messages and letters. This denial emasculated Rewald's defense and prevented the public from learning about the CIA operation. Denying to Rewald's attorney the right to introduce important documents, refusing to allow Rewald to testify to his CIA activities, and refusing to allow testimony as to who funded the CIA operations and where the money was spent. Justice Department and CIA officials suborned perjury from its witnesses. In one case, when Rewald's attorney subpoenaed CIA agent John H. Mason, who had given Rewald many orders in the past, the person appearing was not the John H. Mason that Rewald knew. This same trick, substituting another person,